Hi students, good evening one and all. I am CS Haripriya, Company Secretary and Associate Member of ICAI, Institute of Company Secretaries of India, and I'm also working as Company Secretary and Compliance Officer to one of the listed companies in Hyderabad, and I'm also working as Faculty for Law in MASTERMINDS. Hope you are doing well, and by this time your revision might be completed and you have a good strategy plan for your upcoming examinations. I'm there here for you now to revise our corporate and other laws. And thanks to Masterminds for giving this opportunity to have time for this marathon revision classes. And before starting, we shall see the topics which we are going to cover. Yes. So actually your topic is in paper group 1 and paper number 2. Nothing but corporate laws and other laws, right? Corporate laws and other laws. Now coming to the corporate laws, you're having marks of 60 marks. You'll be able to score marks of 60 marks by covering 10 chapters in corporate law. And coming to the other laws, 40 marks are provided for this topic other laws, and also you have to cover only 4 chapters to secure the above stated 40 marks. So I think by seeing this you can know the importance and prominence of other laws, because 40 marks only you need to cover 4 chapters of the topics relating to the other laws. Now what are the other laws which we are going to see? So other laws, the weightage of the topic of other laws is 40 marks, and there are 4 chapters covering in the syllabus of the other laws. So what are the 4 chapters? Number 1, the Indian Contract Act 1872. Already we have learned the topic of Indian Contract Act 1872 in our foundation topics, right? So we have covered the general principles of the contract. Not all the topics are not covered in your Contract Act, but preliminary topics have been covered for you. And the second topic is the Negotiable Instruments Act 1881. Negotiable Instruments Act 1881. Next, number 3rd category is the General Clauses Act 1897. And the 4th other law is nothing but interpretation of statutes. So actually only 4 topics are there for you under the category of other laws, which carries a weightage of 40 marks. So we need to concentrate. If you have conceptual clarity on these 4 topics, definitely you will be able to succeed in the paper number 2. Now coming to the Indian Contract Act, what are the bifurcations we are going to see in the Indian Contract Act topic? So my order of teaching will be same what I have stated here: Indian Contract Act, Negotiable Instruments Act 1881, General Clauses Act, and interpretation of statutes. Same order will follow the teaching. Next, coming to the Indian Contract Act 1872. What are the topics we are going to see here? Number 1, contract of indemnity, contract of indemnity and guarantee, contract of indemnity and guarantee. This is the first chapter we are going to see. And what are the sections covered here? The sections covered here are from section number 124 to section number 147. Section number 124 to section number 147 we are going to see in the topics of the contract of indemnity and guarantee. Number 2, what is the other topic we are going to cover in the Indian Contract Act? Number 2, nothing but bailment and pledge. Bailment and pledge. Yes, these are the topics of the sections. Bailment, nothing but we are going to cover from section 148, section number 171 up to 171 in the bailment topic. And now coming to the pledge topic, we are going to cover section number 172 to 179 of Indian Contract Act 1872. And also section numbers 180, 181 are covered under bailment. So these are the sections which we are going to see in our further study. Number third topic in the Indian Contract Act is nothing but agency, which is very important for the part of the study and examination point of view also. Coming to this agency, sections we are going to cover is section number 182 to 238. So these are the entire things, because we have to have a basic understanding and preliminary knowledge what we are going to study. So this is of the Contract Act which we are going to study. Now we shall start with the first chapter, nothing but Contract of Indemnity and Guarantee. Contract of Indemnity and Guarantee. So this is the first chapter, Contract of Indemnity and Guarantee under what's under Indian Contract Act 1872. Just a minute, ma. Yes. So easy for editing here. So Contract of Indemnity and Guarantee under the topic of Indian Contract Act 1872. Indian Contract Act 1872. So now we are going to see. So first I will have the gist of the summary of the entire chapter. Then we'll proceed with the important topics which are going to be covered in the examinations or otherwise which may be asked from the examination point of view. Now coming to the yes, what are the learning objects we are going to have? Yes, we'll definitely study what is contract of indemnity and what are the various modes of indemnity and rights of parties to the contract of indemnity, concept of guarantee, and distinguishing features of the means what are the specific features of the contract of guarantee, specific guarantee, continue guarantee, discharge of surety, rights of surety, and the most important other topic is distinction between contract of indemnity and contract of guarantee. Yes, we'll study all these things in our chapter. Now, you can see the weightage of this chapter. Nearly 4 to 8 marks are being asked in the past examinations. A minimum of 4 marks, and it can extend up to 8 marks coverage in our examinations. So, the topic, we can't let it go easily. Right, next. Coming to the point, introduction. What is the introduction which we can have with the contract of indemnity? So, nothing but contract of indemnity. We are going to see what is indemnity and what is other features of the indemnity. Number one. Now, coming to the indemnity topic. What is a contract of indemnity then? Nothing but it's a contract. It's a contract in which one person promises to save the loss to another person. Nothing but these are the things which you can easily remember from in the examinations. Contract of indemnity, it is primarily a contract. In that contract, what happens? One person promises to save the loss to the another person. Loss, by whom it is caused? Yes, the loss is caused by promisor himself, maybe promisor himself, or otherwise any other person. So the loss can be caused by the promisor himself or any other person. This is nothing but the contract of indemnity. Now, contract of indemnity is a contingent contract. Nothing but a contingent contract. Contingent contract means what? It may happen or may not happen. If it happens, the contract will go around. If it doesn't happen, the contract will be suspended. So, this is a contingent type of the contract. Next. Coming to the next point, second point, who are the parties to this contract of indemnity? How many parties are there in the contract of indemnity? Yes, there are 2 parties here. There are 2 parties in the contract of indemnity. Who are the parties then? Very easy. But don't confuse, it's a little bit confusion, but there is no issue, very easy only. So, 2 parties. Who are the parties? Party number 1, nothing but the indemnifier. Indemnifier means the person who saves the loss, the person who promises to save the loss, nothing but indemnifier. And the second party can be called as indemnity holder, or otherwise he can also be called as indemnified. Means the person who got saved, from the loss, person who has been saved. So, only 2 parties in the contract of indemnity. Number 1 is indemnifier. Number 2 is indemnity holder. Only 2 parties. Now, Coming to the third point. Till now, 2 points I have covered. Coming to the third point. What are the essential elements? Essential elements for contract of indemnity. For contract of indemnity. What are the essential elements needed for the contract of the indemnity? Amma, in the Contract Act 1872, we have studied general principles of contract, right? So, all the general principles of contract are equally applicable to any of the contracts also. Equally applicable to any of the contracts also. This is a contract of indemnity is a special form of the contract. Special form of the contract. So, what are the essential elements we have studied for the contract? Valid essentials of a contract. The same shall be also equally applicable to the essential elements of the contract of the indemnity also. So let's see. Let's revise. I can use the term revise because already we have learned the topic under foundation category only. So what are the essential elements required for a valid contract? First of all, offer, or we can also call proposal. Offer and acceptance. Offer and acceptance of the contract. Number two, intention to create the legal obligations. Intention to create the legal obligations. Nothing but instead of writing this entire term, we can simply use a one little bit word. What is that? Nothing but legal enforceability. This is a wonderful term we can use instead of writing all those things. Legal enforceability. Legal enforceability means intention to create the legal obligation, legal relations. Next, number three, competence to the contract. Competency of contract. Competency means nothing but capacity of the contracts. Capacity of contract. Who can able to make to do a contract? Who are the persons able to do a contract? It is nothing but called the competency of the contract or capacity of the parties. Next one, number four, 10 essential elements are there here. Next, number 4, nothing but it is called as lawful consideration. Consideration should be there for each and every contract. So, it is nothing but lawful consideration. Next, number 5, the object which we have entered in the contract should be legal. That's why it is called as legal object is also one of the essential element. Next, number 6, lawful object. Next, number 7, agreements which are not, using the term here agreements, please note, agreements which are not expressively declared to be void. Agreements which are not expressly declared to be void means void agreements, you know already, restraint of marriage, restraint of trade, etc. All these are void agreements we have studied under the Indian Contract Act. Next, 8th one, capable of performing the contract. Yes, the contract should be in such a nature that the contract should be performed. It should be capable. No supervening impossibility to be there in performance of the contract. Next one, number 9. Yes, finally, the terms and conditions which we are going to enter into a contract. Should be crystal clear. Nothing but it should not contain any vague terms or any unambiguity. And the terms should be clear and certain. The terms should be clear and certain. And the last one, nothing but some legal formalities. What are the legal formalities applicable in entering the contract need to be done by the parties. So these are the 10 valid essential elements which are required for the contract of the indemnity. Next point. Third point. We are going to third point. So what is that point? We are already seen in the above point how many parties are there in your contract of indemnity. Only 2 parties we have seen. What are the 2 parties? Party number 1 is indemnifier and party number 2 is indemnified, or can also be called as indemnity holder. Yes, we have seen 2 parties. Now my question is, when does the liability of indemnifier arises? When does it arise generally? Generally, it comes soon after the indemnity holder liability is absolute and also certain. So when it comes, the indemnity holder liability is absolute and certain. Immediately the liability of indemnifier also commences, means starts nothing but. Next, this is a third point. Next, number 4. This is the last topic in the case of the yes. So what is the last topic which we have to see? The topic is nothing but what are the rights? What are the rights of indemnity holder? What are the rights of the indemnity holder when at the time of being sued? At the time of being sued, provided the indemnity holder acted in his authority. Indemnity holder acted in his authority. So what are the rights we are going to see? Also, we have already learned rights and liabilities, because intention to create legal obligations, nothing but the contract will arise some rights and obligations. So coming to the particular rights, now we are going to see the rights related when being sued. When being sued, what are the rights? Yes, very easy only. What are the rights we can have at the time of suing, or at the when the cases, court cases pending especially? So number one, nothing but damages for suit. Damages for suit. If the court orders any of the damage, then yes, the indemnifier need to give the damage for the suit, definitely, because it's a court order, legal order. So at the time, damages for the suit will be payable or becomes a liability to the indemnifier. Next, number 2, cost of suit. Cost of suit means whatever the expenses we have in bringing the suit to the court of law, all the expenses will be definitely moved by the indemnifier. Next, number 3. In case sometimes without going to a court cases, sometimes compromise may happen. So some paid for the compromise. So for both point number 2 and point number 3, cost of suit and some paid for the compromise, some conditions need to be complied. Some common conditions need to be complied. I can use a common, because for both the suits, both the compromise amount and both the cost of the suit can be provided only if some conditions are fulfilled. Now, what are the conditions? What are the conditions need to be maintained by the holder? What are the conditions? Number one, he acted in his authority. It's okay, no issue in that. That means he did not contravene. He did not contravene any of the orders. He did not contravene any of the orders of indemnifier. This is the first condition for availing the expenses of cost of the suit. He did not contravene any of the orders of the indemnifier. Next, number 2. Point number 2. Acted as a common prudent man. If such contract is not there. This is the second condition, need to get benefited. Next, number 3. What is number 3? Nothing but the suit is being authorized by the suit is being authorized by the indemnifier. These are the three conditions which need to be done by the indemnity holder for availing the cost of the suit and some paid for the compromise amount. Next, not only this is exhaustive section. This is actually a exhaustive section. So for this section, there are also some other benefits which can be availed by the indemnity holder. So this is the gist of the topic, contract of indemnity. Simple topic, only 4 important points I have said to you. Let's revise in our material. So you can see here special types of the contract. All these are the special types of the contract. And coming so far, we need to cover section numbers 124 to 147 of the Indian Contract Act 1872. Now, what are the contracts we are going to study? One is contract of indemnity and the other one is contract of the guarantee. Next, write about contract of indemnity. Yes, coming to the definition, simple definition, it is a contract, section number 124, a contract by which one party promises to save the other. One party promises to save the other from the loss caused to him. By what? Loss is caused by what ways? By the conduct of the promisor himself or by the conduct of any other person. Simply it is called as contract of indemnity. Also, we have seen it is a contingent contract. May happen or may not happen. Now, who are the parties to the contract of indemnity? Nothing but only two parties are there. Only two parties. Who are the two parties? Number one is indemnifier. Also, we can call it as promisor. And number two is indemnified. Nothing but he is a promisee. Indemnifier. Who is an indemnifier then? The party who promises to save the other party. He is the person who is going to save the other person, other party, we can say. So, nothing but it is called as indemnifier. The party who saves from loss is called indemnifier. Now, who is indemnified then? Nothing but promisee, getting benefited. The person who is promised to be saved. The person who is promised to be saved against the loss. Against the loss is known as indemnified or indemnity holder. Two things. You can use the term two things here. What is that? One is indemnity holder, or otherwise we can also use the term indemnified. We can also use the term indemnified. He is indemnified and also indemnity holder. Next, yes, existence of loss is also a prerequisite for the contract of indemnity. Next, coming to the essential elements of valid contract of indemnity, we already seen offer and acceptance, intention to create legal obligations or legal relations. Nothing but we can use the term here legal enforceability, consideration, competency to contract, free consent, lawful object, and also agreement must not be expressly declared to be void. The terms of the agreement must not be vague and uncertain, means nothing but clear terms should be there. Clear terms should be there. Clear and certain terms. The agreements must be capable of performance, means doing done. To do an impossible act is already void because an agreement which is made for impossible act is void. That's why for agreement to be valid, the performance, capable of performance should be there in a contract. Next, other legal formalities which are required for the contract to give the legal enforceability. All these are the basic valid essential elements in the contract of indemnity. Next, we'll see this question at last. And yes, fourth question. When does the liability of the indemnifier commence? When it commences? Commences means nothing but start. So when it starts, the Indian contract is silent on the time of the commencement of liability of the indemnifier. So contract act did not specify any time. But coming to the judicial pronouncements, means case precedents, whatever the case precedents are there, from that we have inferred that it can be stated that liability of an indemnifier commences as soon as the liability of the indemnity holder will be absolute and certain. Absolute and certain. Only the liability of the indemnifier will commence when the liability of the indemnifier holder, indemnified or indemnity holder, will be absolute and certain. Only at the time liability of the indemnifier shall commence. Next, number 4. This is a question we have seen pertaining to the rights of indemnity holder against the indemnifier in the contract of indemnity. What are the rights available? So basically, what are the rights available here? Yes, to whom it is available? Indemnity holder, provided he need to act in his scope of authority. With his scope of authority, then only we can gain the advantage of damages. So, how many advantages, how many rights we can have? 3 rights basically. So, what are the first one? Damages in the suit, cost of suit, and also some paid for compromising suit. Some paid for compromising suit. So, damages in a suit. When will the damages awarded? Yes, the damages will be awarded by the court, and the other party, means here the indemnifier, need to compel to pay in any suit in respect of matter covered under the contract. So if any award has been given to pay the damages, as such in a manner, the indemnifier need to pay the damages also. Next, coming to the cost of suit. What is this cost of suit? Nothing but all costs, all expenses which he has paid in bringing or defending the suit, provided that. In bringing or defending means in front of the court of law we are putting our suit. So all the expenses whichever we are going to have in bringing or defending the cost of suit, all can be recovered from the indemnifier. Next, number 3, some paid for compromising suit. So what is this compromise? Without any further events or further hearings, the both parties on mutual consent, they will go to a compromise. So during at the time of compromise, we'll pay some amount to the other parties, or we'll get some amount from the other parties. Then in such a case, sums which he has paid under the terms of any compromise of suit, under the terms of any compromise of suit, in which in here both conditions are very similar. Both conditions are very similar for availing the cost of the suit and also for availing the sum paid for compromising suit. Both are same. So what are the things we can say? He did not contravene the orders of the indemnifier. So we didn't contravene. We didn't go against to any of the indemnifier. Next, he acted in such a way as a prudent man, means a common man, in which the own case in the absence of the contract of indemnity. So if there is no contract of indemnity, how he would have acted in a court of law? The same procedure he has followed. So as a common prudent man, he has went. Next, if the promisor authorized him to bring or defend the suit, only upon the authorization only we can get the suit defend. Next, these are the three conditions which need to be provided for the rights of indemnity holder when sued, at the time of being sued. Next, other rights of the indemnity holder. So what are the other rights of the indemnity holder? What are the other rights basically? The other rights are nothing but specified under section 195 or not exhaustive. Or not exhaustive, means somewhat inclusions are also available. Indemnity holder or indemnified has other rights besides those mentioned under section 125. Means what we have seen previously, damages for suit, cost of expenses for suit, and any sum paid for the compromise of the suit. All these expenses, not only this, there are still more other rights. So what are the other rights which we can have? If the indemnity holder has incurred a liability and that liability is absolute, yes, he is entitled to call upon his indemnifier to save him from the liability and to pay that liability. That's what the thing is there. So if any liability, if the indemnity holder has faced or arised, then he can get from the indemnifier, provided the liability is absolute liability. The liability is absolute liability. So this is a topic which we have covered for the contract of indemnity. Only 4 points we have studied in the contract of indemnity, which is very, very easy. I repeat again the 4 points what we have studied. Number 1, contract of indemnity is a special type of contract. So what is the definition we can see under section 124? Yes, we have seen the definition is nothing but it is a contract. It is a contract where one person saves the loss to another person. One person saves the loss to another person. Now, coming to saving the loss, by whom the loss is caused? It may be caused by the promisor himself, or it may be caused by any other person. So this is nothing but contract of indemnity. And it is also a contingent contract. Next, number 2, who are the parties to the contract of indemnity? Who are the parties, ma? There are only two parties. Who are they? Number 1, indemnifier, means the person who saves from the loss. Party number 2, indemnity holder, or he can also be called as indemnified. Means indemnified means the person who got saved from the loss. So these are the only two parties in the contract of indemnity. Next, what are the essential elements with the contract of indemnity? Very easy. We have already studied the basic essential elements of the contract. In the similar manner, the same valid essential elements will form part for the contract of indemnity also. So what are the valid essentials here then? Nothing but number 1, offer and acceptance. We can also call proposal and acceptance. Next, second one, legal enforceability. Yes, I can use such a short term. Nothing but legal enforceability. Number 3, competency of the contract or capacity of the contract. Next, the lawful consideration. Consideration should be lawful, not in any other unauthorized means. Legal object. Also, the object should be lawful, not only legal. The object should be lawful also. And also, agreements not expressly declared to be void. Yes, there are certain void agreements which are expressly declared to be void. Our contract should not come in that way concern. Means agreements in restraint of marriage, agreements in restraint of trade, etc. All this will be covered as void agreements. Void agreements, I'm using the term. So, next, number 8, nothing but capability of performing the contract. Means the impossibility of performing the contract should not be there. Impossibility should not be there. And also, number 9, which is utmost important, nothing but terms and conditions while entering into the contract should be crystal clear. Means absolute terms should be there, and the terms should also be certain. No unambiguity should be used at the time of entering the contract. Next, when does the liability of the indemnifier arises? Point number 3. When does the liability of the indemnifier arises? When it arises, we have already seen the liability soon shall start after the liability of indemnity holder begins. Liability of indemnity holder begins when the liability of the indemnity holder is absolute and certain. Immediately the liability of the indemnifier also starts. Next, what are the rights of indemnity holder when at the time of being sued? We have seen 3 rights of indemnity holder at the time of being sued. So what are the 3 rights he can avail? They can definitely, rights are many other things in a contract, but we are seeing the rights of indemnity holder at the time of suit only. Being sued only, we are seeing only those rights. The other contractual rights will be also available apart from these rights which we are going to study here. So what are the rights here? Number 1. First one is damages for suit in the court of law. Damages for suit means if the court orders any of the damages to be payable from indemnifier, means definitely he has to oblige the court order given by the court. So he need to make the payment. He will be liable upon the court order awarding the damages. Next, number 2. What is number 2? Cost of the suit, or nothing but we can say expenses in bringing or defending, expenses in defending the suit in the court of law. Cost of suit means nothing but expenses incurred in bringing or defending the suit where in the court of law. So nothing but it is cost of the suit, or the expenses also will be reimbursed by the indemnifier. Next, number 3. What is number 3? Sum paid for the compromise of the suit. Whatever suit we are going, but we are making not suit into the legal picture, but we are compromising our suit. So whatever sum we pay to the compromise way, manner of the closing of the contract through compromise, then definitely those amount will be recovered by the indemnifier, provided the indemnifier need to act within his scope of authority. Not only that, there are some other conditions through which we can avail the damages, cost of suit and cost of other expenses also. So what are the conditions we need to comply? Nothing but the person, he means nothing but indemnity holder. The indemnity holder did not contravene any order of the indemnifier. So we are not going to contravene, or we are not going against to any order of the indemnifier. Next, number 2. Acted as a common prudent man. If so, the contract of indemnity is not there. That way only we have acted. Means like such a common prudent man only. And next, number 3. The suit is being authorized by the indemnifier. If these 3 conditions comply, yes, we can receive the cost of expenses of the suit, and also we can have the sum paid for the compromise amount of the suit. So these are the 3 conditions need to be followed for getting benefited from the expenses of the suit. Next, number 4. Other benefits are also there. 125. This is nothing but rights of indemnity holder under section 125. Only 2 sections we have covered till now, 124 and 125. 124 is nothing but the definition of indemnity, contract of indemnity, what we have seen in the point number 1. And here the last thing is rights of indemnity holder. It is nothing but section number 125. Other rights, other benefits are also there apart from these covering of the damages. Not exhaustive. They use the term particularly section 125. Section 125 is not exhaustive. Means not only this, there may be other exhaustive, there may be other benefits which can be availed by the indemnity holder. So this is a topic, short coverage or snapshot which we can say for the things of contract of indemnity. Only 4 points I have said. So if you remember these 4 points, if any question have been asked regarding contract of indemnity, definitely if you remember these 4 points, it will be helpful to you. So this is the gist of contract of indemnity. And next we'll be continuing with the contract of guarantee topic. Contract of guarantee. And so far we have seen regarding the contract of indemnity. So, what are the things or what are the points which can be covered in the examination regarding contract of indemnity? So, what we have learned in the contract of indemnity, only 4 points we have learned. So, during that 4 points, which of the questions can be asked in the examination point of view? So, the thing is that first one, what is the definition of contract of indemnity? Yes, it may be asked in the examinations, and also the other question which can be asked or which can be presented in the examination is nothing but the rights of indemnity holder when being sued. These are the 2 questions from examination point of view. So, now we are going to continue with the contract of guarantee. So, what is this contract of guarantee? Yes, we have seen contract of indemnity, and this is the second part which we are going to cover in the Indian Contract Act 1872. So, contract of guarantee. Contract of guarantee, section number 126 to 147, we'll see the respective sections in the contract of guarantee. So, first coming to the definition point of view, point number 1, please note. I'm going to say point wise so that you can easily remember how many points we have covered in the topic given. So, what is the definition of the contract of guarantee? Nothing but guarantee is also a contract. It is a type of contract in which what will be fulfilled? It will be fulfilled to perform. What to perform? To perform the promise made. To perform the promise made, or otherwise discharge a liability. It is a contract. What to perform? It is a contract to perform promise made or discharge a liability. Whose liability, sir? Whose liability it is? Incurred by a third person. Provided at the time of default. These are the conditions, essentials for the contract of guarantee. So, what is this? Nothing but the definition point of view, section 126, which says the contract of guarantee is a contract which to perform the promise made or discharge a liability. Whose liability? Incurred by a third person at the point of time of default. So, these are the definition of the contract of guarantee. Now, coming to the things. So, we have seen 2 3 points here. The second thing is parties involved in the contract of guarantee. Who are the parties involved? Just now we have seen there are 3 parties in the contract of guarantee. How many parties are there in contract of indemnity? It's only 2 parties, indemnifier and indemnity holder, right? Only 2 parties in contract of indemnity. Now, coming to the contract of guarantee, how many number of parties, sir? It is a basic difference between contract of indemnity and contract of guarantee. Here, 3 parties we'll see. Who are the 3 parties there? First one, number 1, it is a principal debtor. Number 2, second party, creditor. Number 3, surety. Amma, listen, most of the questions from the examination of point of view in this chapter will be loaded in contract of guarantee only. Less number of questions comes from contract of indemnity. More coverage or more practical questions will be coming from the contract of guarantee. Contract of guarantee is such a huge important chapter. Next, coming to the parties. Who are the parties involved? 3 parties are involved. Who are they? Principal debtor, creditor and surety. Now coming to the definitions. Who is principal debtor, who is surety and who is a creditor? Definitions. First, we will know the definition of the surety. What is the definition of the surety? Nothing but surety is a person who gives guarantee. Look ma, all the 3 definitions regarding principal debtor, surety and creditor lies only with the subject guarantee given. All the definitions will be related to the subject guarantee given because it is a contract of guarantee. Now, who is a principal debtor? For whom or for whose default the guarantee is given. For whose default the guarantee is given. It is called as a principal debtor. Now coming to the creditor. Who is a creditor then? For whom the guarantee is given. for whom the guarantee is given is termed as nothing but the creditor. So there are three parties. Party number 1, principal debtor. Party number 2, creditor. Party number 3, surety. So these three are the definitions which relate to the topic concerned, nothing but the guarantee given. Who is a surety? Who gives guarantee? The person who gives guarantee. Who is the principal debtor? For whose default the guarantee is given. Upon whose default the guarantee is given. Now number 3 is creditor. Definition, nothing but for whom the guarantee is given. So you can observe from this, or from this inference we can take there will be not only three parties. How many types of contracts also arise in this case? Nothing but 3 different types of contracts will be arising from the definition of the contract of guarantee. So what are the three contracts we can say? Contract number 1. The contract between principal debtor and creditor is called as primary contract. So there will be 3 different type of contracts arising between these 3 persons. What is the contract number 1? The primary contract will lie between whom, sir? Principal debtor and creditor. Next, secondary contract lying between the surety and the creditor. Secondary contract, it is lying between the surety and creditor. The third contract is there, nothing but an implied contract. Implied contract. The third contract, it is between the principal debtor and surety. Not only that, this implied contract is nothing but the contract of indemnity. Implied contract is nothing but the contract of indemnity. Hence, will be calling nothing but as tripartite agreement. Tripartite agreement means what? Agreement. There will be 3 different agreements between these 3 different parties. That's why we'll be calling as tripartite agreement. Agreement number 1, it is between principal debtor and creditor. Nothing but it is called as primary contract. Agreement number 2, what is that? Secondary contract. It is between surety and creditor. And there is a third contract because it is a tripartite contract, and in the third contract the agreement will be between principal debtor and the surety. This is an implied contract, which is nothing but the contract of indemnity. So can I use the word contract of indemnity is a subset of contract of guarantee? Can I use the word? Definitely yes. Yes, we can use the statement because contract of indemnity is a subset of contract of guarantee. Means what? In a contract of guarantee, there will be an implied contract, nothing but the contract of indemnity. This is a very, very important point. So, contract of guarantee, the definition we have seen, and also we have gone to the parties involved. Who are the parties involved and what are the different types of contracts in between the parties? Tripartite agreement. So this is a preliminary introduction to the contract of guarantee. Now second thing, what are the essentials? Second point, what are the essentials for a valid guarantee? What are the essentials for a valid guarantee? We have seen already essentials for a valid contract of indemnity. Means whatever lying in the essentials for a contract, all the things are lying for the valid contract of indemnity also. Now, the same things we can learn in the valid guarantee? No, there will be some more extra things in case of the essentials which are required for a valid guarantee. So, what are the essentials then? Let's have a look here. Number one, we are studying 3 parties are there: principal debtor, creditor and surety. Means debtor, you cannot think is that nothing but there should be a principal debt. For this principal debt, 2 conditions will be there. What are the 2 conditions? Number 1, for the principal debt, it is a existing liability. The principal debt is an existing liability. Number 2, the liability is not a time barred debt. What is the reason for this? It should not be a time barred debt? Why can't a outbound or outdated debt can't be made for surety? The reason is that, sir, time barred debt will not have any legal enforceability. Legal enforceability is a preliminary part for a contract. There is nothing but intention to create legal obligations. So if the same thing is not there in case of a agreement, it will not come into a contract. That's why that's the only reason the liability which is present in case of the principal debtor and creditor should be not a time barred debt. Not a time barred debt. One more thing is that in case of principal debt. What is that? What is that? If this is a tricky point. This is a tricky point as far as the examinations concerned. Tricky point. What is the tricky point? We have to know here. Nothing but if a principal debtor, because many questions have been asked on this small concept. What is that? If a principal debtor is a minor. Minor means whether he is competent to contract or incompetent. Definitely incompetent to contract. Incompetent to contract. He may not able to contract, and if so entered also, it will become void. Yes, we have learned that incapacity to contract, right? Next, minor, if he is incompetent to contractor, he is a principal debtor in our case. Now say me whether the contract of guarantee will be valid or void. Generally, minor, incompetent to contract. If he enters any contract, the result is what? Result is a void agreement. Yes, void agreement. Now, here in this case, what happens to the fate of the contract of guarantee? Definitely, it is valid. Please make note. Definitely, it is valid. So, this is the tricky point where you may fall into the trap. The tricky point, please note, minor, if he is a principal debtor, means, yes, what happens to the contract of guarantee? The contract of guarantee is valid here. For suppose, if I change a small thing here, instead of principal debtor, surety is a minor. Instead of principal debtor, surety is a minor. Now, what happens to the fate of contract of guarantee? Whether it will be valid or void contract of guarantee. If surety is a minor, think and say. It's nothing but the answer is void. The answer is void, because coming to the contract of guarantee, ineligible, incompetent person entering into the contract of guarantee will make the agreement void itself. But here, above case, what we have concerned, it is a contract of principal debtor and creditor. It's a contract of principal debtor and creditor. If principal debtor is a minor, yes, he can enforce, the creditor can enforce from the surety. Hence, because it is a contract of guarantee, hence in that situations, it is valid. But surety is a minor means in that situations, it is not valid. Void agreement, nothing but. It's a void agreement. Now, coming to the third essential. What is the third essential we can learn? Nothing but consideration. Nothing but consideration. Yes. What consideration should be there? Lawful consideration should be there. Yes, valid essential elements for a contract. Consideration should be there. If a consideration is a past consideration, means already we have benefited in the past, then can it be allowable for this contract, ma? No past consideration. No past consideration. Please note, no past consideration. Only present consideration should be there. Should form part of the contract. Now, next thing, no past consideration. If consideration is obtained through any benefit to principal debtor, if consideration is obtained through any benefit to principal debtor, whether it will be called as consideration? Yes. Benefit of consideration will be lying always. Benefit of consideration is also acceptable in case of the contract of guarantee. No issue in that. Next one. These are points relating to the consideration. Yes. Agreement relating to the contract of surety. Nothing but the contract of guarantee. Can it be oral? Can it be oral? Means a written agreement is compulsory needed to enforce a contract of guarantee? No, it's not the case. Agreement can be oral or written. Agreement can be oral or written. No form of written agreement only needed. No, it's not like that. It's not like that. No form of written only. No. We can go. Written can be considered, also oral also can be considered. No, there is no mandatory thing that only written agreements can be enforced in court of law. No, it's not such a case. The case is the agreements, whether it can be taken as oral or whether it can be taken as written, both are legally equally enforceable. Both are equally enforceable. Next one. Next point. What is the other thing? Next. If surety is proceeded, against before the principal debtor, means without proceeding first the principal debtor, what the creditor need to do? while enforcing his liability, first he need to sue the principal debtor if at the time of default. At the time of default, if this creditor did not sue the principal debtor, but he sued the surety first, then it will be correct or not? No issue in that. Surety need to pay that. Though he did not, the principal debtor did not sue first, also cannot invalidate the proceedings. Yes, it can't invalidate the proceedings, and hence it can be legally enforceable. Invalidate the proceedings of the contract. Cannot invalidate the proceedings of the contract. It can be considerable only. Next thing. Sixth point. What is the sixth point? Suppose co-sureties are there along with the surety. In the contract of guarantee, we have seen that co-sureties need to be joined. Then what is if the co-sureties did not join at the time of surety payment, the contract is void. Means if co-sureties need to be joined, yes, only if they joined only the contract will come. The co-sureties joined, yes, the contract will come as valid contract. The co-sureties did not join the liability. Then what happened, ma? The agreement will become void in fact. So if there are any co-sureties, means definitely they also need to be joined, and when only they join, the contract comes into the picture. It is a valid contract. So if a co-sureties are not available and did not join the liability, then definitely the contract will become void. Next, and one more thing, one of the important other tricky point in the examinations, is nothing but if the contract of guarantee is obtained, through concealment of material facts. Means any concealment is there, any hiding, nothing but concealment means hiding. Any hiding of a fact of representation is there, or we can also say misrepresentation has been done in obtaining the contract of guarantee. So for obtaining the contract of guarantee, we have done such a thing which amount to concealment of the material facts relating to what, sir? Relating to contract. We have concealed something, we have hidden something from the surety, from the person surety who is giving guarantee. We are hiding. So if he signs without having any knowledge prior to that, then the contract will become definitely void. If any through misrepresentation also you have obtained contract of guarantee, the fate of the contract is nothing but void. It should not be done. So these are the essentials. For a valid contract of guarantee. What are the essentials? Let's see. First of all, there should be a principal debt. Existing liability should be there. The existing liability should not be time barred. A time barred debt can't be enforced in the court of the law. So this is the reason the existing liability could not be a time barred debt. Number 2. In the principal debt only. If the principal debtor is a minor, means what happens to the contract of the guarantee? This is straight away question, scenario based question may be asked, or any case law can also be asked concerning regarding this point. Means they will give minor has obtained a loan from some other person, then surety will be given for that contract, whether if he is a person of minor, can the surety contract be valid or void, or can it be done or not, or surety will be discharged or not. Any of the questions may be posed from the examination point of view. Now, my concern is if a principal debtor is a minor, means incompetent to contract, means the contract of guarantee does not invalidate. Means the surety's liability will be hold good only. There is no thing that the contract will be void for that. But if a surety is a minor, means it can't be enforced. Next, number 3, regarding consideration. Yes, consideration should be there. It can be in any form of benefit to principal debtor also. It can be in any form of benefit to the principal debtor also. But no past consideration is possible in the agreement of the contract of guarantee. I have given olden times. Now, this consideration will not become work out into the contract of the guarantee. Next, yes, agreement can be oral or written. Agreement can be what, ma? Oral or written. Means only written. No, it can be in oral also. No issue in that. Both are equally enforceable in the court of law. Now, fifth point, surety proceeded against before suing the principal debtor. So, if first principal debtor need to be sued, but the creditor what has done in this case? The creditor has done that the surety should be made liable first, or the surety should be sued first. In that case also, it will not invalidate the proceedings against the surety. It will not invalidate, no issue in that. Surety will remain liable to the creditor. Surety will remain liable to the creditor. Next important point is co-sureties. Co-sureties. So, co-sureties should be joined in a contract, means yes, they need to join, then only it will become valid. If they didn't join in the contract of guarantee, means the agreement will become void itself. The agreement will not sustain in the court of law. So, these are the essentials which are required for the contract of the valid guarantee. Next, coming to the next thing. So, we have already learned that there will be three parties: principal debtor, creditor and surety. Principal debtor, creditor and surety. Now, what is the contract between principal debtor and surety? Nothing but implied contract. Nothing but implied contract. The contract is implied itself. Means it is a contract of indemnity, or right? Yes, it's a contract of indemnity. In fact, contract of indemnity. Now, so from this inference, we can say that there is an, my statement, check my statement whether it is correct or not. There is an implied promise by the principal debtor. Implied promise by the principal debtor to indemnify the surety. Correct or not? Whether the statement is correct or not? Absolutely correct. The statement is absolutely correct. There shall be lying an implied promise by the principal debtor to indemnify the surety. At what time? Provided the surety need to pay or paid. Anything holds good. Paid all the rightful dues. Means for any other dues, this will not hold good. Only the rightful payment of dues. Yes, surety if paid all the rightful dues to the creditor, then only the principal debtor liability will come into the picture to indemnify. Right? Yes. So this is a thing of essentials, valid essentials of the contract of guarantee. Now we are moving to the other concept, that is nothing but number 4. Because 2 points we have covered: introduction and essentials of a valid guarantee. Now point number 3. What is the third concept we are going to learn? Very easy. Types of guarantee. Types of guarantee. What are the 2 types of guarantee you know? Types of guarantee. What are the 2 types of guarantee you know? Very easy. The guarantee is, one thing is specific guarantee and the other thing is continuing guarantee. One form of guarantee is specific guarantee. And other point of guarantee, other type of guarantee is nothing but continuing guarantee. Look children, most of the questions will be coming from this continuing guarantee only. Questions, if so asked, may come from the area of continuing guarantee because it is such an important concept. Now, coming to the specific guarantee. What is the definition of the specific guarantee, sir? Definition of specific guarantee is nothing but the guarantee given to one form of contract or one form of transaction. Or else we can also see that only specific transaction we have given a guarantee. So it is called as specific guarantee. Means only one form of transaction you have given guarantee, or only one particular transaction you have given guarantee. It is called as specific form of guarantee. Now, what is the continuing guarantee? What is the continuing guarantee then? Nothing but the guarantee given for a series of transactions. Means it is not related only to the one transaction, 2 transaction. No, not like that. For a series of transaction, it can be series of period or it can be series of installments, any other thing. So it is a guarantee given for a series of transactions or events is called as a continuing guarantee. Now, what are the things? Nothing but we can see that it extends, the guarantee extends not only one transaction but to the series of the transactions. Now, what are the things concerned in guarantee, continuing guarantee? What are the things concerned? Number one is extends to all the transactions in a contract. This is the primary inference we can take, and makes the surety liable to the unpaid balance in the transaction. Makes the surety liable to the unpaid balance in the continuing guarantee. Whatever unpaid balance is there, it need to be paid to the surety only, nothing but, because it is a continuing guarantee. It extends to the n number of contracts entered between the parties. N number of contracts, whatever transactions they have done, all the transactions. Who is responsible to pay if any default happens? Definitely the surety need to pay. So surety will be liable for what amount? For the unpaid balance in a continuing guarantee. Means what happens? Suppose the transaction value is total 1 lakh. So transaction value is total 1 lakh. So in that, the all amounts are paid by principal debtor and creditor, and here is the surety. So here is the surety. Total amount of the transactions is 1 lakh. Total amount of transactions is 1 lakh. So in the main course, 60,000 has been paid by the principal debtor. 60,000 has been paid. What is the unpaid balance? Not paid by the principal debtor. 40,000 is the liability still lying in the case of the principal debtor, but principal debtor is unable to pay 60,000. Now, what the creditor will do? Does he collect rupees 1 lakh rupees or only 40,000 rupees? Definitely, he is going to collect 40,000 rupees only. Means what? What is the unpaid balance amount? That unpaid balance amount will only be collected by the creditor, not other amount, not the transaction value, So it extends to the series of transactions. Liability extends to a series of transactions only. No issue in that. But for the series of transactions, what amount is lying unpaid? What amount is lying unpaid will come into the picture for the point of the surety's liability. Wonderful point. This is one of the wonderful point. Next second point. So when can be revoked? When can be revoked? So if the continuing guarantee, if in a continuing guarantee, if a surety feels he wants to revoke now, For example, I'll say surety and creditor, they have entered into the contract of guarantee that for a period of January to June, means for a 6 months period, the continuing guarantee will be lying good. Now, the term is here April. April month is running. Now, the surety wants to give a revocation of the guarantee. Revocation means he want to withdraw. Nothing but he want to withdraw the guarantee given, continuing guarantee given, because he has up to June the liability. Now, in April, he wants to give the revocation of the continuing guarantee. Can he do so first of all? Definitely yes. He can revoke. Through what way? By giving notice to the creditor. Simply by giving notice to the creditor, sir, I am making my revocation. Of guarantee in the month of April. Now, what is the fate of the contract? The next question comes. January to June, we have agreed for a 6 months period. We have agreed the continuing guarantee, right? Now, in April, he wants to revoke the guarantee. Now, what happened to the other months, sir, then? May month is there, June month is there, so upcoming 2 months are there. What happens? Now, two issues arises. What are they? What happens to the previous contracts? What happens to the future contracts or future transactions? You can use the word. What happens to the future transactions? So, whatever the previous transaction, in our example, we have took from January to April. With the previous contracts made. This is the term where the previous contracts are made. Now, coming to the future transactions, May and June. Actually, the continuing guarantee is given from January to June. But from April onwards, in the month end of April, the person of surety revoked the contract of the guarantee. Now, above thing is that, our concern is that, what happens to the previous transactions and what happens to the future transactions. So, if the April notice is given revocation of continuing guarantee, means the contracts or transactions enter between January and April will be holding good. Means continuing guarantee will be available for these transactions. For the previous transactions, continuing guarantee will hold good. So he gave the notice of revocation. But after the date he gave the notice of revocation, all the future transactions will not be hold good. Means the contract of continuing guarantee will not sustain. This is the fate of the contract. Means what? If the surety wants to give the notice to the creditor, that is nothing but revocation of the continuing guarantee, then only for the future transactions the surety is discharged. Means for all the old transactions, the surety will be lying liable only. For all the old transactions, for the period which they have agreed, the surety will be lying liable only. So, this is the next essential. Next, one more thing. What is the other point? In the contract of surety? Point number 3, right? In the revocation. Now, next, if death of a surety happens. So, in the absence of any contrary to the contract. So, generally in contract, if they mention anything, if surety dies, some other person comes into the picture. If such a thing is mentioned in the contract of guarantee, then it will hold good. But in the absence of any such contract, what the provision will happen? Further, revocation of continuing guarantee will come into the picture. The concept of revocation of continuing guarantee will come into the picture. Revocation of continuing guarantee for previous transactions or future transactions? Future transactions. Only for the future transactions. Not for the old previous transactions. So, nothing but if the death of a surety happens, means what happens? The concept of revocation of continuing guarantee happens. Revocation of continuing guarantee is hold good for the future transaction. Means for the old transactions, the surety's estate will be liable or not? Definitely yes. Surety's estate will be liable for the old transactions. Surety estate will be liable for the old transactions. So, these are the points regarding continuing guarantee. So, once see, there are the two types of the contract. What are the two types of the guarantee contracts? One is specific guarantee and the other one is continuing guarantee. So, what is specific guarantee? It is only for one form of the transaction or specific particular transaction the guarantee will be given. Next, number 2, continuing guarantee. What is this continuing guarantee? The surety's liability will be going to extend to the series of the transactions. What are the other points or other concerns in the continuing guarantee? The other things is nothing but extends to all the future transactions. All the transactions in a contract means nothing but surety shall be liable for the unpaid balances only. Now, any revocation can be possible in case of the continuing guarantee means? Yes, revocation of continuing guarantee is possible. Through what way he can revoke? He can revoke if to giving the notice of revocation to whom, sir? Creditor. To the creditor. Now, for the revocation of the continuing guarantee, whether it can hold good for the previous contracts? Yes, it can hold good. The surety shall be liable for the previous transactions happened. Can the surety be liable for the future transactions after giving the notice? No, surety will not be liable for the future transactions after giving the notice. So, this is another good point, and sometimes these questions may be asked in the examination. Question may come from this part of the topic in the examination. Means they will give a series of transactions and one day the surety will give notice to the creditor revoking the continuing guarantee. Now, what is the fate of the old transaction value and what is the fate for the future transaction value? Next, death of the surety. If death of the surety happen means in the absence of any contrary provision in the agreement. Generally, if any contrary provision is there, as such they will go, as such they will move forward. But if any contrary is not present, this part is concerned only with it is deemed as revocation of continuing guarantee, and that will happen only for the future transactions, and for the previous transactions, surety estate will be liable. Surety's estate will be liable. So now check it in our material. What are the things? So look the definition has been asked in one of the MTPs. Yes. Definition has been asked in MTPs, features of the contract. Features of the contract. Essential. What is the meaning of the contract of guarantee? And state the essential features of the contract of guarantee. We have seen essential features. Yes, there are 6 essential features. What is the essential features we have seen? One is the principal debt, liability. The liability should be existing liability, and also it should not be a time-barred debt liability. Agreement can be oral or written. Consideration can be there, no past consideration. Consideration in the form of benefit also can be taken. Yes, co-surety is joining, only the contract will become valid. And if the creditor sues the surety without suing first the principal debtor, the proceedings will not be invalidated, means surety is not discharged on the act of like that. So these are the essentials of a contract of guarantee. Now you see the meaning. To perform the promise made or discharge the liability by a third person. By a third person. How many number of parties are there? 3 parties. How many number of parties? 3 parties. Who are they? Surety, principal debtor and creditor. So that's why we are having the tripartite agreement. Means principal contract, secondary contract and an implied contract. It is nothing but a contract of indemnity. Contract of indemnity. Now, second question, distinguishing features of the contract of guarantee. Principal debt should be there. What we have seen. And consideration. Yes, past consideration should not be there. Without consideration is void. Next, as a benefit also can be taken. Yes. Next, any benefit given by the creditor to the principal debtor is also sufficient. Benefit also includes the consideration. Competent parties. But this competent parties, principal debtor is incompetent means guarantee is valid. But if surety is incompetent means guarantee is void. We have seen the topic that also. Existence of liability. Yes, we have noted, ma'am. Enforceable and not time barred. Next, misrepresentation or concealment. Yes, if any guarantee has been obtained, by the misrepresentation or concealment of the facts, means it is not valid. It is invalid. It is invalid. Here also see another important point, any guarantee which the creditor has obtained by means of keeping silence. Sir, actually we have studied a question whether silence amounts to fraud or not. Definitely yes. Silence amounts to fraud in some situations as to material circumstances, because it is relating to the material content of the transaction. It is relating to the material content of the transaction. That's why we can say that it is invalid. The contract is invalid. Next. Writing not necessary, oral or written. We can have the agreement, joining of the other co-sureties. That's what I have said. So, till the joining, it will not become valid. It is not valid only. Next. Next question, types of guarantee. Yes, we have seen. One is specific guarantee and one is continuing guarantee. Now, what is specific guarantee? Only for a single let or only for a specific particular transaction. If a guarantee is entered, it is called as a specific guarantee. Now, what is surety's liabilities? When it will be come to an end, or when will be discharged the surety? If the debt is repaid or the promise is duly performed. Anything. The promise is nothing but to repay the the promise is nothing but to repay the debt. So that's why we are using the term here or. If the promise is duly performed or the guarantee debt is repaid, then surety's liabilities shall come into the end for a specific form of the guarantee. For a specific form of the guarantee. Now coming to the continuing guarantee. Continuing guarantee is what I have say. It extends. Highlight the word extends, because extends is important here. Not to a series of transactions. Extends. If you need to present. If the question has been asked on the definition of the continuing guarantee, definitely you need to have the this term extends. The guarantee extends to a series of transaction. It is called as a continuing guarantee. Now, what is the essence? Yes, it extends to any number of transactions. We have said n number of transactions. The guarantee will extend. Next, this is also an important point. What is it? Nothing but unpaid balance, only at the unpaid balance at the end of the guarantee. Now when the liability of the surety extends till, the liability of the surety extends performance of discharge of all transactions, means all transactions need to be done, then only surety will be, liability will be N, or otherwise revocation of the guarantee. Means there are two types for coming out from a continuing guarantee, two types for coming out or discharge. We can use the better word, discharge, coming out or discharge of continuing guarantee. There are two ways. What are the two ways? Number one, whatever the promise made, it is fulfilled, or otherwise means nothing but, or otherwise performance of discharge of all the transactions. All transactions need to be discharged. It's a one way, means fulfilling the contract as such. There is no other option. If we enter into a contract, we need to fulfill the contract. So if it is fulfilled, means automatically it will discharge the surety's liability, or otherwise there is gate 2 also, exit gate number 2. What is that? Nothing but revocation, means we can revoke our guarantee given. We can revoke our guarantee given. This is option number 2, nothing but an exit gate option, right? So next, so these are the things we have studied so far now. What is the definition of the guarantee? Who are the parties involved? And what are the types of agreement between the parties? And what are the essential elements for a valid guarantee contract? And the next one we have loaded with types of the guarantee, two types of the guarantees. And what are the important things in the examination? I have already said while making my explanation only. Can we move forward then now? Yes. Next one. Next picture. Nothing but one more important concept is that. What is the important concept? Section number 132. I'll give all the section number references at the end of the topic. No issue in that. Don't worry regarding sections, how we could remember, etc. I'll give a entire small content regarding the section references. Now, section number 132. What is this here? Suppose, listen my concept. Suppose two persons are there, P1 and P2. Two persons are there. These are the sureties. Let's think. These are the sureties. P1 and P2 are the sureties. They have given the surety or undertake liability. They have undertake the liability. Undertake liability of a creditor. Undertake discharge of liability to a creditor. They have given contract of guarantee to a creditor. Nothing but contract of guarantee has been entered in between them. Contract of guarantee. Who entered Who entered between? P1, P2 plus the creditor has entered. P1, P2 plus the creditor has entered the contract of the guarantee. Contract of guarantee. So here what happened? They have an agreement. They have an agreement. P1 and P2. Internal agreement is there. So one is a contract of guarantee. This is contract of guarantee between sureties. We'll call both P1 and P2 as sureties only. There are no other thing. Sureties will call. So we have entered a first contract between sureties and the creditor. We have entered the first contract between sureties and creditor. But here they have made an internal agreement. P1 and P2 made an internal agreement. What is the internal agreement between them? Yes, they have entered that upon default by the principal debtor, yes, will be liable. Will be definitely liable. This is one of the considerable point. When does the surety's liabilities commences? When does surety liability commences? Definitely by the default of the principal debtor, surety's liability will be started, commenced. Surety liability will be commenced. Now, what happened here? They have made such an agreement. They have made such an agreement that they will be liable. They will be liable on the default of the other. On the default of the other. Means if anyone defaults in this P1 and P2, then only they will be liable. Now see what happens actually to the original contract. Both P1 and P2 will be liable. But here what they have decided, upon default, only other will be discharged and the other party will only be liable. This internal agreement will be affected to the primary contract. What is the contract of guarantee here? No, it will not be affected. Means whatever the contract entered in between the persons P1 and P2, it will not get affected to the contract of the guarantee. It will not affect to the contract of the guarantee. Means it will not invalidate for the creditor to sue both the persons P1 and P2. No, only one liable. My iddharlo okalle liable. No, it's not like that. Both will be liable as far as concerned to the creditor. It is your internal agreement. It is your internal agreement that only one of us shall be liable. It is your internal agreement. But that internal agreement will not invalidate for the creditor to sue both the sureties. Got my point? Yes. So this is also one of the important concept. Next. Our next concept is nothing but discharge of surety. Discharge of surety. Through what ways surety can be discharged? Important topic, very important topic, because most of the practical questions will be coming from this topic, or otherwise direct question may be posed by the examiner. Nothing but discharge of surety. So what is this discharge of surety, sir? What is this? Discharge of surety means getting liability closed. No, nothing but discharge means surety is closed. Surety's liability will be closed. There will be no surety's liabilities and the contract of guarantee will comes to an end. Contract of guarantee will comes to an end. Now, through what ways? My question is, through what ways discharge of surety can happen? What are the different modes of discharge of surety? Let's have a look. What are the different modes? Number one. It is variation in terms of agreement. Variation in terms of agreement. So here, this is section number 133. So what is this variation, sir? What is this variation in terms of the agreement? So if any, there are three types of different agreements we have already seen: primary contract, secondary contract and implied contract. If in any primary contract, especially I am speaking, sir, the primary contract. Primary contract is between whom, sir? Primary contract is between principal debtor and the creditor. Principal debtor and the creditor, the primary contract. So in the primary contract, if any agreement terms, I am speaking about terms, if any agreement terms have been varied without the consent of surety, then automatically the surety will be discharged. So be careful regarding the terms of the contract. Automatically, surety will be discharged. So what is the fate of the contract then? Surety's liability will be nil. What is the reason? For the variation means change of terms of the contract in an agreement. If any such things happens, definitely the surety's liability will be discharged. This is one of the practical question asked on this topic previously in the examination. Practical question has been asked. This is the corner where the examiner can go. If any variation happens in the material alteration, not only a small variation, it is a material variation regarding to the terms of the contract. So here you can also include the word if any material variation went on without any consent of the surety, means the surety will be getting discharged. Surety will be getting discharged from his liability. Now I'll pose a question to you. My question is alteration has been made, means variation we have done. It is benefited to the surety, sir. Benefited to surety. Variation has been done and benefited to the surety. Now you tell me whether surety's liability will be discharged or not. Whether surety's liability will be discharged or not. The thing is, surety's liabilities will not be discharged here. No, because it is obviously benefited to the surety and also a minor variation, not material variation. It is a minor variation. Then it will be not regarded as variation in the terms of the contract. Section 133 will not come into the picture, where in that section, what happens? Surety's liability will be discharged. So this is one of the mode of discharge of the surety's liability. Next, number two. What is the other case for the discharge of surety's liability? This is very interesting. So contract of releasing principal debtor. So this is the other way. Yes, principal debtor and creditor. The creditor has released the debt of the principal debtor. Has discharged the debt of the principal debtor. So if automatically if the primary contract is fulfilled, means there is no chance to go into the secondary contract. Am I right? Yes, definitely. Primary contract close. What is the use of the secondary contract then? No use. because it is discharged by principal debtor, or otherwise the creditor released the principal debtor, means automatically it is discharge of the principal debt only, right? So there will be no coming into the secondary contract, and hence surety will got discharged, and hence surety may got discharged. This is a contract of releasing principal debtor. Next, number 3. What is the other way? Or otherwise I can have here only. Yes, what is the other way? Other way of surety's liability to get discharged. Very, very important, the third one. So, what is that? Settlement with principal debtor. Settlement with principal debtor. By whom, sir? Whom will settle, sir? Obviously the creditor. Settlement with principal debtor. Settlement means some compromise, some agreement has been made in between the principal debtor and the creditor. So what is the agreement, sir? What is the agreement in that here? The agreement here is first one, very, very important, which is a trap for you in the examination particularly. It's a trap, nothing but. So what is this? This settlement has been made by the creditor with the principal debtor. Whom we have made with the settlement? Creditor and the principal debtor. Now, for what they have made agreement? Give time to principal debtor. Give time to the principal debtor means extending time to pay. We have made a settlement with the principal debtor. By whom, sir? Creditor. Creditor has made an agreement with the principal debtor to give time or extend time for the debt, extend time for the liability. Now, here, surety's liability will be discharged or not? Yes, surety's liability will be discharged. Simple like that. Then why madam said it's a tricky point in the examination? See here, the examiner will not ask like this. What will the examiner will ask? The creditor has given time to Mr. X, who is not a principal debtor. He is not a principal debtor. He is not the principal debtor, but this will be communicated to principal debtor by him, Mr. X. Means to a third person, he has communicated that time will be extended. Third person, he has communicated that time will be extended. Now, if such a case is there, surety's liability will be discharged or not? Surety's liability will be discharged or not? Surety's liability will not be discharged in this case. No, surety's liability will not be discharged. Why, sir? What is the reason, sir? The reason is that nothing but it is the agreement made with a third person. This is the trap you will be falling on. Means if the settlement has only made with the principal debtor only, then only surety will be discharged. If the settlement has been made with any third person, surety's liabilities won't be discharged. So while reading the question, everything will good. We've seen the terms principal debtor, creditor, surety. Okay, then the surety will be discharged. You'll write the answer immediately. But it's not the case. You need to check with whom the agreement is made. With whom the agreement is made. So if you observe that carefully, they will give that agreement is made with the third person. Agreement is made with the third person. In such a case, surety's liabilities won't be discharged. It won't get discharged, right? So this is a trap or pitfall you may fall in the exams. Next one. What is the other case for discharge of the surety's liability? The other case is nothing but promisor. He promised, the creditor promised not to sue the principal debtor. He is saying that I won't sue you. As a contract made between them. As a contract made. Is a valid contract? No. That's why surety's liabilities will be discharged there. If he won't sue the principal debtor, we have already learned that. If the creditor, what we have learned, if the creditor, without suing first the principal debtor, without first suing the principal debtor, if surety got sued first, so means anyway the principal debtor will be getting suing afterwards, no issue in that. Means upon first suing us, it will not invalidate the contract. But here what I am saying, there's a slight difference between what we have read in the first part and what we are seeing here. Here we have seen that the promise has been made that not to sue the principal debt. We are not at all suing, sir. We are not all suing. There will be no legal enforceability. Then who will be liable, sir? Primarily, surety only will be liable. But what is a surety liability, sir? It's secondary liability. That's why surety's liability will be automatically getting discharged when the creditor promises to the principal debtor that I will not sue you. This is the reason for the discharge of surety's liability. So here 3 points we have seen. This is section number 134 and this is section number 135. 133 is variation of the terms of the contract. Next, this is section number 136. If it is made with any other third person, it will get automatically discharged. Next, also one more thing, section 137 also we can refer here. It's nothing but creditor forbearance to sue the principal debtor will not discharge, in fact will not discharge the surety. What is here I'm saying here? Creditor's forbearance means creditor has said that I should not lost the right. Forbearance means nothing but he lost the right to voluntarily he lost the right that I won't sue the principal debtor. Not agreement, no agreement has been made here, but forbearance to sue the principal debtor is there. In that case, surety will not be discharged. In that case, surety will not be getting discharged. This is section number 137 saying regarding the creditor forbearance to sue the principal debtor. Next one. Next topic. Next one. What is the next topic here then? What is the other ways of getting discharged by the creditor? Nothing but, I'll write down here, no issue in that because we have already covered a lot of space. Yes, I'll mention here. Next, what is the other case? What is the other case where surety will be getting discharged? So we have seen discharge of the surety's liability when it will be terminated, nothing but. So the first one is variation in the terms of the agreement, and the second one is contract of releasing the principal debtor, means directly he is going to release. After releasing of the principal debtor, there is no issue for the surety's liability. This is one of the reason. Next, number 3, settlement with the principal debtor. Look here, I have said an important point. Settlement with the principal debtor means the principal debtor only will be getting contracted with the creditor, so to release him or give time to the principal debtor. So if it is made the contract with principal debtor means yes surety will be released. Next, afterwards, but there is an exception case in that if the creditor makes an agreement with any third person but not with the principal debtor, then surety's liability will not be discharged. Because he is not the principal debtor. Next, afterwards, one more thing we have seen, nothing but yes, another case also, if a promise is made not to sue the principal debtor, then surety liability will be discharged. Surety's liability will be discharged both ways because legal enforceability may not be there in that option. Hence, surety's liabilities got discharged. Next, afterwards, section 137 also we have seen, that is nothing but creditor forbearance to sue the principal debtor. It will not make the discharge of the surety's liability. Next point. So we are in the next point for the discharge of the surety. Nothing but number 4. What is this? What is this actually? So let's look here. Release of, 1 minute. Yes, release of one co-surety. Release of one co-surety means if any co-sureties are there, in among the co-sureties, one of the surety has got released. So release of one co-surety will not discharge the surety. Next one. What cases the surety got discharged? Next one. Any act or any inconsistency of act, any inconsistent act by creditor. Any inconsistency act of creditor will definitely discharge the surety. This is one of the any act which is inconsistent, whether implied or expressed, anything which has made any inconsistence with the surety means definitely surety got discharged. Next, afterwards, important point. Next one is nothing but notice of revocation. Notice of revocation. As we already know, as we already studied, notice of revocation in case of specific guarantee, in case of specific guarantee and in case of the continuing guarantee, because two types of guarantees are there. So one is specific guarantee and the other one is continuing guarantee. For the specific guarantee, when it need to be made, it should be only revoked. It should be only revoked the liability of principal debtor arise. Liability of principal debtor arise. So before default of the principal debtor, they have to revoke the agreement what they have done, means contract of the guarantee. By whom, sir? Directly surety. Surety can revoke by giving a notice of revocation. For the continuing guarantee, yes, by through notice only, but only for the future transactions. Only for the future transactions, the surety will get released, but not for the previous old transactions. So this is a notice of the revocation, and also different modes of discharge of the sureties. Okay, next, the next concept. What is the next concept? It's very easy. So this is next concept we are going to see. Rights of surety. Rights of surety. Actually, rights of surety have three different rights. What are the three different rights of surety? Against, number one, against principal debtor. So opposing to principal debtor, what he can avail. Next, second one, against creditor. Against creditor. Next, third one is nothing but against co-sureties. Against co-sureties. The rights of the surety are three types. In three different modes, rights he can avail. Because first one, against the principal debtor. Why the against the principal debtor? There is a contract of indemnity, no sir. Contract of indemnity is there along with the principal debtor. It is nothing but a implied contract of indemnity. So first one, for availing the contract of indemnity, one right is provided, right against the principal debtor. In the same way, against creditor, because secondary contract is there with the surety to the creditor. That's why we can have also some rights against the creditor. Next, along with the co-sureties, what are the rights he can avail, being a one of the surety. Next, coming to the principal debtor, very easy sir, nothing but right of subrogation. Right of subrogation. So what is this right, sir? Right of subrogation. What is this right? Nothing but after default of principal debtor. After default of principal debtor, what it happens? Generally, the principal debtor, if didn't paid, means who will come into the picture? Secondary liability, surety will come into the picture. So if surety paid to the creditor, means what he paid, all the rightful dues need to be paid to the creditor. So if he paid all the rightful dues, means definitely the surety will be standing in the shoes of creditor. Standing in the shoes of the creditor, means assumed as in the position of the creditor, he can recover from whom, sir? He can recover from principal debtor. So the surety comes in line with the principal debtor, so that he can recover the amount from the principal debtor. This is nothing but right of subrogation. Very important. So if we need to present these terms from the examination point of the view, right of subrogation. Next one, right to entitle for each and every security. Right to entitle for each and every security. So whatever security he has given, whom, sir? Principal debtor. To whom he has given? Creditor. So whatever security he has given to the creditor, all the security, whether it known to the surety or not at the time of the making the contract, he knows or not knows, unknown. Definitely, whatever rights available with the creditor, surety also can enforce the same right against the securities. Next, third one. So nothing but implied promise will be there from the implied promise will be there from the part of the principal debtor, and hence right to enforce the implied promise, that is nothing but the contract of indemnity, can be enforced from the surety point of view. Next, last one. One more thing, the payment need to be only rightful dues to the creditor only needed to be given by the principal debtor. Means what, sir? Whatever rightful dues the surety paid to the creditor can be recovered from the principal debtor. So this is a case. These are the 4 rights which are available against the principal debtor. Now coming to the against the creditor. So what are the things he can make use? Same things. So after paying dues to the creditor, yes, right of subrogation will be assigned. So right of subrogation will be assigned to the surety. Whatever rights the creditor has should be assigned to the surety upon payment of the rightful dues. Next, second one. So each security what they have provided by the principal debtor will be given to the surety upon clearing the dues. Next, number 3. What is number 3? Next, if any set off is there with the principal debtor and creditor, there can be any set off available in the trading market, any set off available. So the surety can plead the set off with the principal debtor and creditor, because he need to pay the balance. No, that's what the thing. He can pay the balance by making availing use of the set off option. So any set off is available means yes, the surety can make use of the set off available with the creditor. Next, last one, co-sureties. So what is this co-sureties, sir? So definitely there will be sharing will be there between the co-sureties for a liability. So for discharge of any liability against, if the contract didn't make any contrary provision as per this provision concerned, in the agreement we didn't have any contrary provision, then what will be applicable? What is stated in the law. So what is stated in the law? If the agreement is silent regarding the percentage of share of liability, then how much the co-sureties will be paying, sir? Equally, means equal share will be applicable to the all the co-sureties. How many co-sureties are there? Those much of equal shares need to be borne by each surety to pay the or to clear the debt. So this is one of the liability percentage of the share. Next thing, what is the second point here? Up to what is the maximum limit, sir? Yes, equal share will be applicable to the maximum limit they need to pay. Whatever the maximum limit they need to pay, in that the equal share will be presumed in the court of law. Equal share will be presumed unless contrary to the agreement is mentioned, right? So this is the two things which we can say from the rights of the surety. Different rights are provided for the principal debtor, against the creditor, against the co-sureties. Very easy. Now last concept in the guarantee. What is that? Nothing but the last concept. Guarantee when will become invalid. When, sir? Only 2 situations we have already studied in essentials of the valid guarantee. What are the 2 situations, sir? Yes, nothing but this is section 142 and 143, sir. 142 and 143. So when will guarantee become invalid, sir? Very simple, sir. When any misrepresentation has been made, means guarantee obtained through the misrepresentation. Any guarantee obtained through the misrepresentation is always void. And the second thing is concealment of facts. Guarantee obtained through concealment of facts. Both these things makes the guarantee invalid. So these are the 2 situations, and hope so the entire topic relating to the guarantee and indemnity has been completed through this. Entire topic we have covered. So let's see the material also. Yes. So yesterday we have done with some of the topics relating to the guarantee, right? So just if any additional points were there, we'll be seeing, sir. This is one of the points, sir. Liability of the surety. When will commence actually? When will commence, sir? Actually, here commencement is there or I don't know, but I'll be saying. So when will be commenced? The liability of the surety? Soon after default by the principal debtor. Liability of the surety will start. So the liability of surety is, we can say simply, coextensive with that of the principal debtor, means running parallelly with the principal debtor. Coextensive with the principal debtor. Next one. Actually, this is a secondary liability. Yes, on default, here only it is a liability of the arises only on default of the principal debtor, which is a secondary liability but not the primary liability, because primary liability lies with whom, sir? It is a principal debtor. After making default by the principal debtor, then whose liability will start? Surety's liability will start. That's what the thing. Next, and one more thing, if co-sureties need to be joined as per the agreement, as per section 144, only after joining of the co-sureties only, the agreement will become valid and enforceable. Agreement will become valid. Otherwise, there will be no valid agreement between them, because co-sureties need to join means, yes, they need to join. If they don't join means agreement will become invalid, obviously. Next. Liability of two sureties affected by mutual agreement. This is what we have seen yesterday. No, it will not get affected. Any internal agreement between the parties won't get affected as per of concern to the creditor. If any means P1 and P2, I have said an example, P1 and P2, two parties are there and they have an internal agreement among them, because only one will be liable among us for the creditor. But as far as the creditor concerned, both will be liable, though there is any internal agreement between the co-sureties. For creditor, the law is equal only. No, mutual share means equal share only you need to bond. Whatever agreement between you is immaterial to me. That was a section 132 specifies. Next, discharge of surety. Yes, through discharge of surety we have already known. Revocation of the guarantee, notice providing. For continuing guarantee, just notice is enough, sir, and that is only for not liable. In the notice we need to specify. In the notice we need to serving notice to the creditors, and only for what, sir? Which transactions? Only for the future transactions. For the specific guarantee, before the liability of the principal debtor commences. Next, by surety's death. Yes, this also we have seen. Surety's death also, if anything not mentioned in the agreement, means what we'll assume as we have assumed previously only. Nothing but revocation of the continuing guarantee. Next, by novation means any new terms have been added without the consent of the surety, means definitely that it leads to discharge of the old contract, and that's why surety got discharged. Next, the conduct of the creditor. So what way conduct of the creditor we have seen? Yes, release or discharge of the principal debtor, variance in the terms of the contract. Variance is not terms of the contract. See here, one more point is there, here. One more point is that, please students see, if the variation is not substantial and is beneficial to the surety, not substantial means not material, that's all, right? Not material and is beneficial to the surety means, in that case, surety will not be discharged. In that case, surety will not be discharged, because some of the case laws may come from here, like a question of relating to case law will come, and this point needs to be clarity, whether surety will get discharged or not discharged. Next, give time, agrees not to sue. Yes, this we have studied. Creditors of surety were not discharged. Were not discharged, it's a, what is the thing? Any act inconsistent which the surety required to do, and discharge of surety by invalidation of the contract of the guarantee means any misrepresentation. We have seen the sections just now, section 142 and 143. Misrepresentation, guarantee obtained by concealment is invalid, means hiding facts, nothing but. Concealment means hiding facts. And co-sureties, only upon joining of the co-sureties only the picture comes into the opening. Next, discharge of surety when creditor compounds means makes a settlement. Compounds means nothing but makes a settlement. Yes, we have seen all the things very in an easy manner, right? Makes a composition, there is nothing but give time and not to sue the principal debtor. If these things happen, the surety will be getting discharged. Surety will be getting discharged. Next, where surety is not discharged. This also we have seen, if any agreement to give time to the third person, we are giving time to the third person, surety won't be getting discharged. And creditor forbearance to sue, not to discharge surety, then surety will not be getting discharged. Next, state the rights. See, have already discussed just now, rights of the surety against principal debtor, against creditor, and against co-sureties. Against co-sureties, three different types of rights we have seen. So first one is right of subrogation, as I have mentioned you, and implied promise to indemnify surety. Yes, that's why we are making an enforcement there. Right to enforce, nothing but. See the rights of the surety against the creditor. Against the creditor, we have seen right to set off, and any securities of for the creditor has been given, means same set of securities also will be provided to the surety also. Right to share reduction. Yes, any reduction of the creditor's liability is there. In the same way, the proportionate reduction for the surety's liability will also come into the picture. Next, rights of sureties against co-sureties equally. Unless any agreement is there, they need to contribute to the equal. bound in different sums. If in bound in different sums means subject to the maximum limit, principle of equal contribution shall apply. Next. So these are the things we have studied. And one more thing, this is one of the important concept as far as concerned with the examination point of view. One time asked, recently November 2020 it has been asked. So our material is very good because each and everything stating in the material only which MTP is given or which year the question has been asked, student friendly material which we can say easily, right? So November 2020 4 marks. Look at the differences, contract of indemnity and contract of the guarantee, all the meaning, how many number of parties, agreements, how many number of agreements are there, primary liability, secondary liability, all those things what you have learnt in the contract of indemnity and contract of guarantee, both we can post here. So this is one of the simple question. And now coming to the, I have said section differences I'll make. So here are the section differences you can see. 124 we have covered indemnity. 125 rights of indemnity holder being sued. When sued, what are the rights available to him? So 126 definition of contract of guarantee and the parties, consideration for the guarantee, surety's liability means secondary liability, we have seen all those things, secondary liability, definition of the continuing guarantee and revocation of the continuing guarantee, section number 130, surety's death, by surety's death also revocation of CG will happen, so it is number 131. Yes, agreement between them won't affect the surety's picture. Discharge of surety by variance in terms of the contract, all these are the nothing but discharge of surety. Discharge of surety up to 136, 138, 138, 139, up to 139, all the things are discharge of surety only. Next, rights of surety on payment of performance, and these are what are the rights available with the surety. All those things will be coming into this one. Next, co-surety is liable to contribute equally, indemnify. Section number 145, liability of co-surety is bound in different sums, section number 147. So all these are the reference of the sections, and if anyone wants to mug up with these sections, yes, no issue in that, you can go through these sections which are provided in our material, or you can make a screenshot while looking into the video playing, right? So this comes to the end of the chapter of contract of indemnity and contract of guarantee, first part of the Contract Act, right? Now we are going with the second part of the Contract Act, that is nothing but contract of bailment and pledge. Contract of bailment and pledge. This is the second part which we need to see with the Indian Contract Act, second part. So what is this second part? What is bailment and what is pledge? Yes, sir. Coming to the things. What is meant by bailment, sir? Bailment is also a contract or not? First we'll go with bailment topic, sir. Then we'll go with the pledge topic. Okay. After that, agency. Three parts are there. In the first class I have said to you, three parts are there. First one, contract of indemnity and guarantee. Second one, bailment and pledge. And the third topic is agency. If these three topics have been covered, means we will be ending with the Indian Contract Act, chapter number 1 in the other laws. Right? Yes. Coming to the contract of bailment. What is this contract of bailment then? What is this contract of bailment? Nothing but it is a contract. It is a contract. In this, what we can know? The contract will be means an act by which goods are delivered. By which goods are delivered. An act by which goods are delivered from one person to another person. One person to another person. Bailment, the word bailment comes from a French word. A French word, nothing but. Means nothing but to deliver only. To deliver means to give or to pass on. To pass on. So it is a contract. It is a type of contract. Bailment is a type of the contract in which the goods are delivered from one person to another person for a purpose. For what? For a purpose. For a purpose, and if the after accomplishment of the purpose, the goods should be returned back to the person who has passed it, or otherwise disposed according to the directions of the person delivering them. According to the directions of the person delivering them. Got it? 3 points we have seen here. What are the 3 points in the contract of the bailment? So definition is very clear. Definition is very clear definition. What are the 3 points we can know? First, bailment is a contract. It is a contract. For what? An act in which goods are delivered. in which goods are delivered. Means here delivering of the goods is a important thing. Delivery of the goods from one person to another person. Why they are delivering? For some purpose. For some purpose. After the purpose, what the person he need to do? He need to return back or he need to dispose as per the instructions given by the person delivering them. Got it? Now coming to framing of the essentials of bailment. What are the essentials of the bailment? Nothing but what we have seen now. First of all, goods. We are making transfer of goods. These goods should be movable. Next, second one, a contract should be there. Yes, it's a contract we are saying. Contract should be there. Contract can be express or implied. It can be express form of contract or it can be implied form of the contract. Next, third one. Yes, as we have seen, delivery is important in the point of contract of the bailment. So what is this delivery? Delivery can be actual delivery. Already we have learned in the foundation topic only. There are two types of the delivery. Three types actually we have learned. Actual delivery, constructive delivery, symbolic delivery. So here it can be actual delivery or constructive delivery only. Any delivery can be made for the contract of the bailment. Next, number 4. What is number 4? Purpose of the delivery. Yes, for some purpose, for fun, repair or any other thing we are giving. We wish to do that purpose. So, for some purpose specified, for specified purpose, we need to give to the other person, pass on to the other person. Next, fifth one. Here, custody and possession need to come. Custody plus possession. Both should be there with the other person. If only custody is there but no possession, no, we can't call it as a contract of the bailment. So custody should be there. Also, possession also should be there. Next, sixth one. Return of goods. As we have already seen in the definition, yes, after accomplishment of the purpose stated, after accomplishment of the purpose stated in the contract, the goods what need to do? The goods should be returned. So, goods should be returned or otherwise what happens? It should be disposed according to the instructions of the another person. So, these are the essentials. Goods, contract, delivery, purpose, custody and possession, and also return of the goods are the basic essentials in the contract of the bailment. So, how many parties are there? Next question. How many parties are there in the contract of the bailment? As we have seen, only two parties, no? One person transferring to goods to another person. Two parties are there. Who are they, ma? The person who is transferring the goods is called bailer and the person who is receiving the goods is called the bailee. Got it? So, bailer is the person who is transferring the goods. And bailee is the person who is receiving the goods. Goods here, movable or immovable? Movable only. No immovable property will be dealt in the contract of the bailment. So, two parties are there. One party is bailer and the other party is the bailee. Next. So, after this one, next. Coming to the forward to the picture of directly for these two parties, bailer and bailee, some rights will be there. Some rights as well as some duties. Here also, for bailee also, some rights will be there and some duties also will be there. Some rights and some duties. Look carefully. These are important area of the examination in which sometimes case laws may be coming, practical questions may be coming, or otherwise direct questions like scenario based questions. Means they will give some story into the examination and they will be asking state the rights of the bailer or state the duties of the bailee. Like this, a scenario based question may be coming or specifically a direct question, state the rights on and duties of the bailer. Like this, straight away question also can be come into the thing. Otherwise, they will draft a case law. And make you answer a practical question. Make you answer as a practical question. So, remember two things here, bailer and bailee. The rights of the bailer will be the duties of the bailee. The rights of the bailer will be the duties of the bailee. In the same way, duties of the bailer will be the rights of the bailee. Cross vice versa. Nothing but a vice versa point. So, very easy. So, if you remember any one's rights and duties, you can write easily the other person's rights and duties. Let's see. So, here I am keeping heading for the bailer rights. So here, bailer rights means nothing but implication. Same time, parallel time, we'll write the other also. Nothing but duties. Duties of bailee. Duties of bailee. So, what are the rights and what are the duties? So, coming first of all, we'll start with the duties of the bailee. What he need to do? Because in the bailies, we have submitted our goods. How he need to take care of the goods? So, what ma? So, we are passing goods to the bailee upon some fate. So, he should not use unauthorized. No unauthorized use. No unauthorized use. Unauthorized use he should not make. 1 minute. Okay. No unauthorized use of goods. So, unauthorizedly he should not use the goods. Only with the authorization of the bailer only he need to use the goods accordingly. No unauthorized use. Number 1. No mixing of goods. No mixing of goods. Amma, listen carefully. Here, these 2 points are critical points and many of the questions will be coming in your examinations. Recently also, one examination question paper I have seen, and in that, no mixing of goods, only based on this concept, the implications. What are the implications after mixing of the goods? What are the implications after mixing of the goods will be coming. Now, number 3. What is number 3? Unauthorized use, no mixing of the goods. And number 3 is, yes, to return the goods. To return the goods. When to return, ma? Probably after accomplishment. After accomplishment, the purpose. After accomplishment of purpose. So, after completion of the purpose of the contract, then we need to give back the goods, or otherwise after expiry of the term. After expiry of the term. Implications I'll say you in another just a few minutes after, but first, as far as now concerned, just we'll look after the rights and duties. That's all. The implications I'll tell you in a couple of minutes. Next, so to return the goods. Number 4. Yes, number 4. To deliver any profit accredited, any profit increase in keeping the goods, with the goods lying or otherwise. So, if any profit has been accrued to the goods, then we need to, as a bailee, we need to return the profit to the bailer also. Next, afterwards. Next, not to do inconsistency, not to do any inconsistent act which makes loss to the bailer, We should not act anything against to the bailer terms and conditions. Next afterwards. That's all. These are the 5 different types of duties of the bailee. Now, coming to the bailer's rights. Means you can know the implications here only. See, ma? First of all, what are the implications? If we made unauthorized use of the goods we are making, means what? Damage will come to the goods, no? Or loss will come. Or loss will come to whom, sir? Bailer. Loss will come to the bailer. If we make any unauthorized use of the goods, loss will come to the bailer. What we need to pay then? If loss comes, means what we need to pay? Definitely, we need to compensate that loss. So, this is one of the right for the bailer. Right to compensate. For what? For unauthorized use of goods. So, if the bailee use the goods unauthorizedly, then if any loss has been caused, definitely loss will be causing, no? That's why the bailee needs to compensate to whom, sir? Bailer. So, this is one of the right to the bailer. Next, for the mixing of the goods. So, for the mixing of the goods, 2 important points are there. Number 1. So, loss will come to whom, sir? Bailer. So, he need to compensate the loss caused to the bailer. Number 1. He need to compensate the loss caused to the bailer. What is second point here? The second point is nothing but the mixing of the goods can be with the consent of bailer or without consent of the bailer. With the consent and without consent. Look here, very, very important point. Here only the crux lies. It's a trapping point for you, I can say here. So, with the consent of the bailer. So, consent bailer only we are making mixing of the goods. Then why we need to pay the loss, sir? There is no need to compensate, no? Right? In case of consent with the bailer. So that's why if any share has been there, profit or loss, if any share has been there, they can share as per the percentage of their interest. They can share as per the percentage of interest. Yes, whatever share they have, they can share as per the percentage of the interest, whether it is a profit or whether it is a loss. Whether it is a profit or whether it is a loss. Now, without consent, he have made an unauthorized, means mixing of the goods. He has mixes the good. Now, what happened if the goods, here again two things will be coming. If the goods are separable. If the goods are separable means if the goods are, we can separate the goods easily, or otherwise. Second point. What is the second point? Goods are not separable. Goods are not separable. So if the goods are not separable, what happens? And if the goods are separable means what happens? Means if the goods are separable, the bailior is asking, give me my goods. What we'll do? What we'll do? We'll separate. No, we'll getting it separated. We'll get it separated. So the expenses which are used for the separation of the goods for the unauthorized use of the goods will be bearing by whom, sir? Bailey only. Will be bearing by Bailey only. So this is the point we can write here. So right to compensate for unauthorized use, for mixing of the goods also. For mixing of goods also. Right. Next, and also right to get any profit if with consent any mixing of goods has been made. Any mix of goods has been made. Just now we have seen the share can be shared further between bailior and bailey as far as the interest concerned. So any profit share is there means with the consent of the bailior you have mixed something means yes, you need to get those profit itself. So this is one of the right. Now if the goods are not separable, so if the goods are not separable, what happens? We can't give the goods back. No, if the goods are not separated, we can't give, because bailior is asking, no, only my particular type of goods need to be get to me. Only what the goods I have supplied to you, those goods only I need to get. But what we have done, we have made an mixing of the goods which is inseparable. We can't separate it. So what we can do, sir? Can we mix it and give it again? Or can we separate? No, it's not possible. No, that's what. So that's why only the loss, whatever the loss the paid by the bailior because of this inseparable act, we need to compensate the loss. We need to compensate the loss. Whatever loss, we need to compensate it. So nothing but right to compensate. Right to compensate loss caused for unauthorized mixing for inseparable case, for inseparable of goods case. The goods are inseparable. That's why we are making good the loss caused. So these are the rights as far as pertaining to the no mixing of the goods. Now to return the goods. So here return the goods is a duty of the bailey. Now what is the right of bailior, sir? Here then to right to get back the goods. Right to get back the goods. Yes, this is one of the right to the bailior. Next, afterwards, what we have seen, any profit increase in the goods. So here also right to share the increase in the profit. Right to share the increase in the profit. Not to do inconsistent act. So if any inconsistent act has been done, loss will come to the bailior. So he need to compensate the loss. That's what the point here. Sixth one. Right to receive compensation. Right to receive compensation for the loss caused because of an inconsistent act by the bailey. See here, very easy or not? So if we draw a complete picture of bailior and bailey rights and duties, it's very easy now, right? It's very easy. What are the consequences, etc. also we have seen here, right? So I feel personally it is easy now after listening this. Next one. So in the same way, we'll be writing here rights of bailior completed. Now the second thing we'll write, that is nothing but the second thing, duties of, or we can say simply rights of bailey. Rights of bailee. It will be same as duties of bailer. Duties of bailer. Duties of bailer. Cross no. That's why rights of bailee will be same as duties of the bailer. Number 1. So we are supplying the goods, sir. We are supplying the goods. What are the duty we need to do, sir? What the duty we need to do? First of all, while supplying the goods, because goods will be supplied by the bailer, while supplying the goods, first what is one? Disclose all known material facts. So whatever facts are there in the goods, you need to disclose all the things. Means any repair or any other thing, any damage is there in the goods, then we need to communicate to the bailee whatever material faults are there in the goods. Next, number 1. Number 2, also disclose any dangerous nature of the goods. Dangerous nature of goods. So any explosive nature or any other danger nature is there. So we need to communicate that to the bailee also. If any loss caused without disclosing dangerous nature, means yes, we need to compensate the loss. We'll see while coming to the rights. We'll see what are the effect of the compensation also. We'll see. Now number 3. Now reimbursement of expenses. Reimbursement of expenses. What to reimburse, sir? What to reimburse? How to reimburse? Nothing but. So reimbursement of expenses means if any expenses has been made by the bailee for the repair or any whatever purpose we have given, for that purpose he has incurred some expenses. So those expenses need to be reimbursed by us, because we are the owner. No, we are the owner. That's why if any expenses has been incurred, means we need to reimburse the expenses. So for the type of the gratuity, there are two types of the bailment. Gratuitous bailment means it is free of charge, nothing but gratuitous bailment. And the second one is non-gratuitous bailment. Non-gratuitous bailment. So for gratuitous bailment means it is free, no. That's why we need to reimburse all the expenses as far as ordinary plus extraordinary expenses. All the expenses we need to reimburse. If it is a non-gratuitous bailment, means without no charge is there, only consideration is there. So that's why only the extraordinary expenses will be getting reimbursed. By the bailer. Next, so reimbursement of the expenses. Next topic. Next one, number 4. What are the other things? Yes, we need to indemnify for having defective title, for the loss caused, for having the defective title. So if any defective title is there, any loss caused to the bailee. For the defective title, any loss caused. So who will be responsible, sir? We are the owner of the goods, and we need to compensate or indemnify the loss caused to the bailee for the defective title, for giving the defective title. Next, number 1. Indemnify any loss caused for the premature termination of the contract. For the premature termination means closure of the contract before commencing only. Premature termination of the contract. So if it is a gratuitous contract, or if it is a non-gratuitous contract. So if it is a non-gratuitous contract, as per the Contracts Act provisions, breach of contract shall apply. Breach of contract provisions will apply. If it is a gratuitous contract means, if the bailer has made any premature termination of the contract, definitely loss will be suffered by whom, sir? Bailee suffers the loss. So whatever the loss suffered by the premature termination of the contract need to be reimbursed by whom, sir? Reimbursed by nothing but bailer. So this is the case, indemnify any loss caused. So these are the 5 different points, the duties of the bailer. Now here, rights of the bailee. What are the rights? So he did not disclose all the material facts. What will happen, sir? If he did not disclose means some loss may be accruing to the bailee. So whatever loss caused, the bailer need to compensate. So this is our first right. So right to compensate any loss caused for non-disclosure of material facts or otherwise dangerous nature or otherwise dangerous nature of goods. Dangerous nature of goods. So due to non-communicating the dangerous nature or non-communicating any material facts disclosure, it leads to some loss to the bailee. So if any loss caused to the bailee, who need to reimburse? Bailier need to reimburse. So these 2 points covered for the rights. Now second one, reimbursement of expenses. So right to claim expenses. Right to claim expenses. Whatever thing he can claim this expenses. Now right to indemnify. Right to indemnify the loss caused. Right to indemnify the loss caused for what's a premature termination of the contract. Premature termination of the contract. Whatever the loss is caused for the premature termination, you need to have a right for that. So this is the right. Next one, fourth one, yes, right to indemnify. What indemnify? For passing the defective title. For passing the defective title of the goods, whatever loss you have incurred, those loss will be reimbursed by the bailier. So these are the different rights for the bailee. So from this you can see the rights and duties very easily. Yes, so if any one thing we can make assessment of the another duties. Rights of the bailier will be the duties of the bailee, and in the same way the rights of the bailee will be the duties of the bailier. Very easy, no? Yes. Next one. One important concept is that, so two things we have to do. First of all, different forms of the bailment, and this is a very small concept only. It's nothing much here. It's a different forms of bailment. What are the different forms of the bailment? Through what ways we can make a delivery? Yes, we can make, suppose we are giving you to transport or carriage, any transport or carriage to pass on or to deliver the goods to some other place. It is nothing but a form of bailment. Nothing but a form of bailment. For any hire or reward we are making, or for any work we are making, any work we are giving our goods to the other party, nothing but the bailee. Next means for any purpose, work or purpose we can say here, work or purpose. And also as a security of a loan, we are providing, then also form of a bailment only, no issue in that. Next, these are the different forms of the bailment we can have, the different in the contract of the bailment. Next, termination of the bailment. When can be the bailment can be terminated? Termination of bailment means closure, nothing but. When can we close? When can we close? Simple. We have already noted 2 things there. After accomplishment of the purpose. After accomplishment of the purpose, whatever purpose we have delivered, if for the purpose has been accomplished or fulfilled, means definitely it comes to the end of the contract of the bailment. Next, second one, after expiry of the period. So we have given, so after expiry of the period, so we said after 3 months please give back my goods. After expiry of the period, what the other person need to do? He need to return back the goods which have been delivered after expiry of specified period. After expiry of specified period, 3 months is an example, sir, not here. So what is a specified period? We need to have the contract closure. Next, number 3, notice. So by providing notice to the other party, so I'm revoking my contract of the bailment, so please take your goods. No issue in that. By providing notice to bailee also, we can get back our goods. We can get back our goods. It means nothing but termination of the contract of the bailment. Notice to bailee means nothing but termination of the contract of bailment. Next, last one. 2 things are there, so still termination of the contract. Death. Any unfortunate situations, death of bailier or bailee. Bailier deaths or bailie's deaths makes the contract inevitable. We can't move the contract forward. So that's why death of bailier or bailee will comes to the termination of the contract of the bailment. Next, last one, destruction of the subject matter. Yes, subsequent impossibility or the way supervening impossibility. Destruction of subject matter. So subject matter has got destroyed, means definitely the bailment will come to an end. And one more thing, sir. One important thing, this is many times asked a question, recently also asked. The next concept we are going with is nothing but rights and duties of finder of lost goods. Finder of lost goods means if any person found any of the goods which is lost by any other person, what he needs to do? Sir, first of all, he need to make a reasonable search of the person, reasonable search of the owner of the goods. reasonable search of the owner of the goods. Number 2, preservation also need to be made, no, for the goods. Yes, preservation of goods. Preservation of the goods. So by following this, he may incur some expenses. By following this, he may incur some expenses. So these are the duties: preservation of the goods, reasonable search of the owner. The duties nothing but duties of the finder of the lost goods. But what are the rights? Rights is nothing but right to reimburse. Right to reimburse for the reasonable search and also preservation of goods. Preservation of goods. For the reasonable search and preservation of the goods, whatever expenses he has incurred, yes, he is having a right to reimburse the same. From whom, sir? From the owner of the goods. From the owner of the goods. Now, my case is if the owner of the goods fails to reimburse, then what is the option available to him, sir? What is the option available to him if the owner didn't provide him any compensation or expenses what he has given? Then definitely he can sell the goods. That's the only option available, no? Whatever goods are lying in that, we can have a sale. So this is nothing but right to sell the goods. Right to sell the goods if the reimbursement is not given by the owner of the goods. Next number. He is having right to sale for another case also. When, sir? Right to sale when the expenses incurred by him for the preservation or founding, if more than 2/3 value of the goods, expenses has raised more than 2/3 value of the goods, means definitely he can have a option to sell the goods because he can't bear the expenses. No, that's the only basic reason. Next number 4. He is also having right to sale when, sir? Can you think what is the last category here? Nothing but it is of perishable nature of the goods. It is of perishable nature of the goods. So if any perishable nature is there present in the goods, means yes, definitely he can have a right to sell the goods. So these are the different rights and duties of the finder of the lost goods. The primary duty is reasonable search. Second duty is preservation of the goods, and also one more thing, sir, whatever duties are there for a bailee. Whatever duties are there for a bailee, yes, the same duties applies to the finder of the lost goods also, because he is in the position of the bailee simply. That's why the finder of the lost goods need to follow whatever duties we have specified above in the contract of the bailment pertaining to the bailee. Then he need to follow the same rights and duties also. So let's check the material for the same. Bailment and pledge. Yes. So you can see how much weightage previous questions, practical questions have been asked, and also May 2022 different questions have been asked. So weightage is good, sir, concerning this chapter, and more number will be coming from bailment only. Bailment only they will be coming. So contract of the bailment definition we have seen, sir. Whatever the definitions we have seen. Parties to the bailment, bailer and bailee we have seen. Essential characteristics of the bailment. For the valid contract of the bailment, contract should be there. Yes, goods should be movable. Delivery of the goods can be of two types, actual and constructive. Purpose should be accomplished. Possession means mentioned, delivered for some purpose and mentioned in the contract also. Possession, return of the goods, when to be returned the goods. So all these are the essential characteristics of the contract of the bailment. Different forms of bailment. This also we have seen. Delivered to a carriage for any repair, any security of the loan, any for the bailor's use, hiring for the reward, etc. All these comes into the one more thing. We didn't specify friend. If anything has been given to the friend, it also comes into the two without any charge, because friend, no, that's why no charge is there. So for his own use, here look here point, own use is also there. Friend for his own use, then only it comes into the contract of the bailment. Next, basis of rewards. We have seen two types of the bailment: gratuitous, non-gratuitous. No issue in that. So duties of the bailor. Yes, we have seen all those duties. To disclose faults. Yes, all the material facts, whatever we know. To disclose dangerous nature of the goods. Yes, sir. Duty to pay necessary expenses. Whatever expenses incurred, yes, we need to reimburse the same. Next, indemnify the bailee for the premature termination of the contract. Yes. Indemnify the loss. This also we have seen, right? Bailor's responsibility to the bailee. Rights of the bailor. Seen. Not to make right to demand the goods, unauthorized use, terminate the contract in case of the unauthorized use of the goods, right to sue the bailee, right to compensation, right to demand, and whatever profit has accrued, we can have the profit also. See here, rights of bailer is equal to duties of the bailee. Very easy. So we can skip the duties of the bailee. Yes, because already we have seen. Rights of the bailee, same discussed above. Next, any other reads is right of lien. I didn't go. So after we'll see for the founder of the lost goods rights. We are in the topic of finder of lost goods. What are the rights and duties available for the finder of the lost goods? As already said, it's a part of the bailment only. The founder of the lost goods should act in the similar manner where the bailee acts. So all the rights and duties applicable to the bailee definitely will be applicable to the founder of the lost goods also. Now coming to the rights, what are the rights available? First of all, what are the things he need to do? He need to search the true owner, because in order to deliver the or return back the goods, he need to search the true owner. Afterwards, he need to have expenses for preservation of the goods. Whatever the expenses he is going to use for the preservation of the goods, these two expenses can be claimed from whom, sir? From the owner of the goods. He can claim these expenses. What are the expenses? For reasonable search of the owner and for also preservation of the goods. He can claim from the owner, provided if the owner for sometimes he may reject to give the reimbursement of these expenses. He will not give. He will not accept to give the reimbursement of the expenses. No, I would not like to, because I don't want those goods. He may say several reasons. So he rejected to give the expenses incurred by you. Then what is the option you are having, sir? Definitely you may sell the goods, right? You may sell the goods, or you may retain the goods. Retain or sell, anything is okay. You may retain the goods or sell the goods, but you cannot sue on him. You cannot sue upon him for the case of reimbursement of the expenses. No, it's not possible. One more thing is also there here, interesting thing. If the owner rejects to pay any compensation to you, then you may retain or sell the goods and collect the proceedings, and also you may not able to sue upon him. So this is one concept here, one important concept here. Next, second thing. The second concept is nothing but if the owner announce reward to the founder of the lost goods. Yes, sometimes in the newspapers we will see some reward may be awarded for the persons who found those lost goods, because it may be precious to them. So if any reward has been announced by the owner, means definitely you are eligible to claim the reward. You are eligible to claim the reward. If the owner does not pay any reward to you, is not paying the reward to you, then at such a case, what you can do? You can sue upon him for the reward announced. You can sue upon true owner for the reward announced to him. These are the two important things concerning here, right? Okay, next, I already explained you when can we sell the goods. You can sell when they are in perishable nature, means the goods quality is very much deteriorating. So perishable nature, if the expenses incurred is more than 2/3 value of the goods, and if the reimbursement of expenses is not done by the owner, at such a cases you are having right to sell the goods. This is the concept behind founder of the true owner, and also the delivering the lost goods to the true owner. Okay, and only one more concept is left for you, that is nothing but in the bailment topic, that is general lien and particular lien, as it is important in the examination point of view, right? So what is the two liens available in our concepts? Lien means right to retain the goods, right to retain the goods provided, or goods which we have possession, which we are in the possession. Now lien is of two types. How many types? Two types. One is general lien, and the other one is particular lien. General lien and particular lien. Now these sections, particular lien is section number 170 and general lien is section number 171. These are the two types of lien, and for whom these liens will be applicable, it's important. And also general lien and particular lien both are important for the examination point of view. He may ask a question from this area. Now what is particular lien? Very easy, sir. Particular lien, there is no much relevance, because very easy only. There is no much things in this, but three important essentials need to be taken care for a particular lien. So what are the three essentials you need to take care? Number one, you are the bailee. Bailment is happened. You are the bailee. So the bailee by using his skill or labor. Using his skill or labor or competence, whatever the thing, you need to improve the value of the accounts, value of the goods lying with him. So he, by his skill and labor, made an improvement in value of the goods or increase in value of the goods. Means by using the Bailey's skill, labor, talent, the goods value has been increased. Now what happened? And so for such increase in value of the goods, he need to have some remuneration or any other payment. But what happened here? The bailor did not provide him the remuneration. The bailor did not provide him the remuneration. I am saying increase in value of the goods is important here. Increase in the value of the goods is important. That too only by the skill and labor of the bailee. If such things happen, only particular lien can come into picture. Particular lien can come into picture. Now remuneration is not given by the bailor. Then what happens, sir? Then what happens now if bailor refuses? So bailor refuses to pay the or reimburse the remuneration. He didn't pay. He didn't want to pay anything to the bailee. Now what is the option as a bailee we are having? Definitely at that cases we can retain the goods. We can retain the goods bailed. Such a retaining of the goods bail is nothing but called as particular lien. Particular lien means as we are not provided with the remuneration for what the work we have done from the bailor, then such a case we are having the option to recover the amount of lien, that is nothing but retain the goods of the owner, means bailor, retain the goods of the bailor. This concept is called particular lien. This concept is called particular lien. Now suppose we are not received any amount from them, can we have right to sue here? Can we have right to sue here? No, if we retain the goods, there is no concept of right to sue here. If we retain the goods, means particular lease in force, means we don't have right to sue the bailor. That's one of the fetching to him. So right to sue is not there for this candidate bailee because already we have retained the goods. For suppose means if bailee is holding goods in possession, if goods in possession only, we can do the retaining option. For suppose goods have been delivered. Goods have been delivered. This is point number 1 and this is point number 2. Goods have been delivered, sir. Goods have been delivered already. But still, we didn't get any of the remuneration. We didn't get any remuneration. No remuneration is not given by the bailor after providing the goods also. After providing the goods also. Now such a case, particular lien is possible, sir. Particular lien is possible. Can we get back to the bailor and ask him for the goods delivered? Can particular lien is possible in such a situation where goods are bailed to him, delivered to him? No, it's not possible. In such a case, particular lien is not possible. Now, what we can do, sir? Our one and only option left is right to sue. Our one and only option left is right to sue. Means what? Goods delivered means, Amachina, just listen, important point. Goods delivered means we have waived our right of particular lien. If goods are delivered means we have waived our right of particular lien. Got it? So one and only our option after delivering of the goods is nothing but right to sue. But if the goods are in possession of the bailee, then what we can say? Then we can say that particular lien option is available, but right to sue option is not available because goods are lying with us. We have taken an action for the recovery of the amount from the bailor. That's why this is not available. Now, so this is one more concept, and one more thing is also there. When is particular lien option cannot be availed by us? When can particular lien option cannot be availed by us? Means the right is not there for us. When, sir? If the bailment work is not accomplished in point of time. In specified time, whatever time specified by the bailor, if we didn't complete that work in that particular time, means particular lien option is not there. So 2 times we may lose the particular lien option. It is one of it is means we have already delivered the goods, means we have lost the particular lien. Next, second option is if the bailee not accomplished the work in specific time provided by the bailor. If we not have completed our work in time, means there is no option of the particular lien. So these are the concepts lying here for the particular lien. Now, so This is a particular lien concept. Skill should be there, labor should be there, and value of the goods should be increasing mode. Increasing mode. Remuneration is not provided and the bailer refuses to pay the remuneration. At such a point of time, we have option to retain the goods to recover the amount from the bailer. This option is nothing but called as particular lien. So this is a very simple concept. No issues are there in this. Only apart from those two, when can the particular lien can be lost, waived, means it's determined to be waiver of particular lien option. At what time, sir? When we already delivered the goods, but we didn't still receive the payment from the bailer. So we have lost an option called particular lien because already the goods are delivered to the bailer. Now, coming to the general lien. So what is this general lien? This is very particular case of option only available to, who can avail this option? Only available to bankers, wharfingers, attorneys and policy brokers. Attorneys and policy brokers. Only these people can have an option to the general lien. Lien means nothing but we can have an option to retain the goods. For what? Banks, attorneys, wharfingers, policy brokers, for any amount. For any amount, if we have given our goods as a security purpose, for the debt, then these bankers, wharfingers, policy brokers, what they will have? They will have the option of general lien for only for the general balance of the account. Only for the general balance of the account. They cannot able to retain our goods for any other balance. No. For any other balance, no. For whatever loan, we have kept it as security. For whatever loan, we have kept it as security. The bankers have a right to make a general lien only relating to the security what we have provided. Only relating to the security what we have provided. This is called as general lien. Amma, listen, an important concept question, means practical question has been asked on this point of view. For example, I'll say the concept question. Nothing but one bank is there. So one of the person named X, Mr. X, one of the person, Mr. X, go and fetched a loan of 50,000 towards bank and keeping a security of some gold to him. So first he has taken a loan of 50,000. After few months, he repaid the loan of 50,000 and also availed another loan of unsecured 20,000. Another loan of unsecured. It is unsecured loan. I am saying it is an unsecured loan. Banks, what they have done? For this 20,000 unsecured loan, they have retained this gold which is kept for 50,000 amount. Is this correct action done by the bankers? No, it's wrong. Why? Only whatever security we have offered, only for that security only general lien is possible. Means for the general balance lying in the account, the general lien is applicable, but not towards any other loan. This is called as general lien. Got it, ma? So this is the concept of particular lien and general lien. So if you have a good idea regarding these two, it's very easy. So this ends the concept of the bailment topic. Now we are moving to a important topic, that is nothing but pledge. Topic of pledge. This is also very easy. No issue in this. So if we complete pledge and one more topic is left for us, agency. If we complete both these topics, Indian Contract Act will come to an end. Our first chapter, first agenda will be completed, provided if we completed pledge topic and agency topic. Very easy topics both are, but very important as part of the examinations concerned. Got it? Now coming to the pledge. Nothing but this is also a form of bailment. Means extended form. You can simply say extended form of bailment. I am saying it is a form of bailment. Is the statement correct or not? Absolutely correct. Extended form of the bailment only. Now, what happens? Means all the provisions applicable to the bailment are also equally applicable to pledge. All the provisions. What are the provisions provided in bailment? Like two parties, what is the definition of the bailment, essential characteristics of the bailment, rights of bailer, duties of bailer, rights of bailee, duties of bailee. So everything which is applicable to the bailment, equally applicable to the pledge also. But what is the concept of the pledge then? It is an extended form of the bailment, nothing but. So what is the concept of the pledge? Nothing but. It is also a bailment of the goods. It is also a bailment of the goods. For what purpose we are bailing, sir? For security purpose. For security for payment of debt. Security for payment of debt we are providing. Or we can also say performance of a promise. Payment of the debt or performance of a promise. Performance of a promise. Both these are equally good. Okay, so bailment of the goods, nothing but security for the payment of the debt. Also we can call as performance of a promise. So we are keeping the goods for security purpose. We are keeping the goods for security purpose. Next. So here, how many parties will be there, sir? How many parties will be there? As stated in the bailment, two parties are available here also. Two parties are available here also. Who are these, sir? Simply the person who is keeping as a security some goods, who is keeping some security of the goods is called as pawnee, and the goods for whom the security is given is called the pawnee. Two parties, party number 1 pawnee and party number 2 pawnee. Means we are taking a loan from pawnee, and so we are making our goods as security for the loan. We are taking our goods as security for the loan. This is called as contract of pledge. And the party number 1 who is taking loan or who is borrowing loan or who kept security for the payment of the debt is called pawnee, and the lender of the money or who is keeping the security of the goods is called pawnee. Two types of the parties are there. This also the definition sometimes can be asked in the examination. What is a contract of pledge and who are the parties involved and what are the essential elements for the contract of the pledge? Yes, these questions can become from examination point of view sometimes. Straight away theory questions, no issue in that. If theory questions comes means no issue, we can easily attempt. But if any practical questions comes, you need to assess, think and write the solution. The things need to be done in such a systematic way. Now, coming to the essentials. Essentials of the contract of the pledge. Essentials of contract of pledge. So, what are the essentials required for the contract of the pledge? What are the essentials, ma? Let's see. First of all, we can say that, yes, what is a special kind of bailment. Special kind of bailment. Yes, it is extended form of the bailment as I have said already. And all the essentials what are required for the bailment also are the essentials for the bailment of the pledge. Essentials of pledge also. There is no quite similarity is there. No much difference is there. Now, second thing. What is the next essential? Yes, bailment of the goods. Bailment of goods should happen. Bailment of the goods should be delivered. For whom, sir? To pledge or pawnee. We can use the term pawnee. So, goods to be delivered from pawnee to pawnee. For what is the reason we need to deliver the goods, sir? Bailment means nothing but delivery of the goods. For what is the reason we are delivering to that person? Nothing but delivering. The reason for the bailment is nothing but providing security for the purpose of debt. Or performance of a promise. No such things can be right simultaneously. For the purpose of the debt, we are providing as a security whatever goods we are delivering to the other party. I mean the pawnee. Next, and one more thing. The goods which we are providing should be in existence. So whatever goods we are delivering, they need to be in existence, not in fictitious way. They need to be in existence. Next, that's all. These are the things. And one more thing is, these goods should be the subject matter of the contract. These are the essentials required for the contract of the pledge. What is contract of pledge? Who are the parties involved in the contract of pledge and what are the essentials required? Very easy. All with the goods only. Goods should be delivered. delivered for the reason of security, goods should be in existence, and goods should form the subject matter of the contract. If we know the goods term, we can easily answer what are the essentials of the contract of the pledge. Got it? Now, coming to the next topic. This pledge is from the sections 170 to 182. We have already stated in the first class only sections 172 to 182. These are the sections for the contract of pledge. Now, we are going with the next topic, that is nothing but Pawnee's rights. Pawnee's rights. What are the rights available with the pawnee? So, what are the rights available? What he can do? Very important point number 1. Point number 1. What is that? Let's see. Yes, Pawnee's rights. Number 1. He can retain amount. He can retain amount. He can retain amount. At what? For what, sir? What he can retain the amount? First of all, for the amount of debt. What is the amount of debt? Yes, he can kept for the retain money for the amount of the debt. He can retain money for the amount of the debt, or otherwise he can demand. We can also say he can demand. He can demand from whom, sir? Pawnee. He can demand the amount of money from pawnee. What are the amounts can be collected from him? Amount of debt. Whatever debt is lying, whatever the balance lying in the account of the pawnee, he can collect. He can collect. Yes, amount of the debt. And next, some questions may be asked like this. This is important part of the examination. What are the questions they can be asked? The amount of the debt also includes interest, no? Definitely. Also includes interest for any part of the payment of the security. Debt will be there and principal means principal will be there, and also interest also will be there. Yes, the principal can be collected. Now in this question, the pawnee can demand for the amount of the interest. Definitely he can demand for the amount of the interest also. In fact, this is a question asked as a practical question in one of our recent examinations. Can interest also be demanded? Now number 3, other expenses. If he includes, if he incurred any other expenses, then also the other expenses also can be collected from the pawnee. Yes, these are the 3 expenses which can be collected from the pawnee. This is section number 173. Section number 173. 172, all the definitions, essentials, and this is number section 173. That is nothing but the pawnee's right to collect or to retain the amount of his expenses relating to amount of debt, means performance of a promise. Interest also pertaining the debt, whatever is the interest amount also he can collect, and also the other expenses, if any incurred, if any only other expenses, if any incurred by the pawnee. These are the things. Number 2, what is the thing? The next question is, if any subsequent advances he has given. Subsequent advances he has given means who? The pawnee has given some of the advances after first debt. After first debt, he has given some more advances to pawnee also. He has given some more advances to pawnee also. Now on this security, whatever lying, can he retain the goods? Option of retaining of the goods. Can he retain the goods for the subsequent advances also? Got my point? The point is nothing but the pawnee has asked for more and more money. We have given him the money also. Pawnee, we have given him money. The first transaction is completed, and 2 to 3 more or whatever transactions are there, it happened. And for subsequent advances also, what we have given also, can we retain the goods lying with us for the original or first amount of the debt? No, it's not possible. The pawnee should not retain. He should not retain, because that is only for the first security, not for the other advances. So pawnee should not retain any goods for subsequent advances. No, it should not be done. For subsequent advances, he cannot retain the original goods security lying. It's not possible. Next, number 2. Third one. Pawnee's right for extraordinary expenses incurred. So if any of the extraordinary expenses have been incurred by the pawnee, then such extraordinary expenses can be recovered from pawnee or not? Definitely yes. Whatever extraordinary expenses recovered, yes, you can collect from the pawnee. But there is no retaining of the goods for these for the extraordinary expenses. No retainment of goods is possible. No retainment of goods is possible for the extraordinary expenses. Only he can demand for the, means he can have a right to recover the extraordinary expenses. That's all. But no retaining of the goods for the extraordinary expenses incurred. Got it? Now, next thing. What is the last right available to him? What is the last right? For if pawner has not paid, if the pawner has not paid any amount to pawnee, he didn't pay. Means he had made a default in payment. He had made a default in payment of the debt. Default in payment of the debt. Now, what the pawnee can do? What are the options available with the pawnee when a default has been made? What are the options? The options seems like this. The options available with the pawnee are, yes, the options available with the pawnee are, first of all, what he can do? He can retain the goods. Yes or no? Definitely. He can retain the goods. What he can retain? First only we have seen for amount of the debt, for any interest lying, and for any other additional expenses incurred. Any other additional expenses incurred. So, for this purpose, he can retain the goods. Number two, he may sell the goods. Am I right? He may sell the goods. He may sell the goods. Can he sell the goods? Yes, of course. If amount is not recovered from the pawner, what is the option we are having? Goods are not useful to you. Then what you will do? Obviously, you will sell those goods. You will sell those goods. What you are having possession. What are the goods you are having possession? They are not required by you. Means what you will do? Obviously, you will sell the goods. So, sell the goods. Sell the goods means you should have a reasonable notice. To whom, sir? Whom we have to give the reasonable notice? We have to give the reasonable notice to pawner. Sir, because of the debt lying from balance from you, we are unable to pay. You are unable to pay my debt. Hence, I am wishing to sell your goods lying on my possession. Which are the lying in my possession? I'll sell those goods. So, with a prior notice, reasonable time should be given to him, because he may take and he may pay. No, that's why he may take the goods and he may pay the balance to you. So, for that reason, you need to provide a reasonable notice to the pawner. Now, pawner. So, these two are alternatives available for the in hands of the pawnee. Alternatives available in the hands of the pawnee. Now, coming. So, we are sold the goods. Some receipts have been come. Receipts are less than the amount of debt. Receipts are less than the amount of debt. Means you need to collect some more money. Yes. So, for balance of money, what you can give, sir? For balance of money, you can drop a suit in the court of the law. For balance of money, you can drop a suit in the court of the law. Now, if the proceeds collected if the amount collected is more than the debt, if the amount collected is more than the debt, means our debt, interest, additional expenses incurred, all we have taken. There is nothing left. Only additional amount left. Can we take the additional amount then? No, we can't take the additional amount. Now, what to do? The additional amount which is more than the debt or more than our expenses, whatever completed. So, the additional amount should be refunded back to whom, sir? Refunded back to pawner. So, these are the concepts lying. These are the things which a pawnee can have if any default has been made by the pawner. If any default has been made by the pawner. So, this is the case. It means can retain the amount demanded. Subsequent advances, no, it is not possible to retain the goods for subsequent expenses. If any extraordinary expenses incurred, yes, he can collect those extraordinary expenses, but no retainment of goods is possible for the extraordinary expenses incurred. And pawnee's right specifically when defaulted the payment of the amount to payable to the pawnee, he can retain the goods, he can sell the goods, in fact, provided reasonable notice should be given to the pawner. And if the receipts collected or received after sale, should be, if it is less than the amount of the debt, for the balance of amount of the money, we can have a suit in the court of the law, and any additional amount is there, it should be refunded back to the pawner. These are the rights available. Now, next concept. We are moving to next concept. The concept is pawner's right. Now, we have seen pawnee's right till now. So, pawner's right to redeem. What is this redeem? Means goods are lying with the pawnee. So, some goods he have kept for the security. Goods has been given to the pawnee for security for the payment of the debt. So, those goods are lying with the pawnee. And he has given a reasonable notice for the sale, provided he has given a reasonable notice for sale. Now, what pawner can do? What pawner can do? He may redeem. He may redeem the goods, means upon payment only, no? He may redeem the goods at any time before the goods are sold. Before the goods are sold means before the goods are sold, he can take his goods by paying the or by clearing the amount of the debt. By clearing the amount of the debt, he can take the goods only before the goods are sold. So, in paying any additional expenses incurred, no issue. Whatever the expenses, he need to pay to the pawnee and he can redeem the goods. He can take back the goods. So, this is the pawnee's right. And one more thing. What is the limitation? Period of limitation. What is the limitation for having a suit against pawnee? Against pawnee for recovering the things. For recovering the goods what he delivered. What is the time limit? If pawnee refuses to deliver the goods back to the pawner, then the time limit available is 3 years. Within 3 years, he can enforce in the court of the law. He can enforce in the court of the law. The time limitation period is 3 years there. Limitation period is 3 years. So, within the 3 years, he can make an enforcement against pawnee for collecting or for recovering the goods lying in the pawnee's place. So, this ends the pawner's right. Only 2 rights are available. One is right to redeem the goods before sale has happened. Number 2, yes, the suit can be proceeded against the pawnee. What is the limitation period? It is only 3 years. So, these are the 2 concepts which are having rights available with in the hands of the pawner. Now, coming to the next topic, important, very, very important topic as far the examination point of view is concerned. This area is a pitfall to you generally. Now, what is the things? Pledge by non-owners. Pledge by non-owners means what? Generally, the owners. Who are the owners? Means the bailer is the owner, no? The owners will have a pledge with the other party, means bailee. Other party, they will have the delivering of the goods for the payment of the security. Means in this case, pawner and the other party is called pawnee. Other party is called pawnee. Means the owners will have a right to pledge the goods. The owners will have a right to pledge the goods. Yes, this statement is correct or not? Definitely yes. Owners only will be having the right to pledge the goods because no other party can take other party's goods and pledge. No, who will have this thing? No, they don't dare. They don't dare. Only the thing is, owners of the goods will be availing an option of pledging the goods to the other party for security of the amount. Now, but in this case, what's the heading is, ma? Pledge by non-owners. Pledge by non-owners. So, when this pledge can happen by non-owners, that too. So, the concept is nothing but we'll see what are the the persons who can have such a right for pledging. Not being an owner. So, number one, who is the person? Pledge by mercantile agent. Mercantile agent means he is a agent to us. So, can he do so like that? Definitely yes. He can do so. Being a mercantile agent, he can do so like that. Now, mercantile agent. Some essentials are needed for this pledge by mercantile agent. What are the essentials required for the same? What are the essentials required for the same? What are the essentials, ma? Number 1. The person who pledged the goods, should be a mercantile agent. Yes, definitely yes. Now, the person who pledged the goods should have the consent of the owner. This is important. Without consent, he should not do. Means with the owner's order only, he need to have the pledge the goods. Number 3. The agent should have the possession of the goods. Either possession of the goods he might be having, or otherwise the document, means documents like title deeds of the goods. Whatever goods like, he might be having title goods. Either both This or this he might be having. Either possession of the goods he might be having, or otherwise title of the goods he might be having. Then only he can pledge. No? Yes, then only he can pledge. Generally, I'm asking it out. Can immovable property be pledged? Can immovable property be pledged? The answer is no. The answer is no. If we keep a security of a immutable property, it is called as mortgage but not pledge. It is called as mortgage but not pledge, because pledge is a contract extended form of the bailment, and bailments involves goods. The goods are movable. First topic only we have studied. Essentials of the bailment. The goods should be movable goods but not immovable goods. But not immovable goods. So here only movable goods can be pledged, sir. Immovable goods, no, it does not relate to the topic of the pledge. It relates to the topic of the mortgage. Got it? Next. So the agent means the mercantile agent should be in possession of the goods, or otherwise document the title goods which are related to him. Next number. What is the other thing? So this possession also only with the consent of the owner. Possession of the goods also to be taken with the consent of the owner. If consent of the owner is not there, he has possession without consent of the owner. He has possession of the goods without consent of the owner. I'm keeping a star mark here. I'm writing possession of the goods is having with the mercantile agent. Possession of the goods is having, but without consent of the owner, he has pledged the goods. He has pledged the goods. Means what happening, sir? The pledge is valid or invalid? Definitely, pledge is invalid. Definitely, the pledge is invalid. Means the consent of the owner is required for pledging of the goods by the mercantile agent. You can know the importance of the consent relating to the pledge by the non-owner. Next one. The pledge must be carried in accordance with the good faith. The contract of the pledge should be carried according to the good faith manner, and also the other party means the pawnee should not have means no notice of the defects of the title deeds. No notice of defects of title deeds should be not known to the pawnee. He does not know, because only in good faith manner he is acting, and he is keeping the goods as a security. Whether he is the owner means defect of the title goods is not aware to the any default is there in the title goods. The person who is making goods security, the pawnee, is not aware of that. He is having no knowledge regarding that. So these are the essentials required. If pawnee is having the knowledge of the defective title of the goods, then that contract of pledge is invalid. When the pawnee is having the knowledge that the goods, title deed of the goods is not correct, or defective title of the goods is there. At that time, the contract of pledge is invalid. Got it? So this is the basic essentials for the contract of the pledge. So what are the essentials, ma? Pledge should be a mercantile agent. Yes, the pledge should be mercantile agent, and also consent of the owner should be there. If consent, the agent should be in either of the possession of the goods, or otherwise document of the title of the goods. Anything he need to have. So if possession is there, but without the consent of the owner, if this mercantile agent pledges the goods, means then the contract of pledge is not valid. It becomes an invalid contract. And also the pledge should be go in around of the good faith manner, and pawnee, he shall have no knowledge or no notice. You can use the term knowledge also, no issue in that. No knowledge of the defects of the title deeds. Means in a bona fide manner, the pawnee is accepting the goods as a security. So these are the basic essentials required for the contract of the pledge. Now, so this is things, and one more thing is that this is all about the mercantile agent. We have studied point number 1, mercantile agent sale by the non-owners. There are other 3 to 4 concepts are also there in this. Now second one, pledge by non-owners. This is the concept we are going in, that sale by mercantile agent or pledge by mercantile agent we have studied. Now second thing, very important, at examination point of view, this question has been asked many times on this concept only. Now what is a concept? Pledge by a person in possession under a voidable contract. You have studied already in the Indian Contract Act, the voidable contracts, section number 19A. This we have studied. What are the voidable contracts? Yes. What are the situations when the other party can cancel the contract? Voidable contracts, all those are. So, if a pledge by a person who is having a possession, that too by a voidable contract, is called as nothing but a, whether the pledge is valid means, yes, we can say the pledge is valid only, provided some conditions are there. So, let's check it out. What are the conditions under this? Now, two parties are there. One is pawner and the other party is called pani. Two parties are there. Yes, two parties are there, pawner and pani. Now, he has obtained possession of the goods. We have already studied possession of the goods should be there with the pawner. Possession of the goods should be there, but he has obtained this possession of a goods through a voidable contract from another third party. Voidable contract from a third party. That voidable contract is not rescinded, means is not cancelled. That voidable contract is not cancelled, means he is having some goods through a voidable contract with other party, but that voidable contract is not rescinded, means not breaked. It should be cancelled before specified time. But the specified time, the contract is not cancelled. Contract is not rescinded, means a voidable contract, he has obtained the possession of the goods. Now, this possession of the goods has been transferred to the pawnee. Pledge has been taken. Pledge of this goods has been given to the pawnee as a security. As a security, he has given the goods to the pawnee. Now, what happened? What happens whether this pawnee acquires good title or not? Good title of goods will be given to the pawnee or not? Definitely yes. Definitely yes. Provided pawnee acts in good faith and bona fide manner. Pawnee acts in good faith and bona fide manner. Good faith and bona fide. So, if he acts like in such a manner, then definitely we can say that the contract of pledge has happened and it is valid only, provided the voidable contract is not rescinded. We have not rescinded the voidable contract. And also, one more thing, acts in good faith and also no knowledge of the defective title of the goods. No knowledge of the defective title of goods. Very, very important, and many questions came from this area. Through a voidable contract, this person has obtained the possession of the goods. 1 minute, ma. So, I can explain you with better again. Voidable contract pledged by a person in possession through a voidable contract. So, through a voidable contract, this pawner has having the possession of the goods lying with him, and this person has transferred the goods security as a security for the payment of the debt to other party called the pawnee. Now, our question is whether this pawnee will have good title of goods or not. Definitely yes, provided some conditions need to be fulfilled for attaining this good title. What are the conditions? The pawnee should act in good faith manner relating to the contract of the pledge. He should act in the good faith manner, and also he should not having any knowledge relating to the defective title of the goods. He is not having any doubt whether these goods belong to him or not. No, he is not having any doubt. Means no notice regarding the title of the goods has not arisen in the minds of the pawnee. So, this is the two essentials which are required under the contract of the pledge by a non-owner. Now, number 3. What is the other case? When pawner has only limited interest. Pawner has only limited interest. Can he pledge, ma? Yes, he can pledge. But the debt will be relating to the limited interest only. So, pledge is valid. Relating to the limited interest only. Whatever limited interest the owner is having, the other person is having, the pawnee will be having only that part of limited interest only, but no other thing. So, this is the one of the area of a pledge by a limited interest, by person having only limited interest in the goods. Now, next concept. Pledge by co-owner in possession. Co-owner means different owners are there for one item of the goods. For one item of the goods, we are having different owners. Means we will be calling as co-owners. So, different co-owners are there. So, means for goods lying with us 1, 2, 3, 4. For example, 4 co-owners are there and goods are lying with party number 2. Goods are lying with party number 2. Now, he want to pledge these goods. He is not the single owner, no? Can he pledge the goods means? Yes, he can have a option to pledge the goods. Yes, he can pledge, provided only with the consent of the other co-owners. Consent of other co-owners only he can pledge the goods. Consent is required from other co-owners. Then only he can have the contract of the pledge. Otherwise, no. Next one, last one, fifth one. Pledge by. This is already we have learned in Sale of Goods Act. Sale of Goods Act, already we had a topic like this. Pledge by a seller or buyer who is having possession of the goods. Who is having possession of the goods. You are having the possession of the goods. Means you are having a right to pledge. Now, what? Seller has commenced a sale. After sale of the goods, after sale of the goods, seller is having possession, ma'am. Seller is having possession. So, seller is having possession of the goods after sale. Now, possession is lying with the seller, no? That's why he kept the pledge of the goods. Whether this pledge is valid means, yes, if it is done in a good faith manner, the pledge is valid only. Same in the case of the buyer also. Same in the case of the buyer also. This topic has already covered in our foundation. This is nothing but Sale of Goods Act. So, that's why this is not that much important to discuss here now. So, these are the cases where the sale by non-owner can happen. What are the cases? Let's revise once again. So, who are the persons can pledge without being the owner of the goods? Means nothing but non-owners. Number 1, mercantile agent, provided all the things need to be done. Mercantile agent. Number 2, pledge by a person in possession of the voidable contract. Important part of the examination, this only. This is mercantile agent. So, pledge by a person in possession who is having obtained the goods possession through a voidable contract which is not rescinded by the other party. Next, pledge by a person who is having only limited interest. If any limited interest is there, can be pledged means yes, but the pledge of the contract is valid only till the limited interest only, but not the whole. Whatever interest he is having, that part of the interest only can be pledged. That's all. Pledge by co-owners. With the consent of the other co-owners, yes, he can have the pledge. Now, last thing is pledge by seller or buyer who is having possession of the goods. These all are the topics for the pledge by non-owners. Means not owners, who are not the owners of the goods. Yes, still they can have the pledge. Very, very important topic. And this ends the contract of pledge also. So far we have completed indemnity, guarantee, bailment and pledge. Only topic left for is agency, which is very, very important topic, agency. So this all completed, and if we complete the contract of agency, Indian Contract Act will be completing. And one more thing, there's a question asked, what is the difference between bailment and pledge? Difference between bailment and pledge. What is the differences for the bailment and the pledge? Very important. You can write the what, the purpose, right of lien when available, what is the consideration, how many parties, etc. So all these things you can make in the differences between the bailment and pledge. Now let's check out our material. So yesterday in the bailment we have seen the thing like particular lien and yes, see here, particular lien is there. We have already covered it. Particular lien. Goods must be in possession, labor and skill must be involved. It should be in additional value, means increase in value to be there to the goods. Increase in value to be there. If it is there only, then he can have the option of the particular lien, but not otherwise. Now, so remuneration is unpaid to him. At that case only, he can have the right to option of the particular lien. General lien, as I've already said, only available to the bankers, factors, warfingers, policy brokers and attorneys of law. They can only have the general lien. On what they can have? On the general balance of the account. General balance of the account. These are the two things. See here, one more point is there here. Under the right of general lien, goods cannot be sold, but only can be retained for the dues. No, this is one of the important point, no sale in case of the general lien. Only retainment of goods is only possible. Retaining only possible, but no sale is possible. Right? Next. So these are the important points in general lien. Rights of finder of lost goods we have already said in a good thing. This is also important as far as examination point is concerned. November 2018 3 marks it has been given. Rights of founder of the lost goods. Very easy. So whatever the expenses incurred, when can be right of sale can be sue for specified reward. This also we have taken. Right. So what are the duties of the bailee? Same as the As a bailee only, he need to act. Who? The founder of the lost goods. So this ends the topic of the bailment. Next, coming to the topic of the contract of agency. Pledge is also there, no? Yes, still pledge is there. Okay. Contract of pledge. So definitions of the pledge, pawner, pani. Yes, we have already seen what is a contract of pledge, who are the parties involved, what are the essentials. Yes, subject matter must be goods, goods must be in existence, delivery should be happen, and return of the goods after the payment of the debt or performance of the promise, return of the goods should be happen. And the main purpose of pledge is nothing but for the security only. For the security only we are providing. Now, rights of the pawner. Redeem goods pledge, we have already seen. Before the, we can say simply before sale of the goods. Before sale of the goods, yes, he can, who? The pawner can redeem. The pawner can redeem the goods pledged. Next, right to receive increase or profits from the goods. Right to receive notice of sale. Yes, notice of sale should be given by the pawnee to the pawner. Rights of pani. Rights of retainer. Yes, this is the important point, crux point. Interest also can be provided. Necessary expenses. See, extraordinary expenses are not provided to sue. No retaining of the goods also possible, but necessary expense only it is possible. Necessary expenses only it is possible. Next, subsequent advances not possible. Extraordinary expenses he can be incurred, but not shall have not to retain the goods. Only sue. He can sue the pawner for such expenses. Next, pawnee's right when pawner makes it. This also we have seen. Yes. So duties of the pawnee, just like what are the duties of the bailee? Same, he need the same here also. Not to mix the goods, return any accretion in the profit, not to make unauthorized use, not to mix the goods, etc. All those things. Duties of the pawner. Provisions relating to pledge by non-owners. Yes, we have seen. What we have seen? This is pledge by person under voidable contract 19 or 19A. I have said to you. And also pledge by mercantile agent. Some essentials need to be done for the mercantile agent. Consent of the owner, good faith. Ordinary course of the business means normal transactions. How the normal transactions will be carrying, they can also move like that. Next, pledge where pawner has a limited interest, only relating to that interest only it can be carried on. Possession, seller or buyer. So this is the concepts. That's all. Bailment and pledge differences has been asked in the recent examination, May 2018, 4 marks. Yes, sometimes they can have the questions like this and be ready with the differences also. First, we need to write the meaning, purpose, consideration, whether right to sale is there or not, discharge, the return of the goods. All these are the things for the differences of the bailment and the pledge. Now, next concept, agent, contract of the agency. Very, very important. So, coming to the definitions of the contract of the agency, who are agent and what is a contract of the agency? What is the contract of the agency? This is the last part in the Indian Contract Act 1872. Now, what is a agency? Nothing but it is a relation between two persons. It is a relation. It is a relation between two persons. One person is employed as an agent. He is employed. One person is employed as an agent. By whom they are employed? The other party. For the other party who is acting on behalf of him is called the principal. Means the other person who is acting for him on behalf of another person for acting, for representing him. We can also say for representing the other party, agent is created. Got it? So it is relation between the two parties. It is relation between the two persons where one person, agent, is employed to act on behalf of the other party. This is called as contract of agency. This is called as a contract of agency. Two persons are there. Relation between two persons where one person is employed. What is the reason for the employment of him? For acting on behalf of him. For acting on behalf of the other person. Who is the other person here? The principal. Nothing but two parties are there. One party is principal and the other party is agent. Two parties are there. The main agenda for appointing the agent is acting on behalf of him. Acting or representing on behalf of him. He is not available, so his agent comes into the picture. That's all. Very easy topic this also. Now, what is the definition of the agent? This is the contract of agency. Contract of agency definition means relation between two persons, where the agent is employed, relation between two persons where the agent is employed for acting on behalf of the another person, This is called as contract of agency. Now what is meant by agent? Who is an agent? Agent is defined as nothing but person employed to do any act, for another, or can also represent him, right? He can also represent him. He can also represent the other person, represent him. So any person employed to do any act for another, to represent him for what? In dealings with which party? With third person, in dealings with the third person. So in the contract of agency, agent is a person who is employed to do any act for another person, or representing another person for what? In dealing with the third parties. This is the term definition agent. Now who is the person of principal? Who is principal here? The person for whom this agent is employed for representing or to do any act, that person is called principal. For whom he is representing, or for whom he is acting, is called the principal. So in a contract of agency, what is meant by agency? Contract of agency, it is nothing but relation. Between two persons, person number one, person number two, relation between two persons in which another person is employed. For what is the reason for the employment? For acting on behalf of another person, or representing the another person. These are the two reasons for which the other party is employed, means agent is employed. This is called as the contract of the agency. Now who is an agent here then? The agent is a person who is employed. Why is employed? To do any act or to representing him. What is the ultimate purpose? Nothing but in dealing with the third parties. So in order to deal with the third parties, for representing the other person called the principal, the agent is employed. Now who is the person principal here? For whom the party is appointed, he is called the principal. So in a contract of agency, two parties are there. One is principal and the other party is agent. Principal and agent relationship is there in the contract of the agency. Principal and agent relationship is there in the concept in the contract of the agency. Now, right, in the contract of the agency, what are the things we can say? What is the test of the agency? What is the test of the agency? With what we can say that relation of agency is there? Number one, principal is bound with the activities or any of the things done by the agent. To whom he is bound? To third parties. Principal is bound for the activities done by the agent in dealing with the third parties. Principal is bound. Next, number two. To establish a contract of privity. To establish a contract of a privity. Yes, he can establish means with a third party. Definitely the agency contract is there. Means what? Principal agent is there. It is an agreement between them. Agent has dealt with the third person. This third person has a option of right to sue. Means a contract of privity means what? In this principal and third party, he is having any right to sue option on principal or not. This is a concept of contract of privity. This is nothing but if contract of privity is there, yes, the agency is there. So this is a introduction for the contract of the agency. What are the tests required for the agency? Very, very important. If these tests are only present, then we can call it as a contract of the agency. So till now we have seen the definition of the agency, who are parties of the agency, and what are the tests required for the contract of the agency. That's all. Next. So far we have started contract of agency. Which is the last part in the Indian Contract Act 1872. Now, coming to this agency, yesterday we have seen that definition of contract of agency. What is the definition of contract of agency? It is nothing but what we have said, that It is relation between two persons. It is relation between two persons and the person is employed. Why the person is employed? One person is employed. Why? What is the reason for employment of that person? Nothing but the person is employed. Number one, to do an act. To do an act on behalf of him. On behalf of him. And the other one is nothing but to represent him. To represent him on before the third parties. Whom he has to represent on before? To the third parties, he has to represent the principal. So, the person who is going to appoint the person to act on behalf of him, to act on behalf of him, to act on behalf of him is called principal, nothing but, and the person who got employed is called nothing but agent. So, there are two parties in the contract of the agency. One is one principal and number two is agent. There are two parties. One is principal and the other party is agent. The person who is employed to do an act on behalf of us in front of the third parties particularly is called agent, and the person who wants to represent him is called principal. So, we can understand that principal appoints the agent. Principal appoints the agent. Right? This is point number one. Now, who is the principal and who is the agent? Yesterday we have seen these things. And also one more thing we have seen. What is the true test of agency? By what we can say agency existed? Agencies existed between the two persons. By what confirmations or by what principles we can know whether he is a principal and the other party is an agent? By what principles you know? There are two tests for the test of the agency. Number one is nothing but the principal. The principal has capacity to bind. The principal has capacity to bind the agent. Acts of the agent, nothing but. Principal has capacity to bind the acts of the agent. Means he is responsible. He is responsible for the acts of the agent. For the acts of the agent. For whom he is responsible, sir? To the third parties. To the third parties, he is responsible. So, the first test is principal has capacity to bind the agent. Means the acts of the principals, he is responsible. For the acts of the principals, for the acts of the agent, principal is responsible. Now, to whom they are responsible? To the third person. This is test number one. Means we are creating a legal obligation and we are making principal responsible. We are making principal responsible. Next, number two. What is the second test? What is the second test? Means the third parties are acting on seeing the agent. There is an agreement between agent and the third party. There is an agreement between agent and the third party. Now here the principal may sue the third party or third party may sue the principal because it is called as privity of contract. Privity of contract, and this privity of contract is possible with the principal. To whom? Third party. So third party and the principal can have a privity of a contract. These are the two tests which we can say whether agency is present or absent. If the two tests say yes, then we can say that agency is there. We can say that agency is there. If no, these do not have any of the tests fail, then we can say that agency is not there. We can say that agency is not there. So, these are the two tests of the agency. By observing these tests, we can know whether principal-agent relationship is there or not. Now, coming to the essentials. What are the essentials? What are the essentials of the agency of creating contract of agency? What are the essentials? As we said, number one, first of all, what is the basis? On what basis we are going to employ an agent? Basis to employ an agent. What basis we are going to employ an agent? It is nothing but the agent need to do an act. To do an act. For whom? On behalf of principal. On behalf of principal. So, he need to do an act on behalf of the principal or otherwise to represent the principal. To represent the principal. These are the purpose we are going to appoint the agent, that too in front of the third parties. That too in front of the third parties. So this is the basis for the contract of the agency. So this need to be present there. So this is one of the essential for the contract of the agency. Now number 2. What is the other thing? What is the other thing? Does listen carefully, does consideration is necessary in contract of agency? Does consideration is necessary in contract of agency? No, no consideration. Consideration need not be there in contract of the agency between principal and agent. No, consideration not all necessary for its validity. Not at all necessary. Not at all necessary for contract to be valid. For contract to be valid, though there is no supporting consideration between principal and agent, no issue in that. Agency will not be validated because of that. Now third one. What is the third one? It's important, ma. Capacity. It is a examine point of view. It is important. From the point of examination, it is important particularly. Capacity of the principal. Capacity of the principal. Generally, capacity or competence to act as a principal. What is the two things we have? No. One is sound mind. He should be sound mind, and also age of majority. Age of majority. Both these should be done by the principal. Then only he is able to make a contract of agency. Number 1 is sound mind. Number 2 is majority. If these two match, then we can say the principal is competent to contract. Principal is competent to contract. Now the second thing. Second question. This is for principal, ma, and the highlight part of the concept lies here. Agent can be a unsound mind or can be a minor. The question is this: can an agent be an unsound mind or minor? In general, what happens here? Generally, a competent person only need to contract. This is our preliminary case. A competent person only. Competent person means whatever eligibility is there for him to contract, all those eligibility need to be met by that particular person. So a competent person need to be done. For any contract. But here in this case, any person can become an agent. Any person can become an agent. Then if any loss caused, because he is a minor, if suppose we take an example, he is a minor and by the act of the minor, the principal has incurred the loss. Can he make the agent responsible? Because of the agent's negligence or agent's unskilled nature, the agent has done a mistake because he is a minor and it caused loss to the principal. Now you say me whether by the acts of the agent, if any loss is caused to the principal, whether it can be binding in between them or not. The answer is if any person means who is not competent to contract acted as an agent, means who is not competent to contract acted as an agent. Incompetent, nothing but incompetent to contract. That person is an unsound mind, or that person is a minor. Any person, whatever incompetence is there, he has made an act in a position of the agent. Then there is no way the principal and agent are bound. There is no way. Means agent is not at all responsible. Who shall be responsible then? Only principal shall be responsible person. Only principal, not the agent. Got it? Principal only responsible for all the acts done by the agent, whether it is good or whether it is bad. So principal only. So what inference we can get from here? We can get that nothing but, I'll tell you. Yes. So what inference we can get you? So if the agent appointed is a minor or unsound, means not competent to contract, then agent shall not be responsible for any of the acts. Agent shall not be responsible for any of the acts. Now, if he is competent, means definitely he is responsible for his negligence or any other thing. Responsible. He is responsible with the principal. Whom he is responsible? With the principal. Here in this case, agent shall not be responsible with whom, sir? Principal here also. Got it? These are the two important points. From the examination of point of view, particularly in the exam, how they will ask, if an agent is a minor, we have given a contract to the minor and ask him to perform an act. Then what happens? By the not familiar or not skill, lack of skill, want of skill, that person minor has not done the contract well. He has made a mistake in the contract. Then who suffers loss? Principal suffers the loss. Now in this case, whether agent is responsible for the loss cost or principal is responsible for the loss cost? The answer is definitely principal will be the responsible person but not the agent, because agent is not liable to the principal in any case because he is an incompetent person. That's the answer. Right. Now next one. So contractual capacity to act as an agent we have seen. So these are the three things for the essential elements for the agency. First of all, I have said the basis. What is the purpose? What is the purpose to make a contract of the agency? What is the purpose? Number 2, whether consideration is needed or not. Number 3, the capacity of a principal and as well as capacity of the agent. What are the contractual capacity of the principal and contractual capacity of the agent? Provided we need to appoint both principal and agent as if they are competent persons only. If any of the incompetent persons appointed as an agent will not be personally liable to the principal. That's the only thin line of difference. Got it, ma? Next. Now, next we are going to the next concept, that is nothing but modes of creation of the agency. What are the different modes? What are the different modes? Different modes of creation of agency. Different modes. There are different forms of agency creation. So what is the first mode? I have said that it's the relationship between principal and the agent. It is relationship between the principal and agent, and principal will appoint or employ an agent to do acts on behalf of him or to represent the principal in front of the third parties in dealings with the third parties. Otherwise we can say. Now the first thing, yes, how the agency can be created, then express or implied agreement. Express or any implied agreement. Express means it can be in oral or it can be in written format. Now next one. So the first one is express or implied. Next one. Second one. What is the second one? Now agency by ratification. Ratification, we are having separate provisions to speak up. So at that point of view, I'll explain in elaborative way. But coming to the here, agency by ratification means before an act has been done. Before only, underline before. It's an old past act. Before an act has been done, and subsequently, what you have said, you have ratified. Being the principal, you have ratified the act done by the agent. Act done by the agent means you're accepting the act done by the agent. You're accepting. So it is nothing but called by the agency by ratification, because you're accepting. We can deem that principal and agent relationship exists between them. Now number 3. It is nothing but agency by ostensible authority. Agency by ostensible authority means what, sir? Ostensible authority means nothing but. So here the conduct of the principal is in a such a manner. What manner? We are deem that we have an assumption that with that manner, based on that manner, we are assuming that there is a relationship between both two. It is called as principal and agent relationship. Means by a way of conduct, the principal acted that he is my agent through way of conduct, an implied way. So that's why what as a third party, how we are going to deal? Oh, he might be the agent of the principal. That's what the inference we can take. So the third parties infer means we can get a conclusion that third parties infer that a contract of agency relationship exists between them. for the conduct of the principal, by the conduct of the principal. So this is ostensible authority, agency by ostensible authority, and it may occur in any of the following ways. Agency by ostensible authority. The first thing is by estoppel. By estoppel means what? So estoppel means only nothing but we are saying that by through an act of conduct or any other way, we are representing in front of all that he is the agent. In fronting all that he is my agent. We are making a representation by estoppel. But also directly the principal may have, or principal may represent, or some other third party may represent. Some other third party may represent. At that time, while the third party is representing, the principal is silent. Principal is silent. Means what you can say the sir, principal accepted he is my agent. Principal himself accepted that he is my agent. Nothing but estoppel. But through a representation, we are making that he can do my act, or he can represent on behalf of me. He can represent on behalf of me. This is a case where agency by estoppel is created. Next, number 2. Yes, next, number 2. So what is this? What we can say? What we can say through this next number? By cohabitation. By cohabitation. What is this cohabitation? Nothing but a relationship between a married woman and married husband. A relationship between a woman and a husband who are married woman and a husband. Now we can assume that through that relationship or through the marital life, through that relationship, we can assume that woman has all powers to represent or to pledge a husband, or to pledge the security or any other thing, to pledge the security, any other thing of belonging to whom, sir? Husband. Belonging to husband. So in such a way, the agency is created by the cohabitation. Means married woman has an authority to use any of the husband's belongings, either way to pledge or either way to represent him, to do an act on behalf of him, anything can be possible. This is called as agency by cohabitation. Next, number 3. By holding out. This is also very similar to estoppel, sir. No issue in that. Means we are representing, the principal is representing that he is my agent. He is representing that he is my agent. In the earlier occasion, we have represented, provided in the earlier occasion, we have represented that he is my agent. So we can say that the agent is the person employed by the principal. Next number, agency. This is very important from the examination point of view. Number 4, agency in emergency. Agency in emergency, or you can also call agent in necessity. Necessity, very, very important, and questions will be coming from this area. Agency in emergency or agency of necessity. Both are same. No issue in that. Questions maybe questions came from this topic. I can say better, right? Questions already, we have questions in the previous examinations regarding to this topic only. Agency in emergency, or it can also be called as agency in necessity. Now what is this agency in emergency? So some circumstances will be there. So some circumstances will be there in which the principal cannot do anything. Principal cannot do anything. So what is the thing then? The agent need to be done on behalf of the principal at such a time. So under certain circumstances, what a person may be compelled, to act as an agent. So this person, some circumstances will be coming, and such circumstances, that person need to be act as an agent. That too with consent of the principal. Then we can say that agency is appointed by the principal. Consent, sometimes without consent of the principal also. Without consent of the principal. So consent of the principal is not a mandate for this. For the creation of the agency, not a mandate for this. Consent general it should be there, but sometimes because of time factor, we may not say that principal consents need to be done at that point of time. That's why it's agency in emergency, right? So there is no requirement that consent of principal should be there. It can be without consent of the principal also. Next, some conditions are there for these, some essentials, or we can say some conditions are there for these. Conditions are there to treat it as a contract of agency in case of the emergency. So what are the conditions? First of all, no opportunity is there for the principal to communicate with the agent. Principal to communicate with the agent. No opportunity is there. No opportunity is there. Next, number two. There is some commercial necessity. There is some commercial necessity. Means some need is there. Trade need is there. So that's why he need to act as an agent. Next, number three. Provided the agent acted in bona fide manner. Bona fide manner means how a normal person acted in such emergency situations. How a normal person acted in such emergency situations, this agent also acted in the same way. Bona fide or fate manner he has acted. Next, agent also adopted reasonable care and skill. Reasonable care and skill. Agent also adopted reasonable care and skill. Such a care he has taken to do the act. So, as a normal person only he has made that care, reasonable care, and in the course of trade of the business. That's why there is no other interest for the agent here. Next number, last one. Agent is having possession of the goods. Agent is having possession of the goods. Possession of the goods and which are subject to the contract now. Which are subject to the contract. Whose possession? Principal's possession of goods are there. So that's why if these conditions are satisfied, yes, we can say that agent in necessity is there. Agent in necessity is there. So first of all, there is no opportunity of communication. There is no opportunity of communication to whom, sir? To the agent by the principal. There is no opportunity to communicate. Then also a commercial necessity has arisen. Commercial necessity has started to act such person as an agent. Agent should act in a bona fide manner, and also reasonable care has been taken by the agent. Next, agent is having possession of the goods. That's why he can able to do the contract. For example, I'll tell you an example. Suppose we being the principal appointed a carriageman to carry a lorry, etc. Appointed a carriage, nothing but to take our goods towards to some other place. Suppose we are in Hyderabad. I requested him to take to Gujarat. Means 2 days time will be there. In these goods, there is some bread lying. We eat no milk bread, etc. All those. So you can know what is the validity of the bread. Maximum 4 to 5 days is the validity of the bread. After that, the bread gets spoiled, obviously, right? Now, during the way, a road strike has came out, and this carrier was stopped in the middle of the journey. Now, what this person has to do? 2 days? No, it's not clear. A barricades have been kept, and there is a break during COVID times. Also, there is restriction to travel from one place to another place. So, in such a case, the carrier has been left at some of the place. Now what this carrier person has done, he went to a near bakery there, and though it is less than the market existing value, he had sold all the goods. Now you tell me whether this carrier person can do like that or not. Definitely yes, because all these conditions got satisfied. It is a perishable goods, means a commercial necessity has came to him in order to sell the goods lying with him. So this is a commercial necessity, and also he has taken reasonable care and skill. Though market price is less for what he has sold, because he will get something. No, something is better than nothing. If goods spoil means we can't fetch any of the thing. At the time of necessity, someone has taken the goods and he paid less than the market value. What will happen? No issue in that, because something is better than nothing. He has taken such a reasonable care and skill in performing the contract. This is called as agent in necessity or agent in emergency. Important topic or important concept in form of the examination. Next, last one, fifth one. Actual authority of the agent and apparent authority of the agent. Actual and apparent authority. So what are these two authorities, sir. What are these two authorities? Actual. Actual means what? The principal has given consent that this person should be the agent of me. This person should be the agent of me. He has said that this person is the agent of mine. So, it is an actual authority given by whom, sir? By the principal. To whom, sir? To the agent. Actual authority given by the principal to the agent. He manifested. He is my agent. That's all. There is no issue. Chapter closed. No issue in that. Now, so this consent can be expressed or implied. This consent can be expressed or implied. So, this consent is nothing but manifestation of the principal that this person is an agent. Now, what is the apparent then? Apparent then, the principal made the consent that one person shall act him as an agent to the third parties. So, in front of the third parties, the principal communicated that that person is my agent. Whatever dealings you are going to do with my agent. Do with my agent. Means he is communicating with the third parties that some other person is the agent. So, this is called as apparent authority. This is called as apparent authority. So, these are the types of the agents what we have studied. By an agreement means agreement can be expressed or implied, right? Once we can have the picture well, no issue in that. So, express agreement, nothing but agreed, it is an agreement. Agency by ratification, before act done, we have ratified now, means already concluding that that person is the agent. Agency by ostensible authority, nothing but conduct of the principal. Now, in what ways the ostensible authority can be said? Yes, through different ways the ostensible authority can be said. What are the different ways? Number one, by estoppel, means we are representing. By cohabitation, yes, married woman has all the rights. Next, by holding out, we are representing by an earlier occasion. Agency in an emergency or necessity, we have already gone through the essentials or the conditions also. Next, actual authority and apparent authority. Actual authority means we are giving the consent directly with the agent. Apparent authority means we are giving our consent to the third parties. So, this is called as agency, different modes of the agency. Next topic. So, previously we have already seen ratification, right? When can ratification be done? Means the old acts what the agent has been done, we are agreeing now. Or giving consent to that old acts done by that person. So, we can assume that he is the agent of the principal. By before acts, he is validating now. Yes, okay, these acts are okay, no issue, I'll agree. Means principal and agent relationship is binding there. That's what the reason to ratify. Now, what are the essentials? Or what are the conditions? Can be seen in the process of the ratification. What is the conditions? Important, ma? What are the conditions? Now, let us see the different conditions which we can have in the ratification process. Now, number one. Okay, ratification can be done. When it can be done? Only when the agent profess to act. Means if he start acting only we can done. He is already in the process of our contract. Then only we can say that. We can only ratify that. So, ratification can't be done which the principal is not permissible. You are not authorized to do the transaction. Then how can you ratify, sir? We can't ratify such acts. So, whatever principal is permissible to do, then only the principal may ratify. Otherwise, the out of scope of authority of the principals cannot be ratified the agent's work. So, this is the first number. Means what? Whatever, if the principal is permissible, yes, if the principal is permissible to ratify the act, then he can do. If he is not permissible, means no, he may not able to ratify. No ratification is possible here. Next, number two. And ratification need to be done by the person who is in existence. That's what, right? If the person is not in existence, how he can ratify? So, this is a preliminary essential that the person who is going to ratify the act should be in existence. Next, valid ratification. How can we say that it is a valid ratification? it relates to the back date. It relates to the back date. What? When the actual date it is performed, it is ratified. When the actual date it is ratified. So contract has been done 1 week ago. Now we are ratifying. Means what we can say? The act is done on that date only. The act is done on that date only. So ratified on that date. Ratified on that date. Next, number 3. So this ratification also can be in express manner, or the ratification can also be in an implied manner. No issue in that. What way you are going to communicate, oral, written, or any circumstantial, then the ratification is possible. Next, number 4. If suppose a full contract is there. Full contract. Now this person wants to ratify only part of it. Can he do so? Or not? No, it's not possible. Means part ratification is not possible. If he gave any part ratification, it amounts to full ratification only. Means the whole contract he need to ratify, but not in short of that. So this is also one of the condition. Next, one more thing. Illegal act. If there is any illegal act is there. Can we ratify the illegal act, sir? No, not possible. Not possible to ratify the illegal act because it's not authorized. Illegal act itself only void. Then how can you ratify, sir? No, it's not possible. Now, if an act is performed, the ratification also need to be done within specified reasonable time limit. Only within some time limit. What is reasonable? It depends on the facts and circumstances of the case. So, if an act is done, it should be ratified only within that specified time only. Means, if act is done yesterday, I want to ratify 2 years after. Can it be possible? It depends on the facts and circumstances. More time limit will not be provided generally. Very less time only will be provided. Next number. Ratification can also be done if agent acted excess of his authority. Means what? We said to perform a promise only till this limit. Means for suppose is an important examination point of area. So we have said that agent, for example, this is an example I am taking, and we the principal ordered the agent to make a transaction only up to 10,000. Means the agent is authorized to do how much, sir? Only 10,000. But this agent, what he has done? He has done some festival offer came. The actual value is 15,000 and the discounted value came to him is 12,000. Actual value is how much? 15,000. The discounted value is how much? 12,000. Anyway, does it exceed the authority or not? Exceeded the authority or not? Exceeded the authority of the agent? Definitely, yes, it exceeded the authority of the agent. Because how much the agent is responsible? Only up to 10,000. But what this fellow has done? This fellow acted to take up to 12,000 a discounted value of the price for a certain item. It resulted to benefit of principal or not? It resulted to benefit of the principal. Now you say me, if he acted in excess of the authority, if the benefit is derived to the principal, then the principal may ratify the act. Means in excess of the authority done by the agent also can be ratified by the principal. No issue in that. Got? So these are some of the essentials which are required for the ratification procedure. Now see, once again I'll have a look here. So ratification. What are the essentials required or what are the conditions required to ratify by the principal? Number one, what the principal is permitted to act only he can ratify. Otherwise, he may not be able to ratify what the principal has having no authority on him. Next, ratification needed to be done by the person who is in existence only. Means who lives can only ratify the acts. Valid ratification means what? Actual date, what it is ratification. Means the back date we are going to ratify the act. On that date particular we are going to ratify the act. Ratification can be in any form like in express or in implied. Now, if any principal want to ratify only part only part of the contract, only part of a contract. Can he do so? Means yes, but part of a ratification will automatically amount to the ratification of the full contract. Now, illegal act can be ratified? No sir, such an option is not available. If an act is performed, ratification should be done within the reasonable time only. Within the reasonable time only. And also, if an agent acted in excess of his authority, means ratification can also be done. Ratification can also be done. We can't deny that the agent has crossed his limits and so I'm not responsible. No, not like that. He can ratify the acts done by the agent in excess of the authority also. Now, coming to the other more important thing. What is the extent? What is the extent of agent's authority? What is the extent of agent authority? What is the extent, sir? Suppose in normal circumstances, how he can act, sir? He can act in such a manner like all the lawful acts can be done. All the performances, what he required to do, he can do those performances. Means in normal circumstances, in a bona fide manner, how he acts in normal circumstances as a prudent man, yes, the agent can also act same like that only. Now, at the time of emergency, why he is going to act at the time of emergency? Because the ultimate interest is protecting the ultimate thing is protecting the interest. Protecting the interest of whom, sir? Interest of the principal. This is the ultimate thing. From what? From the loss. And also provided the agent need to act as an ordinary man only. How he thinks or how he uses reasonable skill, etc. Ordinary man, how he acts, the agent in emergency also need to act like that only. But what is the ultimate thing? He need to protect the principal from the loss to be caused. That's why we are stopping the loss to be caused. Next, number 3. This is an important examination point of view. It is important. Notice to an agent. Means if anyone, any third party or gives any notice to the agent or agent, 1 minute ma'am. So, if any third party gives any notice to the agent or agent gives any notice to the third party, anything is possible. Vice versa is also possible. So, we are providing a notice to whom, sir? From third party to the agent or notice from agent to the third party. It ultimately gives only one thing. What is that? Principal has the knowledge of it. Principal has knowledge of the notice. Without the principal's consent, notice cannot be given or notice cannot be denied that agent did not receive. Whatever information agent received, we can infer that principal is also having same information. Means we can say that through that notice to agent, principal is also having the same info. Principal is having knowledge in that. Whatever information given by the agent to other third parties, we can say that principal is only authorized the agent to give that information. So, this is the case where we can say that the information possessed or information given by the agent is also known to the principal. Now, next thing. What are the duties of the agent? Very easy. Many times asked question also this is. What are the duties of the agent? So, what are the duties of the agent, sir? Very easy, sir. What are required to do by an agent? It need to be done. Why we are appointing agent? To look after the principal business. We are appointing agent. What is the reason for that? To look after or to carry out. We can use a better word, carry out. To carry out the principal's business. This is our ultimate job. No, that's why we have appointed the agent. To carry out the principal business. Next number. Some skill and diligence also need to be required for the agent. Duty to have skill and diligence to do an act. So, for performing an act, the agent need to have some reasonable skill and diligence. Next number 3. Agent to account for. Means what? Whenever the principal demanded, the agent need to provide the accounts to the principal. Agent need to provide the accounts relating to the business, what he is doing. To whom, sir? To the principal. So, very easy authorities to the agent. Next, number 4. Next, number 4. The next authority or next duty of the agent is, next number 4, payment of money. Payment of money. Money payment means what? Whatever money is received by the agent, we need to transfer to whom, sir? We need to transfer to the principal in a fair and transparent manner. No personal benefit of interest should be looked after there. So this is called as payment of money. It is one of the duty. Next number, duty to communicate. Duty to communicate. Why we need to communicate to principal, sir? Because he may direct us based upon the situation. He may direct us. So in order to get the correct direction, how the agent should need to work. How the agent should need to work. In order to get the correct direction from the principal, the agent, what he need to do, sir? He need to communicate with the principal. Yes, fair communication and transparent manner communication need to be there. In a transparent way, communication need to be done between agent and the principal. Agent and the principal. Next, duty to mandate. Duty to mandate means whatever communication we have received from the agent, we need to work on that. We need to work on that, or we need to follow. Simply we can say we need to follow the principal's directions given to the agent. Duty to mandate. Next one. Next authority. Number 7. Not to deal in his own way. Not to deal in his own account. Not to deal in his own account. Because if you do own account, it may result in profit or loss. If it is loss means as you have done in your own way, you have to bear the loss. You have to bear the loss because you are doing in the same manner. Means if principal has given direction means yes, the principal will bear. But you are doing no. Right, yes. If it is a profit means no issue, you need to share to the principal. You need to share to the principal. But loss means you need to bear. So, next number. Repudiation of transaction. Repudiation means nothing but cancellation. Repudiation of transaction by whom, sir? By the principal. Of which act, sir? Acted by the agent. Why, sir? Because agent acted in a misconduct way. Or he concealed some of the facts. So, some facts have been concealed and also acted in a misconduct way. Improper way. Nothing but he has acted in improper way. That's why the principal has an option to cancel the contract. Voidable contract. The principal has option to cancel the contract. This is one of the duty. So, it is one of the duty of the agent not to behave in a misconduct way or not to conceal the facts. If so, you have done such things means repudiation of transaction will happen by the principal. Next, number 9. Duty not to delegate. You should not delegate any of the acts to any other person because you agreed that you will do. Then why we need to delegate, sir? No delegation is possible. No delegation of work is possible except in some circumstances. This concept is called sub-agent. Except in some circumstances, we may not able to delegate our duty. Next, last one, number 10. Duty not to make secret profits. Yes, we have already said duty not to make secret profits. Own benefits should not be seen in a contract of the agency because all that will be carried in a faith and bona fide trustful manner. That's why we will not make any of secret profits from the principal's business. No secret profits. Now, so what are the duties, sir? What are the duties of the agent? How he need to work? How he need to behave? How he will look after the business? All those things are nothing but the duties of the agent. So, first of all, he need to look after the principal business. Next, some skill and diligence need to be applied. And also, he need to account for the agent accounts. Proper accounting, proper and correct in a fair manner accounting need to be done. And payment or any payment received, he need to transfer to the principal. Also, duty to communicate to the principal in order to have direction from the principal. And duty to mandate. Whatever direction is given by the principal, we need to work upon it. And also one more thing, not to deal on his own account. Means on his own action, he should not be there. Whatever direction he need to follow. If followed means if he makes a deviation in following the principal's direction means what will happen, sir? He will bear the loss obviously. Repudiation of the transaction means from this what we can infer, agent should not act in any misconduct way or improper way which results in loss, or otherwise he should not make any concealment of the facts. If so, if he has done like that means the principal may repudiate the transactions. And the last one is duty not to delegate. You should not appoint any sub-agent. And last one is duty to make secret profits. Duty not to make. You should not make any secret profits from the principal's business. You should not make any of the secret profits. Because why? Agency relationship, principal and agency relationship, the base is nothing but trust and confidence. Trust and confidence means only in the bona fide manner you need to work on it. In the bona fide manner you need to work on it. So these are the duties of the agent. Now far coming, what are the rights of the agent? Far coming, what are the rights of the agent? Till now we have observed duties, sir, and now we are going to look after what are the rights of the agent. So what are the rights, sir? Very easy, sir. Right to lien means if you are having any property, any of possession of the goods relating to the principal means as you are not received any remuneration to be payable to you or any commission to be payable to you or any other thing which is not paid to you, then you can take such an action. The possession, whatever the possession of the goods you are having, you can take a right of lien on it. You can stop the goods delivering to the principal. You can have a right on it. That right is called nothing but right to lien. Next, number 2. Next, what is the other right we are having? Right to indemnify. Right to indemnify. So we have worked in skill and diligence only, sir. The agent has worked in proper way only, but some loss has been incurred to the agent. Loss has been incurred to the agent. Now say whether the principal need to indemnify the loss of agent or not. Definitely yes, because agent has taken proper care in doing the acts. That's why if he has any loss incurred after doing correctly also, the principal need to reimburse the same. The principal need to reimburse the same. Next one. That's nothing but all the lawful things done by the agent in a good faith manner, the loss sustained need to be reimbursed by the principal. It's a clarity purpose. Next, number 3. There is no, one more thing, there is no right to indemnify if he has acted in contrary to the provisions of any law. No ratification is possible. No indemnification is not possible if the agent acts in a contrary to any law. No indemnification. Now, next part. Whatever, next right. Injury compensation. Third one, injury compensation. So what is this injury compensation, sir? Nothing but injury compensation. The principal has not acted by applying proper skill. Having no skill and diligence, he acted, we can say that in an improper way, the principal has acted and we have sustained the loss. Then who has to bear the loss, sir? Definitely the principal need to bear the loss. This is called as injury of compensation. Next, right to retain. Right to retain means our expenses, we have received some sums from the third parties, and this is one of the important area asked previously in the examination relating to this topic, right to retain. So what is this right to retain, sir? Nothing but this right to retain is nothing but we have received some sums from the third parties and our remuneration or commission, whatever is there, is lying pending. Our communication is lying pending. Now, what happens to this communication, sir? Only the balance after deducting our lawful communication, only you can process to the principal. Means that is called as right to retain. Yes, if the principal has not given you any remuneration or commission which is lawful payable to you, he didn't give. You have received some sums from the third parties. Then you can deduct those sums and you can transfer only balance of money to the principal. This is called as right to retain. Yes, one practical question came on this, in fact. One practical question came on this topic particularly. Next, last one is nothing but right to remuneration. That's what we have seen. Right to remuneration. Whatever the acts done by the agent, whatever the lawful acts done by the agent within his scope of authority, the right to remuneration is there for the agent. So all these are the 5 rights which are applicable to the agent. Number 1, right to lien. Number 2, right to indemnify. Number 3, injury compensation. And number 4, right to retain his earnings. Number 5, right to remuneration. These are the 5 different types of the rights available to agent. So we have completed duties and rights of the agents. Now next topic. Okay, we are in the chapter of the agency, and till now so far we have completed the definition of the contract of the agency, who can be called as the principal and who can be called as an agent, and how the relationship exists in between them. And also we also cover who are competent persons regarding principal and who are competent persons regarding agent, and their implications also. If any incompetent person acts as an agent, means what are the implications of the contract? We have seen that. Next, afterwards, silent features of the agency. Yes, we have studied different features like what is required for the agency, what an agent need to do. All these we have seen in the essential requirements in the contract of the agency. Now after that, we have also observed modes of creation of agency, means through what mode or what are the different types of agents can be appointed. Number 1, we have already seen through an express agreement, means like oral or written or in any other implied manner also an agent can be appointed. Next, afterwards, by ratification. Ratification means already the previous old acts have been ratified by the principal, means it's a implied meaning that we have accepted what the agent has done to the principal. So this is the agency by ratification. And also we have already learned sufficient information regarding ratification. What are the rules applicable for a principal to ratify the agent's needs or deeds, whatever he did. Next, afterwards, by ostensible authority, means nothing but through different modes we are giving the authority to represent ourselves or to do an act on behalf of the principal in dealing with the third parties. In that we have studied by estoppel, by holding out, cohabitation. A woman will have, it's presumed that a woman will have all the authorities in respect of his husband, her husband. Now afterwards, one of the important topic we have covered, agency in emergency. Also it can be called as agency in necessity. So this is a different types of creation of the agency. And one more thing also we have studied, actual authority and apparent authority. Actual authority means directly with the agent. The principal communicates with the agent that you are my agent. So it is an actual authority giving. But what is meant by apparent authority? It is nothing but agent will have a dealings with the third parties, and the third parties will be informed that he is my agent. So you are making an apparent authority with the third parties, giving an apparent authority. To whom we are giving? To the third parties we are giving. So these are the different modes of creation of agency. Now also we have studied extents of agent's authority. In normal course of business, whatever the things principal required to do, the agent will do. Whatever the things required to be done by the principal, the agent will represent him. So this is a normal course. Coming to the emergency, agent in emergency way, emergency situation. In an emergency situation, yes, the agent has authority to act on behalf of the principals. But for the ultimate thing is protecting of the principal from loss to be caused. Protecting the principal from loss to be caused. This is the ultimate information the agent need to have. Now, next one, notice to an agent. Yes, if any notice is given by the agent or any notice is given to agent, it will be equally deemed that we are dealing with the principal only. Means what we can elaborate any information if an agent is giving to third party, means we can have an assumption that yes, principal has only given this information. Principal has only given this information. Now, if any information is given to the agent by third party, means we can always have that the information will be passed to the principal, and principal comes to the knowledge of this information. Principal will come to the knowledge of this information. So this is the extent of the agent's authority. Now also we have seen two most important things, that is nothing but duties of an agent and rights of an agent. Duty is very important. There are 10 different types of duties need to be performed by the agent. So what are the duties? Let us check in the material. So this is a contract of agency. So definitely question will be coming from this chapter. So in May 2022 also one direct straight away theory question has came. And coming to the practical questions. So 8 marks have been observed from the contract of the agency in the recent examination May 2022. Now coming to the things, question and answers. Term agency, yes, we have done. To do an act for another and to represent another. Test of the agency. Yes, I have also said to you, test of agency. Privity of contract need to be established between principal and third parties. This is one of the important tests. And also, person has capacity to bind the principal and making responsible to the third person. So, in a principal and agent relationship, there should be in such a relation that principal is liable to the third parties. Principal is liable to the third parties, means responsible to the third parties. This is called a test of agency. Next, who may be an agent? Yes, majority and sound mind. There's a minor can also be a agent, but he is not responsible to the principal. That's the only reason why a minor can be an agent. Now, next, different modes of agency. Yes, we have seen agency by express agreement, implied agreement, agency necessary at the time of emergency, agency by ratification, estoppel or holding out. Also, one more thing is that cohabitation. Yes, cohabitation also we have studied, we have seen. Next, what is meaning of the agency by estoppel? Yes, means so only what are the essential things which are required? What is the definition of the estoppel, agency by estoppel? Here it's your information is given. Representation, express or implied, induce with the third person. The principal must have induced with the third person. Means we are saying that in front of the public, he is my agent, inducing nothing but. So, next. Agency by ratification. The previous act, old act need to be ratified. Yes, following are the rules. Rules we have already seen in a separate column yesterday. Now, it should be communication need to be done, ratification need to be done within reasonable time. Yes, all these are there. Express or implied. Through express way or implied way, we can ratify the act of the agent. Now, coming to the things, authority of the agent. Yes, in normal way, we can have normal things what the principal will do, and in case of emergency, we need to have the ultimate interest is protecting the principal from loss to be caused. Protecting the principal from loss to be caused. So, this is the emergency agent's authority at the time of emergency. Sub-agent we didn't cover still. There are two topics called sub-agent and substituted agent, and we'll cover today. Next, substituted agent. Yes, this also will cover today, no issue in that. And we are in the duties and rights. So, if duties and rights are completed, we can move into the other topic. Now, duties of an agent. As yesterday I have said, we need to execute or mandate whatever directions given by the principal. Follow instructions or customs. Yes, whatever instructions or customs are there, we need to follow. Reasonable care and skill. Whatever the principal, how he acts in his business, the agent also need to take care. Such a reasonable skill and care he need to apply at the time of transacting the principal business. At the time of transacting the principal business, he need to apply the same. Duty to communicate with the principal. Yes, we need to have a better communication so that the principal will direct you what to do and what not to do. Duty to avoid conflict of interest means not to deal on his own account. No, he should not deal his own account. He should have the information to the principal, and principal need to give directions, and as per the directions given by the principal, the agent need to be worked. That's what. Duty not to make a secret profits. Yes. And also duty to render proper accounts at whatever the information the principal asked or whatever the accounts the principal or we need to submit the accounts to the principal. Duty not to delegate. Yes, we should not delegate. But a sub-agent concept is there here. That's why it is given here star mark, I think so. Sub-agent concept is there because the agent's duty need not be delegated. Then how sub-agent concept will arise? Just in a couple of minutes we'll see. Agent's duty to pay sums received for the principal. Yes, whatever sums we are receiving, we can pay to the principal. But subject to such deductions, the agent is bound to pay his principals all sums received on his account. So, not to use any confidential information during the process of the transacting the business. Protecting interest of the principal is the ultimate reason for all of the agents. So these are the duties of the agent, and he need to be perform the duties in a such a diligent manner. If anything happen or any contradiction happen in performing the agent's duties in a negligent manner, then who will be liable, sir? Principal or agent? Definitely the agent will be liable because of his negligence only. The loss has caused it to the principal. In such a cases, the agent will be liable. So he need to follow all the duties with reasonable skill and as a care. Now, what are the rights of the agent? Rights of retention out of the sums received. So whatever sums received, he can deduct the eligible expenses need to be paid to him, and after that he can pay to the principal. Right of remuneration. Yes, it's a right to the agent that to receive the remuneration for what the work he has done. Next, right of lien. We already seen right of lien means, yes, if the sums need to be received from the principal is not to be paid then he is the agent. If he is having possession of the goods, yes, he can have a option, nothing but right of lien for the dues to be paid. Next, right to indemnity. Yes, for any lawful acts, any loss has been caused. It means he worked sincerely, so loss caused. Then who need to reimburse? The principal need to indemnify the loss caused to the agent, provided the agent acted within the scope of his authority and also reasonable skill and diligence has been applied by the agent. If these two conditions or criteria met by the agent, then only the principal can indemnify the agent. Next, afterwards, right of compensation. Injury compensation, I have simply said. Injury compensation. This is nothing but the principal. The principal acted in a negligent manner. Here not the agent, sir, but principal only acted in a negligent manner which caused loss to the agent. Then who need to reimburse, sir? Principal need to reimburse to the agent. So this is the right of injury compensation. So these are the things we have studied, covered so far in the agency concept. Now we are moving to the another new concept, that is nothing but when an agent is personally liable. When an agent is personally liable. When, sir? When will be the agent personally liable? Means principal liability is not there, only agent liability is there. So when will be an agent will be personally liable? Number one. Yes, if it is an express agreement. Means any agreement is there between the principal and agent stating that you are liable for the acts done. If it is an express manner, there will be no clashes will be coming, and so directly the agent shall be liable for the acts done by him. Next, second one. Out of his scope of authority. Means what? He acted, because agent need to act within his scope. He acted out of his scope. Means without the principal consent, he acted himself. Much more action has been done by the agent. So in that way, we can say that he acted out of his scope of authority, and definitely the agent only personally liable for what he has done. What the extra he has done, the thing done by him shall be liable by the agent only. Next, afterwards, number three. Means we can easily say he does not have authority to do that. Who will give the authority, sir? Principal will give the authority. So principal did not give the authority to do that act or perform that act. But what this agent has done? The agent has acted out of his scope of the authority. That's why here agent is liable for the act done by him which is outside the scope of his authority. Next, number three, which is outside the scope of his authority. We can use it where? Next, number three. When a contract has been entered, but in reality, there is no need to enter. There is no need to do by that agent. He entered himself. So at that time also, the agent will be personally liable. There is no need or there is no necessity to make that act. But what the agent has done? He has acted on his own way. So that's why the agent is personally liable but not the principal. Now next, number 4. Some circumstances are there. In those circumstances, the agent is personally liable. What are the circumstances? Where the agent is personally liable? Let's see. Number 1. It is expressly agreed that agent is personally liable. You are only liable. It's an agreement given. Number 2. An agent when signs a negotiable instrument in his own name. So he signs, he is going to undertake a liability. In such a case also, agent will be personally liable because he has signed himself. And you know very pretty well, for every negotiable instrument, signing is mandatory by the drawer or by the maker who is going to have the instrument. So signing, he has signed on his own name means who is liable, sir? Agent only liable, definitely. That's why agent when signs a negotiable instrument on his own name, principal will not be liable. In such a case, only the agent will be liable. And also number 3. Agent worked for a foreign principal. Foreign principal means the principal is not residing in our country, a foreign person, an NRI. So he is representing the agent. He is representing the foreign principal, being an agent. Now, this agent will be liable because of the foreign principal, because there are certain things which we may not able to directly sue a foreign person, right? That's why whom we'll see if any happens afterwards, definitely we'll sue the agent available here. So that's why if he is representing a foreign principal also, agent will be personally liable. Next, number 4. Next, number 4. So when agent acts for foreign ambassadors and souvenirs. So if he is acting as an agent for any of the stated people, then agent will be personally liable. And also based upon the trade of the business or custom of the business, trade of business, or you can also use custom of the business. In some situations, agent shall be personally liable based on the custom, whatever the trade business they are doing. If it is a custom to do make agent personally liable, then agent shall be personally liable. Next, also the agent has a interest in the subject matter, personal interest he is having. Agent is having personal interest in what, sir? In subject matter of the contract. So in such a situations, as the agent is having a personal interest in that, agent will be personally liable. So these are some of the situations where we can make agent personally liable. Some situations will be asked in the examination, and you may be asked that who is liable for the loss? If these are in such a case, then definitely the agent will be liable. So one is express agreement. 1 minute. So one is express agreement, means through an agreement you are making agent personally liable. Through an agreement, open agreement, we are making agent liable. Next, outside his scope of authority, means the principal does not give any authority to do an act. That particular act, principal does not authorize him, but principal though did not authorize, what the agent has done? This agent has done that act. Means simply we can say that agent acted in the outside scope of his authority. So this is the reason why agent is personally liable. Next, number 3. A contract has been entered by the agent and acted on his own way, but in fact it's not needed to make. In such a situations, agent shall be liable. And there are some particular situations where we can say in a trade business or any other business, if these situations come into place, then obviously agent will be held liable for the lost cost. Now, what are the situations? If there is an express agreement in the particular contract that agent should be liable, then agent will be liable definitely without any cost. Second one, agent signs a negotiable instrument. So negotiable instrument is having a character that who signs that agent, means while signing also he didn't disclose any of the principal name. Because for principal I'm going to sign. No, in such a declaration has not been made by the agent. So at such a case also, agent shall be definitely liable. While when signing the negotiable instrument without making any declaration that I'm signing on behalf of my principal. No, you didn't make any such declaration. That's why who will be liable? Definitely agent will be liable. Next, number 3. Agent worked for a foreign principal. As there are some NRIs who wish to appoint agents to act in other countries. So that a case, we may not able to have any legal relationship with the foreign persons. So that's why we'll be able to maintain legal relations only with the agent, and hence agent is liable personally. Next, number 4. If agent acts for the foreign ambassadors or sovereigns, etc., then also agent is personally liable. And there are 2 more situations. Nothing but there is a custom in the trade of business that agent should be personally liable. So if it is according to the custom or trade followed by a business, then who will be liable, sir? Definitely the agent will be liable. Next number. Last one, agent personal interest. If any personal interest is there in subject matter of the contract, in such a case also agent shall be personally liable. All the situations we are making agent liable. Now, next topic, information which we are going to take. Sometimes the agent in view of dealing with the third parties, he may not disclose the name of the principal under which he is acting. He may not disclose the name of the principal under which he is acting. No disclosure of name, or the identity of the principal, or the identity of principal is kept in a secret way. Is kept in a secret way. In such a manner, will be calling this principal as undisclosed principal. Will be calling as this principal as undisclosed principal. Means what? The agent did not reveal the name of the principal or identity of the principal where he is dealing with the third parties. No, he didn't disclose. In such a case, what will be calling that principal? Will be calling as undisclosed principal. And my question is whether agent is liable in such a case of undisclosed principal or directly principal is liable. Because in a contract of agency is what? Contract of agency, there must be a privativity of contract between principal and the third parties. This is one of the tests of the agency we have studied in our class. Now, other test is nothing but we are making the principal bound to the third parties. We are making principal bound or responsible, we can use a better word. We are making the principal responsible to the third parties. Responsible to the third parties. In such a case, if these two tests, the principal is not disclosed means, then how can we have the principal liable to us? Because agent didn't disclose him. So, whether agent is liable or principal is liable in such a case? Agent is only liable because it is his mistake to not to disclose the principal. So, that's why in those cases, agent is liable personally. Agent is liable personally. And though the principal revealed his name, it does not change the contract afterwards because agent has already acted. Now, next thing. Now, we'll check principal's liability for the acts of the agent. Principal's liability for acts of the agent means if agent acted, at what circumstances liability of the principal shall arise. At what circumstances the liability of the principal shall arise. Now, okay. Now, let us see. First one. In that first one is nothing but the previous one we have seen. One is agent liable means if he acted outside his scope of authority, then definitely agent will be liable. Means when does principal liability will arise? Simple. Agent has acted within the scope of his authority. Within the scope of authority, agent has acted means who will be liable, sir? Principal shall be liable. Next, number two. When agent notice is given to the agent. Agent received notice. Agent received the notice means, or notice is provided by the agent to third parties. By third parties, we are giving the notice, or agent is providing the notice to the third parties. Vice versa, anything. At such a case, what will be dealing? Any notice, then principal shall be liable. Means before only we have said in the powers of the agents. If any notice is given by the agent or any notice is received to third agent by the third party, then we'll make principal has the knowledge of it. We'll make the principal has knowledge of it. That's the assumption we'll take. So that's why principal shall be liable if any notice is given to the agent or any notice is given by the agent. No issue in that. Vice versa. Next, we are making an estoppel. Agency means then definitely principal shall be liable or not? Definitely liable. Principal shall be liable. Though it is an agency of estoppel, the principal shall be liable. Because estoppel we are making a representation. We are making a representation in front of the third parties that person is the agent. Now, agent shall not be personally liable. Though it's a contract of the estoppel, now the principal only be liable as a original contract only. Express agreement contract, how they are dealing with the contract of estoppel agency also will be dealt in the same manner. Now, next thing. Fourth one, liability cost for the agent's misrepresentation or fraud. For the agent, fraud or misrepresentation. So, agent has been misrepresented or it's a fault of the agent. So, agent has done Principal shall be primarily liable and he may indemnify from the agent subsequently. No issue in that. But who is liable, sir? Principal or agent committed any other fault, any other two third parties, means definitely principal shall be liable. And if agent is responsible for the fraud, then principal may be indemnified from the agent. These are the situations where the principal shall be liable to the acts of the agents. Okay, now next concept. Next concept is nothing but irrevocable agency. Irrevocable agency. So what is an irrevocable agency? What is it, sir? Nothing but we have already observed preliminarily, if an agent is having any interest, any personal interest, if the agent is having any personal interest in what's the subject matter of the contract. Subject matter of the contract. So in subject matter of the contract, we are having personal interest, means the agent is having personal interest, means it cannot be taken back. It cannot be taken back by the principal, means the contract cannot be broken up by the principal. So it is called as irrevocable agency, means agent is having somewhat interest in the subject matter of the contract. Now next thing. So this is, we can call it as agency coupled with interest. Agency coupled with interest. This can also be called like this. Irrevocable agency means what? At this time, why this is irrevocable? Because as the agent is having personal interest, the principal cannot revoke. The principal cannot revoke the contract. Cannot revoke the contract, because the principal can terminate the contract if he didn't have a liking towards the contract, or some other situations may come where the principal may revoke the contract. But if it is an irrevocable agency or agency coupled with interest, means the agent is having somewhat personal interest in the subject matter of the contract, then principal cannot revoke the interest of the agency. Principal cannot revoke the contract in fact. So this is called the agency coupled with interest, or it can also be called as irrevocable agency. Now coming to the other important topic from the examination point of view, that is only two topics left first. One is sub-agent and other one is substituted agent. Other one is substituted agent. So what are the and one more thing, in the recent examination a difference question has been also asked. Difference question between sub-agent and substituted agent. Please make a differentiation between sub-agent and substituted agent. A recent question has also been asked on this. Direct theory question. If theory question comes very easy, sir, you can easily attempt. If a practical question comes from the Contract Act or any other thing, you need to think carefully and you need to assess the provision, you need to assess the implications, what is the contract and what, and you need to write the conclusion. So answering a theory question is bit easy than answering a practical question. Now coming to the definitions of what is sub-agent and what is a substituted agent. As the previous law, we have studied that agent cannot delegate his work because it is a duty. Agent cannot delegate his work. This is what we have learned in the duties of the agent. Agent can't delegate the work of the principal. He may not able to delegate. But in some situations it is necessary as per the trade of business, like just a custom as a custom to keep a sub-agent for that. Means what? Here generally the principal will appoint the agent. Here in this case of sub-agent concept, the agent will also appoint another agent under him. He is called the sub-agent. Means first of all, principal will appoint the agent and agent in turn will appoint another agent to work under him. This is called as sub-agent. If you see, the agent will be responsible for the principal and sub-agent will be responsible to the agent. But sub-agent will not be responsible to the principal. Only whom he will responsible? Only to the agent he will be responsible. This is the difference between sub-agent and substituted agent. Now, next thing. Means when will be agent can be appointed as sub-agent? Generally, first of all, what we need to write? Agent cannot delegate the work of the principal to any other person. Means he may not able to appoint any agent under him. But if in a business, it's a customary to appoint. If in a business, to customary to appoint, or in any other circumstances which require to do so. Then we can appoint a sub-agent under the agent. We can appoint a sub-agent under the agent. Now, principal will appoint agent and agent will appoint the sub-agent to do the work of the principal. But sub-agent only will be responsible to the agent but not to the principal. Only agent he will be responsible, and this agent will be responsible to the principal in fact. Now, next one. So, when does Section 190 provides you, Section 190 of the Contract Act of Agency provides you when that an agent may appoint a sub-agent under him. Sub-agent under him. So, what is the things under Section 190 provided to appoint a sub-agent? Number 1, we have already said it is a custom of trade. Second one, the nature of work is necessary. To appoint a sub-agent. Next, number 3. When the principal only gives consent. To appoint a sub-agent. Means with the principal consents only we are delegating our work. With principal consents only we are delegating. What is the duty of the agent? We should not delegate the work basically. But if the principal only authorized to delegate the work by keeping a sub-agent, means no issue in that. We can appoint a sub-agent at that point of time. Next one. We have communicated, means principal knows that we are going to appoint a sub-agent. Principal is aware of the fact that agent is appointing a sub-agent under him and he did not oppose it. Means we didn't ask permission from the principal. This is an express. Here, point number 3 and point number 4, there is a small slight difference. What is the difference? The third one, principal has an agreement. Principal has an agreed with agent that he can appoint sub-agent under him. But here in the fourth case, what happening? Agent is appointing the sub-agent and this fact is already come to the knowledge of the principal, but principal did not oppose that. No opposition from the principal. So, means what we can assume that impliedly principal has given authorization to the agent to appoint the sub-agent. So, this is the cases where the sub-agent can be appointed. And next, one more thing is also there, ma'am. Some unforeseen situations are there. Where we need to appoint the sub-agent in that unforeseen situations. Next one. Power of agent to delegate work to the sub-agent is inferred from the conduct of the parties of principal or agent. So, impliedly, principal or agent through a conduct, they have communicated that we have appointed a sub-agent. Nothing but estoppel, like an estoppel, they have said that he is my sub-agent. Then no issue in that. So, these are the different modes. Where an agent can appoint a sub-agent under him. Number 1, custom of the trade, means it is customary of the business to appoint a sub-agent, and nature of work is such a case we have to necessarily keep a sub-agent, and also principal's consent is there for the appointment of the sub-agent. And next one, principal did not object anything if agent appointed a sub-agent. Next, afterwards, some situations require some unforeseen situations, or we can also say some emergency situations has been arised that to appoint a sub-agent under us. And next, power of agent cannot be delegated, but it is delegated through the conduct of the parties of the principal and agent in any manner. So, means nothing but we can say that from the conduct of the parties. It is inferred that they have appointed a sub-agent. So, these are all the different situations of appointing of the sub-agent to the agent. Now, my question, previously only we have studied that thing, whether principal is having any relation with the sub-agent. Means the sub-agent shall be liable to the principal or not. So, how can we say this? We can only say this when we have a strong base that whether the appointment of sub-agent is in proper manner or improper manner. Proper manner or improper manner. Improper manner. So, if it is in a proper manner, means what? Principal has only authorized to appoint a sub-agent. If it is in a proper manner, definitely sub-agent shall be liable to the principal. Definitely sub-agent will be liable to the sub-agent. To the principal he will be liable. Now if it is an improper manner, means there is no relation between principal and sub-agent. Only agent is authorized. That's all. No relation between the principal and sub-agent. Here, if principal only gives, there will be a legal relationship between the principal and the sub-agent. So these are the different situations where the principal can be liable to the sub-agent or sub-agent can be liable to the principal. Vice versa. Anything can happen at any point of time. Now, coming to the other point, we have already seen some of the things. Sub-agent we have completed, and now we are going to another concept, substituted agent. Now, who is this substituted agent? Who is this substituted agent? Is sub-agent and substituted concept same? No, it's not same. No, it's not same. We are having a difference. Sub-agent, what we are doing? Principal appoints agent and agent is delegating the work to the some of the agent under him. He is called as sub-agent. Means a sub-agent need to be answerable to the agent and agent will be answerable to the principal. In such a manner it works. The concept of the sub-agent. Now, what is this concept of the substituted agent? Principal will be appointing agent. Principal will be appointing agent. Because of the agent's availability, he may not be available and he may appoint another person as agent. Another person as agent. So, we are appointing another person as the agent. We are appointing. So, he will be called as substituted agent. He will be called as substituted agent. Means instead of you, your work will be done by some other person. Instead of you, your work will be done by the some other person. In such a case, we'll be calling him as substituted agent. Now, what is the difference between sub-agent and substituted agent then? Yes, sub-agent is under the control of agent. Under the control of agent means he works under the control of the agent. But in a case of the substituted agent will be under the control of the agent? No. Will be controlled under the principal agent only. He will be controlled under the principal only. Being a substituted agent, he is having all the equal rights as an agent. All the equal rights as an agent. So, agent who will be responsible? Principal will be responsible. So, the substituted agent also will be working under the control of the principal only. But here, the control of agent, control of sub-agent, who will be controlled, sir? Agent will be controlling. Agent will be controlling, but not principal. But not principal. Now, second thing, what is the other differences? Now, here the agent will delegate the work to him. Agent will delegate the work to the sub-agent. Delegate the work to the sub-agent. But here, substituted agent case, who will delegate the work, sir? Principal shall delegate the work to the sub-agent. Principal shall delegate the work to the sub-agent. Now, next one. Can we point another difference between the agent and sub-agent and substituted agent? Yes. What is the other line of difference? No privity of contract. No privity of contract between principal and sub-agent. I have said already in the starting of this session. Principal and sub-agent, there is no privity of contract. But here, yes, privity of contract is there between principal and substituted agent. Principal and substituted agent. Now, next thing. Next thing, number 4. It's an important, that's why I'm discussing, because it's previously asked question. Number 4. Yes, number 4. Agent is responsible to the principal. Agent is responsible to the principal if any act done by the sub-agent. If any act done by the sub-agent. So, directly agent will be responsible here. Here, agent will be responsible to principal. No, directly the substituted agent will be responsible to the principal. Substituted agent will be responsible to the principal. Now, sub-agents may be improperly appointed. Improperly appointed. We have already seen the sub-agent's liability will be determined based on whether proper appointment is there or whether improper appointment is there. But in case of substituted agents, there is no way of improper appointment. There is no way of improper appointment. Improper appointment means nothing but with the consent of the principal or not. With the consent of the principal or not. If principal gives the consent to appoint, the agent will be calling as proper authority or proper appointment, and there is no consent from the principal side means will be calling as improper appointment. So this is a case. So these are some of the differences where we can find the difference between sub-agent and substituted agent. Substituted agent means nothing but replacing the agent. We are replacing the old agent. That's all. This is called as substituted agent. Now coming to the last topic for in the contract of the agency, the leftover last topic is nothing but termination of the agency. We have started the agency, but now we are terminating the agency. Termination of agency. Through what ways the agency can be terminated? Important concept. Based on this concept also, the examiner may give the questions. Some of the topics here. So, what are the different bases or different forms the termination of agency can happen? So, what are the different forms? Number one. The first thing is revocation of agency. By whom, sir? Principal. By the principal. Relating to this point, just now we have studied one thing. What is that? Just now we have studied. What we have studied? If an agent has an coupled interest in the subject matter of the contract, then principal cannot revoke the agency. That's what we have studied. So there is an exception that when does principal cannot revoke, sir? Principal cannot revoke if agent has personal interest in the subject matter of the contract. If agent has personal interest in subject matter of the contract, then the principal may not revoke the agency. That's what the point we have studied. So if we link it these points, it will be easy to you for the reference. Now, number 2. When does the revocation of the agency happens? Yes. Number 2. When does it happens? Nothing but renunciation by the agent. Renunciation by agent. Renunciation of agency by agent. Means agent is only closing the agency relationship. Then in such a case, there is no point of contract of the agency. Next, number 3. Completion of term of agency. So the agency period has came to an end. In such a case, the agency will be completed. The contract of agency will be completed. Now, next number. What is the other thing? Death of either party. Whether the agent or whether the principal, if any death happens, unfortunate thing happened and it resulted into the death of the agent or death of the principal. In such a case also, agency will be terminated. And last, one more thing is there, that is nothing but if a principal has become insolvent, means competence has been came to him, and incompetence has been came to the principal because he declared as an insolvent. So in such a case, if principal is insolvent means agency relationship will be terminated. Agency relationship will be closed. So all these are the different modes of terminating of the agency. Let us check one time. Termination of the agency. Number 1, revocation of agency by the principal. Yes, the principal may revoke at any point of time the contract of the agency. Renunciation of agency by the agent. Here, agent himself has been closing the contract of the agency. Completion of the term of the agency means particular period. We to be an agent for this particular period for this year. So if the year end comes, means what happens? The contract of the agency will be broken. Death of the either party means whether agent or principal, any of the either party has been died means either party has been died means death of the either party will result into the termination of the agency. Next, last one, principal if had incurred any of the disqualification in the terms of the contract, means he had incurred any insolvency, then the agency will be automatically gets terminated. These are all automatically. There is no other forceful stop there. Now coming to the some more points. One more last point is Dharma. So when does it come into effect? When does termination of agency come into effect? Come into effect means when it can be started, means whether it relate to the principal, if it is terminated between the agent to the third parties, when it comes to the effect. Nothing but before it comes to the knowledge of the third party. Before it comes to the knowledge of the third parties means first it should need to come to the knowledge of the third parties. Then only the agency termination can be held on. Otherwise, no. So this is the concept of agency. closure of agency. So all this we have covered in the contract of agency, and it resulted into the end of the topic. Now just we'll have a revision what we have done in our material, because sub-agent and substituted agent we did not cover. So just we'll have a look on that, if any point is missed in that. So coming to the sub-agent. Who is the sub-agent? Employed by the original agent and also acting under the control of the original agent. Yes, no control of the principal here in this case. Now, prohibition on appointment of the sub-agent. So, generally, we cannot delegate. Means the reason is duty not to delegate. No, that's why it is the duty of the agent not to delegate his work. That's why he may not able to appoint an agent. But if it is in the expressly or impliedly in the ordinary custom of the trade or nature of agency related maintain that sub-agent need to be employed, in such a cases agent can be employed. Now sub-agent can be employed. Exception where an agent cannot appoint sub-agent. So these are the exceptions and implications of appointing a sub-agent. The principal responsible to third person means the principal is bound and responsible for the acts of the sub-agent if sub-agent were an agent originally appointed by the principal. That's what we have said. Proper appointment. If proper appointment is there, then principal shall be held liable. If it is an improper appointment means no, principal shall not be held liable. Next. Agent's responsibility for sub-agent appointed without authority. So we'll treat as agent is treated as principal of such sub-agent, and then the agent shall be liable. Next. Substituted agent is a person appointed by the agent to act for the principal. So on behalf of the principal he is acting. Now, with the knowledge and consent of the principal, substituted agents are not the sub-agents, are the agents of the principal only. How the agent of the principal is there, the substituted agent also will be the agent of the principal. He is not the sub-agent, right? He is not the sub-agent. We will be calling it here as substituted agent. Now, next one. Agent's duty in naming such person. Yes. Cite the rights of the agent we have already covered. Yes. Provisions relating to principal's liability to third parties. That's what we have seen now, right? Within the scope of the authority, then principal shall be liable when the work of the agent is, this part we didn't discuss. See, principal's liability when agent exceeds authority means agent has, this is a contract. For example, this is a contract. Agent is authorized up to here only. Agent is authorized up to here only. Now, this is an important point actually to be discussed, but we have missed in somewhere. So, agent original authority is only up to here, but he acted this also. Means outside his scope of authority he has acted. Then who will be liable for this? Outside scope of his authority. Who shall be liable? So, see, look here. If it is separable, can be separated, means it is separated here. So, if it is separable means whatever the separate amount is there, so much only of what he does within his authority is binding as between him and his principal. So, whatever within the scope he has acted, principal shall be liable. But whatever the out of scope he acted, if it is separable means definitely the agent only will be liable for the separable item of the contract or transaction. If it is not separable means, then what we can do? The principal is not bound to recognize the transaction. Means anyway, principal won't able to recognize the transaction, and hence principal may not be liable for the outside the scope of the authority if the agent is acting. Now, consequence of notice given to agent. Yes, we have covered. Misrepresentation or fraud in the course of the business have the same effect on agreement made by such agents as if misrepresentations or frauds had been committed by the principals. So, if any agent commits any misrepresentation or fraud means we can deem that principal was also involved in that. Principal is also involved in that. So, obviously, principal will be coming into the picture of liability. Next. When the agent is personally liable. Yes, we have seen now. If any foreign principal he needs appointed, foreign ambassadors, foreign sovereigns, if the appointments, agent is personally liable. Termination of agency. Yes, we have seen fixed period. And also, a reasonable notice need to be given for the renunciation. Reasonable notice need to be given whenever the agency revokes the contract of the agency. Explain the provisions relating to termination of agency, completion of business, death or insanity. Yes, termination of sub-agent's authority. This is one important topic asked in the examination point of view. Important topic. What is this? Termination of sub-agent authority. Suppose they may ask, we have appointed an agent and agent in turn appointed the sub-agent and the principal and agent relationship has been broken. Now, whether sub-agent relationship is also terminated or not. This is a small practical question asked in our recent examinations. Termination of agent's authority as per applicable provisions causes automatically the termination of authority of all sub-agents appointed to him. Means whenever the principal and agent relationship is closed, then only it is implied that all other sub-agents also terminated. All other sub-agents also terminated. This is one of the important category of the examination point of view. Principal's insolvency. Yes, incompetence has been came after contract. So that's why principal's insolvency on expiry of the time. These are the things. Irrevocable agency. Agency coupled with interest. We have covered, sir. Termination of agency is effective. We have said already. To the third parties means nothing but when does it will take effect, ma? As regard to agent, only when it comes to the agent's knowledge, and also for third party, knowledge of such third parties. That's all. Next. So, can a wife pledge her husband? This is what we have said, cohabitation. Already covered. Cohabitation, yes, wife has having authority to pledge the goods of the husbands. Right. So, this ends the contract of agency. So, we have completed the entire Indian Contract Act here up to here, because we have already covered the indemnity, contract of indemnity and contract of guarantee. The second topic we have covered contract of bailment, contract of pledge, and the third topic is agency. So this ends the completion of the contract of Indian Contract Act, agency, everything we have completed. So this amounts to the completion of the chapter number 1 in our syllabus, that is nothing but Indian Contract Act. We have completed. So we are starting the next new chapter, that is nothing but Negotiable Instruments Act, NI Act. In short, we'll be calling as Negotiable Instruments Act, NI Act 1881. So this is the next chapter and also important chapter as per the examination. As far as concerned with the examination, this is one of the important chapter, NI Act 1881. So very special chapter actually this is, because definite questions come from this chapter in form of the practical questions or direct scenario based questions, many other things. So important chapter, but also will be coming from this chapter. So if you understand the concept with clarity, definitely it will be useful to you regarding this chapter, so that you can score good number of marks concerning relating to this chapter. Now coming to the Negotiable Instruments Act 1881, this is not a new concept. Not a new concept, because in olden days also we'll be having transactions in the commercial world. We'll be having transactions in the commercial world. So by this act, what happened? It legalized the activities in the trade and commercial world. Whatever the activities are going on in the trade and commercial world, this act legalized the same instruments. Legalize the instruments. Now coming to the definition, what is negotiable actually? What is negotiable? Negotiable is nothing but transferable. So it is nothing but transferable. Now what is an instrument? What is an instrument then? An instrument is nothing but a written document. Instrument is nothing but a written document. Written document by which what are created from that written document? By which rights and liabilities are created. Rights and liabilities are created through that instrument. So negotiable means transferable and instrument means a written document through which rights and liabilities are created to the parties. Rights and liabilities are created to the parties. So nothing but negotiable instrument. By what? This act is enacted. This act is enacted for what is the purpose? For to legalize the instruments, which are used in the activities of trade and commerce. So whatever the instruments we are using in the commercial world, the same are legalized by the act, that is nothing but the NI Act 1881. So the main objective of this law of NI Act 1881 is nothing but to amend the concepts relating to the negotiable instruments. So amend the law. Whatever relating to the commercial instruments, the objective of the act is this only, to define and amend the law relating to the negotiable instruments. We can use, in fact, it's a better word, to define and amend. To define and amend the law. Concepts means nothing but the law relating to the commercial transactions. So this is the objective of the NI Act 1881. Objective of the NI Act 1881. Now, coming to this, nothing but we can say simply it is a law relating to the commercial world. Law relating to the commercial world, and also it gives, the act gives sanctity, means recognition, to various instruments which are used widely in the commercial transactions. It gives sanctity, nothing but. No. And also the basis of this NI Act is nothing but from the English common law, because all the mercantile laws were taken, where the source is, the main one of the source is nothing but, main one of the source is nothing but the English common law. By using the base of English common law, we have amended our laws, we have done with our laws. In the same way, NI Act, the basis of NI Act also common English law. And also, when is the effective date? What is the effective date of this NI Act is nothing but 1st March 1882. 1st March 1882. So, nothing but 4 points are important. Introduction, in coming to the introduction concept, it is a law relating, nothing but it's the objective of the law is to define and amend the law relating to the negotiable instruments. Define and amend the law relating to the negotiable instruments, and also it gives sanctity to the various instruments which are widely used in the commercial world. Negotiable, the word negotiable means transferable, and also instrument means it is a written document through which rights and liabilities are created to the parties of the commercial activities, created to the parties of the transaction. Whatever the transaction is going on, in the transaction, the parties involved, the rights and liabilities will be stated in nothing but in the written document only, nothing but agreement, we will say, right? Yes, after that. So, this is a objective and effective date. Now, coming to our concept, I'll divide this chapter into 11 different concepts, so that concept wise we can move, and we'll having a conceptual clarity regarding each part. So, I would like to divide the chapter into 11 different topics. That is nothing but, so, NI Act 1881. I am going to divide in different topics. Number 1, introduction and definition of the negotiable instruments. Next, number 2, types of negotiable instruments. Number 3, calculation of maturity date. Along with types of other negotiable instruments, I will also tell some more concepts here. Not only types of negotiable instruments, and we'll be dealing with some more concepts which are important from the exam point of view. Next, calculation of maturity date. Of the instruments. Sometimes the examiner can focus from this area also. They will give a problem directly, so that you need to calculate. Mostly in MCQs we can see this. Not only in MCQs, some practical questions also may be coming regarding calculation of the maturity date of the instruments. Next, this is for basic understanding. Concept number 2 is for basic understanding, because that understanding is important, and also sometimes some differences or some direct questions may come from this area also. Types of negotiable instrument. Next, number 4. This is important concept, holder and holder in due course. What is the definition of the holder? What is the definition of the holder in due course? And what privileges are available with holder in due course rather than being a holder? So, all those topics will be undertaken in point number 4 or division number 4. Next, division number 5. Negotiation and its types. In the same way, endorsement and its types. Next, seventh concept, crossing of checks. What are the types of crossing of the checks? What are the different means of crossing of the checks, and what is meant by different way of crossings of the checks? All those will be dealt in the topic number 7, crossing of checks. Next, number 8, presentation of instruments. Means nothing but discharge of the instruments by paying. Presentation of the instruments. Next, number 9. Who are parties to the instrument? And also their rights and liabilities, because this is important. Their rights and liabilities to the instrument. Whatever rights and liabilities can be known. Next, number 10. This is one of the important concepts in which the questions may be coming from here. That is nothing but material alteration. Material alteration. Last, number 11. Dishonor of the instruments. Dishonor of the instrument. Bits will be coming from this concept 11, dishonor of instruments, and many other practical questions also may be coming. What are the sequence for the dishonor? What are activities can be held, or what rights will be available when dishonor of the instruments, or what liabilities can be held to the parties if the dishonor of the instruments happen. All these concepts will be dealt in the topic number 11. That is nothing but the dishonor of instruments. So for our convenience of reading, I have divided the entire chapter NI Act 1881 into 11 different concepts. Number 1, introduction and definition of NI Act can be known in topic number 1, very easy topic. Next, number 2, what are the types of negotiable instrument, and some more concepts relating to the negotiable instruments will be dealing with. Topic number 3, calculation of maturity date. Topic number 4, holder and holder in due course. Topic number 5, negotiation and its types. And topic number 6, endorsement and its types. In the same way, topic number 7, crossing of the checks. And 8th one, presentation of the instrument. Number 9, parties to the instruments and what are the rights and liabilities of the parties of the instruments. Number 10, material alteration. And number 11, dishonor of the instrument. These are the 11 different bifurcations for ease of convenience I have divided. Now, coming to the introduction, I have already given sufficient introduction to the negotiable instruments. That is nothing but the law relating to the negotiable instruments in commercial world. In commercial world is given by the NI Act. Is given by the NI Act. Means NI Act deals with the law relating to the negotiable instruments simply. NI Act deals with law relating to the negotiable instruments. Next, number 2. The word negotiable, as I already said, it is nothing but transferable freely. Negotiable, transferable freely. And the word instrument means, I have already said, instrument means it is a written document which creates rights and liabilities to the parties. Rights and liabilities to the whom it will give the parties. The parties. Next, number 4. The negotiable instrument gives sanctity to the negotiable instruments in the legal commercial world. If the same is not there means, it would be a big havoc to the parties of the instrument. It would be a big havoc, because if sanctity is not there means many of the allegations will rise from different parties, so that it have a jumbling or any other different manner things may happen. So that's why the Negotiable Instrument Act gives sanctity to the negotiable instruments. And next, the objective of the NI Act is nothing but to define and amend law relating to the negotiable instruments. Next, the effective date of the NI Act is 1st March 1882. So it got assent in December 1881, but the effective date of the act is 1st March 1882, one of the oldest acts. Yes. Next. So the definition of NI Act is not given clearly. What is the definition of the NI Act? But it only defined the types of the instrument. That is the definition given here. But the content of definition is not given. So now coming to the topic, what is a negotiable instrument? So what is a negotiable instrument? We have already said. Means what we have said, that is nothing but NI instrument is an instrument in which the instruments are freely transferable from one person to another person. The instrument is freely transferable. And also here the freely transferable in case of a bearer instrument, it is a mere delivery is enough. And in case of order instrument, endorsement and delivery is important. Endorsement and delivery is important. So this is nothing but negotiable instrument. Means a negotiable instrument is an instrument which is freely transferable from one person to another person. But if it is in case of a bearer instrument, mere delivery is sufficient. If it is a order instrument, don't worry, bearer and order instrument are new terms, and we'll be dealing with the terms in a couple of minutes. We'll be dealing with the terms in a couple of minutes. If it is a bearer instrument, means mere delivery is enough. If it is an order instrument, means endorsement and delivery is needed. So this is the definition we can derive from the observations. But the definition is not given by the Act. The definition is not given by the Act. Now, one more thing. The Act gives the definition. The Act gives the definition. What is the definition given by the Act then? Negotiable instrument is a 3 different types of instruments are available. 3 different types of instruments are available. That is nothing but promissory note, number 2, bill of exchange, and number 3, check. And number 3, check. Promissory note, bill of exchange, check. These are the 3 different instruments. The negotiable instrument is there. So this is the definition given by the Act simply. So, negotiable instrument means it is an instrument. It is an instrument. It only three kinds of negotiable instruments are there. It defines that only 3 kinds of negotiable instruments are there. What are these? One is promissory note. Next one is bill of exchange. And the third category is check. So, this is a definition given by the Act. So, it is a common definition. In a common definition, we are giving that the above definition is a common definition. But the definition given by the Act is this one. Definition given by the Act is this one. And third one. Is there any other definition given by the other Acts? Yes. The Transfer of Property Act. The Transfer of Property Act also states the TP Act, we'll call it as, also states a negotiable instrument. What it has said, sir? What it had said? It includes the hundi also. The hundis also. It includes a hundis also. Means as per the trade and customs, what are the instruments available in the commercial world are included, and also hundis are also included. This is the definition given by the other Act. Now, if we see in a group or combining way, the definition of negotiable instrument can be taken in 3 different forms. Number 1, in a normal way. In a normal meaning, what is the definition we can take? Nothing but it is a freely transferable instrument. By what's a mere delivery. Means we can extend our thing that if it is a bearer instrument, mere delivery is enough. If it is a order instrument, endorsement and delivery is also essential. If it is a order instrument, endorsement and delivery is also essential. This is as per the normal meaning. Now, coming back to the Act, what it has said by the Act. Act only defines 3 types of instruments. What are the 3 types of instruments available in the Act? Number 1, promissory note. Number 2, bills of exchange. Number 3, check. These are the 3 different types of instruments as defined in the Act. Next, number 3. Does there is any reference of other Acts? Yes. Reference of other Act is there. What they are saying that the instruments are negotiable instruments in which for the time being, like notes, hundis, orders, etc. As per the trade and customs followed. In the commercial world, all those, if they are negotiable at that point of time or as per the trade consent, then they will be also negotiable here. Now, we'll have a small again revision what we have said now. That is nothing but definition of the negotiable instrument can be taken in 3 different types. 3 types of definition can be observed. 3 types of definition. What is the 3 types of the definition? Number 1, normal meaning. Means because Act does not define what is a negotiable instrument, we have to study the normal meaning as a general rule of interpretation. Because the meaning of negotiable instrument is not defined in the Act. That's why, what is the normal meaning, sir? It is freely transferable instrument from one person to another person. From one person to another person. Freely transferable. This is important word. It is freely transferable from one person to another person. It can be, if it is a bearer instrument, it can be by mere delivery simply. And if it is an order instrument, it can be endorsement and delivery. It can be in the form of endorsement and delivery in the case of order instrument. See here, both cases delivery is essential. Both cases, delivery of the instrument is essential. Next, number 2, as per the Act. Act defines or Act recognizes only 3 types of the instruments as negotiable instruments. What are the 3 types of instruments then? Number 1, promissory note. Number 2, bill of exchange. And number 3, check. These are the 3 types of instruments which are recognized. Next, number 3. That is nothing but reference of the other acts. The reference of the other acts is the other acts also dealt with the negotiable instruments, means which are at the trade and commerce recognized as negotiable. Trade and commercial way recognized as negotiable. Then they can be called as negotiable instruments. For example, notes, hundies and orders are recognized as negotiable instruments at that point of trade and custom. At the point of trade and custom previously. That's why they are also negotiable instruments can be called. So these are the 3 different types of negotiable instruments meaning. Meaning of the 3 types we can know. Now, next coming to the characteristics of the negotiable instruments. What are the preliminary characteristics? Preliminary characteristics of negotiable instruments. What way we can say this is a negotiable instrument? What way? What are the characteristics or essentials? We can also call it as essentials. What are the essentials required to be a negotiable instruments? What are the essentials? Simply by reference to the definition, we can know one thing. What is that? Number one, delivery is important. Delivery of the instrument is important because the definition itself, we are saying that delivery is important. Delivery of the instrument means freely transferable from one person to another person. Means what it should happen, sir? Delivery of the instrument need to be happen. Delivery of the instrument need to be happen. Number two, the instrument need to be written way. Because instrument itself we have given the definition that instrument is a written document. So definitely it is in a written mode only. Written mode and also signed by the parties. Who are the parties need to be signed? It need to be signed by the parties. So sign, nothing but we can take written and signed. Next, number 3. For a consideration. So consideration is also an essential element for becoming a negotiable instrument. Now, next one, point number 4. Bona fide transferee. The transferee need to be in faith or trustful manner. Bona fide transferee. It is important to become the essential element of the negotiable instrument. So, one is delivery of the instrument and the other one is characteristics or essentials of the negotiable instrument. One is delivery of the instrument because the definition itself we have learned that negotiable is a delivery mode. Negotiable means transferable, freely transferable from one person to another person. So that's why delivery of the instrument is a negotiable instrument essential characteristics. And also written mode because instrument will be almost in written mode only. Instrument will be in written mode and also that too signed by the parties. Next, for a consideration. Yes, consideration is important and also bona fide transferee. Whom we are transferring, the transaction need to happen in a bona fide manner, that too with a bona fide transferee only. So these are the essentials or characteristics of the negotiable instrument. Now, next. So coming to the point of types of negotiable instruments. How many times we have recognized as per the Act? Because Act gave definition that there are 3 types of the negotiable instruments. What are they, ma? Number 1, promissory note. Number 2, bill of exchange. And the third one is check. So these are the 3 types of the recognized negotiable instrument. Now, coming to the point, first of all, what is a promissory note and what are the essentials required for a promissory note? Now, coming to the definition, for each of these, we'll be learning definition of negotiable instruments, parties to the negotiable instrument, and also what are the essentials required for the same. What are the essentials required? So for each of these three, we'll be dealing with these three. Who are definition? What is the definition? Who are the parties? And what are the essentials to become that particular negotiable instruments? What are the essentials? Now, coming to the promissory note definition. What is the definition of the promissory note? So, the definition is nothing but, it is given by the section 4. So, the definition is, as per section 4 of the NI Act 1881, a promissory note is an, first of all, it is an instrument, right? So, it is an instrument. That too in what way, sir? In writing mode, because this is a basic essential of negotiable instrument. This is a basic essential of negotiable instrument. Next, what it contains? Containing an unconditional order. Unconditional order. Containing an unconditional order. Next, number 3. Next, number 3. Signed by the maker. Signed by the maker. Signing is also essential element which we have already seen in essentials of the negotiable instrument. So, if it is to be a particular bill of exchange, promissory note or check, the essentials of the negotiable instrument first need to be validated. What are the essential instruments we have studied? Delivery, in writing mode, signed, consideration, bona fide transferee. So, all these need to be there for each and every negotiable instrument. For each and every negotiable instrument. So, if a question comes, what are the essentials of a bill of exchange or essentials of a promissory note or essentials of a check? You can write preliminarily what are the essentials required for the negotiable instruments. Then you can continue with particular things of the instruments. Right? Now, signed by the maker. So, what is the reason for the signing? What is the intention of the order containing an unconditional order? That is nothing but to pay a certain sum of money. To pay a certain sum of money only to or to the order of a certain person, order of a certain person or to the order of bearer of the instrument. To the order of bearer of the instrument. To the order of bearer of the instrument. So, I repeat the definition of the promissory note. This is a definition given by the Act relating to the promissory note. That is nothing but a instrument in writing mode containing an unconditional undertaking signed by the maker. What purpose? To pay a certain sum of money only to or to the order of a certain person or also to the bearer of the instrument. Also to the bearer of the instrument. This is the definition given by the promissory note relating to the Act. The definition is given by the Act. Now, coming back to the essentials of the promissory note. What are the essentials for the promissory note? We'll have a clarity. Now, coming to the essentials of the promissory note. What are the essentials of the promissory note? So, what are the essentials? That is nothing but requirements of the promissory note. We can also call it as the same. Now, number 1, first one, it must be in writing. Must be. There is no optional, no oral. No, not like that. It must be in writing only. There is no other way. Oral agreement can also make a promissory. No, nahi chalta. Only thing is, it must be in writing mode. It must be in writing mode. Number 2, it must be unconditional. It must be unconditional. That's why we have said above, containing an unconditional undertaking. Containing an unconditional undertaking. Only unconditional. So, must be unconditional. Number 3, certain sum of money. Unconditional undertaking, we can say clearly, unconditional undertaking, certain sum of money. There is no ambiguity relating to the money. That's why in the definition also we have seen to pay certain sum of money. To pay certain sum of money means money should be certain sum of money. Number 4, signed by the maker. It need to be signed by the maker. Next, number 5. Promise means the transferee, promisee must be certain. These are the essentials. For the promissory note. Definition we have covered, and essentials must be in writing, must contain an unconditional undertaking to pay a certain sum of money and signed by the maker, and also promisee must be certain. bona fide transferee, we can say. Promisee must be certain. These are the essentials required for the promissory note. Now coming to the third one, who are parties? Who are parties to the promissory note? Who are parties to the promissory note? So I have already said only two parties are there. Two parties are there in the promissory note. Number one, that is nothing but drawer of promissory note and also drawee of the promissory note. Drawer means who signs the promissory note. Who signs the promissory note? We can call him as a maker also. We can call him as a maker also. Maker. Now, drawer. Who is a drawer? Drawee to the promissory note. Nothing but on payee. We can call him as a payee also. We can call him as a payee also. So, there are two parties. In a mean way, we can also say promisor or also promisee. Promisor and promisee. Suppose we are being a promisor. Suppose Mr. Ekalingam. Just say for example purpose. Ekalingam is a person who owes to another person. The person name is Niranjan. For example, he is a Niranjan. He is owing 10,000 rupees money to him. Means Ekalingam need to pay to Niranjan a sum of rupees 10,000. A sum of rupees 10,000. Means now what this person Ekalingam will do? This person will draw a promissory note. Means he nothing but makes. He makes a promissory note. So what he makes? I promise to pay a sum of 10,000 rupees along with interest at the rate 2% per month. At the rate 2% per annum or otherwise. No issue in that. So at the rate 2%. To Mr. Niranjan. And also signed by whom, sir, here? Ekalingam. Means who is the drawer of the instrument, who is making. We can also call him as making, or who is a promisor to the promissory note. He would be signing there. Means this instrument is payable at the order of Niranjan. We can include that to Mr. Niranjan or to his order. We can include that. So this is a promissory note and it needs to be stamped. Means all the legal formalities need to be done regarding the instrument of the promissory note. Now we can call the two parties. Number one is promisor. Promisor means who promises to undertake the liability and for whom the promise is given is called promisee of the instrument. Promisor, promisee. Also we can call one more thing. Payer. He is the payer of the amount. He is receiving the amount. That's why we can call him as payee. So two parties are there in case of a promissory note. One is promisor and the other one is promisee. We can call it as payer and payee also. He makes the instrument. Maker. He makes the instrument or he draws the instrument. Payer draws the instrument. Here on behalf of whom, sir? Promisee or payee. So these are the parties to the promissory note. So by that we have completed the definition, essentials and also the parties to the instruments of the promissory note. Now coming to the next second instrument, that is nothing but bill of exchange. Second instrument is nothing but the bill of exchange. Now coming to the bill of exchange, what is the definition given, sir? What is the definition given under the Act? So a bill of exchange is also an instrument. Yes, that's what we have. Basic essentials of the negotiable instruments. It is an instrument that to in what mode, sir? In writing. Instrument in writing, and what it is containing? Containing unconditional. Here also same we are using, sir, unconditional order. Here we are using unconditional order. But coming to the promissory note, what we have used, sir? Unconditional order there also. Or we can also say unconditional undertaking. Yesterday we have seen the definition of the Negotiable Instruments Act. As per section 13, we have observed the definition of the NI, what is the definition of the negotiable instrument. And now today we are moving to the instruments which are dealing with Negotiable Instruments Act. That is nothing but promissory note, bills of exchange and check. So let us see what are the definitions and who are the parties to the negotiable instruments, and also what are the essential characteristics or elements of being that particular negotiable instrument. Now let's go with start with. So we have observed negotiable instruments are of three types, that is nothing but promissory note, number 2 bill of exchange, and number 3 is check. Number 3 is check. These are the three different types of negotiable instruments. Now coming to the each and everything. So promissory note, what is the for all of these three we are going to see the definitions, parties, and also what are the essentials for being this the negotiable instrument. So now coming to the promissory note, the first part of the negotiable instrument. The first part of the negotiable instrument. Now coming to the promissory note, what is the definition? So the definition is given in section 4 of the NI Act. The definition is given in section 4 of the NI Act. So let's see the definition. So a promissory note is an instrument, in writing. Instrument in writing. These are the basic essentials for a negotiable instrument only. So now coming to the promissory note, what it contains? Containing an unconditional undertaking. Unconditional undertaking. This is important, ma. Undertaking. Unconditional undertaking. Now what they are saying? Signed by the maker. And also the purpose is this: to pay certain sum of money. Only to whom we need to pay? To or order of certain person or to the bearer of the instrument. So this is the definition of the promissory note. Sometimes in the examination they may ask particular definitions of promissory note, bill of exchange or check, and what are the essentials of the same for some amount of the marks. So based on the amount of the marks we need to answer the question. Now coming to the promissory note. The definition of the promissory note can be observed as like such. Just a minute. So instrument in writing, we have already seen for NI Act some essentials will be there. Instrument in writing, signature should be there, and also delivery should be there, and the transferee should be a bona fide transferee. The four things we have already learned in the essentials of the negotiable instrument. Now coming to the promissory note also, the means for every instrument considering to the negotiable instrument, the basic essentials of the negotiable instrument should also be there. So we can easily add those points. First of all, writing a essentials of the promissory note. Instrument in writing should be there, signed by the maker should be there, and in addition to that, in promissory note it should contain an unconditional undertaking. Means a promise need to be made. By the maker. Signed by whom, sir? Here, maker. What is the purpose of the promissory note here? To pay certain sum of money. Means money should be in certain sum of money and to the order of a certain person or to the bearer of the instrument. This is the definition as per section 4 of the NI Act. Now coming to the parties. Who are parties to the instrument of the promissory note? Only two parties will be there. So what are the two parties? Number 1, promisor, because he promises to pay. Promisor, and the other one is promisee, means for whom the promise has been made. Now coming to the promisor, he can also be called as payer and he can also be called as payee because he is receiving the amount. He signs the instrument of the promissory note, means payer signs the instrument of the promissory note and delivers the same to the promisee. These are the parties to the promissory note. And now coming to the essentials. What are the characteristics or requirements for an instrument being a promissory note? Essentials for the promissory note. So what are the essentials for the promissory note, sir? We have already know. What is that? Number 1, the instrument must be in writing mode. And also the promise made to it. For what we are doing? Promise to pay. The promise should be an unconditional undertaking, mean without any conditions, without keeping or posting any conditions, the promise need to be made. So unconditional undertaking, and also the amount which we are paying should be certain. the amount must be certain and also number thing signed by the maker. Signed by the maker. These are the essentials which are required for an instrument to become a promissory note. So, coming to the definition, promissory note definition is instrument in writing containing an unconditional undertaking. This is the difference between this point and this point makes a difference between promissory note and bills of exchange, because in bills of exchange we'll be dealing with some other word here, and to pay certain sum of money, this will be difference in bills of exchange. So that makes a basic difference between a promissory note and bills of exchange. Now just we'll be seeing in a couple of seconds the definition of the bills of exchange. So, this is the definition of the promissory note. How many parties are there in a promissory note? Only two parties. One is promisor and the other one is promisee. And what are the essentials for the promissory note? That's nothing but instrument in writing, promise to pay, unconditional undertaking, amount must be certain amount, and also it should be signed by the maker. These are the essentials for the promissory note. Now, coming to the definition of the bills of exchange. Definition of the bills of exchange. Let us see. Yes, coming to the definition of the bills of exchange. This is the second part of the negotiable instrument, bills of exchange. Now, what is the definition of the bill of exchange? Now, coming to that, as per section 5, section 4 is promissory note. Section 5 of NA Act 1881, the bills of exchange definition is a bill of exchange is here also same instrument in writing. Instrument in writing. And also, what the purpose for here? Now here, containing an unconditional order. We are ordering unconditional order. We are ordering here. Previously in the promissory note, we have seen unconditional undertaking. But here, bills of exchange, we are going to see unconditional order. An unconditional order, and also signed by the maker. Signed by maker. And next one. What is the reason for the bill of exchange? We are giving a direction. We are directing a certain person. Directing a certain person to pay a certain sum of money. To pay a certain sum of money. So here the maker who is having the liability is not drawing the instrument as in the case of the promissory note, because in case of the promissory note the person who is having liability will draw the promissory note, but in case of bills of exchange, the person who is having liability is not drawing the bills of exchange, but here some other person will draw and he orders that person need to be paid to him. He orders that person need to be paid to him. So certain person to pay certain sum of money. Certain sum of money. What is the requirement? Only to or order of certain person, or to the bearer of the instrument. To the bearer of the instrument who is having the instrument. Further, we will be paying the money. So, to the bearer of the instrument. So, now coming to the bills of exchange, the definition is it is an instrument in writing. It is containing an unconditional order. It should be signed by the maker, directing a certain person to pay a certain sum of money only to or to the order of certain person or to the bearer of the instrument. This is the definition of the bills of exchange. Now, coming to the parties. Who are parties to the bills of exchange? So, three parties are there. Three parties are there, and some cases there can be two parties also. There can be two parties also. What is the case? I'll let you know. Now, coming to the three parties. Who are three parties? Number one. The parties to the bills of exchange are number one, drawee, and payee. So, drawee, and payee. Drawer means nothing but who makes the bill, who makes the instrument. Here the instrument is bill of exchange. Who makes the bills of exchange? Now, drawee. Who pays the bill? Who pays? Means the person who is going to pay the certain sum of money. Who pays money? And now, payee. Who receives the money? Who receives the money? Or otherwise, you can also say that whose name is there in the instrument to pay. Whose name is there in the instrument to pay. So, he is a payee. Three persons are there. Drawer, drawee, and payee. Drawer means who makes the bill of exchange. Drawee means who pays the money, means the person who pays or who is having liability can be called as drawee, and the third party is payee who receives the money. Now, I have said two parties can also be there. What situation two parties can be there? If the drawer is payee, there is a situation that only two parties will be there. If drawer is a payee only, means sometimes the drawer can be the payee. So that's why if the drawer is payee, then in such a situation, only two parties will be there. One is drawer and another party is drawee. Means also the drawee accepted, he becomes the acceptor. After accepting the bill of exchange, he becomes the acceptor. So these are the three parties concerned to the bill of exchange. Now let us see the essentials required for the bill of exchange. Essentials required for bill of exchange. So what are the essentials required for the bill of exchange? Number one, first one, you know, very easy. The first one is almost the instrument need to be in writing mode. The instrument need to be in writing mode. And the second one, it must contain an order, to pay. It must contain an order to pay. Number three, it must be unconditional. It must be unconditional. Number four, yes, the amount must be certain. Means certainty of amount should be there. The amount must be certain. Next, fifth one, signed by the maker. Means who makes the bill of exchange, it need to be signed by the maker. Maker means here in the sense the person who draws the bill of exchange. The person who draws the instrument, draws the bill of exchange. Now next, sixth one, parties must be certain. Parties must be certain. Certainty of parties should be there. The two bona fide persons should be there. Now, it is an order to pay. It is an order to pay, money only, not in any kind. Money only. And next, the last one, delivered to the payee. Delivered to the payee, bearer of the instrument. Delivered to the payee. So, these are the essentials required for the bill of exchange. Now, see. What are the essentials required for the bill of exchange? Number one, writing mode, certain, contain an order. Here we are using the concept containing an order. Writing mode, it should be in writing mode, and we have in this bill of exchange nothing but an unconditional order. We are using the word unconditional, so it must be an unconditional and it is an order to pay certain sum of money. So certainty of amount is required and also signed by the maker, and parties must be certain, and the order to pay in form of money only, and one of the other essentially is delivered to the payee. These are the essentials required for an instrument to become a bill of exchange. Now, coming to the last important thing, that is nothing but section 6. Section 6. So, section 4, promissory note, section 5, bill of exchange, and section 6 is check. Nothing but check. We are going to see in our commercial transactions, many of the checks we are issuing, many of the different modes of checks, how they are crossing, etc. All this concept will be relating to the check. Yes. Now, coming to the definition part of the check. What is the definition of the check? So, simply we can say check is also bill of exchange. Check is also a bill of exchange. Now, but what is the concept here? It is drawn on a specified banker. Means the drawee here is a specified banker. Specified banker, and also not expressed to be payable otherwise than on demand. To be payable otherwise than on demand. So to be payable otherwise than on demand means only check means we have to refer one only payable on demand. And also one more thing, it includes the truncated form of check. It includes the electronic image of a truncated check. Means which is in the clearing house. Truncated check cleared by the clearing house. This is the electronic image of the truncated check. So almost we can see that a check is a bill of exchange drawn on a specified banker. And what is the characteristics of the check? Payable on demand. It is payable on demand, and also it includes here and also it includes the electronic image of a truncated check. Now, who are parties to the bills of exchange then? We know already. Parties, there are three parties on the bills of exchange. Who are the parties? One is drawer, means who is making the bill. Other one is drawee, whom has to pay. And the third party is payee, who is going to receive the amount in the instrument. So these are the three parties in case of a bill of exchange. Now we are saying that check is also a bill of exchange. So how many parties are there? Three parties. The person who draws is called, maker of the bill is called drawer, and drawee here in this case will be always the specified banker only. Means in case of a check, drawee will be always a specified banker only. Drawee will be always a specified banker only, and payee means who is the person named in the instrument. Person named in the instrument as going to receive the amount of money. Who is going to receive the amount of money. So these are the three parties in case of check also. No issue in that. Now, what are the requirements? What are the requirements for becoming a check? Means you can easily say whatever essentials required for the bill of exchange, the same essentials are required for the check also. So no explanation, as further explanation is needed here. Now, coming to the, we have completed the three instruments which as per the definition of the Negotiable Instrument Act under section 13. A Negotiable Instrument Act includes promissory note, bill of exchange and check. Yes, we have seen the three different types of negotiable instrument and also pertaining definitions, who are parties and what are the essentials requirements for the negotiable instrument. So, the introduction part has been completed. Now, we are going to see some other instruments. We are going to see some other instruments which are which need to be discussed at this point of time. So, what are the other instruments? Means somewhat explanation is required relating to the terms which we use in the Negotiable Instrument Act. So, I am going to say you about the terms which we are going to use in the upcoming points. Now, first one in that, bearer instrument and order instrument. What is a bearer instrument and what is an order instrument? Very important case. Now, because in the first class only we have studied negotiable instrument, mere delivery. If it is a bearer instrument, mere delivery is enough. If it is an order instrument, we are going with endorsement as well as delivery. So, that's why we need to know the difference between what is bearer instrument and what is an order instrument. Now, coming to the bearer instrument, what are the features required to become a bearer instrument? Here in this case, name of the payee. Name of the payee. Name of the payee is blank. Is blank means we are not mentioning the name of the payee. Then we can say it as a bearer instrument. For example, if you see a currency note, whether names will be mentioned? No mentioning of the names of the payee. That's why name of the payee is a blank and currency note will almost become a bearer instrument. Currency note is always a bearer instrument. Name of the payee is blank. In the same case, or also if the instrument is specified with words. What are the words specified? Like or bearer, pay to the bearer or like that. If any words such like that, then the instrument will become a bearer instrument. Means the instrument is having the words like or bearer. Next, third one. The last endorsement is blank endorsement. The last endorsement is a blank endorsement. Means the name of the last person holder of the instrument is not known. So that's why it's a blank instrument. And also one more thing, we have already said the bearer instrument is always can be negotiated only by mere delivery. So, if these conditions are satisfied, then we can see that it is a bearer instrument. Means the definition of the bearer instrument means the payee is blank, the name of the payee is blank, and if the instrument contains any words like payable to or bearer like that, or the last endorsement is blank endorsement. The feature of the bearer instrument is only by mere delivery we can negotiate. Now, coming to the order instrument, what are the furthermore required for the order instrument? For the order instrument, it is clearly in the instrument they will mention that payable to specified person. Like in the case of bill of exchange, payable to that specified person can be mentioned, or otherwise payable to order of a specified person. So, if these cases are mentioned, then it can be treated as an order instrument. And also with or without addition of the words, like such, payable to the order of the instrument. Payable to the order or his order. Payable at his order. We can say payable at his order. So, that's why if order is mentioned, then it will become almost order instrument. Now, next one. So, these are the three requirements which the instrument will become an order instrument. And also one more thing, and also it should not prohibit or restrict the transfer. So, these are the things which are required for the order instrument. And I have said already, these instrument will be negotiated by endorsement and delivery. And also the payee which we have indicated should be a reasonable certainty. Means certainty of the payee should be there. This is a order instrument. Now let us once recollect the Bearer instrument and order instrument. What is an order and what is a bearer? Simply bearer instrument means we can find that name of the payee is blank, and if the instrument, if the words like such or bearer is there or lost endorsement is blank, then we can call it as a bearer instrument, means freely transferable instrument, and also it can be transferable or negotiated by mere delivery. Now coming to the order instrument, if any of the words like is order, pay to is order is there, then it will become an order instrument. And also if any words like that, payable to a specified person or payable to order of a specified person is there, then also it becomes a order instrument. And one more thing, it is the instrument will not prohibit or restrict the transfer of the negotiable instruments. These are the basic things of a bearer and order instruments. Now coming to the other form, what is the other type of instruments? Yes, next concept. This is concept number 1 because relating to the instruments. And number 2, demand and time instruments. Demand and time instruments. What are demand instruments and what are time instruments? You already know. Demand instruments we have already seen. One of the demand instruments means payable on demand. It comes from payable on demand. That is nothing but a check is always payable on demand. We have studied. Check is payable always on a demand. Now coming to the payable on demand. Nothing but demand instruments are the instruments which are required to be payable on demand. And next number 2. Means we can see that we are clearly stating that 3 types of negotiable instruments are there: promissory note, bill of exchange and check. We have already stated that check is always payable on demand, means check is demand instrument. Is my statement correct? A check is a demand instrument. Yes, it's absolutely right. Check is always a demand instrument. Now coming to the promissory note and bill of exchange, can they become demand instrument? Yes, they can become, provided what are the things required for promissory note or bill of exchange to become demand instruments is nothing but no time for payment is specified. So there is no time has been mentioned by the instrument in the clearing that no time for payment is specified. Then or express it to be payable. Means on the instrument it is clearly written that on demand you have to pay. On demand, or otherwise we can use a similar terms relating to on demand. Similar terms are nothing but at sight and also on presentation. These are the 3 similar words which we will be using for on demand concept. One is payable and on demand, or otherwise at sight. Careful, because afterwards we may be using after sight also. So payable on demand means at sight, on presentation. These are the 3. If the promissory note contains, then we can say it as an demand instrument. Now coming to the demand instrument, it can be presented at any time before the payment. Means of course it is a reasonable time only, so it can be presented at any time for payment. And also one more important thing, it is nothing but not entitled for any grace days. This question is being asked in the examination. How they asked, really somewhat exciting. How they asked, a check which is payable on, like they have given time, like today is 10th October, 8th October. So today is 8th October, payable on 8th October, and grace days have been included 9, 10, 11. It has been praised on 11th October. It has been presented for 11th October. Now say whether this grace days can be allowed to check, sir. No grace days, because check is a demand instrument, and for demand instrument no grace days are allowed. For 1.5 marks this question has been asked. See how important this topic is then. Little bit small information also. Means you need to know a check is a, first of all, demand instrument. Demand instrument is not entitled for the grace days. So that's why no grace days are possible for the check. Now coming to the time instrument. The other type of instrument is time instrument. Time instrument means what? As like before. So coming to the time instrument. In the instrument time is specified. Means the time means nothing but maturity date.
maturity date is specified in the instrument itself, then it is called as a time instrument. Means what? Time instrument, payable. It can be on a specified day. It can be on a specified day. Means for example, 1st December. The instrument need to be paid on 1st December. Means we are almost specifying a day. Or otherwise after a fixed period. Means what? Like after 3 months from today. Means if we are specifying clearly the time need to be paid by the payee, then by the payer, means nothing but to the payee, then we can say that it is a time instrument. And one more thing, what words we can use for the time instrument, because we have used the words here, express it to be payable on demand, at sight, on presentation. But now coming to here, in the instrument, if it is specified that in the instrument, if it is specified that it is payable after sight, or otherwise on happening of an event which is certain to happen. So if these words are there, then the instrument can be called as time instrument. So I'll repeat again, whenever the instrument specifies the instrument need to be payable on a specific day, or otherwise after a fixed period, or otherwise after sight, or otherwise on happening of an event which is certain to happen. So if all these are mentioned in the instrument, it becomes a time instrument. And one more thing, after maturity date, by reaching the maturity date, the time instrument will become a demand instrument. On reaching the maturity time, the time instrument will become a demand instrument, provided it should meet the maturity date. Now coming to the other topic. So this is the demand and time instrument, and this question is asked in the recent examination. Entitled for the grace days or not? Payable on demand, not entitled for the grace days, but time instruments are entitled for the grace days. No issue in that. Now coming to the point number 3, what is an inland instrument? Important, sometimes the examiner asks whether they will be giving 3 to 4 different cases, and they will be saying that this is drawn on America, this is drawn on India, payable at some other China. So different names they will be mentioning, and you need to point out whether it is an inland instrument or whether it is an foreign instrument. Whether it is an inland instrument or otherwise whether it is a foreign instrument. So now coming to the point, one more thing relating to the foreign instrument, there may be also another question like liabilities of the parties relating to the foreign instruments. Yes, this area also chance of coming in the examination. Now coming to the inland instruments, what can be make an inland instrument? Very easy, sir. The instrument, only 2 things are there. So only 2 things. If any one of the conditions met, then it can be called it as an inland instrument. If any one of the conditions met, then it can be called as an inland instrument. For example, the instrument is drawn or made in India. And also made payable in India. So if these 2 cases happen, means instrument is drawn in India and made payable in India on any person, then we can say that it is an inland instrument. And also one more thing is also there. This is condition number 1. And condition number 2, the instrument can be drawn or made in India, and also drawn upon any person resident in India. So if these things happen, then we can clearly say that it is an inland instrument. Now for the foreign instrument, nothing but a foreign instrument which is not an inland instrument. Means if these conditions does not happen, then we can call it as a foreign instrument. Means the instrument is not drawn in India, then we can clearly say that it is a foreign instrument. And also it is not made payable in India, then foreign instrument. So these are the things. These are the things which are relating to the foreign instrument and an inland instrument. Now coming to that, for example, I'll tell you one thing. For example, if an instrument is drawn outside India, and also one more thing also I'm specifying, drawn on resident outside India, means the person is also staying outside India. And also payable in India. Then it becomes foreign instrument, because drawn outside India, drawn on a person outside India, but payable in India. Then also it becomes foreign instrument. Because major of the conditions have in outside India only. That's why it became a foreign instrument. Now coming to the other concepts. Concept number 5. What is an ambiguous instrument? So this is covered under section 17 of the NI Act. Section 17. What is an ambiguous? Means it is not having clarity which type of instrument it is. Now here in this case, an instrument can be considered either as a promissory note or otherwise as a bills of exchange. So there is no clarity regarding which instrument. There is no clarity. That's why it is called as ambiguous instrument. And also holder has choice to treat it as whether it is a promissory note or bill of exchange. But once it is treated as that, we can't go into another thing. But once it is treated as promissory note, we can't reverse it as a bills of exchange. There is no chance. But only holder has choice, that too only one time. He need to declare whether it is a promissory note or whether it is a bill of exchange. So this is called as ambiguous instrument. And one more thing, I have already said here, the liability questions may be asked on inland foreign instruments. So just I'll make a note for that also. So what is the liability of the parties in case of the foreign instrument? Clearly seen that foreign instrument definition is not an inland instrument. So which is not an inland instrument can be go for a foreign instrument. Now coming to the liabilities of the parties, which is very important part as per the examination point of view concerned. That's why I would like to state here. So in the absence of contract to the contrary, means if the contract contain any other thing, we need to follow any other thing as stated in the contract agreement. But if in agreement or contract there is no such thing relating to the liabilities of the parties, then follow as per the act. The act says, what it says? Liability of the maker or drawer of the foreign instrument is regulated under which country? Regulated by law of place where the instrument is made. So wherever the place, in which place we are making the instrument is made, which place the instrument is made, the law relating to the liability of the maker or drawer shall be applicable. And now coming to the liability of the acceptor, means who accepted the bill. Liability of the acceptor or an endorser can have the liability regulated by the law where the instrument is made payable. Sometimes the instrument is made payable in India, but the parties are outside countries. In such a case, the liability of the acceptor will be according to the place where it is made. The instrument is made payable. This is a concept, and based on this concept, the question may come. Yes, there is a high possibility of chance relating to this. Now, coming to the back, ambiguous instrument. Yes, we have seen what is an ambiguous instrument, completed. Now, there is another important point relating one of the other concept. There is nothing but inchoate instrument. So, what are these inchoate instruments and the legal effects of the same? Inchoate instruments is nothing but incomplete instruments. We can call it as an incomplete instruments. Means the instruments which are incomplete in certain aspects, not all aspects, but only in certain aspects. which are incomplete in certain aspects can be called as incomplete instruments or incoherent instruments. We can call it as an incoherent instrument. Means what happens what happens in this incoherent instruments? The person will be signing, the person who make the bill will be signing and also delivers blank or incomplete, delivers blank or incomplete to whom, sir? To another person, and authorizes, and this person authorizes the other person to fill up, to make it as a complete, instrument. So this is called as incoherent instrument. Means the person will be signing and delivering to the another person in an incomplete pro forma and authorizes that person to complete the instrument. So what are the conditions for becoming an incoherent instrument? Simply the conditions are person signs. Number 2, it is stamped because all the legal formalities have been met for the incoherent instrument, and wholly or partially blank, and the last one is delivers to another person. These are the conditions required for the incoherent instrument. Means the instruments which are in incomplete pro forma will be called as an incoherent instruments. Now, what is the legal effect for the same? Whether they are valid or not. The legal effect is nothing but legal effect for the incoherent instrument is, yes, the holder gets the prima facie authority. Yes, he is having authority. Holder gets the prima facie authority. If the holder can have the instrument for what he can have to make it as complete, complete negotiable instrument, he is having the prima facie authority. So valid. Nothing but we can say this incoherent instrument after becoming complete, they are valid. Now coming to the rights of the parties. What are the rights of the parties for the incoherent instruments? Now, what are the rights of the parties? For suppose a holder is there. This is important from the exam point of view of examination, because sometimes scenario based questions come from this point. Liabilities or rights of the parties. Now coming to the holder, if he is a person is a holder, how much amount he can recover based on the incoherent instrument? Now he cannot recover. Yes, he cannot recover amount intended to be paid by the person. Means whatever the person intending to pay to that another person, not more than the amount. Now coming to the person of holder in due course. Don't worry, the definitions of holder and holder in due course will be dealing with couple of minutes. What is the definition of holder and who can become the holder in due course? Now he can recover the amount. Means the whole amount. He can recover the whole amount, but it should not exceed the amount covered by the stamp affixed. So this is the rights of the parties in case of holder and in case of holder in due course. Means and holder cannot recover more than the amount the person need to be paid, and holder in due course can recover the whole amount provided it should not cross the stamp affixed amount. So these are the things which need to be known for moving into the ahead steps. These are the basic things. An introduction part has been completed. Second part, negotiable instrument part has been completed. And the third part which we need to start is maturity date calculation. Let us verify our material once. So coming to the negotiable instruments, yes, section 13 we have seen, sir. 1 minute. Yes, section 13 we have seen, sir. Means only bill of exchange, promissory note and checks payable either order or bearer. We have already seen what is an order instrument and what is a bearer instrument. Yes. Next, definition of promissory note. We have seen, sir, writing unconditional undertaking. It is a common difference between bill of exchange and promissory note, because in bill of exchange we will be seeing order. Unconditional order will be seen to pay certain sum of money only to certain person, order of certain person, or to the bearer of the instrument. Now, so this is a to pay a certain sum of money only signed by the maker. This all are the definition of the promissory note. Coming to the parties to the promissory note, maker, payee. Yes, we have seen. Essentials, we have already observed each and everything in the essentials. And one more thing, ma, in the promissory note, ikkada promise undalsina avasarame ledhu, sir. There is no requirement that promissory note, in the promissory note, promise word should be there. Without promise word also, it can be a promissory note. It can be a promissory note without the word promise also. And bill of exchange, yes, definition we have seen. This is what I have said, unconditional order. Unconditional order. Certain person or to the order of certain person or to the bearer of the instrument. There is nothing more than, and three parties are there. That's why it is a tri-party agreement. Three parties are there. Sometimes two parties can also be there, but provided the, in that case, drawer is equal to the payee. Drawer is equal to the payee. Drawer can be a payee for that. So these are the drawee becomes acceptor. Yes, after accepting the bill, drawee becomes a accepting. And liability of the drawee is primary and unconditional, and drawer is secondary and unconditional. Secondary and conditional. Payee is the third party who is having the authority to receive the money. And what is meant by check? Yes, we have already seen. Check is also a bill of exchange, specified banker, and not expressed to be payable, otherwise than on demand. That's why it is a demand instrument absolutely. Demand instrument absolutely. There is no case of it is a time instrument. It is demand instrument only. Payable on demand. That's what. Three parties are there. Drawer, drawee, payee. Yes, we have seen. The essentials also simple. Bill of exchange essentials only. Yes, we have seen bearer and order instrument also, no? Yes, lost endorsement is blank, only mere delivery is enough. Coming to the order instrument. Yes, this also have said prohibiting or restricting transfer. This have said last endorsement is full endorsement. Coming to the demand and time instruments. Yes, okay, we have seen this also. Where no time is specified, and payable on demand, except on presentment. This is what the question. A check is always payable on demand. And highlight important thing is the demand instrument is not entitled to any grace days. No grace days is possible to that. No grace days. See here, in a promissory note, footnote, in a promissory note or bill of exchange, the expression except on presentment means on payable on demand only. Means similar terms, nothing but similar terms. They are all similar terms. Payable on demand, except on presentment. Similar words. Because time instrument we are using after sight. After sight we are going to use in time instrument. Next, coming to the other part. Inland instrument and foreign instrument. Yes, we have seen. See, a lot of things can be presented in a table here. See. So, if the instrument is made or drawn in India and the instrument drawn on resident in India, payable in India, it automatically becomes inland instrument. India, drawn on resident in India, but payable outside India. Though payable outside India, the two things happen. Any one of the condition can be met. No, any one of the condition can be met. So, payable instrument drawn in India, definitely it becomes an inland instrument. That's the reason it's an inland instrument. Here also, drawn on resident outside India, no issue. Any of the condition drawn on India is there. So, that's why it's an inland instrument. Drawn on India means if we see the condition number 1, we can go ahead clearly keeping inland instrument. Now, coming here, see here, drawn on India, but what happens? Instrument is payable outside India, resident outside India. Instrument payable outside India, resident outside India. So, that's why it became a foreign instrument. Because payable outside India. This is the thing, reason there. Now, outside India, foreign instrument. There is no option for that. See here, one more thing is the liability of the foreign instrument. I have said, no? Liability. Yes, we can observe here, liability of the parties. Liability of the parties in case of foreign instrument. The liability of the maker or drawer of foreign instrument is raw legated in which the instrument is made and acceptor or endorser by the law of the place where the instrument is made payable. Law of the place where the instrument is made payable. Yes, that's what here the question is. See here, they have bought a question here. A bill of exchange is drawn by A in Berkeley, means outside India, where the rate of interest is 15%. Means Berkeley and the rate of interest is 15% and accepted by B in Washington and the rate is there 6% only. rate of interest is only 6%. Now the bill is endorsed in India, means it has transferred to India and dishonored in India. Now what happens in the light of an act? Answer the following questions. The liability of the A, if an action is brought against A in India. So what is the law applicable to there? The place where liability of the drawer, no? So the place where the bill is drawn. Now coming to the liability of the B, if an action is brought against B in India. Now acceptor, he's an acceptor, in fact acceptor and endorser. So for the acceptor, where the place where the payment has been made, the instrument has been made payable. The instrument has been made payable means in India law relating to India will be applicable to him. So this is the liability of the parties. Inchoate stamped instrument, yes, we have seen, not complete in certain aspects. It should be signed. Sign will be there, stamping will be there, blank or partial, and person's signing shall be delivered to other person. That too to make it complete. So that's why it's a prima facie authority holder will get to make it complete. We have already said holder can recover. Oh yes, we have already said whatever holder in due course means not more than the stamp affixed. Holder cannot recover the amount in excess of amount intended to be paid. So this is about the inchoate instruments and legal effects. So I think this is the concept, and now we are going to start the part 3, that is maturity date and grace days. This part of maturity date and grace days directly sometimes may ask in the examination, like MCQs they may come, because to calculate the maturity date, if this concept comes, it's very easy to you, because calculation, that is payable after 3 months, means we have to calculate, we have to see the calculation methodology, payable 3 months, and then we have to add the grace days and we have to give the answer. So like that, this type of calculations will be asked in the examination. This is a point where the examiner can have the questions from this area, calculation of the maturity date and grace days. Now let's see that. So good evening. We are in part 3 relating to maturity date of negotiable instrument calculation. We have completed 2 parts in Negotiable Instruments Act 1881. One is introduction part and the second one is types of negotiable instruments, and other important related topics also we have covered in the topics. Yes, now we are in the part 3 of our chapter. Coming to this part 3, calculation of maturity date of negotiable instrument. Yes, this is very important, because on this date, on the maturity date only, the payee will receive the amount from the payer. Definitely means we need to notate or have a clear-cut maturity date of the negotiable instrument, means on which date it becomes due. On which date it becomes due. Now come on, see. Means nothing but date on which the negotiable instrument becomes due. Or we can use false due for payment. False due for the payment. So we can use this with also. Means maturity date means nothing but date on which the negotiable instrument becomes due or falls due for the payment. So this is called the maturity date of the negotiable instruments. Now coming to the things. It is nothing but what are the sections concerned as far as this relating to the calculation of the maturity date? Yes, there are 3 sections. Section number 22, 23, 24 deals with calculation of maturity date. So what are these sections here? 22, 23, 24, and why we need to consider these sections in this part particularly. So coming to each of these section, number 1, I have said section number 22. So what is the section number relating to? Nothing but it is relating to the grace days. Previously also we have studied one point relating to grace days. Can anyone remember that point relating to grace days? What we have said? Yes, that's what the thing. So grace days is only applicable to the other bills or other promissory notes, but not to the checks, because it is payable on demand. Means the instruments which are payable on demand, at sight, on presentment will not have any grace days. Means what we can say here, a negotiable instrument which is payable otherwise than on demand. On demand means any of the instruments which are payable on demand, they are not allowed for the grace days. On demand, at sight, or on presentment. So it seems both excite or on presentment is nothing but equal to on demand only. So if any instrument is on demand means grace days are not allowed. Otherwise, if the instrument is not on demand, then on is entitled for a period of 3 days grace. For a period of 3 days grace. For a period of 3 days grace means there will be the other instruments which are not under this category, on presentment, excite, on demand, which are not under this category, definitely they will be allowed for a further period of 3 days grace. For the further period of 3 days grace. But remember, the payment should be made, payment to be made on the 3rd day of the grace. Made on 3rd day, but not on completion of 3 days. But not on completion of 3 days. But the payment to be taken on 3rd day of the grace period. 3rd day of grace period. So, this is the calculation of period of grace. Now, coming to the other point, section number 23. So, section number 22 deals with grace days. Now, coming to section number 23. What is this section saying? Section number 23, nothing but calculation of maturity date. How we need to calculate the maturity date of negotiable instruments. How we need to calculate the maturity date of negotiable instruments. Now, let us see. Suppose the point number 1. If the maturity date falls on a public holiday, then what we need to consider, because it is a public holiday, no peculiar transaction will not be taking place relating to the amount of money in banks, etc. That's why it need to be paid. It need to be paid before the public holiday. Before the public holiday means you can use law terms preceding the business day. Whatever the public holiday is there, preceding that day, preceding business day need to be taken. Preceding business day means on which date the transactions will happen on a business day. If the maturity date is on a public holiday, then what date we need to consider? Before the business day, preceding the business day we need to consider. So, the day of business which is preceding to the holiday, public holiday. Now, coming to the, for example, I can say one more thing. For example, if the maturity date falls due on Sunday, Sunday is a public holiday, right? Sunday is a public holiday. Then we need to keep the maturity date after calculating days of grace on Saturday, because on 3rd day period of grace is Sunday. But as it is Sunday, we need to consider the preceding business day, not succeeding, preceding business day. Then we need to go for the preceding business day, that is nothing but the Saturday. So, if it is falls on a public holiday, we need to consider preceding business day. We need to consider the preceding business day. Now, coming to the second point, if there is any sudden holiday declared, any sudden holiday declared by the central government through a notification, etc., then sudden holiday, we cannot go for the preceding, no. That's why we need to go for the succeeding or next business day. Succeeding or next business day. So, after the business transactions happens, so after the holiday, whatever the next succeeding day is there, on that date, we need to calculate the maturity date. That's the end of the maturity date isms. Now, next, number 3. Any other things are there in calculation of the maturity date? Yes, there are still some more things. That is nothing but how to calculate the maturity date. So, in calculation of maturity date, so calculation of the maturity date, for example, the date on which the promissory note or bill of exchange, is at maturity. If it is made payable at stated number of months after sight or after happening of an event which is bound to happen, or otherwise after date, after sight, after date, or after happening of an event. If it is made payable, then how to calculate that one? Then we need to calculate that nothing but period started shall be held to terminate on the day of the month, which corresponds to the date of the instrument, which corresponds to the date day on which the instrument is presented. On which instrument is presented means what, sir? Means the date of presentment date should correspond with the date of the maturity date if it is payable at stated number of months after sight or after happening of an event or after date. So this is a number 3 calculation of the maturity date, means it should be in corresponding mode. Whatever the date on the presentment of the negotiable instrument, it need to correspond with the date of the maturity. Yes. Next, number 3. Next, number 4. Suppose at stated number of months, then and also accepted for honor. Accepted for honor means stated number of months and accepted for honor. Then we can say simply as the date of acceptance. The date of acceptance, we need to consider the day on which it is accepted will be the maturity date calculation. Will be the maturity date of the calculation on whatever which day we have accepted. From then onwards, we need to calculate the maturity date. Next number 1. Suppose in a month there is no corresponding day which ends on that day. Suppose February only 28 days, but 30th is the date of the maturity. Then this month there is no 30th, no. Then how to calculate? Suppose in a month there is no corresponding day relating to the date of maturity. No corresponding day relating to the date of maturity. Then whatever last day of that month, we need to calculate the date of maturity. Whatever the last day, it will be called as the date of maturity. Now, and one more important point is there, one more important point. I think this can be considered. As section number 24. No issue in that. So this is section number 23, calculation of the maturity date. And now we are going to the third part, that is nothing but the section number 24. This is nothing but we should exclude some days in calculation of maturity date of negotiable instrument. What we need to exclude those days? What are the days which need to be excluded in calculation of the maturity date? Let's see. Suppose the date of promissory note or bill of exchange, it is made payable at a certain number of days, like after a certain event, after sight or after date or certain event. Then what we need to exclude? We need to exclude the date of presentment. We need to exclude the date of presentment or acceptance for sight, etc. Acceptance for sight, etc. So all these dates, the dates on which date the presented date or acceptance for dishonor, etc. So whatever is there, we need to exclude that date also. This is section number 24. So there are three sections relating to the calculation of the maturity date. That is nothing but section 22, 23, 24, calculation of the maturity date. So in calculation, we will take part 3, maturity date of negotiable instrument, date on which the negotiable instrument falls due, nothing but gives for the payment. So what are the sections relating to the calculation of the maturity date? There are 3 sections which corresponds to the calculation of the date of maturity date. Now section number 22, it is nothing but the grace days. It is clear that grace days are not allowed. To some of the instruments which are payable on demand or payable at sight or payable on presentment. So it is clear cut version that grace days will not be allowed for 3 types of the things. That is nothing but a negotiable instrument which is payable on demand, at sight or on presentment. But only it is allowable to other part, means like any other part, the negotiable instrument grace days will be allowed. Now it is entitled for, except these instruments, the other type of instruments are allowed for how many days of grace? It's only 3 days of the grace period. Then which date we need to take the grace period? Then after the calculation of the maturity date, we need to add 3 more days, and on the last day or the third day of the grace period will be called as maturity date. Means the third day. What we need to understand? Actually, suppose the bill of exchange, some date is there after 15 days. So bill of exchange date plus 15 days plus 3 days grace period. 3 days grace period will be taken as maturity date of the bill of exchange. So we need to add the period what they have, for it's only example purpose. For example, after 15 days, the maturity will happen. So, we'll add the 15 days period along with 3 days grace period and we'll show the maturity date. Now, coming to section 23, calculation of maturity date. I didn't write here section. So, section 23, that is nothing but calculation of the maturity date of a negotiable instrument. Now, coming to this calculation of maturity date, suppose if the maturity date falls or due on a public holiday, then we need to take the preceding business day. Means whatever the previous business day is there, corresponding to the public holiday, then we need to take that day. Next, second one, if a sudden holiday is declared, means we can't go to preceding day, that's why the succeeding business day. Now, coming to the calculation of maturity date, it is nothing but the period started, held to terminate. When to terminate that one? On the day of the month, which corresponds to the date on which the instrument is presented. Means on which date it corresponds to present, means that date we need to calculate the maturity date, held to terminate on the day of that month. Now, coming to the next one, if any negotiable instrument is accepted for honor, means then the date of acceptance will be the maturity period. Now, in a month, if no corresponding day is there relating to the maturity date of the negotiable instrument, then the last day of the month will be taken as the maturity date of the negotiable instrument. Now, next, section number 24. This is section number 24 is nothing but yes, exclude. We have to exclude some days in calculation of the maturity days. So, what are the excluding days to be noted? The date of presentment or acceptance, foresight, etc. All those things we need to exclude. We should not count while calculating the maturity date. Now, let's go. So, we can derive a small thing. Now, what are the instruments which are available for the grace days? I am asking the question, instruments which have grace days period. For what instruments we can say that instruments are having the grace days, 3 days of the grace is having. On what days we can say? So, instruments which grace period is allowed. So, we have seen previously when instruments for which no grace period is allowed. That is nothing but on demand, at sight, on presentment. We have seen 3 such things. Now, coming to the reverse of that question, we can say that after sight can I use? If an instrument is payable after sight, will it be allowed to grace period? Yes, it will be allowed to grace period, and also on a specified day. I am mentioning a specified day. On 15th July, you need to pay me the amount. Means 15th July, I am specifying the date. So, that's why 3 days grace period is also allowed in such a case. And also after certain period of time. Means after 3 months, you need to pay to me. Certain period of time. After 3 months, you need to pay me the amount. Then in such a case also, grace days is allowed. Next, on happening of a certain event. Happening of a certain event means if such event happens only, then we need to go for the maturity date calculation, and then 3 days grace period is allowed in that case also. Now, sometimes one more thing is also there. If installments payment is there, for installment last day payment is this much. So, for installments also grace period is allowed. Yes, definitely grace period is allowed for installments. Also, for each and every installment also grace period is allowed. So, this is a instruments where grace period is allowed. Now, coming to the for example, I'll tell you calculation of a maturity date. We'll take one example so that it will be clear for us. Now, coming to the point. So my example is instrument which is prepared on 22nd March 2017. If the instrument is prepared on 22nd March 2017 and payable after 15 days. So, some specified date or after certain period of time I am mentioning. Payable after 15 days. Then it will be due on. So, what you need to add, so for 22nd March 2017, we need to add 15 days, whatever the time mentioned in the instrument, and 3 days grace period, and means the third day of the grace. It will amount to 22nd March 2017 plus 15 days plus 3rd day of the grace. It will be amount to 9th April 2017. 9th April 2017. So this is a calculation of the maturity date. We are taken an example here for calculation payable after these many days. Payable after these many dates. Suppose if this 9th April is Sunday, then what is the due date, sir? The due date will be on 8th April 2017. Now, if this 9th April is a sudden holiday declared by the government, then on which date, sir? It is on 10th April 2017. 10th April 2017. If it is a Sunday or if it is a sudden holiday, it makes a difference. Preceding business day, it is succeeding business day. It is succeeding business day. So this is a calculation of the maturity date. Now, so these are the things considered in the calculation of the maturity date. So part 3 completed for us. Now we are entering into another part, that is nothing but holder and holder in due course. Very important from the examination point of the view, and many questions shall come from this area also. Not only this, just know what we have studied in calculation of the maturity date also. Yes, they may ask directly in MCQs, like giving an instrument and an event happens, and after that event these many days required for the maturity. So but if we need to calculate all those things, just take care while calculating the dates and what is whether this falls on Sunday, on whether it is a national holiday, everything you need to observe, and add 3 days of grace. If the instrument is not related to the exceptional categories, then you can easily find the maturity date calculation. So these are the things relating to. Now coming to the other part number 4, that is nothing but holder and holder in due course. Holder and holder in due course. So what are these two terms, sir? Holder and holder in due course, very important. Holder is a normal person, but holder in due course, if the person is a holder in due course, means some special privileges are allowed for a person holder in due course. For a person holder in due course, some special privileges are allowed. So that's what holder in due course is far better than a holder. Holder in due course is better than holder. In fact, we can say best. Now, first we need to know the definition, what is holder and what is holder in due course. So, holder is given in section number 8 of NA Act, and holder in due course, it is nothing but section number 9. Section number 8 and section number 9. Now, let us see what is holder and what is a holder in due course. Now, holder. Who can become a holder? Very easy. Holder of a negotiable instrument. It means any person who is entitled for the possession. First of all, possession should be there. Possession of the negotiable instrument, that too in his own name. That too in his own name means that person need to have the possession of negotiable instrument in his own name, and also one more thing is that to receive, he has right. He has right to receive or recover. He has right to receive or recover the amount due which is stated on the negotiable instrument, amount due which is stated on negotiable instrument from the parties liable to it. From the parties liable to it. So this is called as a holder of negotiable instrument. That is nothing but number 1, he need to have possession of the negotiable instrument, that too on his own name. Possession of negotiable instrument on his own name, and also the second important criteria is right to receive or recover the amount due which is stated on the negotiable instrument from the parties liable to it, who are required to pay, then he need to recover from them. There is a right is there on him. And also one more thing will be considered. Some questions may be asked like this. They will give some instances of different scenarios, and they will ask you whether this person is a holder or whether this person is a holder in due course. Yes, this type of questions may come in the examination point of view. Who is an holder and who is not a holder in due course. Suppose an agent is there. And principal is there. On behalf of the principal, agent will have the possession of the negotiable instrument. For example, this is an example I am taking, the concept of the agent and principal. I am taking. So agent is there, principal is there. So on behalf of principal, agent has a negotiable instrument. Means as per the definition, holder is there. He is having the possession. No, one of the criteria for the holder is met. Now, and the other persons who are liable will pay, means recovering amount is also eligible. The agent is eligible to recover the amount or to receive the amount also. Now, if these two conditions are satisfied as per the definition of section number 8 in negotiable instrument, can I say agent is holder of negotiable instrument? Because the two things which we have said in section number 8 has been met now here. So, can we say whether agent of the principal will be a holder of a negotiable instrument? Principal is holder means yes, we can absolutely say principal is holder because in his own name also. Now, coming to for the agent, because he is acting on behalf of the principal, can we call agent as a holder of the negotiable instrument? The answer is no. We can't call agent as a holder, because the reason is that agent is not having any right to sue upon the instrument. In case of any dishonor or etc. is not having any right. So we need to observe the rights and liabilities also for considering a person as a holder. So this is a fair example and for the holder of the negotiable instrument. Now coming to the other things, who is a holder in due course? Now we are going to study who is a holder in due course. Now, who is a person of holder in due course? Very, very important. Only 3 criteria are there for the holder in due course. So, let us see what are the 3 criteria for the holder in due course. Very, very important. Section 9. Section 9, because holder in due course will have some privileges which are not available to holder also. Means entitled for some privileges. If a person is holder in due course, yes, he is entitled for some of the privileges, for some privileges which are not even available to holder. So that's why every person wants to become holder in due course rather than holder. Now coming to what are the criteria. So definition, any person for consideration means we are paying in value. In value is there some value we are taking of that instrument. Consideration, for some consideration became. So he became what's if is a bearer instrument, he is having the possession of the instrument. Possession of the instrument if it is a bearer instrument. Now if it is an order instrument, this person is the payee or the endorsee. Don't worry, we'll be getting the terms what is meant by endorsee. Payee or endorsee in the negotiable instrument if it is an order instrument. Means he is the last endorsee. He is the last endorsee for which the amount is payable to him. Means possession of the instrument is there in case of the bearer instrument, and in case of the order instrument he become the payee or the endorsee. Now, and also one more second point. I said 3 points are there. Number 1, for consideration or value, bearer possession of the instrument, and order instrument he must be payee or endorsee. Now coming to the second point, before maturity date of the instrument. In the examination they will give all such like, but they will state that after maturity date the person has received. After maturity date. Then if the examiner asks or specifies if the instrument is received after maturity, then you can say whether he is a holder or holder in due course. Just holder, but not holder in due course, because the instrument is received after maturity date. But what is the criteria for the holder in due course? It should be received before maturity date. Number 3, this is much important. Without having sufficient cause to believe that any defect existed in the title of the instrument, or the person who is having the instrument, who derived the instrument. Means there is no suspicion on the title, or the knowledge of the fact that any defect existed in the title has not been, no doubt, has arisen to this person. No doubt or no knowledge of the fact. And one more thing, if suspicion is there, he need to get and inquire that, get and clarify that. If any suspicion is there to that person particularly, then only he will be holder in due course. But if suspicion is there, but upon good faith he took the instrument, means no, nahi chalta. No, it should not be a holder in due course. So this is a point for the holder in due course. Three important main points which you can know the difference between the holder and the due course. That is nothing but so holder in due course. Number 1, any person for consideration for consideration or value, he need to get that instrument. Means for a bearer instrument, it is just possession of the instrument, and for a order instrument, he must be a payee or the endorsee of the instrument. Payee or the endorsee. Now, one more thing, important thing is before maturity date, he need to get that instrument before maturity date, and also without having sufficient cause to believe that any defect existed in the title of the person who has instrument, that named instrument. So, the defect of the title is not known to the person who is buying in good faith. Means the ultimate essentials, you can draw easily the essentials. What are the essentials required for a person to become a holder in due course? So, what are the essentials? That is nothing but, now just we'll go with the essentials. What are the essentials required for a person to become a holder in due course? Number one is good faith, ma'am. Good faith. If he takes the instrument in a good faith for a value, then definitely he will become the holder in due course. Now let us see. Number one, obtained instrument by value, by paying some value, nothing but we can say it as lawful consideration. Lawful consideration means for a value we are taking the instrument. Now also next one, before maturity. I have already said before maturity he need to receive the instrument. Number three, in good faith and without any negligence. Means good faith should be there, and without any negligence he need to take that instrument. Number one, complete and regular. The instrument, whatever is there, not an inchoate instrument, it should be complete and regular on the face of it. It should be in complete mode. No ambiguity should be there in the instrument. Number five. As a holder, he need to get. Means if it is a bearer instrument, upon possession is enough. If it is an order instrument, he must be payee or the endorsee. These are the 5 essentials which are required for a person to become an holder in due course. Now let us see. Now our thing is that what are the privileges? Which we can get by saying that holder in due course. Now let us see the privileges. Privileges to holder in due course. So what are the privileges available, sir? Why we are stating that holder in due course is such an important thing? Yes, the thing is that for suppose number one, privileges to holder in due course, it is nothing but if an instrument is an inchoate instrument. If the instrument is an inchoate instrument, that is nothing but some pending is there. It is legally valid, but some incomplete is there as far as concerned to the instrument. Now, what is this a privilege which is available to the holder in due course? For example, I'll take one thing for the examples so that you can easily understand how we can go for the same. If it is an inchoate instrument, for example, I'll tell you a small example so that you can easily know what is the things. Now, suppose Mr. A is there and he signs a blank negotiable instrument. And which is stamped. That's only legal instrument. That's why it has become an inchoate instrument. It has to bear stamps, etc. Whatever legal formalities, it complied with all the legal formalities. And the only thing is that it is incomplete instrument. That's all. So it's stamped, and he has given for a sum of rupees 3,000 to Mr. B. For a sum of rupees 3,000 only. Now, Mr. B, what he has done, he fills for only 3,000 is authorized, no? But here he fills for 5,000 and he transferred to other person, Mr. C. Now, coming to Mr. C, for some value he has brought that instrument. Bought that instrument, and also he in good faith he had purchased. Now, say me, B is a holder of negotiable instrument, and Mr. C, can I say that he is a holder in due course? Yes. For value he has bought, for good faith, and whatever all the conditions which are there in a holder in due course, he has complied with. Hence, he will be called as holder in due course. So, what is the amount for 5,000? Instrument is for 5,000 for Mr. C. Now, my question is, as it is an inchoate instrument, he obtained for a value of 5,000 from Mr. B. Then, can Mr. C realize 5,000 of amount or only 3,000 of the amount, as only Mr. A given only a right for 3,000? what we can take. So, if an holder in due course received any inchoate instrument for value, then the amount mentioned on the instrument he can carry with, means 5,000 he is eligible to receive. 5,000 he is eligible to receive. But coming to Mr. B, the holder, though 5,000 is written, is not eligible to 5,000 amount, he is only eligible to 3,000 amount. He is only eligible to 3,000 amount, because it is a difference for the holder and holder in due course. Holder and holder in due course. So, whatever inchoate instrument is there, the holder in due course will get whatever on the face of it amount is there, he can get that amount only, but not the previous restricted amount, So, this is the thing, the privilege available to the inchoate instrument, means the holder in due course can be eligible to get the amount written on the face of the instrument, but the previous person be only allowed to 3,000 only, but not 5,000. This is an important previously asked question. Now, second one. What is the second privilege? And number 2, if an instrument is obtained by like unlawful means, and also for unlawful consideration. Unlawful consideration means unlawful means and unlawful consideration, the instrument is obtained. Then what the holder in due course will have? The holder in due course will have privilege to make that title good. Now, means what we can say, holder in due course has a good title than the previous person has. Because of this unlawful means, the holder of that instrument will not get good title. He's having defective title, but after receiving by the holder in due course, the title got changed and he will be having the good title. And hence he will be eligible to recover the amount what is stated in the whatever amount stated in the instrument. So, this is the privilege for the holder in due course. Next, and the important thing is that he can recover. I use the term the holder in due course will recover the amount, means if the person the person liable to pay the amount can say that the instrument is lost, the instrument is gone away, like that he can't deny that fact, because holder in due course is demanding he need to pay that. No part of exception lies on the part of the person who should pay, on the part of the person who should pay the amount. This is one of the privilege available to the holder in due course. Now, coming to point 3. In case of fictitious bill. Sometimes this is also an important part of area of examination. This and this both asked. The privileges to holder in due course always tested in the examination point of view. Always tested. Like any scenario based question or any case law they will be giving, and they will be asking you to suggest whether the person can derive the amount or not, whether the person can be called as holder in due course or not. Most important, most tested concept, it is nothing but the privileges of the holder in due course. Very, very important. Now, coming to the fictitious bill, means sometimes the bill will be signed by a person whose the person is not available. Means we are drawing a bill of exchange, and it will be signed by a person, there is no authority for this person is there. Means fictitious person name they will be signing. That person will not be available, no? Then how can we recover the amount? So, in case of the fictitious bill, who is the drawer of the bill is liable for the amount of the payment. Means sometimes they can say that this drawer will say other person, that this such person, Mr. P, will pay to Mr. A, but Mr. P will not be there. He is a fictitious person. So, who will be held up? So, then drawer shall be liable for a holder in due course to pay the amount. Yes. Now, coming to the fourth one. What is the fourth benefit or fourth privilege which is available to the holder in due course? If it is an escrow, if it is a relating, if the bill is created for a specified purpose, and holder in due course has that, then the other person can say that no, it is only for the specified person, not for you, not for the specified event, not for you. No, there is no such denying in that case possible, because if though it is an escrow bill, means mentioned for the only for the specified person, if it is in the hands of the holder in due course, that person need to pay. Irrespective of the escrow bill. He need to pay. Means liability arises for even in case of the escrow bill, if that such instrument is there with the holder in due course. Now, next one. Fifth one. Original validity of instrument can't be denied. Original validity of instrument can't be denied. Means whatever validity is there, it can't be denied. No, it's not like that. No, it's not. It is like that. No, it can't be denied. If instrument is there with holder in due course, what is the original validity? The holder in due course will also get the same liability, or original validity only will be available with the holder in due course. So, these are the things. These are the things which are the privileges of the holder in due course. Number one, if it is an inchoate instrument, yes, he will get all the amount whatever written on the face of it, irrespective of the previous transaction. Now, coming to the second one, if it is obtained by unlawful means or unlawful consideration, then yes. So, if the instrument is obtained by unlawful means or unlawful consideration is there, then the holder in due course will get a good title. This is important point. He will get the good title, and also the liability can't be denied. The liability can't be denied by the other person. Can't be denied by the other person saying that instrument is lost. Saying that instrument is lost. It can't be denied by saying such a words, because his liability will be good for the holder in due course. Number 3, fictitious bill. So, if any fictitious bill is there, no, we can't deny that it is a fictitious bill, a fictitious person named. No, we can't deny that. The person who draws the bill will be the liability person. Now, if it is an escrow, bill, then actually means if it is a bill mentioned only for the specific purpose, then if it is the person is in holder in due course such bill, then we need to adhere or to follow that bill. We need to follow that bill. Now, the last one is the original validity of the instrument can't be denied. Original validity. So, whatever the original validity is there, we can't deny the type of that instrument. It is there. The privilege of the same privilege will be also available to the holder in due course. These are the privileges which are available to the person of the holder in due course. Now, next thing. So, we have completed holder in due course, holder. Now, the other thing is next part 5 we are going with. Part 5 is nothing but negotiation and its types. Why negotiation is important in favor of the negotiable instrument? We already said in the first class of this chapter, that is nothing but negotiation means nothing but process of transferring, or we can say that delivery. Process of transferring from one person to another person, or simply we can say that delivery of the instrument. Yes, can I use a statement that without delivery of an instrument, the negotiable instrument validity won't take place? Yes, in fact, we have studied in the first class what are the essentials of the negotiable instrument. It need to be delivered to another person. If it is a bearer instrument, simply mere delivery is enough. If it is an order instrument, the delivery with endorsement need to be taken place. Means only with endorsement and delivery is followed by subsequent delivery, the order instrument gets its validity. Means you can know such a huge importance for the delivery concept. Means delivery of the negotiable instrument is such an important thing, without which the validity of the instrument is not granted. For if it is a bearer instrument, yes, it can be transferred by mere delivery. In the definition only we have learned that. And if it is an order instrument, yes, it need to go with not only delivery but also with endorsement. Means first of all endorsement need to be there, followed by the delivery will be there. So, without delivery, endorsement won't happen. So, means if it is an order instrument, endorsement plus delivery both should happen. Means by seeing this, you can know that importance of delivery is much more thing. One more other thing. Before delivery of the instrument, revocation can be taken. Revocation of the negotiable instrument can be taken. Because once we delivered, the validity comes to the instrument. So, if it is not delivered, means we are having a right to revoke the negotiable instrument. So, this is a thing we can call it as a negotiation. Nothing but it is a process of transferring from one person to another person. Simply we can call it as a delivery of the instrument, and validity won't come into picture without any delivering of the negotiable instrument. Now, delivery is of two types. What are the two types? One is actual delivery, One is actual delivery and the other one is constructive delivery. Constructive delivery. Yes, both are valid only. Actual delivery means directly we are giving to the person who wishes to receive or who is authorized to receive the negotiable instrument. We are directly delivering. Constructive delivery means through an indirect mode we are getting the instrument delivered. Indirect mode we are getting the instrument, means some symbolical representation or any other manner we are making the person to take the delivery. This is called nothing but constructive delivery. Two types of the delivery, both are valid only. Now, one more thing. Suppose whole instrument should be delivered. One of the important criteria is whole instrument will be delivered. Whole instrument will be delivered. But if any delivering part, if part of negotiable instrument is delivered, then we can say it is valid delivery or invalid delivery. Invalid delivery. Invalid delivery. This question, this type of question is asked in examination point of view. Is asked in examination point of view. Means what? Means what? I'll tell you an example what the question has been asked. What might be the question they can test in this manner. Suppose Mr. A draws a promissory note in the name of the B, in the means mentioning B, we need to pay the sum amount to the B and he wishes to deliver the same to B. But what he has done, the promissory note, he has for the purpose of the safety, he has tear down the promissory note into one half and the other half, means half of the promissory note he had delivered, he has through post, he has delivered to Mr. B. But in the meantime, what this person has done, he wished to revoke because it didn't receive to the person. He wished to receive back or revoke. He wished to revoke back the promissory note. He wished to revoke back the promissory note. This fellow demanded for the other part of the promissory note also. Demanded for the other part of the promissory note. Now, tell me whether this can happen or not. Means B is valid or Mr. A's action is valid. What we can say? Number one, by seeing the picture or by seeing the thing, what inference can we draw? Number one, is delivery of the instrument happen? Delivery of the instrument happen because negotiable instrument takes its validity after delivery only. After delivery only. Now, what here they have done? They have teared the promissory note and delivered only half of the promissory note for security purposes. First delivered half of the promissory note. So, part delivery is valid or invalid? Part delivery is invalid. Part delivery is invalid. Means we can say that from this point, we can say that delivery didn't happen. We can say that delivery didn't happen. Delivery didn't happen. Now coming to the other point, whether if delivery didn't happen, whether Mr. A can revoke the transaction or not? Definitely yes. Before delivery only we can revoke the transaction. Means Mr. A can revoke the transaction. Hence Mr. A is correct in revoking the transaction, but Mr. B is not correct in demanding the other part of the promissory note. In demanding the other part of the promissory note. That is a small thing. Next. So this is all about the concept delivery. Now coming to the other important topic, that is nothing but endorsement and its types. So fifth part also we have completed, and now we are moving to the other part, that is nothing but part number 6, endorsement. What is endorsement? Who are the parties of the endorsement, etc. So part number 6, endorsement and its types. Very, very important. These also endorsement and its types. What are the types of endorsement, etc. may be asked in the questions sometimes. Now, we are from starting onwards, we are saying one thing. If it is a order instrument, if it is an order instrument, means payable on demand, etc. on presentment. If it is an order instrument, what is the effect of the order instrument? It need to be endorsed and it need to be delivered. E plus D we are writing. Endorsement and delivery need to be there for an order instrument. Now coming to the type of endorsed delivery, we have already seen. Now what is a type of endorsement? What is meant by endorsement actually? Nothing but endorsement means, this is section number 15 which deals with the endorsement topic of the Negotiable Instruments Act 1881. Now coming to section 15, what is an endorsement? Endorsement means nothing but writing, very, very important, just listen, writing on the back or face of the instrument. Face of the instrument means whatever we are going to write on the back or face of the instrument, what we are going to say? or sometimes on the face of the instrument place is not there. Sometimes on the face of the instrument place is not sufficient because a big list of endorsements are there. Face of the instrument we are not able to write. Then what we will do? Then we will be signing on a slip of paper. On a slip of paper. The slip of paper is nothing but a launch. A launch means we'll pin to the negotiable instrument whatever is there and we'll be signing. So signing on a slip of a paper. So writing on the back or face of the instrument, and if the face of the instrument there is no place, then we'll be attaching a slip of the paper to the negotiable original instrument, that is called nothing but a launch. And the other thing is that by who will write? By maker or holder of the negotiable instrument, maker or holder of the negotiable instrument. So nothing but we can say it as endorsement is the process of transferring rights of an instrument. Process of transferring rights of an instrument is called as a endorsement. Through endorsement we are transferring the rights to the other person. That is nothing but the who will be the other party who will receive that instrument. They will be entitled to some rights. It is called nothing but the endorsement. Now coming to the who are parties to the endorsement. Now parties to the endorsement, there are only two parties. One is endorser and the other person is endorsee. One is endorser and the other person is endorsee. We have already said endorsee. For a holder, we have said that endorsee should be there. Now coming to the endorser, who is the person? The person who endorses the instrument. Who endorses the instrument is called endorser. Now coming to the person who is an endorsee, then the person to whom the instrument is given, to whom the instrument is endorsed, is called endorsee. Means the person who endorses the instrument is called endorser and the person to whom the instrument is endorsed is called the endorsee. Now coming to the essentials, what are the essentials of the valid endorsement? So what are the essentials? What are required? I have said on the face of the paper we need to put the signature. Means we can say that the writing of the instrument need to be there. Instrument should be in writing mode. Number 1, signing should be made. Signed by whom, sir? Signed by endorser. Next, by the holder also. By holder. It must be made by the holder of the instrument. It must be made by the holder of the instrument. Means holder of the instrument need to make an endorsement. Number 4, delivery. Yes, without delivery it won't happen. Negotiable instrument validity won't come. So that's why delivery. And last one is nothing. There's no particular form of endorsement and no particular form. If the paper is not sufficient, means yes, they can annex and any separate another paper for the endorsement process also. There is no separate form like this is the form of the endorsement. There is no like such thing. So on the paper we can endorse the things. So these are the essentials of the valid endorsement. Now can we have a look on what the material can give? Yes. So coming to the maturity date concept, date on which falls due. This is important, which falls due for the payment. Days of grace. How many days are entitled, sir? 3 days, but not to the instruments of on demand, at sight or on presentment. Rules for finding. Public holiday, immediately preceding day, emergency or unforeseen holiday, succeeding business day. Yes. Calculation of the maturity. So period ending is nothing but on the day of the month which corresponds with the date on which the instrument is dated. Yes, means suppose instrument is dated 10th October. Instrument is dated 10th October, 3 months. So from 3 months of 10th October we need to take which corresponds to the date of the instrument. Next, instrument of bill of exchange is payable at stated number of months after sight and has been accepted for handover. The day on which it was so accepted will become the maturity date. Day on which it was so accepted. And next, if there is no corresponding day, means last day of such month. And what we need to exclude, sir? We need to exclude the day of the date or presentment for acceptance or sight or of protest for non-acceptance. So all these days we need to exclude in calculation of the maturity date. Means date of the instrument or presentment for acceptance, means that date, which date we have presented for acceptance, we need to exclude or cite or protest for non-acceptance. These are the dates need to be excluded. Now we already said what are the dates included. No issue in that. We have already seen this also. See here, instruments payable 13 days after happening of an event. Means here what is the thing they have asked? A bill is payable after 7 days from the death of C. So if C died on 22nd March 2017, then bill is payable on 1st April 2017, means 22nd March plus 7 days plus 3rd day. Like this we need to calculate. And suppose after certain months, means payable after 3 months, means for 22nd March 2013 we need to add 3 months date and 3rd day date, and here the bill is prepared for cite on 25th June. That's why we have considered 25th June here, 3 months date and plus 3rd day, means nothing at 28th September will be having the maturity date. We have seen also this also, no issue in that. See here, this what I have said relating to the grace days. Relating to the grace days, a bill of exchange is not mentioned expressly payable on demand. Means payable on demand means no grace period is allowed. No grace period is allowed. But what they have said, the bill will be at maturity for payment on 4th March 2021 if presented on 1st March. So date of presentment on 1st March. So we can include 3 days grace for that? No. This statement is not valid as number of days of grace are allowed in case of bill payable on demand. No grace days are allowed. No grace days are allowed. Holder, I have said, possession of the negotiable instrument, that too in his own name, and also to recover the amount due. Right to receive or recover will be there for him. Right to receive or recover there for him. See here, a person who finds or steals a bearer instrument or takes an instrument under forged endorsement. Under forged endorsement is not a holder. Generally, they will be asking, suppose if a person moving a road, he finds a blank check. Then he will take the blank check and he will forge the amount and he will be presenting in the bank. So can we say that he is a holder? No, he will not be a holder because unlawful means. Holder of negotiable instrument must have right to receive the recovered money thereon from the parties thereto. Now next thing, holder in due course. Holder in due course. I have said for a value he need to take before maturity date only. Maturity date, before maturity date he need to take, and there is no reason to believe that any defect existed in the title of the person from whom he derived his title. That's what, good faith and without negligence he need to be there. Good faith and without negligence. Now coming to the privileges of holder in due course. Yes, inchoate instrument have said to you whatever the amount there, the holder in due course can receive, but the holder cannot receive the amount. Only up to what is the limit the holder can receive. In case of fictitious bill, yes, it's possible. The person liable to cannot contend that instrument was launched or was obtained, means he will get a valid title. He will get a valid title. Conditional instrument or escrow instrument. Prior parties cannot argue that instrument was delivered conditionally or for a special purpose only. No, it's not possible for them. Pay's, see here one more thing is there. Pay's capacity to endorse can't be denied. Means in a suit by a holder in due course, either maker of the promissory note or acceptor of bill of exchange payable to order shall not deny that pay's capacity to endorse the same is not there. Means pay has capacity to endorse the same. Next, negotiation and the types. It's have said already, there is no nothing by that. It is essential for bearer as well as order instruments. Can be actual or constructive. Okay, endorsement. Slip of paper. That is nothing but I have used the word. Yes, I have used the word a launch. A launch. That will be annexed to the negotiable instrument. Nothing but the process of transferring rights in an instrument is called endorsement. Two parties are there, endorser, endorsee. So these are the instruments. And next class we will be seeing about what are the types of the endorsement. Yes, but there are some practical questions which I would like to know now. Practical questions, just we'll have a look so that it will be easy for you also what we have learned till now. So coming to the practical questions, see this is November 20, 4 marks. Means we have to determine whether it is an foreign instrument or whether it is an inland instrument, whether it is a foreign instrument or inland instrument. Section number 11 for the inland instrument and section number 12 for the foreign instrument. Now coming to see, there are only two things whether we can determine as a foreign instrument or inland instrument. First of all, a foreign instrument means not an inland instrument. Very easy this one. Now coming to the inland instrument. What is an inland instrument? Only two conditions. Remember, only two conditions are there for inland instrument. Number one, it need to be drawn or made in India. Made in India. This is the first and foremost condition. Means if the instrument is not made in India, directly we can go for the foreign instrument. So the first one of the condition is drawn or made in India. Drawn or made in India. Number two. What is the other second condition? It is drawn on a person resident India. On a person resident India or otherwise, or one more thing is also there. If it is not there, drawn on a person resident India, if it is not there means payable in India. Payable in India means either this drawn on a person resident in India or payable in India. Any things can happen, but one of the foremost condition is drawn or made in India should happen. Drawn or made in India should happen. Now see, if a bill is drawn in Delhi, directly we can think that it is an inland instrument, but we need to check the other two conditions also, either this or this. See here, upon a merchant in Agra, then person resident in India only, no, though payable in London, two conditions met. So this is an inland instrument. Drawn in Delhi upon merchant in London means this is not, but accepted payable in Agra. Inland instrument means this condition is met and this condition is met. A bill drawn in Delhi upon a merchant in London and accepted payable in London. See here, payable also in London means what is an instrument? Foreign instrument, but not an inland instrument. Now, a bill drawn in London upon a merchant in Agra means a bill drawn in London. First of all, the first condition is not satisfied, that is making the bill outside India. Making the bill outside India. Directly we can go with the foreign instrument. There is no checking of the other two conditions. A bill drawn in Delhi on a merchant in Agra means resident in India means but endorsed in London. No issue. Inland instrument. Inland instrument. A bill drawn in London or foreign instrument because drawn in London. Ram draws a bill of exchange in Delhi upon Shyam, a resident of Jaipur. Means two conditions met. Inland instrument. Ramesh draws a bill of exchange in Mumbai. So Ramesh draws a place of drawing is Mumbai upon a Suresh, a resident of Australia. Means person outside India. Person outside India and accepted to be payable in Chennai, but payment in India no. That's why it is an inland instrument. That's why it is an inland instrument. Number 4. Ajay draws a bill of exchange in California. Means outside we are drawing, no issue. Directly we can say that it is a foreign instrument because outside is the first and foremost condition. Mukesh draws a bill of exchange in Lucknow means India upon a Dinesh, a resident of China and accepted to be payable in China. No issue then. It is also a foreign instrument. It is also a foreign instrument. Very, very easy. If you remember these two conditions what I have said to you means inland instruments means we need to follow two conditions. Number 1, drawn or made in India. Less means N condition is there. What is other condition? Drawn on a person resident in India or otherwise it can happen payable in India. If these two conditions will work out, then we can directly go straight away with inland instrument. For foreign instrument, very easy sir. If it is drawn not in India means directly keep it as a foreign instrument. No need to go for any other additional things. No need to go for any other additional things. That's all, very easy. And yes, see maturity date here, May 2021 RTP. Calculate the date of maturity of bill of exchange drawn on 1st June 2019, payable 120 days after considering the relevant provision. So, means nothing but provision number 22, 23, 24. By referring to the provisions of Negotiable Instrument Act, we need to calculate the maturity date of the negotiable instrument. Now, if it is drawn on 1st June 2019, payable 120 days. 120 days means we need to add 120 days, which is ending on 29 September 2019. 3 days of the grace are to be added. 29 September no, so falls due on 2nd October 2019. But 2nd October is Gandhi Jayanti, which is a public holiday. So that's why we need to go for the preceding business day, that is the bill is due on 1st October 2019. Very easy. Oh my god, see these many bits have been asked in MTPs. But the following persons can be called as holder under the Negotiable Instruments Act. Holder. Very simple. No holder in due course, only holder. X who obtains a check drawn by Y for gift. Yes, for gift, no issue, holder. The payee of the check who is prohibited by court order from receiving the amount. No, right to receive also will be there, no. So, not holder. He is not an holder. Finds a check payable to bearer on the road and retains it. Payable to bearer, bearer check he finds. Unlawful means not a holder. Not a holder. Steals a blank check of A and forges A signature. No, not a holder. Agent of Q is entrusted with an instrument without endorsing by Q. Who is the payee? So agent, no, not a holder, because agent is not having right to sue on his own name. So these are the things. Now, whether holder in due course also they might be testing. See here, one more thing, the privileges. They ask a question regarding privileges, whether this person has this or not. One more thing is there. Fictitious name. Holder in due course privileges. Nothing but privileges of the holder in due course topic. So, X draws a bill on Y but signs it in the fictitious name of Z. So, no person is there Z but he signs on that name. The bill is payable to the order of the Z. Yes. The bill is duly accepted by Y. M obtains the bill from X, thus becoming the holder in due course. Can Y avoid the payment of the bill by saying the fictitious bill? No, it's not possible, sir, because there is the privilege available to the holder in due course. So, we need to write the same. As per section 42, in case of bill of exchange drawn payable to the drawer's order in a fictitious name and endorsed by the same as the drawer's signature, it is not permissible for the acceptor to allege, means to conduct against the holder in due course that such name is a fictitious. No, it's not possible. Therefore, Y cannot avoid the payment by raising the plea that drawer is fictitious in front of the holder in due course. In front of the holder in due course. Next, see, this is also one of the beautiful question. November 2019, 3 marks, this question has been asked. Raman is the payee of an order check. John steals the check and forges Raman's signature. So, forgery is there. Forges Raman's signatures and endorses the check in his own favor. John then further endorses the check to Anil, who takes the check in good faith and for valuable consideration. Means forgery is there. Now, if it is an unlawful means, stealing means okay, sir, holder will get. But forgery won't have the privilege of the holder in due course. Holder in due course, forgery is not applicable. So, forgery confers no title and holder acquires no title to a forged instrument. Means null instrument. That's what. In case of forged instrument, the person claiming under forged instrument cannot acquire the rights of holder in due course even if he is purchased for value in good faith also. Means if he purchased holder in due course means value in good faith only he will be purchasing. Though he will be purchasing forgery instrument, they will not have any privilege. So, he will not acquire any title. See here, one of the nice question. On a bill of exchange for rupees 1 lakh, X acceptance to the bill is forged. Acceptance is forged. A takes the bill from his customer for value and good faith before the bill becomes payable, means before maturity date only. State with reasons whether A can be considered as a holder in due course and whether he can receive the amount of the bill from X or not. Yes, definitely. He can receive, no? Yes, he became the possessor of the bill for value and good faith before the bill becomes payable, but A obtains a forged instrument. The thing is that forged instrument is a thing. So, A can be considered as holder in due course, but A cannot receive the amount on the bill even though he is in holder in due course. Means he cannot receive the amount. Here, two questions are asked. No? Whether A can be considered as holder in due course is the first part of the question. The first part of the question is whether holder in due course applicability yes or no. Yes, he can be holder in due course, but he can't receive the amount because it is a forged instrument. He can't receive the amount. So, these are the two things. Here also forged instrument only, no issue with that. Same, the same is applicable. And one more thing, see here also one more thing is that previous conditions can be applicable to holder in due course or not. See here, Akhil made a promissory note for rupees 4,500 payable to Bhutan and delivered the same to the Bhuvan on condition that Bhuvan will demand payment only on the death of the chairman. So, he has put some condition. Only after the death of that person, he need to have the thing. But before the death of the chairman, Bhuvan endorsed and delivered the promissory note to Deepak. Other one means who received in good faith. Means Deepak is here holder in due course. On the date of maturity, Deepak presented the promissory note for the payment, but Akhil denied for the payment by stating that he issued in the promissory note on the condition that the death of the chairman can now recover the amount or not. Yes, definitely he can recover, sir, because holder in due course have such a privilege that the previous conditions won't get come to him applicable. So, you can see from the above provisions, it can be said that Deepak has received the promissory note in good faith. That's why he is in holder in due course and his rights will not be affected by any condition attached to the instrument by any prior party. Means any prior party conditions won't be limited to the holder in due course. So, that's why he can happily recover the amount. And let's see here one more thing. Inchoate instrument. Blank check he is giving because he don't know amount, how much amount he is there. Inchoate instrument, fraudulently amount larger than the amount payable by Ram and endorses the Chandra in full payment of things owned due. Now states the rights and liabilities of these two persons. Very easy, sir. This is very important. Section 20 provision. where one person signs, look here because I think we may not discuss this one. Section 20, where one person signs and delivers to another person a paper stamped in accordance with the law relating to negotiable instrument, then force India, either wholly, blank, or having written thereon an incomplete negotiable instrument, means inchoate instrument has been transferred, thereby gives prima facie authority to the holder thereof to make or complete as the case may be. Yes, this is what we have studied in inchoate instrument only. The holder will be having the prima facie authority to fill up this one. Yes. Upon it, negotiable instrument for any amount specified therein, not exceeding the amount covered by the stamp, means it should not exceed the amount covered by the stamp. So, the persons of signing shall be liable upon such instrument in the capacity in which he signed the same to any holder in due course for such amount. Shall recover from the person delivering the instrument anything in excess of the amount intended by him to be paid thereunder. See here, Singh can claim the actual amount due from Ram. However, Chandra claims from Ram, then he can claim full amount of the check. Means full amount is possible for the holder in due course person, but inchoate instrument, legal effects, privileges available to holder in due course, we have seen this. Yeah, this one. Sending what I have said, the example I have said to you. He cuts the note in half and posts one half to B. He then changes his mind and calls upon B to return the half of the note which had sent. B requires A to send the other half of the promissory note. Decide what are the rights available. So, the claim of the B to have the other half of the promissory note sent to him is not maintainable because no delivery happened. The reason is that no delivery happened. Now, the first half sent by him, he can change his mind and refuse to send the other half of the promissory note because revocation is possible. Revocation of the note is possible because delivery did not happen. This is what you can write because negotiation, importance of negotiation. Yes, so this is endorsement and we will see tomorrow what is the endorsement and what are the things. So, we have seen the concept of endorsement. Only the introduction part we have completed. Endorsement is nothing but the process of transferring rights. The process of transferring rights. On where we will show the endorsement? Particularly on the face of the instrument or on the back of the instrument, and if so the instrument back or front there is no place for the endorsement, then we'll attach an additional slip to the instrument which is called as an launch, and in that we'll have the endorsement. We'll have the endorsement signed by the holder. This is the process called endorsement. How many parties are there in endorsement? Only two parties. Who are they? Endorser, endorsee are the two parties of the endorsement. And essentials also we have seen. Essentials nothing but sign, delivery, etc. All those things, and there is no particular form of the endorsement. So this is all about the endorsement introduction. Now today we'll go with the types of endorsement. How many types of endorsement are there, and particularly important. One of the topic is important as far as form as concerned for the examination purposes. Now, coming to the endorsement types. Endorsement types. So, nothing but endorsement is nothing but process of transferring rights. Process of transferring rights. So, through endorsement, we will be transferring some rights to the other party. Nothing but. So, it's nothing but negotiation and delivery concept. We are transferring to other party whatever the rights we are having to other party, then it is called as an endorsement. Now, coming to the, yes, endorsement can be particularly of different types. So, what are the types of the endorsement? Number one, blank endorsement. Blank endorsement. Number two, full endorsement. Full endorsement. Blank endorsement, full endorsement, or full endorsement, or otherwise can also be called as special endorsement. Special endorsement. Not only full endorsement. Suppose in the examination they may ask regarding special endorsement. So do not confuse. Nothing but full endorsement is nothing but a special endorsement. Number three, restrictive endorsement. Restrictive endorsement. And number four, restrictive endorsement. Number four, partial endorsement. Partial endorsement. And number five, conditional endorsement. And one more thing I am saying, in the part 5, conditional endorsement, there are still some more things which need to be discussed in conditional endorsement. So, these are the different types of endorsement. I repeat again, the process of transferring rights is called nothing but endorsement. And endorsement, two parties are involved. The party who is going to transfer is called endorsee, and the party who is receiving the instrument is called the endorsee. Endorser, endorsee. Now, coming to the types of endorsement. Number 1, blank endorsement. Number 2, full endorsement or special endorsement. Number 3, restrictive endorsement. Number 4, partial endorsement. And number 5, conditional endorsement. Conditional endorsement, there are 3 to 4 types of conditional endorsements. Now, coming to the first one, blank endorsement. So, coming to the blank endorsement, nothing but if the endorser just keeps his signature, means only the signature is specified but no other thing is specified. Means whom to pay, etc. All those things, or direction of that person to pay. No, all such things are not available. Only the signature of the endorser is available. Only the signature of the endorser. So, if such a case is that, we can call it as a blank endorsement. Means clearly we can say that without specifying the name of the endorsee, there is no specification regarding the details of the endorsee. So, that's why it is called as a blank endorsement. It's called as a blank endorsement. And one more point here to know that, and also as far as concerned from the examination point of view, suppose if an order instrument is there previously, we can now turn it into a blank instrument by this endorsement. Whatever the endorsement we are doing, if it is mentioned in a blank mode, then the order instrument will also become a bearer instrument, nothing but the blank instrument. Yes. Now, second point, full endorsement. Coming to the full endorsement. So, what is this full endorsement? The full endorsement or special endorsement is nothing but we are keeping the signature, means endorser anyway signs, because the endorsement needs some authentication. That is nothing but one of the essential of the endorsement is signature of the endorser. Yes, so it will be valid, no issue in that. But what is here? He specifies, the endorser specifies the name of the endorsee, or otherwise he may also say pay to the order of the endorsee, not only the endorsee's name, or otherwise the order of the endorsee is also available on the negotiable instrument. So, if such a case, then we can call it as an special or full endorsement. Means we are specifying the name of the endorsee, means who can be eligible next to receive the amount. We are specifying the name of the endorsee. It is called as special or full endorsement. Means there is no other change. Means what we are doing here, signing his name, endorser is signing his name, and also specifying the name of the endorser along with the direction to pay, So, this type is called a special endorsement type. And one more point is included here. Other point is a blank endorsement. Can it be converted into special endorsement? Yes, definitely. A blank endorsement can be converted into the special endorsement. By what? By drawing the name of the endorsee, by simply mentioning the name of the endorsee, or otherwise the order of the endorsee, the specified name of the person, providing the order of the specified person. Now, this is the blank or full endorsement. Now, coming to the third one, restrictive endorsement. So, what is this restrictive endorsement, sir? Nothing but it restricts the right to transfer further. It restricts the right of endorsee to further transfer of the instrument. So, there is not possible to again endorse the same. This is called as a restrictive endorsement. So, this is called as a restrictive endorsement. So, in that what will happen? The holder of the instrument cannot make an endorsement to any other party. This is called as restrictive endorsement. Now, coming to the partial endorsement. Actually, it is not valid. Partial endorsement is not valid because only nothing but partial endorsement means nothing but passing only half of the rights. half or some of the rights, only half or some of the rights to the other party. Now passing some or half of the rights is not tenable under law, because if you pass, you need to pass 100% rights. There is no thing that you need to have only, you can avail only these much of rights. No, it's not possible. So that's why partial endorsement is not recognized under Negotiable Instruments Act. No partial endorsements, not valid at law. Now next one. So it cannot have only this amount is eligible. No, it's not possible. Next, conditional endorsement. Now, what is this conditional endorsement? Conditional endorsement means the endorser keeps some conditions or specifications or happening of an event, etc. All those things. So by keeping or imposing some conditions, and after filling up of those conditions, after fulfillment of those conditions, yes, the holder means the endorsee of the instrument, holder or endorsee of the instrument is eligible to receive the payment. Is eligible to receive the payment means endorser's liability will commence upon them. Endorser's liability will commence upon them. So this is a keeping on imposing some conditions, and conditions can be of conditions precedent or conditions subsequent. Any conditions, if we put on negotiable instrument, then only after fulfilling those conditions or meeting those conditions only the liability of the person will start. So this is called as conditional endorsement. So finally we have studied what are the different types of endorsement. Number one, blank endorsement. Blank endorsement means we are not specifying name of the endorsee or any other order of the endorsee. No such things are not provided in the negotiable instrument. Means we are leaving the payee name in blank. So it is called as an blank endorsement. It is called as a blank endorsement, and only just the endorser keeps the signature. That's all. Nothing else in the instrument left. Now coming to the special or full instrument, yes, along with the endorser sign, will specify the name of the endorsee who is going to receive the payment, and also any order of the endorsee, any person to the order of the endorsee. It is called as full or special endorsement, and also blank endorsement can be converted into special endorsement by specifying the details of the endorsee. Now coming to the restrictive endorsement. This restrictive endorsement is nothing but which restricts the right of endorser to further endorsement or further negotiation. Such further negotiation is restricted in case of the restrictive endorsement. Now coming to the partial endorsement means nothing but transfer of only part of the amount of the instrument. Transfer of only part of the amount. Transfer of only part of the instrument. Only part amount of the instrument. So such case is not possible because transferring of part amount of instrument is not valid as per law. Now coming to the other last negotiation, that is nothing but conditional endorsement. In this, the endorser keeps on some conditions to met so that the endorsement is effective only after fulfilling those conditions. Now what are the possibilities how the endorser can keep the conditions? Now let's see what are the possible sequences for the conditional endorsement. Okay, so number one in the conditional endorsement, number one, liability depend upon a contingency. Liability dependent upon a contingency. Contingency means an event. On negotiable instrument, they will specify an event which may happen or may not happen. That event may happen or may not happen. So depending upon the fulfillment of the contingency, then the instrument will takes its validity. Means what? Only after happening of such event, the liability of the endorser arises. Means will commence from this. And if the event is not possible to happen, or it's become impossible, by any other nature, then what will happen? Or otherwise we can also say that conditions not fulfilled. So if any of these things happen, the liability of the endorser is existed. The liability of endorser is removed, means gone away. Then what are the situations if it is impossible to perform the conditions or not possible to happening of an event, or otherwise conditions which are kept on the negotiable instruments are not fulfilled? In these three cases, the liability of the endorser will extinguish. So these are the cases of the contingency. Liability depend upon a contingency. And next number two, what are the other cases of the conditional endorsement? Next, this is a popular one, sans phrase endorsement. sans phrase endorsement. So what is this endorsement? So sans phrase endorsement, nothing but the endorser specifies while transferring. Endorser is the party who transfers the instrument and endorsee is the other party who receives the instrument. Now in this case, what the endorser specifies that? The endorser specifies that the holder should not incur any of the additional expenses, should not incur any expenses on his account, any expenses on his account on this instrument. So there is no possibility to incur any expenses on the instrument. Such a type of endorsement is called sans phrase endorsement. Means the liability is limited only to that amount, no additional expenses to be incurred. No additional expenses to be incurred. Next, number 3. Facultative endorsement. Facultative endorsement. So what is this facultative endorsement? It is nothing but it is a type of endorsement which restricts the liability or which increases the liability. Anything is possible. So nothing but facultative endorsement is nothing but an endorser through express words, abundance, some rights or increases liability. Abandons some rights or increases liability. Any of the thing may happen. Means through words, the endorser says that no, you are not able to, no notice of dishonor is required. Such a case means what? We are abandoning some rights. We are removing or waiving some rights. So through those words, he specifies that by abandoning his rights or he may increase the liability. So this is called as facultative endorsement. This is called as facultative endorsement. Now next number 4. It's very important. Sans recourse endorsement. Sans recourse or otherwise without recourse. Without recourse endorsement. So what is this type of endorsement, sir? Sans recourse endorsement or without recourse endorsement? Nothing but the endorser liability. Endorser will relieve himself from his liability. Endorser will relieve himself from liability. Means what, sir? Means what? By specifying on the instrument that sans recourse, then he will be getting out of from his or discharged from his liability. So if he uses the word sans recourse in the endorsement or without recourse in the endorsement, what will happen? So what is the effect of the instrument? The endorser's liability will be discharged. So these are the 4 types under the conditional endorsement. So conditional endorsement, there are further 4 types of classification. Number one, 1 minute. Okay, so 4 types of endorsement. Number 1, liability dependent upon a contingency. So event may happen or not happen. On happening of the event only, the liability of the endorser arises. Only upon happening of an event or fulfilling of the conditions or otherwise only after non-happening of an event, etc. Whatever the conditions kept by the endorser, if those are fulfilled, means then only the liability of the endorser arises. Now coming to the if things are not happen, means impossible to perform or not possible to happen or conditions not fulfilled, any of the conditions not fulfilled, whether it is condition precedent or whether it is condition subsequent, then liability of the endorser comes to an end. Now next type of endorsement, sans phrase endorsement. In this sans phrase endorsements, the endorser specifies clearly that there is no need to incur any expenses on his account. Such type of endorsement specifying on the negotiable instrument is called sans phrase endorsement. Now coming to the facultative endorsement. So what is this type of endorsement? So it is nothing but the endorser will increase the liability or abandons the rights of the endorsee. Abandons means waives the rights of the endorsee. So in such a case, if this happens, then it is called as facultative endorser. Through express words they will communicate. Means in writing only, no issue in that. Now, sans recourse or without recourse. Coming to the sans recourse or without recourse, the endorser relieve himself from his liability while endorsing to the other party. So relieving himself from the liability is called as sans recourse or without recourse endorsement. So these are the different forms of endorsements. Now coming to the next important topic, that is called nothing but negotiation back. What is the negotiation back formula? Now negotiation back. So what is this negotiation back? It is nothing but, for example, I'll take three parties, P, Q, R, S, T. So I have taken the names of Mr. P, Mr. Q, Mr. R, Mr. S, Mr. T. Now, Mr. P has made an endorsement to Q. Q made an endorsement to R. R made an endorsement to S. S made an endorsement to T. Now, T made the endorsement to P. T made an endorsement to P. Now, say if in the process of the endorsement, if any of the endorser passes, if any of endorser passes the instrument, passes the negotiable instrument to a prior party, it is called as negotiation back. It is called as negotiation back. Means again the story starts where it has started. Again the story has came to and where it has started. So this is called as negotiation back. Now what are the effects? So well and good, negotiation back. So whom to I pass it, and now it came to me only. So I need to pay to myself. Now coming to the effects of this. So what are the effects? Now holder, who is the holder, cannot enforce the payment, against an intermediate party, to whom previously liable. So he cannot make, or he cannot again, no, I want my money, because whom he processed, the intermediary parties whom he transferred, he cannot go and demand the money, that saying that I am liable. No, they have cleared the payment by passing to you, by endorsing to you. That's why. So there is no possibility for the holder cannot enforce the payment from intermediary party who was previously liable. So there is no such chance for the holder of the instrument if it is a negotiation back case. Now coming to that, we know holder in due course can sue all the parties. Now this thing is not applicable here, because why? Above only we have said intermediate parties are not liable to the holder if it is a negotiation back case. Now holder in due course, then he is having a chance as a general rule. What he is having a chance, what is the extra privilege he is having rather than the holder? That is nothing but suing all the prior parties. Now coming to here, there is no such possible case. He can't sue all the prior parties. So these are the things where the effects of the negotiation back. And one more thing, suppose if the holder received a sans recourse endorsement. Now in such a case, holder can sue all prior parties. So if it is a sans recourse endorsement, means yes, he can sue all the prior parties. This is the things or the legal effects of the negotiation back. So completed. We have done with negotiation and its types, endorsement and its types. Now 6 parts we have completed in the Negotiable Instruments Act. Now coming to the next important part topic. And one more thing, I would like to say one practical question relating to this one. Endorsement type. We'll go with that and we'll move next for the next topic. See, yesterday we have missed one more concept, that is nothing but question number 17. It's also one of the holder in due course concept. Just please, we'll have a small look into that. So, X was the holder of a check for rupees 10,000 payable to a bearer. He kept the check in his safe, so he didn't have any negotiation to any other party. But why? A thief stolen the check from X's safe. So, a thief has stolen the instrument. Can this be considered as negotiation of check by X to Y? It will be considered as negotiation. Huh? No, because unlawful or illegal means. Unlawful means he has obtained the check. So, if any person obtained the check on unlawful means, it cannot be said that negotiation and delivery has been done. Has not been done. Now, if Y delivers the check to Z for a consideration and Z receives the same in good faith before its maturity, then what are the rights available to Z? Now, means this Y person who is having a defective title, passed this check to Mr. Z. Now, Mr. Z, he received in good faith before maturity and for consideration, etc. So, holder in due course is applicable to Mr. Z or not? Yes, if he satisfied all the conditions or all the essentials relating to holder in due course, yes, Mr. Z can avail as a title of the holder in due course. Now, What is the thing? What are the rights available to Z? Whether he can have the check of 10,000 rupees payable to him or not. That is a straight away question. Now see, so finder of NI instrument or thief or NI cannot become holder of the instrument since the instrument is not being validly delivered. This is point number 1. If such instrument is negotiated to holder in due course, prior parties cannot argue that the instrument was delivered conditionally or for a specified purpose, because these are the privileges which are available to holder in due course. Privileges available to holder in due course. So in the given case, X has kept the check in his safe, X not delivered the check. Now, there is no negotiation. First point is whether there is any negotiation between X and Y. There is no negotiation because Y obtained through illegal means. Illegal means. Now, it may be also noted that if Y delivers a check for some consideration to Z who receives him in good faith before maturity, Z will become the holder in due course and will be entitled to receive the amount from the instrument. Will be entitled to receive the amount from the instrument. That's what the privilege available to holder in due course. So, this is one of the fine question of the holder in due course concept. Yesterday, we have covered this also. Question number 18, we have seen now. Half of the promissory note cuts the note. Yes, we have seen. Yes, this is question number 19C, December 21, pre-match it has been given. Wonderful question is also. See, what is the thing here? What is the thing here? An important point needs to be discussed before the going into the question. Important point. What is that important point? The important point or the topic relating to the examination point of view, the question asked is nothing but cancellation of endorsement. Cancellation of endorsement under section 40. Under section 40. So, what is this? What is this cancellation of the endorsement? That is nothing but very, very important. Just listen. So, cancellation of the endorsement under section 40. So, what is this, sir? So, if holder of a negotiable instrument, if holder of a negotiable instrument. So, we are having the negotiable instrument position and we are holder. Now, what he does? He destroys or impairs, destroys or impairs the, what he destroys or impairs, endorses remedy against a prior party, So, means he is disturbing the liability of remedy which is available to the endorser against the prior parties with consent or without consent, that is without consent. Without consent. So, if the holder of a negotiable instrument destroys or impairs the endorser's remedy against a prior party without consent of the endorsers, then what is the effect, sir? The endorser, the effect is nothing but endorser is discharged from the liability of instrument. Discharged from the liability of instrument to the holder to how much amount, sir? How much amount? To the same extent, which has been paid at the time of the maturity. So, this is to the same extent, if at the time of maturity, what amount he would be having paid, that amount would be deemed to be cleared. If what? If he, if the holder of the instrument destroys or impairs any of the right remedy available to the endorser. Right, or remedy available to the endorser without the endorser's consent, then we can say that endorser is discharged from the liability of the instrument to the holder at what amount? To the same extent which would have been paid at the time of extent of the maturity. So, this is a section 40 important concept, and based on this concept the question is asked. Let's see the question. A is the holder of a bill of exchange and made payable to the order of the B. So, to the order of the B. A is the holder. He is the holder of a bill of exchange and it is made payable to the order of the B. The bill of exchange contains the following endorsements in the blank. First endorsement B, second endorsement C, third endorsement D, fourth endorsement E. So, this is the negotiable instruments order, endorsements order has been given. Now, A, the holder of the instrument, what he has done, sir? A strikes out without E's consent, means endorser. He is the endorser, no previous one, because A is the endorsee now. A is the endorsee now because he received, holder means he received the instrument. So, from whom, sir? From E, he has received the instrument. Now, without the consent from the endorser E, strikes out the endorsement by C and D. So, he striked out the prior parties. The prior parties strike has been made without the endorser consent. Now what will happen, sir? Decide with reasons whether A is entitled to recover anything from he. So he can recover anything from he ante. This is not possible. Discharged. The simple is discharged as per section 40. As per section 40. Now let us see the answer. So according to section 40, where the holder of negotiable instrument without the consent of the endorser, destroys or impairs the endorser's remedy against a prior party, the endorser is discharged from liability to the holder to the same extent as if the instrument has been paid at the maturity. Any party liable on the instrument may be discharged by the intentional cancellation of his signature by the holder. So, any signature has been cancelled intentionally, then the other party will be discharged. Simple. So, we should not get into the other party striking out, or we should not make anything in the prior endorsements. Now, in the question, see, it has been made. The reason being that between D and E, D is the principal debtor, E is the surety. If D is released by the holder, so based on the surety's concept, if D is released by the holder under section 39 of that, E being surety will be getting discharged. Hence, when the holder without consent of the endorser impairs the endorser's remedy against a prior party, the endorser is discharged from the liability to the holder. That's what, no? Because if the principal debtor is only relieved from the liability, automatically the surety also gets discharged. Thus, if A strikes out without E's consent, the endorsement by C and D, E will also be discharged. Very smart answer. Sans recourse also some thing is there here. Okay. So here one more thing is also asked in December 2021 3 marks. See here, A is the payee holder of bill of exchange. He endorses it in blank. So blank endorsement and delivers it to B. So now A is transferring a blank endorsement to B. B endorses it in full. So can blank be converted into full? Yes sir, no issue. Now B endorsed it to C. This is full endorsement and this is blank endorsement. With C without endorsement transfers the bill to D. So directly only without any endorsement he will transfer the bill to D. State giving reasons whether D is the bearer of the bill of exchange is entitled to recover the payment from A. Sir, once it is, first of all, a blank instrument can be converted into the full instrument. There is no issue. There is no issue. Full instrument we can convert. Now, if it is transferred without any specifying any endorsement like blank mode, can it be made or not? That is the question. Now, see the answer. According to section 49, if an endorsement in a blank is followed by an endorsement in full, the instrument still remains payable to the bearer. That is, the nature of the bearer will not be affected and negotiable by delivery against all the prior parties to the endorser in full. So, the endorser is full only liable to the holder who acquired directly through the endorsement and a person deriving title through such holder. Because and without endorsement also bearer check can be passed. Endorsement is not required. For order, endorsement and delivery need to be required. For bearer, only delivery is required. So what he has done, delivery has been done. Now, as a bearer instrument, as a holder of the bearer instrument, can D claim from A means, yes, D is the bearer of the instrument and can receive the payment or sue the drawer, acceptor or A who endorsed the bill. Nice, very smart answer this also. Now, so to this, we have covered. So 21 questions. Okay, fine. Now, coming to the other important concept that is nothing but the crossing of the checks, part number 7. Now we are in the part number 7. Totally I have said 7 parts. We are now came into the part number 7, that is nothing but crossing of the checks. Crossing of the checks. So what is this crossing of the checks? We are in practical situation, we are very familiar with this. In practical situations, we use many different types of crossings and we may receive different type of crossed checks. So what is this crossing of the checks? Why it is necessary? Generally, if you open a bank account, we will be receiving a checkbook. We'll be receiving a checkbook, right? We'll be receiving a checkbook. Any banks are immediately providing the checkbook at the request of the holder, bank holder, at the request of the holder of the account holder we can call simply. Now, in the checkbook, if we transfer the check to any other person, then what will happen, sir? There are two modes, open check you can transfer or otherwise crossed check you can transfer. Open check or crossed check you can transfer. Now, what is open check, sir? Nothing but open check means it will be paid at the counter of the bank. So, if you present the check to the bank over the counter, they will pay you the money. If you give them the check, they will pay the money. This is called as open check, means counter of the bank. They will pay the money. Now, coming to the crossed check, there is no counter. No counter for the cross check. It need to be paid only. It need to be paid through only banking channel. It need to be paid only through the banking channel. So these are the open and cross checks. Open and cross checks. Now why? Our thing is why crossing is necessary. Why crossing of the check is necessary. So in order to actually there are many cyber crimes, not only the normal crimes, cyber crimes are also raising actually. But previously in the olden days, if any wrong person went to the counter of the bank and he collected the money instead of the original person, means we could not able to trace the original person. We could not able to trace that person who has collected the money. Now that's why it is to keep a check on the, to keep a stop on the open check, cross checks has been kept. Means the safety of the check has been increased. Safety of check has been increased. Safety, account payments, we can easily trace out who received our amount. We can easily trace out. So the safety of the check has been increased a lot by crossing a check. How we can cross? Generally, if it is a check, you can have a check number here, check number, MICR code, and pay to the, like this person's name, order, or any other person. Here account number will be getting, signature will be doing here. Now on the piece of the check, if any two parallel lines have been crossed, any two parallel lines, not only here, generally it's usual for us to cross at the left hand side top, but on the face of check, anywhere you can have two parallel transfer lines, anywhere you can have, no issue in that. So anywhere we can have the transverse lines. So if any transverse lines are found on the check, means what it is clearly indicating, it is an instruction. It is an instruction to the paying bank. Instruction to the paying bank that what is the instruction, sir, from the drawer, that this check need to be paid only through the banking channel, but not on over the counter basis. Over the counter basis, no counter check, not is an open check, it is a cross check. That's why you need to pay only to the banking channel and not to the counter mode. This is the warning, nothing but indication of the person to pay only to the account holder of a bank, but not to any other person without having any account in your bank, or any other bank code. No issue in that. So this is a case where the crossing of the check is done. Now coming to the question I would like to ask is, by crossing of a check, negotiability of the check may lost or not? Negotiability of a check may lost or not? No. The answer is no. Because crossing of a check does not restrict the transferability of check. Transferability or negotiability of check. It can be passed on to somewhere also. Negotiability of the negotiable instrument. One more thing. Crossing is only available to check. Not all the negotiable instruments only available to check. The promissory note, the bill of exchange are not having an option of crossing. They not have any option of crossing. The crossing option is only available to check. That's one of the negotiable instrument. So that's why I have used here negotiable instrument, but it is not applicable to promissory note or bill of exchange. Only it is applicable to the check, sir. That's all. Now, coming to that, various types of the crossing. The next concept is nothing but various types of the crossing. So what are the various types of the crossing available? Various types of the crossing available in our banking channel. Yes, different types of crossing are available. Now coming to the various types of the crossing. Number one, general crossing. So what is this general crossing? Number two, special crossing. Number three, account payee crossing. And number four, account payee crossing. Number four, not negotiable crossing. So general crossing, special crossing, account payee crossing, and not negotiable crossing. So what are these? First of all, what is the general crossing? Okay, so coming to the general crossing, it's very easy. Nothing but a check is said to be have a general crossing if on the face of the check, two transverse lines are placed anywhere. Two transverse lines are placed anywhere on the check. If two transverse lines are placed anywhere on the check, it is called as general crossing, and it may contain with or without addition of the words. With or without addition of the words. So, what are the addition of the words? Nothing but it may have the words like N company, or in short form N company, not negotiable, End company and not negotiable, or simply and company and not negotiable. All the words. If it may contain these words or it may not contain these words, anything. But if any transverse lines with or without addition of these words is placed on the face of the check, then we can be calling it as a general crossing. We'll be calling it as a general crossing. Now coming to the special crossing. So, what is the purpose? What is the purpose of this general crossing actually? Is there any indication? Nothing but the indication is nothing but check should not be. The indication is nothing but check should not be presented over the counter. Simple instruction. Presented over the counter basis. No. And not to counter basis, and only to the banker. Pay the amount to the banker. This is the instruction given by the endorser who passes if he is having two transverse lines on the face of the check. One is number one, not to be presented over the counter basis. No, if he has a crossed check and he presents to the over the counter basis, no, it's not acceptable. The banker should not make the payment. If he makes the payment, then it will be banker's liability. It will be upon banker's liability if he makes a payment of a crossed check. Now, number two, what is the order given by him? You need to pay only to the banker who presented the check. So, who presented the check, that respective bank only you need to pay, but not to other person. So, these are the two instructions given in case of a general crossing. Now, coming to the special crossing. What is a special crossing then? It is nothing but crossing of specially. Crossing a check specially. Now, what we are including in this special concept? What is the including? It also bears two transverse lines. It also bears two transverse names, but in the transverse lines, what we are indicating? Pay to SBI. Means we are indicating a particular bank. That is called as special crossing. Not to all the banks. We are only indicating that only SBI in any branch, no issue. In any branch, this check can be encashed. But what is the thing? Only in the SBI. So, this is called as a special or particular crossing. Now, what happens in this case? What is the effect of the special crossing? The effect is nothing but it is a direction. Given by drawee bank. So, what he is giving direction, sir? Two ways he is giving direction. One is should not made across the counter, and the second one is to pay amount only to the drawee bank. So, these are the two instructions. The definition is nothing but the two instructions, special crossing instructions. Here, general crossing, you can pay to any banker, no issue. But banking channel is important. But whereas here coming to the special crossing, the particular drawee bank also we are giving. Particular bank which the bank needs to pay. This is called as a special crossing. Now, coming to the account payee or restrictive crossing. This account payee crossing is nothing but account payee means in the transverse lines will be stating that account payee. Means we are adding for a general or special crossing, we are adding this account payee. So, what is this account, sir? Account payee check means the collecting banker is supposed to collect on behalf of the holder, on behalf of the holder. So here, in the case of the account payee check, what we are directing, giving a direction to this means nothing but on the face of the check, two transverse lines are there and with mentioning the words account payee. So what is the effect, sir? What is the direction we are giving? The collecting bank need to collect on behalf of the holder who is mentioned in the payee as in the check. Who is the person mentioned as payee in the check? If the banker collects to any other person other than the payee, then the banker will be having own liability. So this is the case. In the case of account payee check, it is more restrictive in nature. Means the check is only payable to the person named as payee in the check. But not to any other person, that too in the banking channel. Only to the person named in the check. This is called as an account payee check. Now, coming to the other part, that is not negotiable crossing. What is this not negotiable crossing then? Then it requires, if in transverse lines, if it anything mentioned like not negotiable, and it is called as a not negotiable check. What we are dealing with this not negotiable check means a general or special crossing accompanied by these words. Not only in the transverse lines, it can be right in above also. No issue in that. It can write in above also. So if in general crossing or special crossing, if you are using the words not negotiable, means nothing but the negotiation or endorsement is not possible in such type of the instruments. Negotiable is not possible. Nothing but simply we are restricting the transfer of the instrument. So what are the special characteristics of negotiability? The check loses. What are the special characteristics of the negotiability? The check automatically loses. So this is called as the not negotiable crossing. So these are the topics which are included in the types of the crossing: general crossing, special crossing, account payee check, and not negotiable crossing. And next class we will see the payment in due course, rights and liabilities of the parties, etc. So good evening all. Till now we have completed the different types of crossing of checks. Yes, we have seen. Now we are going into another new topic, that is nothing but negotiable instrument, payment in due course. What is meant by payment in due course? And this is a thing, important concept, where if the banker has done the payment with payment in due course, then his liability can't be there. So this is such a type of special privilege added to the banks, provided if they had paid or cleared the payment in the procedure according to the payment in due course. Let's see what is a payment in due course. Now, coming to the payment in due course, section 10. So what makes us that this is the correct type of payment? What are the essentials basically required for a banker to have a payment in due course? Now let us see the essentials. Number 1, payment is done according to the apparent tenor of the instrument. Apparent tenor of the instrument means what, sir? Apparent tenor of the instrument means what? Generally, the payment will be made to the payee. That's all. Final. Yes, payment will be made to the payee, or sometimes payer may order that payment can be done at the order of payee also. Means whatever the direction given by the payee, then the banker has to check and they need to process the payment accordingly. Not only banker, anyone. They have to check accordingly that he is the apparent tenor of the instrument. Means what? According to the direction of the payer. We are going to pay the instrument. Now, second thing, that payment is made in good faith. Yes, this is of course important. Like all such type of things, essentials, we have already seen in holder in due course. Yes, the same is applicable here also. Now, we are paying, or we are clearing the instrument, or we are accepting the instrument in a good faith manner. Now, third essential is payment is made without any negligence. Means negligence should not be part of the payment. No more negligence, because the bankers should take utmost care. The bankers, for example, I'm considering bankers here because payment in due course is mostly related with the bankers, because They will suffer liability if any check got wrong payment, etc. Being a banker also. So that's why I'm taking the examples of bankers, but other persons also it's applicable, equally applicable. There's no issue. But for example purpose, I'm taking here bankers. Now coming to the bankers, if they have to take a proper care while making the check payment, particularly because whether it is account pay check or crossed check, specially crossed check, not negotiable check, etc. All these things they have to take consider. They have to check the signatures and they have to check the other party collecting banker details, etc. Whether they are correct or not, then they have to pay. And also one more thing, not only that, yes, the bankers will definitely take care because I have received a check, particularly a 50,000 amount example. I have received a check. Then the bankers from that branch will call, madam, you have received a check of rupees 50,000. Is it for you or not? Or can we pay? Yes. So means they're asking confirmations. If there are huge amounts, the bankers are taking care in such a manner that they are asking confirmations from the party. Yes, need to be paid. Yes, that's what the confirmations means. Negligence should not be there in case of the payment in due course. Next, number 4. Payment is made to the person who is possession of the instrument. Means the instrument should be there with him. Then only the payment can be made. Means possession is important. Not only that, negotiable instrument we have studied. Possession is essential of the negotiable instrument. Now, next, number 5. And also, the payment is made at the circumstances where there is no knowledge of the defects. Means we are not having any suspicion. We are not having anything doubted at the possession of the instrument, or he's a person we need to pay. So there is no reasonable ground. We can also say there is no reasonable ground for believing that he is not entitled to receive the payment. Reasonable ground for believing that he is not entitled to. Means that person payee is not entitled to receive the amount. Means there is no suspicion regarding the person who is going to be benefited through that instrument. There is no suspicion. Next, the other thing is, one more important thing is the payment should be made in terms of money only. 6th one, payment should be made in terms of money only. Yes, these are the things which are required. These are the things which are required for a payment in due course thing. Let's see once again what are the things required for a payment in due course. Means protection can be get by the paying person who is going to honor the instrument. Protection will be getting provided if he has made in payment in due course. So what are the essentials required for the payment in due course? That's given in section 10 of the NI Act. Number 1, first of all, the payment is according to the apparent tenure of the instrument. Means according to the directions given by the payer. According to the directions or specified directions given by the payer. Next thing, payment is made in good faith. Yes, in good faith manner and without negligence. As I have said, utmost care they have to use before paying anything instrument to any other person. Means without negligence the persons should pay. Next, payment will be made to the possession of the instrument. Who is having possession only will be getting the payment. Next, payment while paying there is no reasonable ground for believing that the payee is not entitled to receive any amount. The payee is not entitled to receive any amount. Means we are not having any suspicion towards the payee. Next, last one, payment should be made in terms of money only. No other monetary benefits. No other type of additional benefits in kind, I can say. So only in money only we need to give means in rupees only we need to provide the payment. So these are all the requisites for a valid thing of payment in due course. Now we are going to see what is the protection available to the paying banker. Means here there are two types regarding for a account holder. For a paying bank will be there, and collecting bank will be there. In case of terms of check we are speaking, sir. In terms of check we are going to see these instructions, because payee and payer passes the check to payee and payee will deposit the check in the paying bank. The payee will deposit the check in the paying bank, and the whatever the account the collecting bank the payee has, the paying bank transfers the amount to the collecting bank. Payee bank transfers the amount to the collecting bank. So this is the process concerning. Now if any mistake is made by a paying bank in terms of the passing money to the collecting bank, who is going to be liable? Who is going to be liable? Whom? Generally who? Whether it is payer, because payer has given the instrument, or whether it is paying banker, or whether it is collecting banker. Who is a default? Who has to bear this liability if anything happens gone wrong? If or anything gone wrong or anything happens wrong, who has to face the liability then here? Let's check. So first of all, we will know first what is the protection available to the paying banker. Now coming to the so the topic, protection available to the paying banker. Available to the paying banker. So what is the protection available to him, sir? Paying banker. So the thing is, before that we will see at what cases the paying banker is liable. At what cases the paying banker is liable. So at what cases, sir? Very simple, sir. Very simple. Number one, just now we had seen one topic. What is the topic? Payment in due course. Payment in due course. So if the payment is not made in due course, means what will happen, sir? Definitely the paying banker will be liable. So the first point here is when payment is made out of due course, not in due course, but out of due course, means without having any good fight, not having with negligence and having doubt regarding the accounts holder, everything. If the payment is not done in due course, then we'll be calling it as payment is made in out of due course. In such a case, definitely who will be held liable, sir? Paying banker will be held liable. Now, suppose what are the examples we can take in payment in due course, out of due course? So the examples are suppose if it is a generally crossed check, if it is a generally crossed check, what happens? The paying banker paid to a person other than banker, means he paid, he has cleared the payment, who is not a banker, but it is a crossed check, no? Then how he can pay to a person other than a banker? Means at the counter, how he can pay? He cannot pay the banker. If it is a crossed check, he should not pay at the counter base, because the purpose of crossing is only that only, no? So if the banker has made mistake in paying the banker at the counter of the check, then definitely the paying banker will be liable. Now next thing, if it is a specially crossed check, he paid to other person other than a banker. I mean any person other than a banker. Here also the same mistake has been done. Whether it is a generally crossed check or specially crossed check. Specially crossed means we need to see what is the bank we are paying. Means directly to that bank only we need to pay. That's called a specially crossed check. Now if you are not paying to that banker, we are paying to any person other than a banker. And also it's made nothing but payment out of due course, and hence the paying banker will be liable. Now next thing. And one more thing, suppose the second category, first category is payment out of due course. The second category, if payment of check on which the drawer's signature is forged, then the bank which is paying that check shall be definitely liable. Bank will be liable, particularly the paying bank will be liable. Paying bank will be liable means who has obtained a check in case of the forgery of the instrument, means drawer's signature has been forged and the bank should verify the signature first of all in case of a check paying. So if they didn't have verified, means it's a clear-cut negligence from the Banking Act, and hence we cannot avail protection against the payment. So that's why the paying bank is liable in this case. Now coming to the protection, one is payment out of due course and the second one is the drawer's signature is forged. Here only I have right. Drawer's signature is forged. These are the cases where paying banker is liable. Now coming to the other situation. What is the protection available to the banker? What is the protection available to the paying banker? So what is the protection, sir? It's nothing but what are the cases of getting protection? Now number one, suppose if it is a order check. What is the type of protection? If it is a bearer check, what is the type of protection? If it is a generally crossed check, and if it is a specially crossed check. So in these type of things, how the paying banker is escaped from the liability. What are the situations? What makes the banker not liable to the things? Now, first one, the banker will be discharged for all the cases if the payment is made in due course. If the payment is made in due course. So in following all the essentials, whatever we have studied as per section 10, means by following the payment in due course method, then definitely the banker may have protection regarding order check, bearer check, generally crossed check and specially crossed check. Now coming to the other parts, the protection is even available. The protection is even available when, sir, at what situations? At what situation? If the endorsement subsequently turns out forged. Endorsement subsequently it is forged. Turns out to be a forged instrument, and also the endorsement is made by the payee's agent. Payee's agent without authority. Pays agent without authority. So in these situation also, though the endorsement subsequently forged and also endorsements is made by the pays agent without the authority, then also the protection is available, provided if the banker has made the payment in case of the payment in due course. Now next thing, second thing, this is for the order check, ma'am. This is for the order check, because endorsement forged and pays agent without authority, this is for the order check. Now coming to the bearer check, if it is a bearer check, what is the protection available? If it is a bearer check, here also payment in due course, this is the first basic point I have said. In all these cases, if the payment is made in due course, then automatically the banker gets discharged. And the second case, because it's a bearer check, if it is it is freely transferable from one person to another person, a bearer check is always be bearer. That's why there is nothing else to say in that case. Only payment in due course is enough for that. Now, number three, generally crossed check. Generally crossed check. So here also, but bearer check we have to see who is the apparent holder. Who is the apparent holder of the check? We have to check that and we have to give the check as a banker. Now coming to the general crossed check. The thing is that what is the rule, sir? We have to pay generally crossed check to a banker. It should not be paid at the counter. So it should not made at the counter. Not made at the counter of the bank. So this is one of the thing. This is nothing but payment in due course. If it is made in payment in due course, yes, the generally crossed check also will not have any liability from the banker's side. Now, coming to the specially crossed check. Special crossed check. So here also, some conditions are there. If the conditions have been satisfied, then the paying banker will not have any liability. So, what are the conditions? So, the payment is made to the banker on whom the check is crossed. On whom the check is crossed means what? What is the definition of specially crossed check? We have done accordingly. A banker on whom the check is crossed means specifically they will give the bank to in special case of check like Allahabad Bank or Dina Bank, etc. Whatever the bank they have provided, we have made to the payment of that bank only. So that's why as the definition itself given, we have done accordingly. And also payment in due course. So only these are the two conditions where the paying banker will not have any liability in case if it is made like that. Now, next thing, payment in due course of a crossed check. So what about this crossed check? It is nothing but crossed check means we already know different types of crossing will be there. It's okay. But if it is a crossed check means we should not pay at the counter. And payment in due course has been made. Only these are the two conditions for which a paying banker will not be liable. So once again, just we'll have a look for what we have. We are in the process of the protection available to the paying banker. What is the protection available to the paying banker? And also sometimes in the examination of point of view, this may be important. examination point of view, this may be important. Now, coming to the cases first where payer banker is liable. At what situations the paying banker will be liable? Suppose if it is made out of due course, means not in payment in due course, and also if the drawer's signature is being forged, then these two situations the paying banker will be definitely liable. Now, coming to the protection available to the banker, order check, bearer check, generally crossed, specially crossed. Now, coming to the order check, we need to see for all these things one is common point. This is I have said as a common point here. So one is a common point. One of the common point is nothing but payment is made in due course. So if any of the banks, the first thing they have to satisfy is payment is made in due course. Number 2, as per the requirement of the check, we have to pay. Means like what? Generally cross check only to the banker, specially cross check only to the specified banker, bearer check to the apparent tenor of the instrument. Who is the apparent tenor of the instrument? Next, order check to the person whom they have specified. So, if all these things happen, then the paying banker will not be liable. Now, in the same way, what is the protection available as per the collecting banker? Protection available to the collecting banker. Now, coming to in the case of the collecting banker, collecting banker, what are the protections they may have availed? Means nothing but the collecting banker also need to receive the amount, on behalf of the holder, on behalf of the account holder. Means who is the payee? We have to receive the amount as the agent, to the account holder. Now, let's see what are the essentials. Number 1. Suppose if he has collecting banker has taken these things, what are the essentials? What we have saying these things, the collecting banker will not be liable. Now, what are the things? What are the essentials? Not be liable if even if the instrument is defective. So, if the instrument is found defective afterwards also, the collecting banker will not be liable provided if they have met the essentials. Now, what are the essentials? So, first one, the collecting banker acted as an agent on behalf of its customer. So, yes, definitely, because we are receiving on behalf of a customer, we need to act like as an agent to them. Next, number two. And the collecting banker receives the amount for a crossed check. Definitely for the crossed check only the banker shall receive the amount. So it should be a crossed check. Next, number 3. The check must have been crossed. Before it gets into the collecting banker. Yes, in the bank they should not cross. No, before receiving the check from the customer, the collecting banker, what they will do? The collecting banker will check whether the check is crossed or not. Next number, 4th one. And done in good faith and without negligence. So, if these essentials have been met by the banker who is receiving the payment on behalf of the customer, then definitely the collecting banker will not be liable. So, these are the things we have studied in crossing of the checks. This part 7 has been completed by this, and now we are moving to the part 8. Part 7 has been completed, totally 11 parts I have said, and very easy all those are. Next, number 8, part 8, that is nothing but presentation of the instruments. Now, coming to this part 8, what is this? Presentation of the instruments. Nothing but means clearing. We need to clear the instrument. So we are making our presentation of the instrument. Now, coming first of all, we need to see the parties once again. So drawer, drawee, payee. Suppose they are the 3 parties in case of a bill of exchange. Now, coming the drawer will make the instrument, and the drawee will accept the instrument, and the payee will receive the amount. The drawee, after getting the bill from the drawer, the drawee accepts, and then he becomes the acceptor of the instrument. And he will become payee, receiver of the instrument. There is nothing more. Now, coming to the point, there are 2 things here. Number one, if the drawer feels that the acceptor means the drawee here may not accept the instrument, is afraid of that drawee may not accept the instrument. may not accept the instrument. Now, what will happen, sir, if he does not accept the instrument? The instrument validity will not be there, no? That's why drawer in such a case may specify additional name of another person. Additional name of another person. So, if we are specifying an additional name of another person in the instrument, if the drawee who is stated first in the instrument will not accept it, the second person will accept. So, this is called, the second person who is accepting the instrument is called nothing but drawee in case of need. Drawee in case of need. Now, a doubt comes to you. What is that doubt? Madam, first of all, this person did not accept no. This person has to accept first of all. But here this person does not accept no. Then can we call as a dishonor of the instrument? Because dishonor by non-acceptance is their concept. So can we call the dishonor by non-acceptance? No, it's not possible. Because why? There is another drawee we have mentioned in the instrument. If that drawee also not accept, then it can become the dishonor of the instrument, but not the preliminary non-acceptance of the drawee. Got it? Now, coming to the things, what is the liability for the drawee in case of need? What is the liability? His liability arises only after the bill is dishonored by the drawee or the acceptor. So first of all, if the bill is dishonored, then only his liability will be starting or arising. Now, coming to the other part, I have said just now, dishonor of the bill will not be happen, so dishonor of the bill will not happen if the drawee won't accept. Dishonor of the bill, when it will happen, so generally until it is dishonored by drawee in case of need also. In case of need also, so the preliminary non-acceptance by the drawee will not affect the instrument. In case of drawee in need also did not accept, then it amounts to the dishonor of the bill. Then it amounts to dishonor of the bill. So this is a concept behind drawee in case of need. We have drawn a concept that is nothing but drawee in case of need. Now coming to the same way. Second thing, just now we have said who is the acceptor. Acceptor is nothing but who accepts the bill, and also who accepts the bill and delivers the instrument to the holder. Delivers it to the holder of the instrument. So it is nothing but the acceptance of the bill and delivering the instrument to the holder of the instrument. He is called the acceptor. He is called the acceptor. Sometimes we will be specifying another person called acceptor for honor. Acceptor for honor. So what is this acceptor for honor? Nothing but see here the small terms which differs from drawee in case of need. Now, coming to the acceptance for the honor, if the bill is dishonored, due to the reason is non-acceptance, what shall the holder allow? The holder allow any other person to accept the bill. Because the bill has to be sent, no? That's why bill has to be validated. That's why if the bill is dishonored, the first thing essentially is here acceptance for honor in case the bill is dishonored. What is the reason for dishonor? Non-acceptance of the holder, non-acceptance of the person. Then the holder will allow. What he will allow? Any other person to accept the bill. So this any other person is called acceptor for honor. So the thing differentiates between drawee in case of need and acceptor for honor is drawee in case of need means drawer only will specify the additional person name. But in case of acceptor for honor, the first thing is bill should be dishonored. Number two, any other person shall accept the bill. So this is a case of acceptance for the honor. Now these are the things essential for the presentment of the instrument. Acceptance should be there. Acceptor for honor, drawee in case of honor. Yes, these are the things which need to be dealt in the concept of the presentment of the instrument. This is the thing. Now coming to the next part, part number 9. That is nothing but parties to the negotiable instruments. And when will they get discharged? Very important concept, because discharge of the instrument, yes, parties to the negotiable instrument and when the instrument will get discharged. So because discharge of the instrument makes automatic discharge of the parties. Now parties to the instrument we have already studied for the negotiable instrument like promissory note, bill of exchange and check. We have seen all the parties. We have seen all the parties. Now what is, actually there are two different things here. Discharge. In the discharge can be discharge of negotiable instrument or discharge of the parties. Here discharge of negotiable instrument means it will get discharge of the parties also. Discharge of parties also. But discharge of parties does not mean completely discharge of negotiable instrument. Discharge of negotiable instrument provided if all the parties are discharged. If all parties are discharged, then only negotiable instrument is clear. No, if not all parties are discharged, then we can't say that negotiable instrument is discharged. We cannot say that negotiable instrument is discharged. So these are the things. Now let's see. The first thing, when does negotiable instrument gets discharged? When does negotiable instrument get discharged? What are the situations where negotiable instrument get discharged? There are only 6 type of situations. Very easy. Number one. The first of all is, we have already studied, if any payment has been made in due course. Payment in due course has been made by the payer. Then definitely the negotiable instrument get discharged. Number two. By cancellation. Cancellation means if the holder of the instrument cancels any name of the person or any of the person who is primarily liable, not all the persons, but who is the primary person liable, if he cancels his name or strikes out his name, automatically he get discharged. This person will be discharged, and so the negotiable instrument will be discharged. Number three, by release. By release means we are through any other mode apart from the cancellation. Suppose in an agreement we have taken an agreement and we are dealing that, so you are released from the payment of the instrument. So in that manner also directly the primary liable person will get discharged and automatically amounts to the discharge of the negotiable instrument. Now number four, nothing but by negotiation back. Yes, we have already seen this concept, negotiation back. In the case of the endorsement, we have seen this concept. So, if the case of the negotiation back means in the process of the negotiation, it comes to the party of the drawer only, then we can say that negotiation back is there effective, and negotiation back automatically means nothing but discharge of the instrument. He is the payer, he is the receiver. There's no farak. That's why. Now, number 5. By operation of law. By operation of law. So, when will be the operation of the law, sir? Nothing but if it is a time-barred debt. If it is a time-barred debt, then we can't claim the negotiable instrument. So, this is a case. Now, next thing. Next bill coming into the acceptor hands after maturity. After maturity. So, if the bill is coming to the acceptor's hands after maturity, what is the use, sir? There is no use. It becomes a invalid instrument. So, these are the situations where we can say that negotiable instrument is discharged. Where we can say that negotiable instrument is discharged. So, the things are number 1. So, number 1, negotiable instrument get discharged if the payment is made in due course. By cancellation means we are cancelling the primary liable person's name. We are cancelling the primary liable person's name. If the discharge of primary liable person is made, automatically it gets discharged of the negotiable instrument. By release means through an other than agreement, like other than thing. By cancellation means by type of agreement we can have the negotiable instrument get discharging. Next, so by release means not the thing act done by the cancellation. We are agreement or any other mode. We are releasing the person who is primarily liable. Now, negotiation back is also one of the other concept where we can see the holder receiving the instrument be the drawer or any other person. Now, then it's a negotiation back and the endorsement is made to the person who has started the endorsements. Then also it will be treated as a negotiation back, and the negotiable instrument get discharged by operation of the law. Yes, time-barred debts. If it is a time-barred debt, no, we can't enforce. No enforceability is possible in case of the time-barred debts. Now, next one, bill came to the acceptor hands after maturity. So, all these situations, nothing but the negotiable instrument gets discharged. Now, other case where here parties get discharged. Just now we have seen the negotiable instrument gets discharged, and now we are going to see when does the parties get discharged. when that the parties get discharged. So here all the some of the cases where parties get discharged in the negotiable instrument. Now number one, first one, by allowing drawee, because drawee has to get his acceptance. Now if that acceptance is more than 48 hours, excluding public holidays, so the drawee has taken time for acceptance of more than 48 hours. It is called nothing but delayed acceptance. So if any delayed acceptance is made, then the parties get automatically discharged. Now number two, the holder agreeing for a qualified acceptance or any other limited acceptance means we can clearly see that the event may happen or may not happen, or any contingency is there in case of that event which is certain or uncertain. Then in such a case, if the holder has given his acceptance for a qualified manner, then automatically the parties get discharged further. Now next, number three, non-presentment of check within reasonable time. Yes, definitely the check need to be presented within reasonable time. Now being a check holder, we didn't present the check within a reasonable time to the banker, then what will happen, sir? Definitely it gets bounced or any other thing it may happen. Now whatever the loss suffered, we are not responsible. Because as a party we are discharged. What is the reason? Because of non-presentment of the check within the reasonable time is a what reason for the same. Now next, number four, the easy thing. When this party get discharged, it's a preliminary thing. If payment is made, the primary liable person, who is the person responsible to pay the instrument or honor the instrument, has made the payment, then also the negotiable instrument parties get discharged, and automatically this is equal to negotiable instrument discharge only. Next, number five, release. By release means we are releasing some of the parties in the instrument. We are striking off the names, by striking names or any other mode. We are releasing some of the parties. It also amounts to release of the parties only. Like not only striking names but any other agreement also, or waiving, etc. All this amounts to release of the persons only, parties, we can say. Now cancellation. Yes, if I have made directly cancellation, what I have said here, we have striken off the name of the person, then automatically the subsequent parties also get discharged. Now next, number seven, failure to get notice of dishonor. We didn't go through the topic of the notice of the dishonor, but for time being, just know notice of the dishonor need to be received by some of the persons. If the same is not provided, if the notice of the dishonor is not provided, then such a case will be treating as it as a discharge of the parties to the instrument. Now next thing, important thing, material alteration. Material alteration means if any material alteration, the concept of material alteration will be dealt in few minutes, nothing but. So if a material alteration is made by any of the party, then all the parties who are not consenting to that material alteration, means without our authority or without our consent, they have changed altered some contents of the instrument, then such a case the parties automatically get discharged and the instrument is void. Also. Not only parties get discharged, but also instrument is void. This is the concept of the material alteration. Next, number 9, nothing but operation of the law. So what is the operation of the law? It is a time barred debt. Already we have seen in case of the negotiable instrument, time barred debt, and also the party has become an insolvent, means incompetent person. Insolvent, also we cannot able to collect our debt. So automatically the negotiable instrument gets discharged. So let's see what are the cases where the parties to the negotiable instrument get discharged. So First one, there are different cases here. 9 cases we have seen in case of the parties to be discharged in case of the negotiable instrument. Now, first one, delayed acceptance. I have already said delayed acceptance means more than 48 hours, excluding the public holidays we have taken. Delayed acceptance it will be called, and then in case of a delayed acceptance, the parties get automatically discharged. Now, second one, holder gave a qualified acceptance. Holder gave a qualified acceptance, and also the check has been presented within the check not presented within a reasonable time. Check not presented within a reasonable time. It also, we can see that the parties to the negotiable instrument gets discharged. Number 4, payment is made. This is a normal case where you can easily automatically discharge the negotiable instrument also. Next, number release. By an agreement or waiving off, we are releasing the parties to the negotiable instrument by cancellation or striking of the names. Striking of the names of the parties implies automatically cancelling the parties who are liable, and so the parties get discharged. Failure to get notice of the dishonor, and next number, material alteration. The parties who are not consenting to the alteration get automatically discharged. The parties who are not consenting, I am saying, if the parties consent, then there is no issue of discharge. So, parties who are not consenting to the material alteration, they will be automatically discharged. And next, by the operation of the law. If it is a time barred debt, and also if the party became insolvent. These are all the cases makes the release of the discharge of the negotiable instrument parties. Negotiable instrument parties, very easy. If it is asked straight away as a theory question in the examination, easily you can go with. Because payment, first thing is payment, non-presentment of the check, delayed acceptance, and also the second one is if the holder gave any qualified acceptance, and next, release, cancellation, material alteration, if not consented, operation of the law, and failure to get notice of dishonor. So all these points, if you can specify, definitely marks will be in your pocket. Now, coming to the other concept, that is nothing but, we are in the last concepts. Only 2 concepts have been left for us. That is dishonor of the negotiable instrument, and other concept is material alteration. If these 2 concepts are completed, the Negotiable Instruments Act will be wholly completing. Now let's see our material. Any questions, practical questions left? Because theory I have already discussed it to you, sir. So any practical questions which needs to be discussed as part of the crossing of the checks, etc. We'll have a look. So here see question number 22. Previously asked a 3 marks question. Previously asked a 3 marks question. See here, A signed in his name on a blank check with not negotiable crossing. Means the check should not be negotiated, which he gives to B with an authority to fill up a sum of 3,000 only. But B what has done? 5,000. B then endorsed it to C for a consideration of rupees 5,000, who takes in good faith. This is actually a clear cut. C is nothing but holder in due course. Casual. But in case of not negotiable crossing, holder in due course facility will not be available, because the instrument itself saying that not negotiable. So if it is taken in good faith in the manner of the holder in due course also, the benefits may not be availed. Defective title only he will be having. Defective title only. No better title from the transferor. He won't get better title as in the case of the holder in due course. Now let us see the answer. Examine whether C is entitled to recover the full amount of the instrument from B or A as per the provisions. No, not possible. No. That's what the case. As per section 130, a check marked not negotiable is a transferable instrument. Transferable instrument, we can transfer, but holder will not get holder in due course possibility. The inclusion of the words not negotiable, however, makes a significant difference in transferability of the checks. They cannot be negotiated. The holder of a such check cannot acquire title better than that of the transferor. So this is a reason for which the holder in due course may not have the amount to be claimed. So in the given situation, blank check, not negotiable crossing, but only authorized to fill 3,000, but he filled 5,000. Then endorsed it to C for 5,000. So C is not entitled to recover the full amount from A or B, as C cannot acquire a title better than that of a transferor. But we need to write more. The holder in due concept is not as per the not negotiable case. In the not negotiable case, the privileges which are available to holder in due course will not be applicable in case of a not negotiable check. If that point also presented here, it will be more good. You see here, one more thing is also there here, because MTP asked a question November 2018, 4 marks given. Mr. Muralidharan draw a check payable to Mr. Vyas or order. So it is clearly a order check. Mr. Vyas lost the check and was not aware of the loss of the check. The person who found the check forged the signature of Mr. Vyas and endorsed it to Mr. Parashwant, who has consideration for the goods bought by him from Mr. Parashwant. Means defective title is there for Mr. Vyas. Mr. Vyas, I mean the person who has founder of the check. Here the founder of the check, defective title, founder of the check, because it's Vyas check but lost. That's why. Now Mr. Parashwant is a holder in due course here, and cashed the check on the very same day from the drawee bank. Mr. Vyas intimated the drawee bank about the theft of the check after 3 days. So late intimation. Examine the liability of the drawee bank. So whether drawee bank is liable or not in this case. It's a forged check actually. Forged check actually. But what happened? Mr. Vyas has not made any intimation to the bank to stop the check. That's why let's see what is the provisions need to be considered here. Section 85 need to be taken. Check payable to order. Where a check payable to order purports to be endorsed by or on behalf of the payee, the drawee is discharged if it is made in payment in due course. That's what we have learnt in order, no? Order case, that's what we have learnt. Payment in due course made. Originally expressed to be payable to bearer, the drawee is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement, whether in full or blank, appearing thereon, and notwithstanding any such endorsements purports to restrict or exclude further negotiation. Now, here, what is the thing they have given? Mr. Vyas or order? It was lost. Forged and endorsed it to Mr. Parashwant, who encashed the check. After a few days, is intimated the theft. So, according to the provision of section 85, the drawee banker is discharged when it is made a payment against the check payable to order, when it is purported to be endorsed by or on behalf of the payee. Even though the signature of Mr. Vyas is forged, the banker is protected and discharged. Yes, we have seen such thing also. In forged case, the protection is available to the paying banker. Forged case also, when if the payment is made in due course. If the payment is made in due course, the true owner, Mr. Vyas, cannot recover the money from the drawee bank in this situation. There is no chance for the Vyas to recover the money. But he can, there is one possibility, so here, that is, the possibility is, he can, Mr. Vyas can recover the amount from the person who found the check and forged. Who found the check and forged. Because the question has asked only for the liability of the drawee bank, no remedies available to Mr. Vyas. They didn't ask. If they asked remedies available to Mr. Vyas, then we would have also added additional point that Mr. Vyas can collect the amount from the person who found the check and has forged. That person we can cash. But here the question is limited only to the liability of the drawee bank. That's all. So that's why there is no chance for him to recover the amount. See here, one of the thing here. A promissory note was not made. This is a question relating to material alteration, I think. So we didn't complete the material alteration. We'll see that question after completion of the material alteration topic. It's very easy only. There is no issue in that. This is all about the 138, dishonor of the negotiable instrument. What is the remedy available? We'll see after the concept has been completed. So we are in the last part of the concepts of NI Act 1881. That is nothing but material alteration, and the next part is dishonor of the negotiable instrument. These are the two things which we need to complete. Upon the completion of these two things, the NI Act will be completed. So let's see the material alteration. What is material alteration? So part 10, because we have already divided into 11 parts the entire Act. Part 10, that is nothing but material alteration. Material alteration. So what is this material alteration? Important as far as the examination is concerned, because last May 2022 examination also a question, that too a scenario based question, has been asked from this concept only. May 2022 means recent examination also it got attracted, the concept of the material alteration, a scenario based question. The two, that's a very crux question, and different confusing points have been raised in the particular question. Upon deep insertion or of concentration onto the question, we can get into the answer, because it is very divertive type question. So please be careful such type of questions. Now coming to the concept of material alteration, any negotiable instruments upon drawing of the negotiable instrument, and ending is nothing but presentation of the negotiable instrument. Presentation of the negotiable instrument. So in between drawing period and presentation period, sometimes the negotiable instrument may get altered. Alter means nothing but simply changed. May get changed. Changing means what, sir?
Nothing but any change in the form of the negotiable instrument, in the content of the negotiable instrument, not form particularly, we can say it as a content of the negotiable instrument. Now coming to that change, if it is a immaterial, means not at all important, immaterial alteration, there is no reflecting to the parties or any other thing, there is no issue. Material alteration means it's okay, like chelta, no issue in that. But coming to the material alteration, if it is a material means there is no issue, sir. Coming to the material alteration means, what is meant by material alteration? The material alteration is nothing but if the alteration made changes the legality of the instrument, changes the legal character or legal nature, legality of the instrument, legal character of the negotiable instrument, and also the rights and liabilities of the parties, may get affected. So if such a case, if either the liabilities of the parties to the negotiable instruments got changed, or otherwise the legal character of the negotiable instrument got changed, in the both cases the effect will be calling as material alteration. Both cases the effect will be calling as material alteration, either the legal character change or the rights and liabilities of the negotiable instrument, parties of the negotiable instrument. Then in such a case we'll be calling it as a material alteration. For example, what makes a material alteration? Like example, if we see some of the examples, I'll give you examples of material alteration. So what is a classic example? Suppose if you are a negotiable instrument has been made for an amount of 10,000 rupees. Now you are saying to keep 1 lakh. Then can you say that it's material alteration or not? Definitely yes, because we are changing the amount, change in amount we have made. Or otherwise, date of instrument we are changing the date of instrument, or otherwise place of payment we are changing. All these are the examples of the material alteration. Okay, fine. Now we got understand the term, what is the meaning of the material alteration. Now what the next thing is, what is the effect of material alteration? What is the effect of material alteration? So if any material alteration is made by any of the party in the negotiable instruments, alteration made if by the negotiable instrument parties, then what shall be the effect? Now coming to the effect of material alteration, first of all, first case, the instrument shall become void. This we have seen already in the terminating of the instrument. Hope you remember the scene. While when does the discharge of the negotiable instrument happens? Negotiable instrument discharge. When it happens, sir, automatically if any material alteration is made, one of the last point is that only. If any material alteration has been made, now the instrument shall become void. So the status is nothing but void. It is not valid as per the law. Provided where here parties of the negotiable instrument not consented to the material alteration. Means what, sir? Then another doubt arises for you. What is the doubt? So if parties gave a consent to the material alteration means, can we say that material alteration is valid then? Can we say that material alteration is valid and also the negotiable instrument is also valid? Can we say like that? Yes, definitely. So as the parties given consent for the material alteration, the negotiable instrument is valid and there will be no discharge of the parties. But as far as the above thing is concerned, it shall become void, and here the parties of the negotiable instrument are discharged in this case. The parties of the negotiable instrument are discharged in this case. So this is the effect of the material alteration. So what is the effect, sir? First of all, means it depends upon the consent of the parties. So now coming that it depends upon the consent of the parties. If the parties of the negotiable instrument gave consent for the material alteration, then the negotiable instrument is valid and the parties to the negotiable instrument also won't get discharged. Now coming to the second part, if the parties to the negotiable instrument did not show their consent to the material alteration, the law what is saying, sir? The instrument shall automatically become void and the parties of the negotiable instrument will get discharged from the same. So this is the effect of the material alteration. Now coming to the other concept, there is nothing but material alteration. What are the material alterations authorized under Act? What are the material alterations authorized under an Act? So whether Act authorizes any material alterations? If so, what are they? Just now we are saying the material alterations, if made, are void provided the consent of the parties is not there. Now the Act only authorizes some material alterations. So what are the material alterations authorized by the Act, sir? Number one. So we already studied incoherent instrument means incomplete instrument. Incoherent instrument means what, sir? The instrument is valid because all the things have been done in the instrument, but some particulars are not filled. Means an incomplete instrument. Incomplete instrument is valid as per the law. So that's why if we are making an incomplete instrument into a complete instrument, incoherent instrument into a complete instrument, means what we are doing? Filling the blanks. Complete instrument means filling the blanks of the incoherent instrument. So whatever the pending is there, we have completed the pending in case of the incoherent instrument. In such a case, material alteration is not there. Though we have added some words, or we have indicated some other things in the negotiable instrument, it won't amount to negotiable instrument material alteration because we are making it into a complete one. Next, number two. Conversion of a blank endorsement into full endorsement. So for converting a blank endorsement into full endorsement, we can't say that material alteration is there. It is not a material alteration. Now number three, crossing of the checks. So what is this crossing of checks, sir? It is nothing but crossing of checks we have already studied under section 125 of the Negotiable Instrument Act. So coming to the crossing of checks, if you are previously it's not there, but we are making it a crossing of the checks, so it does not amount to material alteration. Now next one, number four. The fourth part is nothing but so general crossing is there, but we are making into special crossing or account payee crossing. So all these are the material alterations which are authorized by the Act. Means through Act we can see that these are authorized and there will be not amount to any discharge of the instrument. So let's see once again. What are the alterations which are authorized under the Act? Means NI Act. Now coming to the completion of the incoherent instrument, means we are transforming the incoherent instrument into a complete one. So while we are making complete one, we are filling what are the blanks in that, what are the things unfilled in the instrument, we are getting filled. So it does not amount to material alteration. Number two, conversion of a blank endorsement into full endorsement. So the conversion process of the blank endorsement into full endorsement does not amount to material alteration. Next, number three, crossing of the checks. Next, number four, general crossing. It's a general crossing is made, but we are converting it into special crossing or account payee crossing. So this also does not amount to the material alteration. So all these are the material alterations authorized by the Act. Now coming back into the things concerned. Suppose, for example, if rate of interest has been changed. If rate of interest, let's suppose rate of interest is 12% and now we are changing into 8%. Does it amount to material alteration or not? Material alteration. Now I'll tell you another example. Rate of interest is 21%. But we are making it to 18% only. Means which is beneficial to the party. Now can I say that it's a material alteration or not? Because it is beneficial, no? Can I say that's material alteration or not? Definitely it is a material alteration. Means whether it is beneficial or whether it is not beneficial to the other party, it's not not finalized. It's not important. But the thing is that if any alteration is made without consent of the other party, then it will be definitely called as a material alteration. Now, coming to the one of the important thing which in your recent examinations has been asked, that is nothing but the case law they have been asked. Sir, the case law is nothing but Veera Exports versus T Kalavati. Veera Exports versus T Kalavati. This is a case law in 2002 which has been framed, which has been judicial pronouncement given for that. The thing is that nothing but drawer of the check, who is a drawer of the check, has been changed the date of the check. Changed the date of the check. For what, sir? Why will be changing the date of the check, sir? Because to revalidate the check. Because to revalidate the check means the drawer himself has given the check to someone else, but it is not correct date, and hence he wanted to change the date to revalidate the check. Now this revalidation of the check, will it amount to material alteration or not? Revalidation of the check amount to material alteration or not? What the party is saying, it amounts to the material alteration, and so it amounts to the material alteration, and so the negotiable instrument is void, and there is no need to discharge the negotiable instrument, and there is no need to discharge the instrument. This is the thing argued by the drawer. But what happens, what the thing in the case law Veera Exports versus T Kalavati, the pronouncement, judicial pronouncement given by the judiciary is nothing but, sir, drawer of the check has always a option of revalidating the check. Option of revalidating the check. Voluntarily he can do that. No permissions, no consent, etc. not needed. So that's why option of revalidating is always available. To the drawer of the check. Then it does not amount to material alteration, and so the negotiable instrument is valid, and the parties to that are not discharged. This is the question asked in your May 2022 examination. This is one of the tricky point where the students may fail. By seeing the question, all will think that we have to write some about regarding other concepts or like insufficiency of funds, etc. They may got diverted upon seeing the scenario based question like that, but it is not the case. So the question is somewhat tricky point, and the tricky point is this only. So always open to the drawer of the check to revalidate the check. So that's why revalidate the check means nothing but changing the date of the check. So that's why it's not amount to material alteration. Next. So these are the things covered in the concept of the material alteration. That's all. Material alteration topic got completed. Now we are moving into the last part of our topic, that is nothing but part 11, that is dishonor of the negotiable instrument. Very many times asked bids for CMA students also, sir. That is nothing but dishonor of the negotiable instrument can be possible by two types. So what are the cases of the dishonor of the negotiable instrument possible? Number one, by non-acceptance. Number one is non-acceptance. Number two, that is nothing but simply, you guess, that is nothing but non-payment. Yes, if these two are there, then we can say the dishonor of negotiable instrument happen. One is non-acceptance and other cases non-payment. But remember one important thing. Actually, there are three types of the negotiable instrument. What are they, sir? Promissory note, bill of exchange, and check. Promissory note, bill of exchange, and check. Now coming to the non-acceptance category, only bill of exchange is there. Applicable only for bill of exchange, but not promissory note or not check, because it does not require any acceptance. Now coming to the non-payment cases, yes, promissory note can happen, bill of exchange can happen, or check also can happen. All the three negotiable instruments come for the non-payment category, but for non-acceptance category, only one of the negotiable instrument will be there, that is nothing but the bill of exchange, because it requires acceptance. Now coming to the non-acceptance bill of exchange category, what amounts to non-acceptance? What are the things can be considered under non-acceptance category? Now coming to the non-acceptance category, number one, we already seen delayed acceptance. Means acceptance, we have given time already 48 hours. If the acceptor takes more than 48 hours for accepting the negotiable instrument, then automatically it gets discharged. So delayed acceptance. Next, number two, if the drawee gives qualified acceptance. Drawee gives qualified acceptance. Means any conditional acceptance is given by the drawee means and the holder does not accept the same. And the holder does not accept the same. This case also bill of exchange got dishonored. Next, number 3. Drawee cannot be found on reasonable search. Can't be found on reasonable search. Means non-acceptance simply on reasonable search. And the next category is drawee is an incompetent person. Drawee is an incompetent person. So if an incompetent person is not able to perform the contract and so it get discharged, means the negotiable instrument won't be valid. Incompetent person. And next, other case, drawee is a fictitious person. Drawee is a fictitious person, means a person who is not at all there. It is a fictitious person. And next, one more thing. For the instrument, there are more than two drawees, and all of them did not have acceptance to the instrument. All of them did not give the acceptance for the instrument. So this is the case also. We can say that the negotiable instrument get discharged. Now, and also one more thing is a bill of presentment. Means bill of exchange for presentment is excused. Presentment is excused. And the bill is not accepted. So these are the cases. We can say that the dishonor of the negotiable instrument happens to the non-acceptance category. Now, coming to the cases where the bill of exchange or promissory note or check can be dishonored due to non-payment. So, what is the cases dishonored due to non-payment means simply it is nothing but we didn't pay at the time of payment. The holder did not pay. The holder did not receive the amount of the instrument. Now, in case the promissory note means maker. In case the bill of exchange, the acceptor. In case of check, the drawer of the check defaults payment on its presentment. Means the holder did not receive the amount of the money which he is able to get it. Because he is the payee. So that's why these persons defaulted the payment on the presentment. Now, on the payment date they have to pay, but they did not pay. That's what nothing but called as dishonor by non-acceptance of the non-payment of the instrument. Now, coming to the other things. So these are the two cases where we can say that dishonor of the negotiable instrument happens to the non-acceptance category and dishonor of the negotiable instrument happens to the non-payment category. Means the persons who are responsible to pay defaulted the payment. Now, this is the case. Next. So, I'll tell you an example regarding the dishonor of the negotiable instrument. That is, suppose a promissory note has been sent through the post to the other party. But this party refused to receive the post. Now, can we say that dishonor happens or not? Can we say that the instrument is dishonored or not? The negotiable instrument is dishonored or not? Yes, the negotiable instrument is dishonored. Because he didn't receive the post. The act amounted to dishonor of the negotiable instrument. So this is one of the question. Now, coming to the things, notice of dishonor. This is also one of the important concepts. Sometimes may be asked as a theory question also. So, when does notice of dishonor is required? Notice of dishonor is not necessary or not required. Generally, it is required. So, which cases the notice of dishonor is not required? So, what are the cases? Number one, it is nothing but where the party who is entitled dispensed with. Means he is not able to. He already said that I'm not. There is no need to give the notice of dishonor. So that's why if that such statements are made by the party himself, then we can say that there is no notice of dishonor required to send. So this is one of the condition. Now next thing, when is the notice of dishonor not required? So when the drawer of the check made a countermanded payment. Countermanded payment means what, sir? Means what? He himself revoked the check.
he himself revoked the check. So in such a case also, the drawer of the check, if countermanded payment, means that the notice of dishonor is not required. Now next case, we have already submitted sent the notice, but what happened is party entitled to the notice could not be able to find. Party entitled to the notice could not be able to find. We could not able to find the person. Could not able to find the person means we are not able to find the person who is able to receive that one. So if the person is not found out of reasonable search also, there is no meaning to send the notice to him. Hence, notice of dishonor is not required in such a case also. Now, next thing. Now, the person responsible for sending, means otherwise you can say bound to send, the person who bound to send also, the person responsible for sending could not able to send, not at its own default, could not able to send, but not default of him. Not default of him, not means not default of that party who is able to send that notice. Means what? Postal strike is there. He could not able to send the notice of the dishonor. So in such a case also notice of dishonor is not required. Next one. And when the party charged could not suffer for the damage, for want of notice. So really for only notice which is required to send, but the other party didn't send. What happens? Party charged could not suffer. They may not able to bear the expenses for the damage of the want of the notice. This is also one of the situation where we can say that notice is not required at that point of time also. So these are some situations where notice of dishonor is not necessary. Now coming to the other important topic, that is nothing but sometimes we will be able to see these are the many cases which practically occur, and this part is particularly important for the examination point of view. So what is this? Nothing but a check we have issued, but it did not paid, means the check has been dishonored. But what is the reason for the dishonor, sir? It is nothing but insufficiency of the funds. So further, because of the insufficiency of the funds in drawer's account, the check did not be paid. Dishonored. The check has been dishonored, means remain unpaid by the bank. So very important concept, and many questions come from this part only. Means what are the remedies available to the parties, or what is the penalty levied to the parties, etc. will be asking from the examination point of view. Now coming to the case check dishonored due to insufficiency of the funds in the drawer's account is, what is the things, or what are the penalties required? Penalties imposed by the act. I am saying it clearly, it is a criminal offence. Means code of civil procedure will not be applicable, code of criminal procedure will be applicable. Criminal offence. So dishonor of the check is a criminal offence. Now coming to the penalties, first of all, what is meant by dishonor of the check, and we'll be seeing the other effect of the check. Now coming to the what is required for the conditions for attracting liability. What are the conditions for attracting liability? Under section 138 of the Act. Attracting liability means punishment, nothing but under section 138. So what are the conditions need to be there? Number one. First of all, the check needs to be dishonored. What is the thing for the dishonor of the check? Means check needs to be dishonored means what are the thing here? For payment of money to another person from the drawer's account, from the drawer's bank account. For what we are giving? So for payment of the money to another person from the drawer's account, but for what we are making the payment? That is nothing but to clear debt or discharge liability. Whether wholly or in part. It's not material for us, whether wholly or in part. That's what. Next, this is one of the important case where the examination traps you. But the examiner asks, Suppose if any check has been issued as a gift or donation, means what? I'll tell you a small thing. Tomorrow is my birthday. Let's hope tomorrow is my birthday. Now, for my birthday, my dad gave me a check of 1 lakh rupees on the occasion of my birthday. 1 lakh rupees on the occasion of my birthday. So the very next day, I have been deposited in the account of my dad, but unfortunately, for the insufficiency of the funds, it got rejected. Means what? The check dishonored. Check dishonored means that due to insufficiency of the funds means we have a criminal offence. We are having a criminal offence under section 138 of the Negotiable Instrument Act. It's a criminal offence. Now, coming to that, can the penalty can be attracted to my dad? Means no, it's not possible, because we have received the check in case of the gift part. In the same way, donation, these are not applicable. So this is the trapping where the examiner keeps you. So it is not applicable. The thing only applicable is clearing of the debt or discharge liability. Discharging a liability. Only these two cases, the section 138 is applicable. Now, next number 3 is the check will be returned by the banker. As unpaid check. The reason is that because the reason is due to insufficiency of the funds. So these are the things where the check gets dishonored. All these things should be happened. Now, what are the conditions now? What are the conditions for having penalty under this? Soon after, first of all, the check must be presented within the reasonable time. Because reasonable time is very important. Presented within reasonable time. Means what? The validity of the check is actually 3 months. So within 3 months, we need to present that check. After 4 months or 5 months, for example, if you are going to the bank and if you want to collect the amount, if it is dishonored due to non-availability of funds, means it's not responsible, because we did not present within the time. Reasonable time is very, very important for the presentment of the check. Validity period, that's nothing but we'll be calling as the validity period of the check, which is 3 months currently. Now, second thing. So, after dishonor of the check, the banks will give an intimation to us. After getting intimation from the bank, within 30 days, we need to demand for the amount from the other party, from another party by sending with a notice. So, through a written notice, we need to demand the amount within 30 days from receiving the information from the bank. Now, after this one, we need to do another thing. The failure of drawee to pay the amount, failure of drawer to make the or pay the amount after 15 days of the notice. So, after 15 days also he didn't pay. The drawer didn't pay. The 15 days also the drawer didn't pay. Then now our chance has been come to file the complaint for the dishonor of the negotiable instrument under section 138. But it will be available only after 1 month from the time is only 1 month from the failure of the drawer to make the payment. So, these are the conditions for the dishonor of the check and attracting the penalty. Let's see once again. Yes. So, first of all, what is the conditions for attracting liability under section 138? Means if any check got dishonored due to the insufficiency of the funds, the liability under section 138 will be attracting. For attracting the liability under section 138, some things need to be fulfilled. So, what are the things? First of all, check needs to be dishonored. Check needs to be dishonored means what for? Means a drawer has been given for the payment of money to another person. For what is the purpose of giving the check? To clear the debt or discharge the liability. And of course, it is returned by the banker as an unpaid check. it is returned by the banker as an unpaid check. Means it is not clear due to the insufficiency of the fund. The main reason is due to insufficiency of the funds. Now, coming to this is all called as the dishonor of a check due to insufficiency of the funds. After that, after receiving from the information from the banker, within 30 days, we need to demand the amount from the another person, means nothing but drawer. We need to demand the amount from the drawer with a notice, written notice. Means within 15 days period, this person need to pay. Within 15 days period, after receiving the notice, this person need to pay. So, of course, if we didn't pay within 15 days also, then we are having, means the holder will be having a right to give a complaint under section 138. Holder will be having a right to give a complaint under section 138 of the Act. So, this is a case, provided this all will be applicable only if the check is presented within the reasonable time, that is nothing but validity period of the check. Validity period of the check. So, if the thing presented within the validity period of the check only, then this 138 shall be applicable. Now, another question for you. A small example I can take, small example. So, I have given a check to one of the employee as a outside obligation. Means what? Nothing but I am giving an amount for a favor for me, means to select my name, I am giving some amount to the other party. A favor, I am asking a favor from another person. So, for another person selecting my name, I am giving an amount of 1 lakh rupees check to that person. I am giving an amount of 1 lakh rupees check for that person. Now, that only no, suppose that only, think like that only, because he is giving a favor and I'm clearing the amount. So, it's an obligation to me. So, I gave 1 lakh rupees amount, but the check unfortunately got dishonored by insufficiency of the funds. So, got dishonored by the insufficiency of the funds. Now, my question is, can the other party file a complaint under section 138 or not? Another party can file a complaint on me under section 138 or not? Yes, they can file. No, they can't file. They can't file because a illegal obligation it is. Illegal obligation. So, if it is an illegal obligation also, section 138 will not be applicable. Illegal obligation also, section 138 will not be applicable. Now, so this is the information for which the dishonor of the check due to insufficiency of the funds. Now, coming to the penalty. What is the penalty levied under section 138 for the dishonor of the check? So, penalty is nothing but imprisonment for a term up to 2 years. 2 years, up to 2 years, and fine, not enma or fine, which may extend up to the amount twice the amount of the check, which may extend to the twice the amount of the check, means 2 times the amount of the check. So, imprisonment for up to 2 years, or they may have fine which may extend to extend to twice the amount of the check, or sometimes both. Here, sir, extend up to twice the amount of the check, means from the amount of the check, any amount up to the twice the amount of the check they can extend. So, this is the penalty under section 138. Now, if for dishonor of the check, if suppose a company is there, dishonor of a check, a company is there. So, what is the liability for the company? What is the liability of the company for dishonor of check? What is the liability of the company? And liability of the company means we can also say person in charge. Who can be the person in charge of the company as well as person in charge? What is the liability? What is the liability under section 138? Now, coming to the liability part. So, if it is dishonored, then the company and the person in charge, means the person who is responsible for managing or running the affairs of the company, the person who is responsible for managing or running the affairs of the company shall be deemed to be guilty of offense. Deemed to be guilty of offense means committed offense, guilty of offense, and he shall be punished accordingly.
and they shall be punished accordingly. Means in case of a company, if a check is discharged, who shall be punished? It's a company, and also person in charge will both be liable, guilty of offence, and they will be punished accordingly. So this is a case where case of the company, check got dishonored due to insufficiency of the funds. When the person in charge will not be liable. When the person in charge will not be liable. If good faith manner, if he acted in good faith manner, then definitely he will not be liable. So what are the situations where the person in charge will not be liable? First one, if he proves that such offence is committed without his knowledge. Without his knowledge means there is no involvement in the dishonor of the check. There is no involvement for third person on the dishonor of the check. Number 2, he had exercised all due diligence. Means whatever he had worked in good faith manner and transparent manner. He had exercised all the due diligence during that process. Next, number 3. This is one of the highlight thing. If a person is nominated director, means like representing any other bank, etc., means a nominated director, then also this person will not be liable because he will not be involving in the day-to-day affairs of the company. The only reason is that only. So these are the cases where the person in charge in case of a company won't get any liability, have any attraction of the liability. So this is a case for the dishonor of the negotiable instruments. So hope so the things have been completed relating to the negotiable instruments. Each and everything got completed. We have covered major of the topics entirely, I think so. Up to 80 to 90% of the syllabus have been completed by me, and different topics we have seen in the chapter of the negotiable instrument. Any topics left, we'll see in the material also. So if some of the I want to discuss you some practical questions. So on seeing these practical questions, yes, we can say that our syllabus has been completed. Look at this, ma'am. Look at this. July 2021, 4 marks. The question has been asked. Harsha donated means donations, which is clearly excluded under section 138 to NGO by check for sponsoring the education of one child for 1 year. Later, he found that NGO was fraud and did not engage in philanthropic activities. He gave a stop payment to the instruction. Check was not honored by the bank. The NGO has sent a demand notice, means the other conditions need to be followed, and threatened to file a case against Harsha. Advise Mr. Harsha about the course of action available under him. What is the course of action? Whether he is liable under section 138 or not. No, he is not liable, sir, because donation is not in the conditions of the dishonor of the check in case of the liability. Now, check is given as donation for the sponsorship and is not legally enforceable debt or other liability. So, donation is not a legally enforceable debt or other liability. That's why he is not liable for the donated amount which is not honored by the bank to the NGO. Not at all liable. And you can also write no offence under section 138. If it write this point, it will be more clear. No offence under section 138. Now, next thing. Any other questions which need to be discussed here? See here also, one of the beautiful question. In November 2020, it has asked, and May 2018 also it has been asked. Bholinath drew a check in favor of the Surender. After having issued the check, Bholinath requested Surender. So after issuing the check, we requested the other party not to present the check for the payment. Why, sir? And also gave a stop payment request to the bank. Means we have instructed the bank not to proceed for the payment, and also we have requested the other party not to present the check. And then in respect of the check issued to Surender, decide under the provisions of the Negotiable Instruments Act whether the said acts constitutes an offence. Means the stop payment to banking, and also requesting the other party not to present the check. So whether these acts, not to present for the check and stop payment request, will be considered an offence under the section 138 or not. Let's see. So here one of the case law is there, sir. So Supreme Court in Modi Cements Limited versus Kuchil Kumar Nandi held that once a check is issued by the drawer, a presumption under section 139 will be taking place merely because the drawer issues a notice thereafter to the drawee or to the bank for stoppage of payment. It will not prevent action under section 138. Means useless. Whatever the things done by the drawer against to the 138 section, they are useless. So, the object of section 138 to 142 is to promote the efficacy of the banking operations and to ensure credibility in the transacting business through the checks. So that's what 138 to 142 are dealing with. So as per section 138, once a check is drawn on a specified banker to discharge a legally enforceable debt or other liability, and he is informed by the bank about non-payment of the check either because of the insufficiency of the amount to honor the check or the amount exceeding the arrangement made with the bank. Such person shall be deemed to have committed an offence. Obviously, he will be attracting under section 138. That's why we are saying that he is deemed to have committed an offence. And so, drawer liable to have committed an offence under section 138. Here, Bailment in this case, Bailment is liable to have committed an offence under section 138 of the NA Act 1881. One of the fine question, right? Next. So, any other questions? So, I think material alteration here we didn't see, I think so. Just we'll have a look here also, because many times asked, see, I think we have completed this one. The holder added on demand on the face of the instrument. A promissory note was made without mentioning any time for the payment. So, promissory note, actually if it is not having any indication for the payment, we can deem it to be taken as on demand. If though the maker or any other person writes on demand, there is no issue, there is not material alteration. So, let's see the answer, J. No, it's not a material alteration, because addition of the words on demand to a demand instrument, because it's a demand instrument, does not affect the character of the instrument. It does not affect the character of the instrument. That's why we cannot say that it is a material alteration. Next. So, I think these are the cases. That's all. We have completed our syllabus, and if anything, because I wish to say only the important trapping points in your case. Any other question need to be discussed here? Differences are important, and sometimes they may be asking in the examination a straight away question. That's why do not ignore the differences part also. If the differences came, happily you can write. This is a question MTP asked. Offences relating to trial of two cases as per the provisions of the NA Act, section 143. So, these are the things of NA Act. We have completed this chapter, NA Act. So, good evening. This is the chapter we are going to see today, General Clauses Act 1897. So, actually this part of the other law is important, and also minimum average of 4 to 7 marks can be coming in the examination point of view relating to the chapter General Clauses Act 1897. So, we should not ignore the chapter, and we need to study what are the things which can be maybe asked in the examination. So, let's see. Now, coming to the General Clause Act 1897, first of all, we will see the divisions in this chapter, what areas are core areas or what areas are important from the point of the examination, and also why this General Clauses Act is important. So, we will see this. Now, coming to the division, what are the contents of this GCA Act? Nothing but number one. The number one is preliminary. So, nothing but section 1 will be there. Preliminary section 1. Nothing but in the preliminary concepts, obviously you will see about short title, extent, commencement and application of the Act. These are the things which are provided in the preliminary part. Short title, extent, commencement and application of the Act. Generally, this will be provided in the preliminary part of the section. Now, coming to the second division, that is nothing but, this is important point from the examination, because in these area only bits may be asked, and also questions, little bit like 2 marks questions, 3 marks questions can be posed from this area. The area is nothing but definitions. Definitions part. Generally in every act, definitions will come under section 2. Definitions will come under section 2. But this is the only act where definitions will be coming from section 3 to 4A are loaded with the definitions part. And this part I am saying you important regarding the examination. If you study some of the definitions, it will be really helpful to you. Now, number third division. General rules of interpretation. General rules of interpretation. So, coming to this general rules of interpretation, section 5 to section 13 will be coming here. Section 5 to section 13. What are the rules of interpretation will be standing here this, and this is also some important part of the examination. There is no issue. Next, number 4. Number 4th area. The fourth area is nothing but powers and functionaries. Powers and functionaries. Section 14 to 19. Section 14 to 19. Actually, in this area, powers and functionaries, still now the questions have not been asked under this provision. Now, next one. Last section here is, one more section is also there. Last but one section we can call it as. So, the next section under this General Clause Act 1897 is provisions as to order, rules for making enactments. Yes, this is also one of the important area for the examination point of view. Section 22, Section 24 will be dealing with here. Section 22, Section 24. And then the last area under this GCA is nothing but miscellaneous topics. Section 25 to 30. Yes, some of the practical questions can come from this area, miscellaneous. And not only direct questions, ma'am, in this General Clause Act 1897, sometimes we may expect practical questions also. Probably in our CA into more practical questions only they are focusing. So, all the practical questions, if we thorough in what topics they are concentrating the practical questions, then it will be definitely helpful for us. Now, let's go into the, so these are the divisions which can be areas of the General Clauses Act. One is preliminary section 1, number 2 definitions, section 3 to 4A, and number 3 general rules of interpretation, rule number 5 to rule number 13. Yes, this is important part of the examination, and practical questions shall also be coming under this area. Practical questions also this scope under this area. Powers and functionaries, section 14 to 19, and the fifth part is provision as to orders, rules for making enactments, and this is under section 20 to 24. This is also important part of the examination, and the last one is miscellaneous, section 25 to section 30. So if we cover these important topics, yes, General Clause Act is in our hands. Now, coming to the introduction part of this General Clauses Act, what is the use of this General Clauses Act? Why we need to learn this act? Because every act has its own scope, has its own definitions, has its own extent and application. Yes. Then why do we need to learn this General Clauses Act? The thing is basically nothing but it contains definition of certain terms, certain terms for the general principles of interpretation. So, in general, if suppose in any of the act is silent regarding the definition of a particular thing, if any of the act is silent regarding the definition of a particular thing, then we can refer the General Clauses Act for general definitions. Only for general purpose we can use, provided if the definition is not there in the particular act, then only we can refer that. Now, so the main objective of this act is this intends to provide general definitions. Yes, we have already seen, provide general definitions, and also which are applicable to all acts and regulations, central acts. You can identify it as central acts all applicable to central acts and regulations where there is no definition part. Where there is no definitions, means if the concern respect to definition is not available, we can refer the General Clauses Act. This is the main objective of the act. Next number. And also it is very effective. The act is very effective for providing clear definitions. Where if the definition is not there, it provides a clear-cut definition. And also where there is a not only if no definitions are available in respective act, it's okay, but and also if there is a conflict, if there is any conflict between pre-constitutional laws and post-constitutional laws, pre-constitutional laws and post-constitutional laws, if there is any conflict, then we have to refer the General Clauses Act. It is very effective and also helpful in understanding and providing the clear-cut definition. Next. Also, the Act gives a clear suggestion for conflicting provisions. So, if any provision is conflicting and and also it differs from the regulations, then we have to refer the General Clauses Act. Means if there is any conflicting area, then also our General Clause Act will be helpful. Now, next number. The other important is it is enacted to shorten the language. Enacted to shorten the language. Means whatever the Act provides, it is somewhat, if any definition if you refer, Act provides somewhat typical nature in the definition. But General Clause Act helps in shortening the language which is used in laws. So very easy to understand and very easy to interpret the things. So this is a basic introduction for the General Clauses Act. The main intention is we are providing certain definitions and also it is helpful for the general principles of the interpretation. And wherever in the specific act there are no definitions, means yes, we need to refer the General Clauses Act. And also it is very effective. To have the clear definitions. And also the Act gives a clear suggestion wherever or whenever there is a conflicting provision or there is any pre-constitutional, post-constitutional differentiations, and also it's helpful for the understanding and interpretation. That's all. So these are the preliminary objectives for the General Clauses Act. And now I'm going to not discuss about the general applicability because it's not helpful for us at this point of time. Now, coming to the sections, we have already learned that there are three first section which is called as preliminary sections. In the 6 divisions, I have seen the preliminary first one. So now coming to the preliminary section, it is nothing but section 1, which is states the short title, extent and commencement of the Act. So simply here in this section 1, it only gave the short title of the Act as the General Clauses Act 1897. General Clauses Act 1897. So it is the only short title given here in the section 1. Now coming to the definitions area. I already said the definitions part are very important. As in the examination point of view, because many questions can be asking from what is the definition of this, what is the definition of good faith, etc. So many questions will be coming based upon the marks we can extend our answer. Now coming to the important areas, the definitions, section 3 deals with the definitions. Now let us see some of the definitions which are useful for you at this point of time, which may be asking, there is a chance of asking in the examination. Now, coming to the first definition, affidavit. The term affidavit. So, generally in many things, we'll be seeing the term affidavit, like in Companies Act 2013, we'll be seeing, and many other laws, also particularly we'll be seeing the please give a affidavit. So, what is this affidavit? What is the nature of the affidavit? Now, just it is nothing but it includes a affirmation as well as declaration. In case of a person's by law instead of swearing. So generally in court of law we'll be seeing swearing and saying some issues or points, etc. So, but instead of that oath or swearing, we can have in a document printed matter. So, nothing but it includes a affirmation as well as a declaration. In case of persons by law, that is instead of swearing, we can use affidavit as a weapon. Instead of swearing, we can use affidavit as a weapon. Now, we can primarily understand there are two things in the case of the affidavit. So, what are the two things in the case of affidavit? Number one, it is nothing but affirmation. Affirmation means nothing but confirmation, sir. So, affirmation as well as declaration. So, we will affirm and declare that some statement. We'll affirm and declare some statement. It is called as affirmation and declaration. Next, number two. That is nothing but persons allowed affirming instead of swearing. So these are the two highlight things we can point out in case of the term definition. So I can say that the term affidavit includes affirming and declaring. The term affidavit includes affirming and declaring is some statement of fact or any other thing. Next, also it includes declaration. Not only affirmation, sir, it also includes declaration. It also includes declaration. Now, next thing, simply we can see that simply in general terms. In general terms, we can say that means in a common language. In a general term or common language, we can say that it is a written form of statement. Written form of statement confirmed by oath. Confirmed by oath. Or affirmation for use as evidence in court. Evidence in court of law. So this is nothing but written form of a statement confirmed by the oath. Oath means nothing but a promise. By making a promise, we are saying that the above said statement is correct and true as per as the best of my knowledge. So this is called as an affirmation and declaration. So simply if the examiner asks explain to the term affidavit, simply you can write these 2 points. Number one, that is affirmation is an affidavit is an affirmation and includes a declaration. This is point number 1 to be noted in the examination. Affirmation and includes declaration. Number 2, who will provide, sir? Persons allowed affirming instead of the swearing. So instead of swearing in front of the court of law, in written statement will be providing the affidavit. It is nothing but simply in general terms we can say that it is a written form of the statement that is nothing but confirmed by oath. Confirmed by oath. This is the term affidavit. Now second definition will be seen. Only important areas I am going with, sir, because of the constraint of the time. We are moving with important areas only. Now, where there is a chance of scope being asked in the examination. So, now the second definition is commencement of the act. Commencement of an act. So, it is very important, sir, because for every act to have its effect, when it will be effective, generally we'll be asking when this notification is effective or when this act is effective. So in having the effective date of the act, we have to check for the commencement of the act. We have to check for the commencement of the act. So what is this commencement of the act? When we can know, or where we can know. Instead we can use where we can know. Where do we search for the commencement? How do we know that this is the particular date of the act? Generally we don't know, because we'll be seeing or reading in books, okay, this act comes into effective from this one, right? We'll be reading like that. But where is that taken from? Where we can find? Simply there are two things how we can find the commencement of the act. There are two things. So what are the two things? So commencement with respect to act or regulation, with respect to act or regulation is nothing but day on which the act comes into force. Acts comes into force means simply we can see that commencement of an act or regulation is the day when is the starting point of the act, day on which the act comes into force, when it will be incoming or when it will be having legal effect. Also we can simply say that when the act will be having legal effect, or to know the legal effect, that is nothing but known as a commencement of the act. Now coming to the commencement, one more point is also there. Coming to the commencement, one more point is also there. So what is the point? Nothing but it refers to the process by which the legislation comes into force or have the legal force and effect. So when will be the legislation coming into force and when it will be having the effect. Now coming to this area, so how can we know? Suppose for commencement of an act, what we need to check? When it will be the effective date. When the effective date will be there. Generally, the effective date will be mentioned in the act itself. Mentioned in the act itself means the notification itself specifies. Mentioned in the act means nothing but notification itself specifies. The notification in the official gazette itself specifies the date of the effect of this act. So this act comes into force from this time. Like that, directly in the act itself we can find the date of the force. Now sometimes if this date is not mentioned, if effective date is not mentioned in the act, then how can we know that so if effective date is not mentioned in that, how could we know? Then simply, generally, the basic process of the bill conversion into act, when it will be converted, sir, when it receives the assent of the president. So generally, a bill will be converted into an act at the point of time where the bill it receives the assent of the president. So if the specific date is not mentioned in the act, we need to take the when the assent of the president is received for this bill, where the assent of the act is received by the president. So we'll be taking it as an effective date, provided if it is not mentioned in the act. So this is regarding the commencement of an act. Simply you need to write, 1 minute. Yes, simply we need to write what is commencement of an act, nothing but effective date of an act or day on which the act comes into force. Day on which it comes into force or effect, or also it refers to the process by which the legislation or act or regulation comes into effect. Legislation or act or regulation comes into effect. This is the first point you need to write the definition. Now coming to the effective date, when the effective date will be there. So if it is mentioned in the act itself, then we'll be taking as the effective date of the act, means it is already notified in the notification or official gazette. When will be the act will be the effective. If the effective date is not mentioned in the act, then when it receives the date or day which it receives the assent of the president will be taken as the commencement of an act. So now let's see the third definition here. The third important definition is nothing but document. So what is meant by document? We will be having many times on many cases, document, information, etc. Means in the Companies Act 2013 also we will be seeing filing these documents with the registers, filing information with this registers, etc. Documents will be making more time will be using that. So what is the definition of the document? So generally Companies Act 2013 does not provide any definition relating to the document. So what is meant by document? So if the definition is not provided in the particular act, which act we have to refer? General Clause Act we have to refer. So the General Clauses Act explains the document here as such. So what is the definition of the document? It is nothing but a matter expressed through written form described upon any substance. So this is the term document, means matter expressed in a written form. Described upon any substance. So we will be describing something. in the information. Now, how do we describe the information in written form? Means by means of letter, figures, words, etc. in any other means. Also acceptable. In any other means we will be describing the information. Different ways we may describe the information. Now, what is the ultimate purpose of creating the document? It is nothing but for the purpose of recording the matter. We'll be dealing with the document for the purpose of recording the matter. So this is called as the document definition. So simply document means it is a written form. Matter expressed, any matter expressed in a written form, described upon any substance. So we'll be describing upon anything. So, by what way, sir, we are using? Letter, figures, words, or in any other means. In any other means like painting, etc. also we may describe. Next, for the purpose of, what is the ultimate purpose of the document? Recording the matter. Means in record we will be keeping, for example, books, files, etc. Books, files, etc. These are the examples of the document. So, generally, in the examination, they will be asking, explain the term document along with some examples. So, what you will be doing, sir? Document means a matter expressed in a written form described upon any substance, by which means, sir, letters, words, figures, etc. or through diagrams also we can have the information passed like that. For the purpose, in any other means, because they are also saying that in any other means we can say, for the purpose of the recording matter. This is called the word document. Now, coming to the next important definition. So, the next important definition is nothing but number 4 we are going to see, sir. The next important definition is the word financial year. The word financial year. Yes, we will be seeing the term what is meant by the financial year. So, generally financial year means we will be having a common sense that it will be starting from 1st day of April and ending from the next 31st March of the next succeeding year. That's what we will be having in a common sense of language. Now here also seems so commencing on 1st day of April, commencing on 1st day of April, and ending the next March of the succeeding year. Next March of the succeeding year. So, this is the general definition of the financial year. Now, generally, as per section 3, subsection 66, the British calendar, they will be specifying that under General Clauses Act, an year means a calendar year. So, under General Clauses Act, if they specify year means, what is the information they are communicating? It is nothing but the calendar year. Now, calendar year means what, sir? We will be saying that it is starting from the 1st day of January. It is starting from the 1st day of January and ending on 31st December of that year. It is the calendar year specifying. So, this is a financial year and this is a calendar year. But as per General Clause Act, if an year under the British calendar, an year means it is a calendar year which is starting from the 1st day of January to 31st day of December. So, this is a definitions, and can we go once regarding the practical questions which might be asked in the examination. See here, we can see in the question wise analysis of the previous examination, May 2022. Theory question has been asked and no practical question, I think so. Yes, in December 2021 also you can see 8 marks. 8 marks have taken noted here, right? The previous examination also 4. Practical question 4 marks. So 8 marks. 8 marks December 2021 examination. So should not able to just leave this chapter. So objective is already set to shorten the language. So going to the practical questions. See here, sir, this question. Referring to the provisions of GCA, find out the day or date on which the following act or regulation comes into force. So effective date of the act, nothing but. So the Act of Parliament, this is Act of Parliament which has not specifically mentioned a particular date. So just now we have seen, if any particular date is mentioned, the date on which the assent of the President has been taken, assent of the President has been noted on that specific act. So, according to section 5 of GCA, where any central act has not specifically mentioned a particular date to come into force, it shall be implemented on the day on which it receives the assent of the President in case of Act of the Parliament. In case of the Act of the Parliament. If any specific date of announcement is prescribed in the official gazette, the Act come into enforcement from such date onwards. So, this is many times asked a 3 marks question. See here? Yes. So, analysis and the question. So, first one, the first bit, any central act has not specifically mentioned a particular date means then day on which it receives the assent of the President in case of the Act of the Parliament. Now, second question C. The Securities Exchange and Board of India issue of capital and disclosure requirements, Fifth Amendment Regulations 2015 was issued by SEBI, white notification dated 14th August 2014 with effect from 1st January 2016. So, though notification is dated on 14th August 2015, what is the effective date, sir? 1st January 2016, because clearly mentioned. So, what we need to take, sir? SEBI Regulations 2015 shall come into force enforcement on 1st January 2016 rather than the date of notification in the Gazette. So, we should not take the date of notification. We need to take when it will be effective. So, it will be effective from 1st January 2016 onwards. Now, see here one more thing, sir. Government. Income tax provides that gratuity paid by the government to its employees is fully exempt from tax. You are required to explain the scope of the term government and clarify whether the exemption from gratuity income shall be available to state government employees or not, because we don't know what is meant by government, whether it is applicable only to the central government or state government. So, give your answer in accordance with the General Clauses Act. So, government, generally the term includes both central government and state government. So, whenever we use the term government, it includes both central government and state government. So, here in this case, Income Tax Act provides that gratuity paid by the government to its employees is fully exempt from tax. Means here the government both includes central government as well as the state government. Here we can say that government includes both, hence exemption from gratuity income shall be available to state government employees also. So, very simple, sir. Very small point, that to ask it for 2 marks. So, if it is very small also, we should not ignore 2 marks, because simple term, government includes central government plus state government. Next. See here, sir, one more thing also. May 2022 RTP, this question has been asked, sir. So, we'll just have a look for that. Ayush and Vipul are good friends and pursuing CA courses. While doing group studies for the paper of Corporate and Other Law, they're confused about the provisions of the Section 3 of the Companies Act 2013. Section 3 of Companies Act, sir, not any other, provides that a company, there is nothing but Section 3 is nothing but formation of the companies, right? Formation of the companies, Section 3 is covered. Formation of companies. Yes, it is the first point. We'll be saying that a company may be formed for any lawful purposes by any of the persons interested, like that it will be stating. So, here both Ayush and Vipul are in difficulty about the meaning of the word may, whether it should taken be as a mandatory or directory. Means what? We have to interpret that whether may can be taken as in directory mode or whether may is a mandatory mode. Generally, may means obviously in our common language sense, may will be using for a compulsory or mandatory thing only. May can means if difference, it may have some difference. So, now word shall is used to raise presumption of something which is mandatory or imperative, while the may is used to connote something which is not mandatory. Shall means compulsory, may means it can or may, cannot. So, there is some probability, but it is only directory or enabling. Means may in general sense will be taking directory or enabling. However, sometimes may has a mandatory force also. May will be having a mandatory force also. However, word may and shall can be interpreted interchangeably depending on the intention of the legislature. So, what is the, we have to take ultimate thing is intention of the legislature. So, we need to write this also. What is the ultimate thing of the legislature intention? Then we can take that whether may can be covered under the mandatory purpose or may under a directory purpose. Now, see this is the thing. In the given case, it can be said that word may should be taken as a mandatory force because the law will never allow the formation of the company with unlawful object. Only lawful object only they need to incorporate a company. If it is unlawful object means there is no chance of incorporating a company. That's why may will be taken having effect as an mandatory force only. Here the word used may shall be read as shall. Here, so we are taking may is equal to shall only. Uses of the word may here makes it mandatory for a company for the compliance of Section 3 for its formation. So, may can be treated as shall here in this case because it have the effect as per the intention of the legislature is it is should be done. Means it is only the company need to be formed for the lawful purpose and legal object. That's why there is no directory effects. The interpretation or the intention of the lawmaker means legislature is nothing but to have a mandatory effect on Section 3. That is formation of the companies that is for the lawful object. So, yesterday we have seen some of the concepts regarding General Clause Act, introduction and some basic things we have learned yesterday. Now, today we are continuing with some other topics and definitions which are needed to be revised or discussed now in the form of the marathon classes. Now, coming to one of the question which they have asked recently, it's nothing but write a note on preamble. Preamble does not override the plain provisions of the Act. Comment also gives suitable example. So this question asked in May 2019 for 3 marks, a small question, very easy to explain, because nowadays each and every act, for each and every act there will be preamble. There will be preamble, means in Telugu we'll be calling as like mundu mata or whatever required, what is the purpose of the thing. Preamble can be shown in every act. So that's what every act, that's why every act has a preamble which expresses the scope, object and purpose of the act. Yes, definitely it explains scope, object and purpose of the act. Not only that, it is a main source for understanding the intention of the lawmaker. That's what the highlight point is. It is the preamble. Through the preamble of studying an act, we can understand what is the intention of the lawmaker, why this act need to be there, intention of the lawmaker. Wherever there is an ambiguity in understanding any provision of the act, so while referencing the provisions of the act, we do not understand why this intention is there. Then preamble is accepted as an aid to construction of an act. Means we can have an added benefit by reading what is meant by preamble. Now, preamble of the statute is a part of the enactment and can be legitimately used for understanding. That's what we have just discussed now. Now, however, this is the main point, sir. It does not override the plain provisions of the act. There is no overriding. Just what is preamble defining? Object, scope and other powers of the act. Preamble will be describing that. But it does not anywhere in the act, it does not relate to overriding the provisions of the act. There is no chance of overriding the provisions of the act through the form of the preamble, So that's why, suppose you can also see the examples like preamble of the Companies Act 2013 will be saying that an act to consolidate and amend the law relating to the companies. This is the preamble. Means what? Why this act has been made. Why this act has been made. What is the purpose of making this act? So the purpose of making this consolidated, Companies Act 2013 is nothing but act to consolidate and amend the law relating towards companies. So this is the preamble. Like that, in the same way, preamble of the Negotiable Instruments Act 1881. So coming to this Negotiable NA Act 1881, that is nothing but to define and amend the law relating to the negotiable instruments. Nothing but promissory notes, bills of exchange and checks. Means through the preamble, we can understand scope, object and purpose of the act. Why this act has been framed. That's what. Very simple. If this question comes, you can easily attempt, sir, because you can write examples here itself and you can write 2-3 points regarding the preamble. Yes, if any provision, if you do not understand, then we can refer the preamble for that, so that it will be helpful in it. It shows an aid to the construing it, means understanding it. Simply we can say that. So this is a preamble. Now coming to the other next important questions. Yes, some definitions yesterday we have looked out, and yesterday we also seen one more thing, may and shall. The interchangeable uses of may and shall. Yes, shall and may. We have seen a practical question regarding that, because in the Companies Act section 3 has been provided for companies may be formed. Here it is the companies may be formed for any lawful purpose. For any lawful purpose, means here maybe means whether it is a mandatory provision or whether it is a directory provision. Then if any doubt arises for us, sir, actually shall means mandatory. May, according to the intention of the lawmaker, we can take it. Here the intention of the lawmaker is only incorporation of the lawful object of a company. It is a lawful object. So we can see from the interpretation of the lawful object of the lawmaker is it is a mandatory provision, but not the directory provision. That's why, however, the words may and shall can be interpreted interchangeably depending on the intention of the legislature. Depending on the intention of the legislature, means if any word which starts from may, then we need to check the intention of the lawmaker. Then we can understand whether it is a mandatory provision, mean compulsory provision, or otherwise it can be a directory provision. So that's what we have yesterday seen this practical question. Now coming to the other things. Yes, have already said short title, General Clause Act 1897. Definitions part. Coming to the definitions part, affidavit, yes, we have learned yesterday. Affidavit includes affirmation and declaration by person instead of the swearing. That's what the definition is. Simple, very simple. So it includes 2 important points, affirmation and declaration. In case of the persons allowed affirming a declaration instead of swearing. So instead of swearing, we are taking this affirmation. Means in general practice, we can easily say that affidavit is a written statement confirmed by oath or affirmation for use and evidence in court or before any authority. Amma, one more point is also seen in the definitions. Oath also will be seeing some topic. Oath also will be seeing small definition. For 1 mark, it has been asked in the last question and answers. So oath means nothing but it also means affirmation only. So there is no much difference between oath and affirmation. Both are equally same. And affidavit equally same. All are like synonyms. Now, commencement of the act. Yesterday we have seen. Yes, commencement of the act means which have its legal force and effect. Which have its legal force and effect, or otherwise the day on which the act or regulation comes into force. The day on which the act or regulation comes into force. For this, I have extended like what is the date of commencement. Yes, it will be learned in upcoming session just now. No issue in that. So it's simply now, if any question has been asked, what do you understand by commencement of the act, means nothing but the day on which the act or regulation comes into force. Effective date. Simply, we can also say the effective date of the act. Effective date of applicability of act. Applicability of act. As simply we can write this one word statement. Yes, equally good. That's also we have seen document also, no? Yes. Any matter written, expressed, or described by means of letters, figures, or marks. Nothing but ultimate purpose is purpose of recording that matter. That's the ultimate purpose. Means we need to keep a record of that matter. Like book, file, painting, even computer files, all are the documents. Now, other financial years, we have also seen financial year as a year reckoned according to the British calendar. This, as per General Clause Act, year means a calendar year. Generally, so if any act there is no clarity regarding financial year means we need to refer the General Clause Act. So in the General Clauses Act, we will referring financial year means nothing but a calendar year as per the British calendar. As per the British calendar means calendar year means it will be starting from January 1st and ending with 31st December. 1st January and ending with 31st December. So calendar year only we will take if any provision is not there relating to the financial year definition in particular act. Financial year means we know 1st day of April but ends on 31st March. But ends on 31st March of the subsequent year. Next. Yeah, this is important, ma. This is very important because many times asked a question and good faith, I have to say something more. Then actually here it's good, no issue in this. So nothing but whatever we do, suppose if we do good faith means what from our inner part of the heart will be doing in good faith means manchi namakamto, nothing but we will be doing like that. So if we do anything from good faith manner, though we have acted negligently, then it does not invalidate the transaction. It does not invalidate the transaction. Means the ultimate thing is what? We need to act in a good faith. Means we have no any intention to defraud others. We don't have any intention to overcome others. No, it's not our intention. Our intention is to deal any transaction in good faith manner. To deal in any transaction good faith manner. Suppose I went to a watch shop. So I have opened the good watch, like nice color or high price, whatever I wish to buy. I have opened the watch and okay, it's fine for me and I have brought that. Means bringing that watch means in a good faith manner only because I'm not having any intention to defraud others. I'm not having any intention to destroy the things at the shop. No, I'm not having any intention. My intention is to purchase a good watch or good electronic watch to my hand. Good electronic watch. So for that I am making a purchase. So it can be said that in good faith manner, though I didn't make any inquiry regarding the watch. There is no inquiry needed. Means if no inquiry is also there also, it does not invalidate the transaction. So that's what is here saying. A thing that can be done in good faith where it is in fact done honestly. Means what is the thing we need to have? Honest manner we need to have, whether it is done negligent or not. So if we have done negligently also, it does not affect good faith. It does not affect good faith. That's what the thing is. The question of good faith under GCA is one of the fact. It is determined with reference to facts and circumstances of the each case. So not a general applicability. So depending upon the facts and circumstances, we need to discuss whether there is a good faith or not. Now, coming thus, anything done with due care and attention which is not malified is presumed to have done in good faith. So what? Simple due and care, if you follow, it's enough, sir. It's enough. Not heavy skills are not required. If you follow simple due care and some good faith, then it's enough for a transaction. Now, so the term good faith has been defined differently in different enactments. As per GCA, it is a definition here. It's a definition here which is done in good faith. That's all. Yes, it won't be applied. If any act contains a special definition for the term good faith, then that definition only it will be applicable. That definition only it will be applicable. If any act good faith definition is not there, means then we need to follow the definition as per the GCA only. That's what the content is. Now, mostly in the examinations, I'm saying you, the examiner may test this category with either asking directly define the term good faith or otherwise a scenario based question. Or a scenario based question means he will be giving an incident like what I have said just now, purchasing a watch in a shop, So like this, he may ask some questions and ask you whether the purchase has been made in good faith or not. Those are the questions which may be coming from the good faith topic. Now, the term government, yesterday we have already seen one case study regarding this also. Government shall include both the central government and state government. That's all. There's no other things. So, other definitions are also there. One more definition, important definition is immovable property. This is the definition where bits or MCQs can be asked or direct definition can be asked or case law, a small practical question, like practical question also can be asked from this immovable property. Such an important topic in General Clauses Act. So what is this immovable property? Generally, we know immovable property means which are fixed to the things and which are not movable. Yes, in a common sense, we'll say that yes, this is not movable. Building is an immovable property, definitely, because it is not movable. Means land. If you purchase any land, it also comes under the category of the immovable property because it may not have any movable capacity. That's what. So here also we can take the same meaning. It is an inclusive definition. Inclusive definition means it includes a land, things attached to earth, means things which are attached, which cannot be removed from the earth. I am saying here only which can be removed from earth or separated from earth. Which can be removed, or I can also use the word here separated from earth. Benefits to arise out of land. So what are the benefits arising out of the land? We can also call it as an immovable property. And permanently fastened to anything attached to earth. Permanently fastened to anything attached to earth means permanently removed from this one. Next, example, see here. Yes, these are the examples which can be asked in the question paper. Like what includes. If you read now, it's okay. We can easily understand the term immovable property. But at the time of writing examination, that too in the MCQ saying, then we'll have a little bit thing. What is the definition of the immovable property? What is the definition? Now see, trees are immovable property because trees are the benefits arise out of the land. Trees means pakka immovable property. Timber is not an immovable property as the same are not permanently attached to the earth. They are not attached. Timber means after cutting of the trees, they won't be called as immovable property. That's what we have said. Buildings are immovable property. Yes, we know. And see, this is a question they have asked, right to drain of water. So there is a thing, right to drain water. It may also come under the immovable property means no, it does not come under immovable property because it is not coming under above categories what the definition has. That's what the thing. Right of way to access from means way, a small path we can say from one place to another may come within the definition of the immovable property because it constitutes the definition of the immovable property. Any machinery fixed to the soil, standing crops can be held as immovable property according to the GCA. So, this all the definitions of the immovable property and some of the examples. Particularly, he will be testing in examples manner only, but no other sense. Only in the examples. Timber after cutting tamarind trees, timber will come. So whether it is constituted as an immovable property or not. No, it does not come under the point of the immovable property. That's all. Now, so these are the things. Here month also see only to the British calendar. Movable property, except immovable property. Oath, I have said no, oath is also other definition. Nothing but include affirmation and declaration. Nothing but here also include affirmation and declaration. In case of the persons by law allowed to affirm or declare, but what? Instead of the swearing. Instead of swearing. If asks for 1 mark, you need to write all these things. It includes affirmation and declaration by persons allowed under law instead of swearing. If you write this point as it is, you'll be attaining 1 mark. You'll be attaining 1 mark. Now, offense, okay, it's not no issue. Official Gazette, person, rule. See here, December 2021, 1 mark. Rule. Rule means a rule made in exercise of the power conferred by any enactment and shall include regulation made under any enactment. That's what. Because Companies Act 2013, there are many rules. There are many rules need to be studied along with the sections or provisions of the Act. Along with the sections or provisions of the Act. Means, rule means shall made in exercise of the power conferred by an enactment. Yes, it is a power conferred by an enactment. And shall include a regulation also. That's what. Next, when does the legislation or enactment comes into force? We have already discussed regarding commencement of an effective date of the act or regulation. We have already discussed this point, section 5. Yes, this is important from the part of the examination because we have already seen a practical question has been asked on this. We have already seen yesterday the practical question relating to it. Yesterday I have said actually it is depend on 2 types. Yes, if specifically any date is mentioned in the act itself, then that specific date we need to follow. If no specific date means the date on which the assent of the precedent has been taken. Assent of precedent has been taken. This is the date of effective date for the particular act. Examples also we have seen. Also see here, one of the interesting point is no cognizance of fraction of the day. No cognizance of fraction of day means if it is starting on the first day of January itself, then it will be after when the December 31st after 12, it will be automatically effective date of the act. It will be automatically the effective date of the act. That's what. Now, effect of repeal. Yes, this is also one time asked question for 3 marks. I mean, recent. May 2022, 3 marks. Effect of repeal. What is the effect of the repeal? Means any changing in law or any closing of the law. What is meant by effect of the repeal? So, any central legislation or any regulation made after the commencement of this act repeals any act made or yet to be made. So, any act already repealed, say. Then, what are the things? What is the effect of this? Revive anything not enforced or prevail during which the repeal is effected. Yes, revive anything which is not enforced. It cannot be revived. Now, affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. It affects the previous operation basically. Yes, that's what. Because generally repealment does not involve any retrospective. Right? That's all. Affect any right, privilege, obligation or liability acquired, accrued or incurred under any enactment. So, definitely it affects any right, privilege, obligation or liability acquired. Yes, what is the new act? We need to follow that only. Why we need to follow the previous act? There is nothing. So, it all affects everything. Affect any penalty, forfeiture, punishment incurred in respect of any offence committed against any enactment so repealed. Yes, definitely it affects the punishment also in the same manner. Affect any inquiry, litigation or remedy with regard to such claim, privilege, debt or responsibility or any inquiry, litigation or remedy may be initiated, continued or insisted. So, these are the effects of a repeal. All these are the effects of the repeal. Yes, it's an important question and previously asked question in the recent past. See here, explain briefly any 4 effects by repeal of an existing act by any central legislation in section 6 of the General Clauses Act. Section 6 means what we have studied, effect of the repeal. Yeah, this is important, huh? Very, very important question and many practical questions have been asked in this area. Many practical questions have been asked in this area. Yes, I will say for this, no issue in that. Yes. Now, commencement of time and termination of time. Commencement of time and termination of time. Termination of time. So what is this? What is this commencement and termination? Means a simple technique. It is a simple technique. Sometimes we'll be saying a range from the date onwards, within 30 days or within 15 days of the show cause notice. Generally, we will be using the time period when to start or when to close, or how to calculate the time period when any act provides. So it is nothing but how to calculate the time period, of any provision which it is made. So how to calculate basically a time period. That's what the thing relating to this. Now, for calculating a time period, generally we will be saying that within 15 days we need to file a form. For suppose file an e-form with the authorities, concerned authorities. Now, within 15 days means, suppose from which date, reference of the particular date will be given. Reference of date, that is nothing but, for example, in our example we'll be taking, suppose a date of meeting, board meeting. So with the conclusion of the board meeting, the form should be filed within 15 days. For example, we are taking. So the conclusion of the board meeting, the form need to be filed within 15 days. Now for example, we'll be taking the date of board meeting. Date of board meeting is 18th October. 2022. The date of board meeting is 18th October 2022. Now within 15 days we need to calculate. So what we shall be doing, sir? How to calculate this 15 days period, sir? What need to be included? What need to be excluded? Basically there are two things. One is excluded date, and other one is included date. So what is the exclusion date? Board meeting date means date of event shall be excluded. Means we need to count from which date, sir? Because 18th October is the date. So which date we need to count, sir? 19th October 2022 we shall be counting. 19th October 22 we shall be counting. Now how many days? 15 days we need to count. See here. 19th October we need to count. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. So 15 days on which day, sir? 2nd November. So inclusive date will be the date ending. Means 2nd November we need to include. Date of ending 2nd November we need to include. So this is the way of calculation of time period. Means from the date of event, the date of event shall be excluded. The next day of the event we need to take. Next day we need to count. Means first day after certain event. We need to be included, and the ending date we need to include. This is the calculation of the computation of time. Now let's see here. Section 9. Yes, this is one of the important thing. Many practical questions will be coming, and not only that, while answering this practical questions, he will generally include other acts also. Means we need to have that provision also in mind. Means he will be including, suppose here only it's company declares dividend for its shareholders. Means as per the provisions of the dividend, declaration of the dividend, section 123, you need to refer here also. The provision need to know about regarding that provision, and also you need to know regarding this section 9 also. Let's see. It shall be sufficient for the purpose of excluding the first in a series of days or any other period of time to use word from. Means first day, that day we need to exclude. And for the purpose of including the last day in a series of days, last day we need to include. Suppose see here, a company declares dividend for its shareholders in its AGM held on 30th September 21. Yes, 30th September is automatically the last date for the AGM. Yes, last date of the AGM, because 6 months from the end of the financial year. Under the provisions of the Companies Act, company is required to pay declared dividend within 30 days from the date of declaration.
So here what is the event, sir? Date of declaration. Which date? Meeting date. Nothing but what is the AGM date? 30th September. So do we need to include that 30th September in our counting days? No, we should not include. We should not include the first day of or date of the event. Then we need to say from 1st October 2021 to how many days? 30 days. 30th October. 30th October we will be including. That's what. Yes, this is very important. Very easy also. If you understand the question, easily you can write. If such question comes, definitely don't leave. See here, November 2018, 4 marks. Simple question. 4 marks will be right away in your pocket. Yes, if you write the answer correctly. Next, computation of time. Yes, that's what. Computation of time, section 10 also important. This is section 9, that is commencement and termination of time, and computation of time is section 10 here. Section 10. Now, whereby any legislation or regulation, suppose any court orders to be done on that specific day, but on that specific day, court is a holiday. On that specific day, court is a holiday. Then what we can count, then which date we can go into the court? Simply, it is done or taken on the next day afterwards on which the court or office is open. Not only court, any office. If any office we need to take the time, but office is closed on that date, means the next day on which the office is open. The next day on which the office is open. That's what the computation of time is. Yes, next one. How to measure distances. It's also one practical question came recently, sir, regarding this also, measurement of distances. The distance shall, unless a different intention appears, be measured in a straight line on a horizontal plane. Simply, if you write that referencing, it's very easy. Simply, if you write that distance shall, unless a different intention appears, to be measured in a straight line on a horizontal plane. On a horizontal plane, straight line. That's all. Next, gender and number. See, many times asked question, gender and number. May 2021, recent also it has been asked. Nothing but while any studying or any provisions of the act, if any masculine gender is included, means if he includes, we can simply say he includes she. Means the masculine gender includes the feminine gender also. And also the singular includes plural. Singular includes plural. That's what the General Clauses Act says. That's all. Very easy. Yes, here see, when a word connoting a common gender is available, but the word used conveys specific gender, means we are saying a specific gender only, then in such a case GCA will not apply. The word bullocks could not be interpreted to include cows. That's what. Specific gender cheppinappudu means if they specify any specific gender, that gender only we need to say. That's all. Now, important question this is also. Sometimes bits or other things may be coming. Powers and functionaries, there is nothing need to be discussed. Provisions regarding rules made under enactments. See here, one of the important questions. I think MTP, is an MTP. Power to make rules or bylaws and issue orders between passing and commencement of the act. So, very things. So generally an act provides, yes, these persons have authority to make rules or enactments. These persons have authority to make rules and enactments. But unfortunately, the act didn't came into effect, or act did not commenced. Act did not commence. Means if the act is not commenced, means whether that power to make bylaws will start. Power to make bylaws is an enabling provision in the act. Is an enabling provision in the act, but without commencement of that particular act, is the provision will be effective, sir? It will not be effective. That's what here saying. Simply means, see here, the power may be exercised at any time after passing the act or regulation. After passing means if the act comes, its enabling provision will be into effective. Before passage of the act or before commencement of the act, how this enabling provision will be ineffective, sir? It won't be ineffective simply. Rules, bylaws or orders so made or issued shall not take effect till the commencement of the act or regulation. Means we can simply write only after commencement of the act. Only after commencement of the act, the power of bylaws will have its effect. The power of making of bylaws will have its effect. That's also. Next, applicable to making of rules, bylaws after previous publications. This is also one of the important questions, sir. Miscellaneous provisions. See here, this is also one of the important things that are asked in the examinations many times. That's nothing but, suppose
a person is liable under two different acts. A person is liable under two different acts. How he can be punished? Under both or under single or twice the punishment. That's what here it is. Provision as to offence punishable under two or more enactments. Two or more enactments. So, punished under either or any of those enactments. Only one enactment, but shall not be punished twice for the same offence. Many times asked bit services. Many times asked. MCQ questions they might be asking this bit. Means, but shall not be punished twice. No twice under single offence. Under single offence, no penalty of twice. That's what the thing is. This is also one of the important question many times asked in practical questions, basically PQ questions. Service by post. How can we assume that service by post is there? Means service by post means there are some requirements need to be done for that particular service by post. That is nothing but properly addressing, because many times, particularly in the Companies Act 2013, we'll be seeing notice should be reach the member of the company. Means service of the post should be effective. Service of the post should be effective. When service of the post will be effective, sir? If it is properly addressed, prepraying the stamps and posting by the registered post. Means registered post only important. Posting by the registered post, we can say that if all these three matches, then we can say that it is effective. The post has been sent or delivered to the particular person. Post has been sent or delivered to the particular person. So this is the meaning of service by post. Many practical questions will be coming. So if we see the practical questions, what can be asked in the examination, just for a look, then we can understand the entire Act GCA, and we have completed the whole revision also. If we see the practical questions. See, yeah, I have said no, commencement of the time. Computation of the time. Declare dividend. 27 September 2019 is the date. Now, the date during which Komal Limited required to pay the dividend. What's a, so this is the date of event. Date of event need to be excluded. So, 28th September will be taking the starting date. Within 30 days, we need to complete. Means the other part of the date is within 30 days from the 28th September 2019. So, let's see what is the ending date. Nothing but ending date will be included. Counting of ending date means the 30th day will be included. 30th day will be included. So, first answering such type of questions, provision need to be taken. So, provision not as per the Companies Act, sir, but we need to write General Clause Act provision. Remember this. So, the provision as per section 9 of the General Clause Act for computation of the time, section 9 GCA says that in any legislation, regulation, it shall be sufficient for the purpose of excluding the first in a series of days and for the purpose of including the last in a series of days. Means last date we need to include, first date we need to exclude. That's what. So, in the analysis you can write as per the provisions of the section 127 of the Companies Act. A company is required to pay dividend declared within 30 days. Within 30 days from the date of declaration. So, here date of declaration is 27 September will be excluded and the last 30th day 27 October will be included. That's what they say. 27 October will be included. Means last date will be included. Now, second question, see. Here also, which Komal Limited is required to transfer the unclaimed dividend or unpaid dividend to unpaid dividend account. Means 7 days from the last date of the above. 7 days of the last date of transferring to its members. Now, see here. So, as per section 124, within 7 days from the date of expiry of the set period of 30 days, we need to transfer to an unpaid dividend account. So, here the last date is what, sir? 27th October is the last date. 27th October. So, can we count 27th October, sir? No, we cannot count 27th October. So, 28th October 2019. Within 7 days. The last day of the 7th day is nothing but 3rd November. 3rd November. Yes, we need to include this also. That's what. Next. See here, one of the classic questions. Many times asked questions. So this is very, very important. Mr. X owned a land with 50 tamarind trees. Land is there. Trees are there. See carefully. He sold his land and timber after obtaining the cutting of the 50 trees. Means timber has been separated. Permanently fastened. Timber has been permanently fastened. Mr. Y wants to know whether sale of timber can amount to sale of immovable property or not. Advise him with reference to General Clauses Act 1897. So, immovable property will be seeing that. Immovable property shall include land, benefits to arise out of land and things attached to a permanently fastened to anything attached to the earth. Now, 4 elements, it will be continuing. Inclusive definition. In the instant case, X sold land along with the timber obtained after cutting trees or 50 tamarind trees of his land. So, according to the above definition, land is a immovable property. Definitely, here land itself is the first point. So, land is an immovable property. However, timber cannot be called as an immovable property since the same are not attached to the earth. Means things attached to the earth will be coming into the earth, but things which are removed cannot be coming into the definition of the immovable property. So, this is what the thing. Yes, dividend, same computation of time, section 9, sir. There is no change here. Yes, we have already completed the effect of the date. Yesterday only we have seen. The term good faith. See here. Mr. K went to a jewelry shop to purchase diamond ornaments. The owners of the jewelry shop are notorious and indulging in smuggling activities. Mrs. K purchased diamond ornaments honestly without making proper enquiries. So, without making proper enquiries will not invalidate good faith, sir. Because good faith means honest. That's all. Good faith means honest. That's all. Was the purchase made in good faith or not? Yes, definitely it's made in good faith only, because if done any honestly, whether it is done negligently or not, it won't be affecting. So, thus anything done with due care and attention which is not mollified is presumed to have done in good faith only. Also, one case law, you can mention the case law, sir. If you remember, you can mention the case law, or otherwise you can directly write the analysis. No issue in that. So, an honest purchase made carelessly without making proper enquiries cannot be said to have made in good faith so as to convey good title. So, here Miss X purchased a watch carelessly from Mr. Y without proper enquiry. As proper enquiry was not made, we can say that purchase cannot be said made in good faith. Just please remove 5 minutes which I have said here, good faith, and this also. Just please remove from I think 10 minutes before, please remove. I'll be continuing from that only. Like the topic which I have started. Practical questions is okay. This one from here, from this question onwards, previously what is there, just please remove that. Now I'm going to say this question again. So please remove the previous part which I have started from question number 2. Okay, recording video. So I'm closing. Yeah, I'm again opening, just so please delete the previous 10 minutes which I have started from the practical questions, because now I'm again re-saying this one. So from this question number 2. So please see question number 2. Mr. X owned a land with 50 tamarind trees. He sold his land and timber, that's what, after obtaining the cutting the 50 trees. Now, whether the sale of timber tantamount to sale of immovable property or not. Here, timber has been removed, sir. Timber has been removed. Means it's not attached to the earth. It's not attached to the earth. Here, the immovable property shall include land, benefits to arise out of land, and things attached to the earth, and permanently fastened to anything attached to the earth. Permanently fastened to anything attached to the earth. So here we can see that X sold land along with the timber. Here land is an immovable property, no doubt. Land is an immovable property. Coming to the timber of 50 tamarind trees of his land. Here land is an immovable property. However, timber cannot be immovable property since the same are not attached to the earth because they are removed. Now, this same, so this is previous question, computation of the time, section 9 we have seen already. This also yesterday we have seen, sir. Section 5, effective date of the act, nothing but. We have seen, yes, see here, good faith. Mr. X purchases a watch carelessly from Y without proper inquiry. Whether the purchase made could said to be made in good faith or not. So let's see. Good faith, whether in fact done honestly, whether it is done negligently or not. That's what the term good faith is. Means honesty is important there. Anything done with due care and attention which is not malified is presumed to have been done in good faith. Yes, if you're not having any malified or intention of the defraud to others, then simply it can be called as, we can have in good faith manner only. So here case law, if you are able to remember this case law, please mention the case law, sir. Or think that if you do not remember the case law, just leave as the simple analysis you can write here. Good faith which is done without care. So here from the act we can understand that nothing is said to be done in good faith which is done without due care and attention. So without due care and attention, if nothing has been done, we can't say that it has been done in good faith manner only. That's why conclusion, in the above case, Mr. X purchases a watch carelessly. X purchases watch carelessly from Mr. Y without proper enquiry. As proper enquiry was not made, we can say that purchase cannot be said made in good faith. That's what. No good faith is there in that. Now, see here, distance, computation of distance, I have said section 11, nothing but straight line on a horizontal plane. Straight line on a horizontal plane. So, in the measurement of any distance, for the purpose of any central act or regulation, nothing but to be measured on straight line. So, here they have given two ways to reach two cities. One is roadways 100 kilometers and by water 80 kilometers. What will take, sir, generally? Horizontal plane, straight line. Nothing but 100 kilometers will take. That's all. 100 kilometers. So here, particular date, fixing of the court or any other office is closed on a particular date means how we can approach. Means the next succeeding day we can approach. That's what the case here. The court fixed the date of hearing on 29th April, which was announced to be a holiday subsequently by the government. So after the holiday, whatever the next day for opening of the office, next day for opening of the office will be taken into account. Simply that's all. Now see. Computation of time, if it is done or taken on the next day afterwards on which the court or offence is open. That's what, next working day, simply. Here the next working day is not given, so next working day, not suppose after 1st May is an holiday, public holiday, then we can't take public holiday. That's why the next working day they have specifically mentioned. Next, government, yesterday we have seen, includes both central government and state government. See here, under statutory rules, to be sent by registered post, acknowledgement due. Means along with the registered post, acknowledgement due also need to be there. But what they have sent by only registered post only. Now whether the presumption regarding serving of the notice by registered post under GCA is available or not. Not available because it is a statutory rule. No. Statutory rule said that posting need to be done register post with acknowledgement due. But as per GCA, simply register post if you have made, though you have made register post, it does not validate, but not tenable. That's what. So, means section 727, serving by post, these are the things required. A letter containing document to have been effected at the time at which letter would be delivered in the ordinary course of the post. Now, here in this case, register post has been made. But it's a statutory rules, register post acknowledgement due is to be made. So, it will not be the compliance of the said rules. However, if such provision was not provided by the such statutory rules, then service of notice if registered post only shall be deemed to be effected. Because it is made by the statutory rules, the same thing need to be followed as if statutory rules are prevailing. As statutory rules are prevailing than the General Clauses Act. If there is no statutory rule, yes, ordinary post is also means register post is also tenable under GCA. Register post is also tenable under GCA. Now see, here also notice of refusal. With an endorsement of refusal, decide with reference to the provisions of GCA whether notice was rightfully served on Mr. Vyas or not. So if they followed as per section 27 whatever required for the register post, then it will be deemed to be effectively served to the person only. So here, in the given question, it can be deemed that notice was rightfully served provided if they meet the conditions in section number 27 of GCA. That's all. So, see here, expert advice on taxation matters. Ram is liable to a fine for acting fraudulently both under Advocates Act as well as the Income Tax Act. Means punishment under two different acts or enactments. What we can take, how we can take. Simply, sir, we can take either of them, but not twice punishment. That's what the thing is there. The offender may be prosecuted and punished under either or both of the enactments, but shall not be liable to be punished twice for the same offence. This is what the thing. So, he may be punished under Advocates Act or the Income Tax Act, but shall not be punished twice for the same offence. Yes. See here, bill of exchange. Date of presentment. Date of presentment is a holiday, sir, actually. So, which date? Simple. Next date. Next day when the office is open. Already seen. Next day when the office is open. That's what. A key managerial person shall not hold office in more than one company except its subsidiary. So, here only singular term is used, sir. Singular term except its subsidiary. Referring to section 13, examine whether a whole-time director can be appointed in more than one subsidiary company or not. Yes, because singular includes plural as per the GCA Act. That's what. That word singular shall include the plural unless there is anything repugnant to the subject or context. If it is any contrary is there, then we need to follow that only. But here no contrary. So as per GCA, what's singular includes plural. So more than one subsidy also can be appointed. That's what. Notice could be served. Could not be served on account of the fact that house Mr. P was locked. So house was locked. Then how? Means section 27 effective means notice was served. But if the person wants to prove in the court of law, it would be for Mr. P to prove that it was not really served and was not responsible for such non-service. This is the thing. This we have already completed, sir. Yesterday only we have completed may and shall. That's all, sir. And this is here, sir. If any authority to appoint someone, the same authority is also having for removing the same person also. It includes, means in the provision, if any thing regarding appointment came, means the authority is also having regarding removal. Appoint includes both authority and removal. That's what the question is here. May 2022 MTP 4 marks. Very easy. If this question comes, very easy. Section 16 of GCA. The authority having the time being power to make the appointment shall also have power to suspend or dismiss any person appointed. So this is the same. Appointment includes, the authority includes appointment as well as the removal or suspend also, right? So we have completed the General Clauses Act. Only interpretation of statutes is there. So now we are in the last chapter of our other laws. There is nothing but interpretation of statutes. This is the last chapter, and if we cover this chapter, we'll be successfully completing the whole topic of the other laws. Now coming to this interpretation of statutes. How many percentage of marks or how many on average can be present in the examination relating to this chapter? So actually this is also an important chapter in the examination point of view, but not more marks. On an average they may come, right, 4 to 6 marks average they may be coming in the examination. Now see, let's have a look for the May 22nd additional concepts for self-study, 6 marks. December 2021, 3 marks, 3 marks, 6 marks. In the same July 2021, 3 marks. So it may vary between minimum 3 marks are guaranteed. It may vary between 3 marks to 6 marks. Only some short questions can be asked from this, and also practical questions we can expect from this, because there will be different rules of interpretation. In that we may have some focus, right? Now coming to the chapter interpretation of statutes. Nothing but generally statute means law. We know that. Nothing but simply rules and regulations. Statute means. Interpretation means law we are interpreting. Means for understanding the law, we need some rules of interpretation, because law is such a critical concept. Law is such a critical concept. If anything goes wrong, it may change the meaning. In fact, also it may change the meaning. Hence, there is a necessity, or there is huge importance to understand the law basically. Because if you don't understand the law basically, it will give many complications. And hence moving to a courts or court of law can help us, but this is not always possible. Court also look for the interpretation of statutes only. In what way it is beneficial to the parties, in what way we can give the best judgment. There also the judges will study the interpretation of the statute, what is applicable in this case. So these are such a huge important concept which is very important to understand the law, practically. Now coming to the points, what are the things here we need to know? What are the things we need to concentrate in the examination point of view? So I have already said statute means law. Statute means laws and regulations of every kind. Yes, we use synonymally statute, act in our common language. Yes, define the term document. We have already seen the document definition previously in the GCA also. General Clause Act also document we have seen, like where it should be recorded form is must. All these things we have seen in the general clauses also. Now here if you see, the definition can be taken from the Indian Evidence Act as well as the General Clauses Act also, right? Document means any matter expressed or describes any substance by means of letters, figures or marks, or one of those means.
for the purpose of recording that matter. This is the definition same we have seen in the General Clauses Act also. Now coming here, interpretation of statutes. It also gives some definition. So nothing but document contain the following 4 elements. So what are the 4 elements it will be having? One is matter, means what is the area you need to take. Any matter in definition reveals the definition of document is exhaustive. Any matter, any issue, etc. Record. The second thing is recording the matter is important. Recording the matter means on record we need to take. If any information we have provided, what we will say, sir, is we have taken on recorded or we have noted on record. That's all. Substance. Substance means in which form you are storing. Permanent in nature. Permanent in nature. In the same way, means, which means you are storing. Like what is the way of representing the recording matter? What is the way of representing the recording matter? Like letters, figures, marks, symbols communicated between 2 persons, means the method we are using to record that matter. Method we are using to record the matter. So here document contains 4 things. One is matter, second one is record, substance and means. What is the method of recording? Simple. If you write this definition, yes, it is helpful for you, and I think it is asked only for the 1 mark or 2 marks. That's all. Very easy. If you write these 4 points like matter, record, substance and means, if you write these 4 points, definitely it will be useful to you. That's all. Now, instrument already we have studied in NI Act also. Nothing but it is a letter or document which provides rights and liabilities to the parties, contracting parties, rights and liabilities to the contracting parties. Simple, you can write formal legal document which creates rights and or records a pact. Legal effect is creating a liability. That's what. Very easy, right? Now, deed also same thing, no? Like sale deed, will enforce, will execute deeds if any agreement is going on. Deeds means nothing but what? What is the mutual understanding between the 2 parties, which creates rights, which creates liabilities, understanding, etc. Whatever the terms and conditions of a contract, will be writing in the deed. So that's what. Deeds are the instrument. Though all instruments are not maybe deeds. According to the legal dictionary, deed is an instrument in writing, purporting to effect some legal disposition. Means we are creating some legal obligations or rights. Creating some legal obligations or what we are creating? Rights. Legal obligations are rights. Next, what is meant by interpretation? Significance of interpretation. Nothing but interpretation means there is a huge importance to understand the laws. That's what. Not much important as far as concerned to the examination point of view. Classification of interpretation is Jolowitz and Fitzgerald both have interpreted the type of interpretation, but these are also not much gain importance basically. So hence we are no need to study at this point of time. Construction means nothing but we need to know the true interpretation, means what is the intention of the lawmaker. What is the intention of the lawmaker? Yes. Generally in examination, most of the questions will be asked from this area. Examination important point of area. What is this? Rules of interpretation or construction of the statutes. So there are 2 different rules we can bifurcate. That is nothing but primary rules of interpretation and secondary rules of interpretation. So what is this? Rule of construction, rule of reasonable construction, rule of harmonious construction, rule of beneficial construction, rule of exceptional construction and as judem generis. In this all some legal language or some quotations will be there, and sometimes we need to correlate the quotations with what is the rule. This also examination they may have some questions like that. Secondary rules, effect of uses and associated words. Now, what is meant by rule of literal construction? Nothing but literal construction means in the normal legal sense. How do we take the act? So simple, sir. It's nothing but we can say plain words require no explanation. If it is clear, there is no need to explain much further. If it is easily understandable, you can take in that particular meaning only. We cannot add any other thing more than that. So that is nothing but rule of literal construction. Now you see, it is also called as, this is important, sir, and many times asked it bit. What is the cardinal rule of construction? Cardinal rule of construction is nothing but rule of literal construction only. That a statute must be construed literally and grammatically, giving their words ordinary and natural meaning. Whatever the natural, in the preliminary sensible way, what we take regarding the understanding, that only it will be there. Now, so this is the rule of interpretation, natural and grammatical meaning. Means whatever the natural and grammatical meaning, we need to interpret as accordingly. We need to interpret as accordingly. Means in the natural, ordinary or popular sense, or in the popular sense. Technical words are constituted in technical sense only. Yes, if technically they have given some words, we need to understand as per technical sense only, but not in logical manner. So this is the rule of literal construction. It is also called as cardinal rule of construction. The second thing is reasonable construction or golden rule of interpretation. It can also be called as golden rule of interpretation. See here the magazine used atrues majus valet quam period, which means that statute must be understood based on reasonable meaning. Statute must be understood based on reasonable meaning. The previous one, the literal construction, Latin maxim is absoluta sentior, means exposit non indigent, which literally means an absolute sentence or proposition need not any explanation. Here expositor only came, need not require any explanation. Need not require any explanation. That's what. So here also legal term is this one. It is nothing but statute must be understood based on the reasonable meaning. Now, see here, while interpreting the law, two meanings are possible. One making the statute vague, meaningless, and other leading to certainty. Which meaning will take, sir? Obviously, the meaning which is going to have certainty and absolute meaning only will take. That's all. This is the thing. Rule of harmonious construction. Harmonious construction means nothing but if there is any conflict, between two provisions of a statute, then similarly this rule comes to our aid when there is conflict between the provisions of a statute and the object which the legislature had a view. Now what we need to take means if there is any conflict between two provisions in the act or object or any other provision of the act, then how to solve that? Then see here, where an expression is susceptible of a narrow or technical meaning as well as a popular meaning, the court would be justified in assume that the legislature uses the expression in the sense which would carry out its object and reject which renders it invalid. Means how the court will take which fulfills the object or which is according to the objects of a company will take that one, and which avoids the objects of the company will remove that one. This is called as nothing but rule of harmonious construction. Here also see, a specific rule will override a general rule. That's what really, if Companies Act, we'll see many things in this. Specific act will override the general rules. That's what. Next, significance of the term subject to. Notwithstanding. Notwithstanding means nothing but the other will not be having their validity, but the thing which we have stating clearly, it will be having validity. Notwithstanding anything contained in the contrary to the provisions, means which will prevail, sir? The former one will prevail, but not the later one. Making the provision prevail over the others. One file classic example I'll say to you. Section 6 of the Companies Act 2013, it will provide that Act will override the MOA and AOA. Act will override the provisions of MOA and AOA. Means what? If we see or study Section 6 of the Companies Act 2013, it will clearly state that notwithstanding anything contrary to the provisions contained in MOA or AOA, Act will prevail. That's what it's saying. So notwithstanding, you're using the term there also. So these are all the examples which need the explanation of the notwithstanding, but not important. If you study once, okay, it's okay. Rule in Haydn's case or mischief rule. Sometimes a question may be asked, which rule may be also called as like this. Same, Haydn's rule or mischief rule. There is not a difference. See here, what is the applicability of rule here? Where the language used in the statute is capable of more than one interpretation. Means there are 2-3 interpretations possible from reading a same act or provision. Then the court must adopt the construction which shall suppress the mischief and advance the remedy. Means which gives for the remedy but not the other things. Only which gives the remedy we need to take and suppress the mischief also. Hence this rule is called mischief rule or Haydn's rule. Beneficial construction. See here, it's asked for MTP and also May 2018. No, May 2018 MTP, only one. Which brings into effect the provisions of improving the conditions of certain class of the people who are underprivileged and who have not been treated fairly in the past. Means what, sir? Beneficial construction means we need to take the act in such a way that it gives benefit to the other persons. It gives benefit to the other persons. Rule of exceptional construction. Exceptional construction means here elimination of the words in a statute which defeat the real objective of the statute or make no sense. If they are not needed in that particular act, then what we'll be doing, sir? We'll eliminate those. We'll eliminate those. So that's why if we want to eliminate this, we can construe or understand the rule as per the rule of exceptional construction. Elimination rule means if it is defeating any real objects, we can eliminate the same. We can eliminate the same. That's what. See here, sometimes the questions can be coming from mandatory versus directory provision. Yesterday we also saw some things in General Clauses Act. Shall, may, use of shall and may. When shall can be used as a directory, or may can be used as a directory, and shall can be used as a compulsory provision, right? That's what mandatory provision. When a provision is mandatory, it must be strictly observed. When a provision is directory, just if we comply with, enough. If we comply with, it is enough. But whereas to coming to the mandatory provision or compulsory provision, we need to adhere to the provisions strictly. There is no bypassing that. Mandatory versus directory provisions. Yes, we have already seen in the General Clauses Act. So next topic is may and shall. That's what just we have learned now. See here, shall, though mandatory, it is read to be may. Means based on the facts and circumstances and also interpretation of the lawmaker. What is the intention behind the lawmaker? We need to check all these and we will guide whether may also can be taken as mandatory provision or shall also can be taken as directory provision. Anything interchangeably can be used based on the thing is that intention of the lawmaker is important here. Intention of lawmaker. We need to check the intention of the lawmaker and also object of the facts and circumstances of the case. Rule of as judim generis means the same kind of species. This sometimes may be asked as a bit. What is the term as judim generis? Means same kind of species. Same words unnappudu. The rule of as judim generis means where specific words are used and after those specific words some general words are used. Then general words would take their color only from the specific words used. Means general words cannot exceed the specific words. Cannot exceed the specific words. If first of all in a sentence we are using some specific relating content and then we are having some general related content. Now general content means many things will come, but they should not override the things of the specific provisions. That's what the case is. So it's not much important as per the examination also. There's no issue in that. Yeah. Internal aids to interpretation or construction. This is nothing but sometimes they'll be asking in MCQs, pick out the odd one, or what is an internal aid to construction. They will be giving all the external things and they'll be asking to pick any of the odd one out. Like they'll be merging like internal and external interpretation things, examples. Then we need to identify what is internal and what is external. So they are basically the factors which need for the understand depends upon external and also internal. Coming to the internal aids of interpretation means when we see a act or when we see a provision, some will be helpful for our understanding basically. So what will be helpful in what document we can see easily? Long title and short title, preambles, heading and title of the chapter, marginal notes, definitional section and clauses, illustrations, provisions, explanation, schedules and reading the statute as a whole. Basically yes, for every act, first of all we will see the sections or provisions. We can also be equally calling sections, subsections and sometimes headings will be having seen. And the first one of course is title, short title, preamble. We'll check all these also, and also we'll be seeing provisos. Sometimes provisos also will be coming. Clauses, provisos, clauses, subclauses, schedules. In Companies Act also there are 7 schedules particularly. So schedules. Previously in Companies Act 1956 there are notes. Some notes. So all those will be having the internal aids of the interpretation. All those will be saying the internal aids of the interpretation. Now coming to external aids of interpretation means we need to take outside considerable points. So what we can take, sir? What we can take? Historical setting means whatever the case precedents we can take. Consolidating statute and previous law, usage, earlier and later analogous act, explained by the later act, reference to repealed acts, dictionary definitions. See, we don't know. Dictionary definition is an external one, and this question has been asked recently also. What is the dictionary definition? Use of foreign decision. So all these are the external aids to interpretation, means which help us to understand the or interpret the statute external by using external factors. Long title, nothing but short title and long title merely identifies the enactment, just identifies the enactment, and only for our convenience we are using. But whereas long title is used for enactment and does not merely identify it. Means long title will be always describing the enactment. Short title identifies the enactment. What is the name? Companies Act 2013, Negotiable Instruments Act 1881. Short titles, all these are. Long titles, it describe the enactment. Preamble, we know already preamble is Mundu Mata. Yesterday also I have seen, General Clause Act also we have seen what is meant by preamble and what it gives, scope, objective powers, etc. The intention of the lawmaker also it will be used, no issue in that. Headings and titles. Yes, definitely there will be some headings or there will be some titles relating to the concept of the explanation under each provision. So we need to take those headings and things also into consideration. Now coming to the marginal notes. See here, one of the important previous question asked. Marginal notes are the summaries and side notes often found at the side of a section or group of sections in Act pertaining to some of the effect of that section. Means some side additional notes they will be providing in Act. So we need to consider those notes also. Suppose footnotes will be taken like that, same as the case of the marginal notes. They are not, one of the important points here, they are not the part of enactment, but they were not present. Means when the act has been passed, there are no revelation of the marginal notes. But after the act is passed, when the act was passed in the parliament, but inserted after the act has been so passed, means after the act came into effect, then only they have, for better understanding, they have passed it. For better understanding, they have passed. Hence, they are not an aid to the construction. Means they are not aid to the construction. Sometimes they may be considering, sometimes they may not be considering. Depending on the facts and circumstances, we will be taking into account. That's what, because they are not passed separately, we are not taking into aid to construction. Definitional sections. Restrictive and extensive clauses. Yes, generally we will see extensive definitions, restrictive definitions, somewhat we will be seeing. This question number means and includes. Means and includes, a question has been asked for example stating means and includes, and how do you interpret as per the interpretation of the statutes. Means and includes is an important concept. Ambiguous definitions means not in we find the definition section may itself be ambiguous, and so it may have to be interpreted in the light of the other provisions of the Act. Means some provisions of directly cannot be understandable by easy reading, cannot be understandable. So what we will take, sir, help of the other provisions we will take. Such type of definition is not to be read in isolation. Means we must be read according to the context of the phrase, not individually. We should not have any individual look onto that, but only we should have the group reading, which is defines realizing the function of a definition to give accuracy and to give certainty. How do you interpret the definitions which are contrary to the context? Means which are against the context. See here, when a word is defined to bear a number of inclusive meanings, means different meanings are there. Different meanings. The sense in which the word is used in a particular provision must be ascertained. So synonyms will be there probably every word. So how do we know the correct definition? It is as per that context only. So can be seen only from the context of the scene, the language of the provision, and the object intended to be served thereby. This is the main thing. So according to the object of the context, we need to go. According to the object of the context, we need to check our interpretation. If any word is having different meanings, two or more meanings, in fact. Importance of provision. Yes, provisions are nothing but they will exclude, provided that. We'll be seeing in Companies Act or any other act, simply we'll be seeing provided that this can be done. like this. They will exclude. Means if a provision is there, they will have some additional informations like provisions which excludes the above provision. See here. So, normal function of the proviso is to accept something out of the enactment. Means we are not including that one. That's why we are keeping it separately. Or to qualify something stated in the enactment which would be within its purview of the proviso were not there. Means we are excluding. A proviso should not be ordinarily interpreted as general rule because it is not general. It is an exceptional case. So, here exceptional clauses, saving clause, except the main provisions. So, these are the things. That's all. If any question has been asked on this, like RTPs, RTPs and MTPs, we can see this question. And also November 18 and November 2020, 3 marks, proviso to very easy. If such a question comes, happily you can write, because only thing is you need to explain the same. Provisions are used to deal with an additional information under the each section or each provision to exclude something or to qualify something. That's why we can use as an exceptional clause, and it starts with the word provided with. That's all. Next. External aids of interpretation, historical setting. Yes, if there is any things we can use. Uses. Normal uses, reference to the dictionary definitions. Yes, suppose if there is not defined in the act, if anything is not defined, because generally in the act definition sections will be there. If definitions is not there, we will refer general clauses act which are applicable generally. In general clause act also, if you do not find anything, then we can go to dictionaries directly and we can understand the common meaning of that, which is referring to the context of that matter, because each word may be having different meanings as per different situations. Now here, as per the general sense, which is in the context, we need to use the same only. In selecting one out of several meanings, we must always take into consideration the context in which it used. Means at what situation it is used. At what situation we are using that. That's what dictionary. Judicial decisions laying down the meaning of the words and constituting statutes in pari materia will have greater weight. So, if any judicial decisions is there, then we can consider them only. Foreign decisions. Yes, see here, important. July 2021, 3 marks. December 2021, 1.5 marks. Foreign decisions. When we'll take, if any Indian court hadn't have any such previous decisions, means then we need to refer the foreign decisions obviously. Following the same system of jurisprudence as ours and given on laws similar to ours can be legitimately used. We can use for construing our own acts. However, primary importance is always given to the language of the Indian statute. When guidance can be obtained from Indian decisions, reference to foreign decisions may become unnecessary. Definitely, I have said that only. So, if Indian decisions are not available, then we can go for the foreign decisions under the same circumstances of the case. Read statute as a whole. Definitely, so we need to include all the things while reading the statute as a whole. Rules of interpretation. Yes, see here some of the questions are there. Formal legal document which creates, it's a legal document, but which creates or confirms a right or record. Documented deed as statute instrument. Instrument creating rights and liabilities. Which among the following is the cardinal rule? I have said, sir, cardinal rule is nothing but literal rule of construction. Rule of reasonable construction is based on the maxim. At res magis valid quam pariat. Rule of beneficial construction is known as mischief ruler, Haydn's ruler, purposive construction. Mischief ruler and Haydn's ruler same, so. Golden rule actually. Golden rule of construction. Pick out the odd one of the following aids in interpretation. Odd one. So preamble, proviso, marginal notes, all are internal aids of interpretation. All are internal aids. What is external, sir? Uses. Which rule of construction is applicable where there is a real and not merely apparent conflict between the provisions? Yes, any conflict is there. Rule of harmonious construction. An internal aid that may be added to include something within the section or to exclude something. We can include and we can exclude something. Explanation. An aid that expresses the scope, object and purpose. Preamble simply scope, object and purpose of the act will be given by the preamble. Yes. So can we see some of the practical questions? See here, beneficial, rule of beneficial construction. The meaning of the word to be judged by the company it keeps. Explain the term nocitor a sources. This is also asked in MTP question. The preamble to the act discloses the primary intention of the legislature but cannot override the provisions of the act. Yes, sir. In General Clause Act also we have learned the same. Explain the function of the provision. I have already said provision is an thing which excludes or qualifies something. Yes, see here, what are the rules of interpretation of deeds and documents will you apply while doing so? What are the things we will apply? Very easy. See here, means and includes. I have said already. 3 marks it has been given. Means inclusive definition. Includes means what? Means prima facie, restrictive and exhaustive. We must restrict the meaning of the word to that given in the definition section. Means we are restricting the word. There is no other scope to include that. Now coming to the include, the word is defined is not restricted, but meaning is assigned. This is the thing asked in May 2022 MTP. 3 marks also it has been asked in. Yes. Associated words to be understood in common sense manner. Yes. Associated words means group of 2 or more words. See here, when 2 or words or expressions are coupled together, one of which generally excludes the other, obviously the more general term is used in meaning excluding the specific one. Yes. Means obviously we will take the specific one, we should not take, sir. We will take obviously the general term which can be understandable. General term which can be understandable and easy. There is a concept of nocitor a sources, that is to say that the meaning of the word is to be judged by the company it keeps. Means what? When 2 or more words which are capable of analogous, means similar words, meaning are coupled together, they are to be understood in their cognate sense. Means whatever as per the context of the phrase, we need to take them. That's why they take, as it were, their color from each other. The more general is restricted to a sense analog to the less general. Means specific we are not taking. We are including only general thing. That's what the definition is. Next, see here, one small case law, January 2021. For 3 marks this has been asked. Sohel, a director of the company, not being personally concerned or interested otherwise in the matter of the proposed motion placed before the board meeting, did not disclose his interest. Means here his is there. We can't take it as a personal interest. If any relatives, his close relatives interest is also there, we need to inform the close relatives interest also while doing an related party transaction. Now see here, interest, although he has knowledge that his sister is interested in the proposal. Sister is not interested, then he need to tell that, he need to convey the same. He restrains from making any disclosure of his interest on the presumption that he is not required by law to disclose any interest as he is not personally interested or concerned in the proposal. What he is thinking? As per the law, only here his term is used, no sir. So only myself, but not any other, Now say whether this is correct or not. Explaining the scope of interpretation under this rule in the given situation, decide whether the decision of Sohel is correct or not. So this is as per the thing of rule of literal construction. Means as per the cardinal, there is a cardinal rule of construction, and as per the literal construction we need to take absoluter sententa exporter non-indigent. Means what? The sentence, if it is absolute, do not require any additional explanation. Plain words require no explanation. So what is the ultimate thing here? In the given question, Sohel did not disclose his interest in a matter placed before the board, as he is not personally interested or concerned in the proposal. Here, he thought to have considered broader meaning of the provisions of the law. Yes, we need to take what? General, not specific. And therefore, even though he was personally not interested or concerned in the proposal, he should have disclosed the interest. Because what? Interest means not only his interest, his relatives, close relatives interest also, he need to disclose in the resolution. That's what. How will you interpret the definitions in a statute? Means and includes. I have said no. Means and includes. Means restricting, completely restricting. Includes, not restrictive manner. Not restrictive. That's all. See here, definition of a director. 234. Director means a director appointed by the board of a company. The word means suggest exhaustive definition. Means whoever not appointed by the board will not become director. Whoever not appointed by the board will not become a director. That's why here means completely restrictive and only includes that person only. However, if we see the definition of a whole-time director, includes a director in the whole time employment of the company. Means any director. It can come any director who is in the whole time employment of the company. That's what the difference includes. Difference is that. Grammatical interpretation, and what are the exceptions to the grammatical interpretation? So grammatical interpretations go beyond the letter of the law. Is the sole from allowable. MTP it has been asked, sir. MTP 4 marks. So the thing is that coming to the grammatical interpretation, it should not go beyond the letter of the law. It cannot go beyond the letter of law. Means what? Logically defective on account of ambiguity, inconsistency or incompleteness. The defect to the ambiguity, the court is under duty to travel beyond the letter of the law so as to determine from the other sources the true intention of the legislature. Means what? If there is any ambiguity or inconsistency in the provision what we have read, the court will decide by considering other things. That's what. Grammatical interpretation and logical interpretation of statute. What are the duties of the court in this regard? Just now we have seen grammatical interpretation and logical interpretation. Concerns itself exclusively with the verbal expressions of the law. Means beyond law we need to think. Beyond law, not beyond the letter what we have. Application to the principles of the court. See, the court cannot delete or add or modify the letter of the law. However, the letter is logically defective on account of ambiguity, then out of the law. The main principle is, first of all, cannot go out of the letter of law. If there is any inconsistency in letter of law or any ambiguity in letter of law, then we can go outside, go beyond that letter of law. That's what is grammatical interpretation. And the court applies these principles in deciding the case. However, if there are two possible constructions of a clause, the courts may prefer the logical construction which emerges from the setting in which clause appears and the circumstances in which it is used. Means logical interpretation only we will take rather than the grammatical interpretation. Logical interpretation prevails. Yes. What is the effect of the proviso? Does the main provisions of an enactment. Proviso already have said many times that just to accept something or to qualify something. Interpreted as general rule. Yes, it is not a general rule. Carves out an exception to the main provision. That's what. Regarding a particular provision, it shows an exceptional category. Mandatory provision versus directory provision. Yes, we have already seen that. Preamble can be used as an aid to interpretation. Yes, definitely, sir. But it cannot override the provisions of the Act. Preamble will not override the provisions of the Act. See here, when will the courts refer to the preamble? Situation 1. Where there is any ambiguity in the words of enactment, the assistance of the preamble may be taken to resolve the conflict. Means if any ambiguity in the words particularly. Situation 2. Where the words of an enactment appear to be too general in scope of application, then courts may resort to the preamble. Means if there is more general meaning in that particular provision, then they will refer the intention of the lawmaker. Dictionary definitions. I have already said to you, we have already taken a look regarding dictionary definitions. Yes. Means if the Act is not having any definitions, in the Act there are no definitions relating to the term, then we need to go with the dictionary definitions and we need to understand the clear meaning of that relating to the context of the situation. That's what. At the time of interpreting a statute, what will be the effect of usage or custom? Uses or custom definitely at the basic point of law, sir, because law, one of the main source for constructing law is nothing but customs and usages. That's what, because based on the previous usages only we have designed our law. Means how much huge importance we are seeking from the uses and customs, definitely. So in connection we have to bear to Latin language. Custom is the best interpreter of the law. The best way to interpret a document is to read as it would have been read when made. Means at that point of made. At the point of made means source of law, nothing but. Source of law is nothing but one of the main source of law is uses and custom. That's all. How for the title and preamble in Act helpful in interpreting any parts of the enactment. Title. By the title you can know short title, long title. I have said short title, it is describing and identifies the what is enactment. Long title describes the enactment. It describes the enactment. Preamble, scope, objective, powers, etc. can be known. Purpose of the act also can be known. Proviso explanation. Proviso, I think no explanation is required. Coming to the explanation, may be added to include something. Yes, explanation may be added to include something with the section or to exclude something. If anything else we want to do in that particular section, then we can add an explanation by adding something or by deleting something. That's all. So we have completed the whole topic, that is interpretation of the statutes. So by this we have almost completed the topic of the other laws. Thank you very much, and thank you for the wonderful opportunity given by me, by the management of the Masterminds, for standing in front of you and taking the huge summary of the other laws. And I particularly thank our academic advisor Mr. Prakash Garu and the other co-supported staff there. Thank you so much, and my dear students, I wish you all the best to you, for you to be in a success mode upcoming examinations. I wish you all the best, and hope this material shall be helpful for you in at least gaining some few marks regarding my explanation. Thank you so much, and bye. Thank you.